338A, 338B, 339, 340, 344, 350B. National Commission for Scheduled Castes, National Commission for Scheduled Tribes, National Commission for Backward Classes, Scheduled Areas and Scheduled Tribes Commission, Backward Classes Commission, Official Language Commission and Official Language Committee of Parliament, Special Officer for Linguistic Minorities, Constitutional Prescriptions, Chapter S, T Compositions, Table 55.1 Constitutional Prescriptions with respect to compositions USI. No. Institutions Bodies Composition Related Article 1. Central Council of Ministers Prime Minister and other ministers 74. 2. Parliament President, Rajya Sabha and Lok Sabha 79. 3. Rajya Sabha 250 members 80. 4. Lok Sabha 550 members 81. 5. Supreme Court Chief Justice of India and other judges 124. 6. State Council of Ministers Chief Minister and other ministers 163. 7. State Legislature Governor, Legislative Council and Legislative Assembly, or Governor and Legislative Assembly 168. 8. Legislative Assembly maximum 500 members and minimum 60 members 170. 9. Legislative Council maximum 1/3 of the total number of members. In the State Legislative Assembly and minimum 40 members 171. 10. High Court Chief Justice and other judges 216-11. Panchayats determined by the State Legislature 243 C12. State Finance Commission determined by the State Legislature 243-1. 13. State Election Commission State Election Commissioner 243 K14. Municipalities determined by the State Legislature 243 R. 15. District Planning Committee determined by the State Legislature 243 ZD. 16. Metropolitan Planning Committee determined by the State Legislature 243 ZE. 17. Interstate Council determined by the President 263. 18. Goods and Services Tax Council. Chairperson, Vice Chairperson, and members 279A Constitutional Prescriptions 455. SI. No. Institute Launch Bodies Composition Related Article 19. Finance Commission Chairman and 4 other members 280. 20. Interstate Trade and Commerce Commission. Determined by the Parliament 307. 21. Union Public Service Commission. Chairman and other members 316. 22. State Public Service Commission. Chairman and other members 316. 23. Joint State Public Service Commission. Chairman and other members 316. 24. Central Administrative Tribunal. Determined by the Parliament 323A. 25. State Administrative Tribunal determined by the Parliament 323A. 26. Tribunals for other matters determined by the appropriate legislature, Parliament, or State Legislature. 323B. 27. Election Commission Chief Election Commissioner and other election commissioners. 324. 28. National Commission for SC's Chairperson, Vice Chairperson, and 3 other members 338. 29. National Commission for ST's Chairperson, Vice Chairperson, and 3 other members 338A 30. National Commission for BC's Chairperson, Vice Chairperson, and 3 other members 3386 31. Scheduled Areas and Scheduled Tribes Commission. Determined by the President 339. 32. Backward Classes Commission. Determined by the President 340. 33. Official Language Commission. Chairman and other members 344. 34. Official Language Committee of Parliament. 30 members, 20 from Lok Sabha and 10 from Rajya Sabha. 344. 35. Legislative Assembly of Nagaland. Minimum 46 members 371A. 36. Legislative Assembly of Sikkim. Minimum 30 members 371F. 37. Legislative Assembly of Mizoram. Minimum 40 members 371G. 38. Legislative Assembly of Arunachal Pradesh. Minimum 30 members 371H. 39. Legislative Assembly of Goa. Minimum 30 members 371-1. 40. Tribes Advisory Council. Maximum 20 members 5th Schedule. 41. District Council of an Autonomous District. Maximum 30 members 6th Schedule. 456 are Indian Polity. T. Appointments. Table 55.2 Constitutional Prescriptions with respect to appointments. SI. No. Functionaries bodies appointed by I acted by related Article 1. President Electoral College consisting of the elected MPs and MLAs. 54. 2. Vice President Electoral College consisting of the MPs. 66. 3. Prime Minister President 75. 4. Central Ministers President 75. 5. Attorney General of India President 76. 6. Members of the Rajya Sabha elected MLS President 80. 7. Members of the Lok Sabha voters 81. 8. Deputy Chairman of the Rajya Sabha members of the Rajya Sabha 89. 9. Speaker and Deputy Speaker of the Lok Sabha. Members of the Lok Sabha 93. 10. Judges of the Supreme Court President 124. 11. Comptroller and Auditor General of India President 148. 12. Governor of a State President 155. 13. Chief Minister Governor 164. 14. State Ministers Governor 164. 15. Advocate General of a State Governor 165. 16. Members of the State Legislative Assemblies Voters 170. 17. Members of the State Legislative Councils Local Bodies Graduates Teachers. MLS Governor 171. 18. Speaker and Deputy Speaker of the State Legislative Assembly. Members of the State Legislative Assembly 178. 19. Chairman and Deputy Chairman of the State Legislative Council. Members of the State Legislative Council 182. 20. Judges of the High Courts President 217. 21. District Judges Governor 233. 22. Administrator of a Union Territory President 239. 23. Chief Minister of NCT of Delhi President 239 AA. 24. Ministers of NCT of Delhi President 239 AA. 25. Members of the Panchayats Voters 243C Cons and 2 Diona Prescriptions 457. SI. No. Functionaries bodies appointed by elected TTY related Article 26. State Election Commissioner Governor 243 K27. Members of the Municipalities Voters 243 or 28. Chairman and members of the Finance Commission. President 280. 29. Chairman and members of the UPSC President 31630. Chairman and members of a SPSC. Governor 316. 31. Chairman and members of a JSPSC President 31632. Chief Election Commissioner and other election commissioners. President 324. 33. Chairperson, Vice Chairperson and members of the National Commission for SCs. President. J. 338. 34. Chairperson, Vice Chairperson and members of the National Commission for STs. President 338A. 35. Chairperson, Vice Chairperson and members of the National Commission for BCs. President 338B. 36. Scheduled Areas and Scheduled Tribes Commission. President 339. 37. Backward Classes Commission President 340-38. Chairman and members of the Official Language Commission. President 344. 39. Members of the Official Language Committee of Parliament. Members of the Lok Sabha and members of the Rajya Sabha. 344. 40. Special Officer for Linguistic Minorities. President 350B. 41. Members of the District Council of an Autonomous District. Voters Governor. SS, J 6th Schedule. 42. Commission on the Administration of Autonomous Districts and Autonomous Regions. Governor 6th Schedule. TH. Table 55.3 Constitutional Prescriptions with respect to age. SI. No. Election Appointment Retirement Others Prescribed Age-Related Article 1. Election of the President 35 years 58-2. Election of the Vice President 35 years 66-3. Electron of a member of the Rajya Sabha 30 years 84-4. Election of a member of the Lok Sabha 25 years 84. Continued. For 58p Indian Polity. Election Appointment Retirement Others Prescribed Age-Related Article 5. Retirement of a Judge of the Supreme Court 65 years 124-6. Appointment of the Governor of a State 35 years 157-7. Election of a member of the State Legislative Council 30 years 173. 8. Election of a member of the State Legislative Assembly 25 years 173. 9. Retirement of a Judge of the High Court 62 years 217-10. Election of a member of the Panchayats 21 years 243 F11. Election of a member of the Municipalities 21 years 243 V12. Retirement of a member of the UPSC 65 years 316-13. Retirement of a member of a SPSC 62 years 316-14. Retirement of a member of a JSPSC 62 years 316-15. Registration as a voter in the electoral roll 18 years 326. T. Oaths. Table 55.4 Constitutional Prescriptions with respect to oaths. SI. No. Functionaries oath administered by, or made and subscribed. Before. Related Article. 1. President before the Chief Justice of India, or the senior most. Judge of the Supreme Court available. 60. 2. Vice President before the President, or some person appointed him. That behalf by him. 69. 3. Union Ministers by the President 75. 4. Candidate for election to the Parliament. before some person authorized in that behalf by the Election Commission. 84. 5. Members of the Parliament before the President or some person appointed in that behalf by him. 99. 6. Judges of the Supreme Court before the President or some person appointed in that behalf by him. 124. 7. Comptroller and Auditor General of India before the President or some person appointed in that behalf by him. 148. 8. Governor of a state before the Chief Justice of the State High Court or the senior-most judge of the State High Court available. 159. 9. State ministers by the Governor of the State. 164 Constitutional prescriptions for 459. SI. No. Functionaries oath administered by or made and subscribed before. Related article. 10. Candidate for election to the state legislature before some person authorized in that behalf by the Election Commission. 173. 11. Members of the state legislature before the governor of the state or some person appointed in that behalf by him. 188. 12. Judges of the high courts before the governor of the state or some person appointed in that behalf by him. 219. T. Term. Table 55.5 Constitutional prescriptions with respect to term. Continued. For 160 Indian Polity. SI. No. Functionary institutions term duration related Article 20. Board of Directors of a Cooperative Society 5 years 243 ZJ21. Chairman and members of the UPSC 6 years 316-22. Chairman and members of the SBSC 6 years 316-23. Chairman and members of the JSBSC 6 years 316. 24. Chief Election Commissioner and other election commissioners. Determined by the President, subject to the law of Parliament. 324. 25. Chairperson, Vice Chairperson and members of the National Commission for SCs. Determined by the President, subject to the law of Parliament. 338. 26. Chairperson, Vice Chairperson and members of the National Commission for STs. Determined by the President, subject to the law of Parliament. 338A. 27. Chairperson, Vice Chairperson and members of the National Commission for BCs. Determined by the President, subject to the law of Parliament. 338B. 28. Elected members of the District Council of an autonomous district. 5 years 6th schedule. 29. Nominated members of the District Council of an autonomous district. During the pleasure of the Governor's 6th schedule. T. Salaries. Table 55.6 Constitutional prescriptions with respect to salaries. C. No. Functionary salary determined by related article. 1. President Parliament 59. 2. Vice President no salary. Entitled to the salary of the Chairman of the Rajya Sabha. 64. 3. Prime Minister Parliament 75. 4. Central Ministers Parliament 75. 5. Attorney General of India President 76. 6. Chairman and Deputy Chairman of the Rajya Sabha. Parliament 97. 7. Speaker and Deputy Speaker of the Lok Sabha. Parliament 97. 8. Members of Parliament, both Rajya Sabha and Lok Sabha. Parliament 106. 9. Judges of the Supreme Court Parliament 125-10. Comptroller and Auditor General of India Parliament 148-243K. I-20. Chairman and members of the UPSC President. Governor 318. Chairman and members of a JSBSC President. 324. 338. 338A. 338B. Governor, subject to the law of the state legislature. President, subject to the law of Parliament. Parliament. 18. Judges of the High Courts. 21. Chairman and members of a SBSC. 19. State Election Commissioner. 26. Chairperson, Vice Chairperson and members President, subject to the law of the National Commission for BC's Parliament. 24. Chairperson, Vice Chairperson and members President, subject to the law of the National Commission for SC's Parliament. 23. Chief Election Commissioner and other election commissioners. 25. Chairperson, Vice Chairperson and members President, subject to the law of the National Commission for ST's Parliament. 221. 318. Assembly and Council. SI. No. Functionary salary determined by related Article 11. Governor of a State Parliament 158. Chief Minister State Legislature 164-13. I State Ministers State Legislature 164-14. Advocate General of a State Governor 165-15. Speaker and Deputy Speaker of the State Legislative Assembly. State Legislature 186. W. Chairman and Deputy Chairman of the State Legislature 186 Legislative Council. 17. Members of the State Legislature, both State Legislature 195. F. Resignations. Table 55.7 Constitutional prescriptions with respect to resignations. Continued. For 62.0 Indian Polity. SI. No. Functionaries' resignation submitted to related article. 6. Members of the Rajya Sabha Chairman of the Rajya Sabha 1017. Members of the Lok Sabha Speaker of the Lok Sabha 101. 8. Judges of the Supreme Court President 124-9. Governor of a State President 156. 10. Speaker of the State Legislative Assembly Deputy Speaker of the State Legislative Assembly 179. 11. Deputy Speaker of the State Legislative Assembly Speaker of the State Legislative Assembly 179. 12. Chairman of the State Legislative Council Deputy Chairman of the State Legislative Council 183. 13. Deputy Chairman of the State Legislative Council Chairman of the State Legislative Council 183. 14. Members of the State Legislative Assembly Speaker of the State Legislative Assembly 190. 15. Members of the State Legislative Council Chairman of the State Legislative Council 190. 16. Judges of the High Courts President 217. 17. Chairman and members of the UPSC President 316. 18. Chairman and members of a SPSC Governor 316. 19. Chairman and members of a JSPSC President 316. T. Removals and dissolutions. Table 55.8 Constitutional prescriptions with respect to removals dissolutions. SI. No. Functionaries' bodies removed by dissolved by related article. 1. President Parliament 61. 2. Vice President Parliament 67. 3. Rajya Sabha not subject to dissolution 83-4. Lok Sabha President 85. 5. Deputy Chairman of the Rajya Sabha 90. 6. Speaker and Deputy Speaker of the Lok Sabha 94. 7. Judges of the Supreme Court President. On the recommendation of the Parliament. 124 Constitution of Prescriptions 463. Parliament. SI. No. Functionaries' bodies removed by dissolved by related article. 8. Comptroller and Auditor General of India President 148. On the recommendation of the 9. State Legislative Council not subject to dissolution 172. 10. State Legislative Assembly Governor 174. 11. Speaker and Deputy Speaker of the State Legislative Assembly 179. 5. Legislative Assembly WR-7_12. Chairman and Deputy Chairman of the State Legislative Council and Legislative Council. Commission on the Administration of Autonomous Districts and 13. Judges of the High Courts President. On the recommendation of the Parliament. 14. State Election Commissioner-R. TA. President on the recommendation of the Parliament. 15. Chairman and members of the UPSC, a JSPSC, and a SPSC. President. 16. Chief Election Commissioner President. On the recommendation of the Parliament. 17. Election Commissioners or Regional Commissioners. President on the recommendation of the Chief Election Commissioner. 18. I. District Council of an Autonomous District and Regional Council of an Autonomous Region. Governor on the recommendation of the Autonomous Regions. 217. 243K. 317. 324. 324. Sixth Schedule. T. Submission of reports. Continued. Table 55.9 Constitutional prescriptions with respect to submission of reports. SI. No. Functionaries' bodies report submitted to related Article 1. Comptroller and Auditor General of India President, related to the Union, and Governor, related to the State. 151. 2. State Finance Commission Governor 243-13. Chairperson of the District Planning Committee State Government 1. 243 ZD. 4. Chairperson of the Metropolitan Planning State Government AC. 243Z. Committee 5. Finance Commission President 28464 Indian Polity. SI. No. Functionaries' bodies report submitted to related Article 6. UPSC President 323. 7. SPSC Governor 323. 8. JSPSC Governor 323. 9. National Commission for SC's President 338. 10. National Commission for ST's President 338A. 11. National Commission for BC's President 338B. 12. Scheduled Areas and Scheduled Tribes Commission. President 339. 13. Backward Classes Commission President 340. 14. Official Language Commission President 344. 15. Official Language Committee of Parliament President 344. 16. Special Officer for Linguistic Minorities President 350B. 17. Governor President, regarding the failure of Constitutional machinery in the state. 356. 18. Governor-President, regarding the administration of scheduled areas in the state. 5th Schedule. 19. Commission on the Administration of Autonomous Districts and Autonomous Regions. Governor 6th Schedule Part 1 Non-Constitutional Bodies. In this part. 56. NITI Aayog 57. National Human Rights Commission 58. State Human Rights Commission 59. National Commission for Women 60. National Commission for Protection of Child Rights 61. National Commission for Minorities 62. Central Information Commission 63. State Information Commission 64. Central Vigilance Commission 65. Central Bureau of Investigation 66. Lokpal and Lokayuktas 67. National Investigation Agency 68. National Disaster Management Authority 69. Bar Council of India 70. Law Commission of India 71. Delimitation Commission of India. Chapter E in NITI Aayog. Establishment. On the 13th of August, 2014, the Modi government scrapped the 65-year-old Planning Commission and announced that it would be replaced by a new body. Accordingly, on January 1, 2015, the NITI Aayog National Institution for Transforming India was established as the successor to the Planning Commission. However, it must be noted here that the NITI Aayog, like that of the Planning Commission, was also created by an executive resolution of the Government of India, i.e., Union Cabinet. Hence, it is also neither a constitutional body nor a statutory body. In other words, it is a non-constitutional or extra-constitutional body, i.e., not created by the Constitution, and a non-statutory body, not created by an act of the Parliament. Resolution of the Cabinet Secretariat v. No. 511721-2015 Cap. Dated the 1st of January, 2015, published in the Gazette of India, Extraordinary, Part 1, Section 1, dated the 7th of January, 2015. The NITI Aayog is the premier policy think tank of the Government of India, providing both directional and policy inputs. While designing strategic and long-term policies and programs for the Government of India, NITI Aayog also provides relevant technical advice to the centre and states. The center-to-state one-way flow of policy that was the hallmark of the Planning Commission era is now sought to be replaced by a genuine and continuing partnership of states. In a paradigmatic shift from the command and control approach of the past, NITI Aayog accommodates diverse points of view in a collaborative, rather than confrontationist, setting. In the spirit of federalism, NITI's own policy thinking too is shaped by a bottom-up approach rather than a top-down model. Rationale. While explaining the reason for replacing the Planning Commission with the NITI Aayog, the Union government made the following 466 Indian Polity. Observation. India has undergone a paradigm shift over the past 6 decades, politically, economically, socially, technologically as well as demographically. The role of government in national development has seen a parallel evolution. Keeping with these changing times, the Government of India has decided to set up NITI Aayog National Institution for Transforming India in place of the erstwhile Planning Commission, as a means to better serve the needs and aspirations of the people of India. The new institution will be a catalyst to the developmental process, nurturing an overall enabling environment through a holistic approach to development going beyond the limited sphere of the public sector and Government of India. This will be built on the foundations of *3. Government of India document on NITI Aayog entitled As From Planning to NITI Transforming India's Development Agenda, dated February 8, 2015. 3 Ibid. For inch we will use every provision in the Constitution to push reforms. Open Magazine, January 9, 2015. 1. An empowered role of states as equal partners in national development. Operationalizing the principle of cooperative federalism. 2. A knowledge hub of internal as well as external resources, serving as a repository of good governance best practices, and a think tank offering domain knowledge as well as strategic expertise to all levels of government. 3. A collaborative platform facilitating implementation. By monitoring progress, plugging gaps and bringing together the various ministries at the center and in states in the joint pursuit of developmental goals. In the same context, the then Union Finance Minister Arun Jaitley said, the 65-year-old Planning Commission had become a redundant organization. It was relevant in a command economy structure, but not any longer. India is a diversified country and its states are in various phases of economic development along with their own strengths and weaknesses. In this context, a one-size-fits-all approach to economic planning is obsolete. It cannot make India competitive in today's global economy. For the resolution observed, perhaps most importantly, the institution must adhere to the tenet that while incorporating positive influences from the world, no single model can be transplanted from outside into the Indian scenario. We need to find our own strategy for growth. The new institution has to zero in on what will work in and for India. It will be a Bharatiya approach to development. T. Composition. The composition of the NITI Aayog is as follows. A. Chairperson, the Prime Minister of India. B. Governing Council. It comprises the Chief Ministers of all the states, Chief Ministers of Union Territories with legislatures, i.e., Delhi, Puducherry and Jammu and Kashmir, and LT. Governors of other union territories. C. Regional councils. These are formed to address specific issues and contingencies impacting more than one state or region. These are formed for a specified tenure. These are convened by the Prime Minister and comprises of the Chief Ministers of states and LT. Governors of union territories in the region. These are chaired by the chairperson of the NITI Aayog or HISHO nominee. D. Special invitees. Experts, specialists and practitioners with relevant domain knowledge as special invitees nominated by the Prime Minister. E. Full-time organizational framework. It comprises, in addition to the Prime Minister as the chairperson, Vice Chairperson, HISHO is appointed by the Prime Minister. She enjoys the rank of a cabinet minister. 2. Full-time members. They enjoy the rank of a Minister of State. NITI Aayog KJ 467. 3. Part-time members, maximum of 2, from leading universities, research organizations, and other relevant institutions in an ex officio capacity. Part-time members would be on a rotation. 4. Ex officio members, maximum of 4 members of the Union Council of Ministers to be nominated by the Prime Minister. V. Chief Executive Officer. HISHO is appointed by the Prime Minister for a fixed tenure, in the rank of Secretary to the Government of India. 6. Secretariat, is deemed necessary. F. Objectives. The objectives of the NITI Aayog are mentioned below. 1. TB evolve a shared vision of national development priorities, sectors, and strategies with the active involvement of states. 2. TB foster cooperative federalism through structured support initiatives and mechanisms with the states on a continuous basis, recognizing that strong states make a strong nation. 3. TB develop mechanisms to formulate credible plans at the village level and aggregate these progressively at higher levels of government. 4. 7b ensure, on areas that are specifically referred to it, that the interests of national security are incorporated in economic strategy and policy. 5. 7b pay special attention to the sections of our society that may be at risk of not benefiting adequately from economic progress. 6. TB design strategic and long-term policy and program frameworks and initiatives and monitor their progress and their efficacy. The lessons learned through monitoring and feedback will be used for making innovative improvements, including necessary mid-course corrections. 7. TB provide advice and encourage partnerships between key stakeholders and national and international like-minded think tanks, as well as educational and policy research institutions. 8. TB create a knowledge, innovation, and entrepreneurial support system through a collaborative community of national and international experts, practitioners, and other partners. 9. TB offer a platform for the resolution of intersectoral and interdepartmental issues in order to accelerate the implementation of the development agenda. 10. 7b maintain a state-of-the-art resource center, be a repository of research on good governance and best practices in sustainable and equitable development, as well as help their dissemination to stakeholders. 11. TB actively monitor and evaluate the implementation of programs and initiatives, including the identification of the needed resources so as to strengthen the probability of success and scope of delivery. 12. TB focus on technology upgradation and capacity building for the implementation of programs and initiatives. 13. TB undertake other activities as may be necessary in order to further the execution of the National Development Agenda and the objectives mentioned above. F. Functions. The NITI Aayog's entire gamut of activities is divided into 2 main hubs, SPAM India and Knowledge and Innovation. The 2 hubs are at the core of NITI Aayog's efficient functioning. The SPAM India hub carries out the mandate of fostering cooperative federalism and designing policy and program frameworks. It provides requisite coordination and support in NITI Aayog's engagement with states. The Knowledge and Innovation Hub maintains a 468 YS Indian Polity. State-of-the-art resource center, a repository of research on good governance and best practices, provides advice and encourages partnerships with key stakeholders, including colleges, universities, think tanks, and non-governmental organizations at home and abroad. 5. The various functions performed by the NITI Aayog can be divided into 4 main heads. 1. Policy and program framework. 2. Cooperative and competitive federalism. 3. Monitoring and evaluation. 4. Think Tank, Knowledge and Innovation Hub. The NITI Aayog is functionally divided into various vertical cells, which are responsible for examining and looking into sectoral issues and priorities for national development and economic growth. The different vertical cells of NITI Aayog provide the requisite coordination and support framework for NITI Aayog to carry out its mandate. The list of vertical cells is as follows. 6. 1. Administration and Support Units. 2. Agriculture and Allied Sectors. 3. Aspirational Districts Program. Cell 4. Communication and Social Media. Cell 5. Data Management and Analysis and Frontier Technology. 6. Economics and Finance. Cell 7. Education. 8. Governance and Research. 9. Governing Council Secretariat and Coordination. 10. Industry. 11. Industry. 11-12. Infrastructure Connectivity. 13. Infrastructure Energy. 14. Micro, Small and Medium Enterprises. 15. Natural Resources and Environment and Island Development. 16. Project Appraisal and Management Division. This information has been obtained from the official website of the NITI Aayog, Government of India. 6th Annual Report 2022-23, NITI Aayog, Government of India, p. 7. 17. Public-Private Partnership 18. Rural Development 19. Science and Technology 20. Social Justice and Empowerment, Involuntary Action Cell 21. Social Sector. Skill Development, Labor and Employment, and Urban Development 22. Social Sector. Health and Nutrition, and Women and Child Development 23. State Finances and Coordination 24. Sustainable Development Goals 25. Water and Land Resources. 7 Guiding Principles in carrying out the above functions. The NITI Aayog is guided by the following principles. 1. Antyodaya, prioritist service and uplift of the poor, marginalized and downtrodden, as enunciated in Pandit Deendayal Upadhyay's idea of Antyodaya. 2. Inclusion, empower vulnerable and marginalized sections, redressing identity-based inequalities of all kinds, gender, region, religion, caste, or class. 3. Village, integrate our villages into the development process to draw on the vitality and energy of the bedrock of our ethos, culture, and sustenance. 4. Demographic dividend, harness our greatest asset, the people of India. By focusing on their development through education and skilling, and their empowerment through productive livelihood opportunities. 5. People's participation, transform the developmental process into a people-driven one, making an awakened and participative citizenry the driver of good governance. 6. Governance, nurture an open, transparent, accountable, proactive, and purposeful style of governance, transitioning focus from outlay to output to outcome. Government of India document on NITI Aayog entitled As From Planning to NITI Transforming India's Development Agenda, dated February 8, 2015. 7. Sustainability, maintain sustainability at the core of our planning and developmental process, building on our ancient tradition of respect for the environment. Therefore, the NITI Aayog is based on the following 7 pillars of effective governance. Pro-people agenda that fulfills the aspirations of the society as well as individuals. 2. Proactive in anticipating and responding to citizen needs. 3. Participative by involvement of citizens. 4. Empowering women in all aspects. V. Inclusion of all groups with special attention to the SCs, STs, OBCs, and minorities. 6. Equality of opportunity for the youth. 7. Transparency through the use of technology to make government visible and responsive. Through its commitment to a cooperative federalism, promotion of citizen engagement, egalitarian access to opportunity, participative and adaptive governance, and increasing use of technology. The NITI Aayog seeks to provide a critical directional and strategic input into the development process. This, along with being the incubator of ideas for development, is the core mission of NITI Aayog. Cooperative Federalism 8. 9 IBIT. The NITI Aayog has been constituted to actually the important goal of cooperative federalism and to enable good governance in India. On the premise that strong states make a strong nation, NITI Aayog acts as the quintessential platform for the Government of India by bringing states together as Idiom India to work towards the national development agenda. In view of this, a number of steps have been taken by NITI Aayog to foster cooperative federalism through structured support initiatives and engagement with the state's UTs on a continuous basis. These include 1. Meetings between the Prime Minister, Cabinet Ministers, and all Chief Ministers. This information has been obtained from the official website of the NITI Aayog, Government of India. NITI Aayog M469. 2. Subgroups of Chief Ministers on subjects of national importance. 3. Sharing of best practices. 4. Policy support and capacity development of state UT functionaries. 5. Launching of the Aspirational Districts Program for development of backward districts. 6. Theme-based extensive engagements in various sectors. 7. Framing model laws for land leasing and agriculture marketing reforms. And 8. Area-specific interventions for the northeastern and Himalayan states and island development. The NITI Aayog has been providing relevant technical advice to the center, states, and UTK. It has also established models and programs for the development of infrastructure and to reignite and establish private-public partnership, such as the Center-State Partnership Model Development Support Services to States and Union Territories, DS8S, and the Sustainable Action for Transforming Human Capital, STH program. Competitive Federalism 9. The NITI Aayog endeavors to promote competitive federalism by facilitating improved performance of states' UTs. It encourages healthy competition among states through transparent rankings in various sectors, along with a hand-holding approach. Some of the indices launched by NITI Aayog are School Education Quality Index, State Health Index, Composite Water Management Index, Sustainable Development Goals Index, India Innovation Index, and Export Competitiveness Index. The NITI Aayog also releases Delta rankings for the performance of aspirational districts every month. The ranking of states in various social sectors based on quantitative objective criteria encourages them, and even districts, to improve their performance. The NITI Aayog Indian Polity. Works closely with all stakeholders, including the state UT governments, concerned ministries departments in developing indicator frameworks, review mechanisms, and capacity building. Autonomous and attached bodies. The NITI Aayog is supported by an autonomous body, i.e., the National Institute of Labor Economics Research and Development, and an attached office, i.e., the Development Monitoring and Evaluation Organization. These are explained below. 1. National Institute of Labor Economics Research and Development. The National Institute of Labor Economics Research and Development, NILARD, was formerly known as the Institute of Applied Manpower Research, IMR. It is a central autonomous organization under the NITI Aayog. Its primary objectives are research, data collection, education, and training in all aspects of human capital planning, human resource development, and monitoring and evaluation. 10. This information has been obtained from the official website of the National Institute of Labor Economics Research and Development. The IMR was established in 1962 under the Societies Registration Act of 1860 as an institution that would function as a clearinghouse of ideas and undertake policy research on human capital development to inform prospective planning and promote policy integration. The IMR has been renamed as NILARD in 2014. The NILARD is mainly funded by grants and aid from the NITI Aayog, formerly Planning Commission, and supplemented by its own revenue from contracted research projects and education and training activities. The institute moved to its own campus at Narela in 2002. Narela is a developing urban and institutional hub declared as a special economic zone for knowledge in the National Capital Region. 2. Development Monitoring and Evaluation Office. The need for an efficient and independent evaluation mechanism in India was recognized by the planners and policymakers right from the introduction of planning process in the country, and resultantly, the Program Evaluation Organization was established by the government in 1952 to carry out independent and objective impact evaluation of the central government-funded programs. 11. In an effort to accord more functional autonomy to the program evaluation mechanism in the country, the government established the Independent Evaluation Office in 2010. The Development Monitoring and Evaluation Office, DMEO, was established by the government in 2015 as an attached office of the NITI Aayog by merging the erstwhile Program Evaluation Organization and the Independent Evaluation Office. As the apex monitoring and evaluation office in the country, the DMEO supports the government to achieve the national development agenda through monitoring and evaluation of government policies and programs. Since its inception in 2015, the office aims to support rigorous, data-driven, citizen-centric, and outcomes-driven program management and policy-making. The DMEO's mandate involves monitoring progress and efficacy of strategic and long-term policy and program frameworks and initiatives to help innovative improvements, including necessary mid-course corrections. And 2. Actively monitoring and evaluating the implementation of programs and initiatives, including the identification of the needed resources so as to strengthen the probability of success and scope of delivery. The DMEO's mandate also expands to technical advisory to states, under NITI Aayog's mandate of cooperative and competitive. This information has been obtained from the official website of the Development Monitoring and Evaluation Office. NITI Aayog 471. Federalism. Its institutional positioning gives the organization convening power to create a platform for monitoring and evaluation advancement in the country. The headquarters of DMEO is in NITI Aayog, New Delhi. Till 2017, the DMEO had 15 regional offices known as Regional Development Monitoring and Evaluation Offices, RDMEOs. The RDMEOs conducted field surveys and data information collection work for evaluation studies, and they also played an important role in promoting cooperative federalism by their interaction with the states and UT administrations. However, keeping in view the changed functional requirements, they were closed in 2017 and the staff were transferred to DMEO headquarters in New Delhi. Erstwhile Planning Commission The Erstwhile Planning Commission was established in March 1950 by an executive resolution of the Government of India, i.e., the Union Cabinet, on the recommendation of the Advisory Planning Board constituted in 1946, under the chairmanship of K.C. Naogi. Thus, the Erstwhile Planning Commission was neither a constitutional body nor a statutory body. In India, it was the supreme organ of planning for social and economic development. The functions of the Erstwhile Planning Commission included the following. 1. 1b. Make an assessment of material, capital, and human resources of the country, and investigate the possibilities of augmenting them. 2. 2b. Formulate a plan for the most effective and balanced utilization of the country's resources. 3. 2b. Determine priorities and to define the stages in which the plan should be carried out. 4. 1b. Indicate the factors that retard economic development. 5. 1b. Determine the nature of the machinery required for successful implementation of the plan in each stage. 6. lb. Appraise, from time to time, the progress achieved in execution of the plan and to recommend necessary adjustments. 7. lb. Make appropriate recommendations for facilitating the discharge of its duties or on a matter referred to it for advice by central or state governments. It should be noted that the Erstwhile Planning Commission was only a staff agency, an advisory body, and had no executive responsibility. it was not responsible for taking and implementing decisions. This responsibility rested with the central and state governments. Composition. The following points can be noted in context of the composition, membership, of the erstwhile Planning Commission. 1. The Prime Minister of India was the chairman of the Commission. Husha presided over the meetings of the Commission. 2. The Commission had a deputy chairman. Husha was the de facto executive head, i.e., full-time functional head, of the Commission. 3. Some centra ministers were appointed as part-time members of the Commission. 4. The Commission had 4 to 7 full-time expert members. 5. The Commission had a member secretary. The state governments were not represented in the Commission in any way. Thus, the erstwhile Planning Commission was wholly a center-constituted body. Critical evaluation. The erstwhile Planning Commission was originally established as a staff agency with advisory role, but in the course of time it had emerged as a powerful and directive authority whereby its recommendations were considered both by the Union and states. The critics had described it as a super cabinet, an economic cabinet, parallel cabinet, the fifth wheel of the coach, and so on. The following observations were made on the domineering role played by the erstwhile Planning Commission. 1. First Administrative Reforms Commission, ARC, of India. The ARC observed, under the Constitution, the ministers, whether in the center or the states, are in effect the ultimate executive authorities. Unfortunately, the Planning Commission has, in some measures, earned the reputation of being a parallel cabinet and sometimes a super cabinet. 1213. Interim Report on the Machinery for Planning, 1967, para 15. 13K. Santhanam, Union-State Relations in India, Asia Publishing House, 1960, p. 70. Report of the Fourth Finance Commission, New Delhi, Government of India, 1965, pp. 88-90. 5-inch NDC to be scrapped, NITI Aayog Council likely to get its powers, The Hindu, dated January 1, 2016. 2. K. Santhanam, this eminent constitutional expert stated that planning has superseded the federation and our country is functioning like a unitary system, 13 in many respects. 3. P.V. Rajamannar, this chairman of the Fourth Finance Commission observed that there was an overlapping of functions and responsibilities between the erstwhile Planning Commission and Finance Commission in federal fiscal transfers. 14. National Development Council. On the 1st of January 2016, it was reported 1. That the Modi government is also going to abolish the National Development Council, NDC, and transfer its powers to the Governing Council of the NITI Aayog. However, till now such a resolution has not been passed. It must also be noted here that the last meeting 57th of the NDC was held on the 27th of December, 2012 to approve the 12th Plan, 2012 to 2017. The NDC was established in August 1952 by an executive resolution of the Government of India on the recommendation of the first 5-year plan, draft outline. Like the erstwhile Planning Commission, it is neither a constitutional body nor a statutory body. Composition. The NDC is composed of the following members. 1. The Prime Minister of India as its chairman and head. 2. All Union Cabinet Ministers since 1967. 3. The Chief Ministers of all the states. 4. The Chief Ministers Administrators of all Union territories. 5. Members of the Planning Commission, now NITI Aayog. Objectives. The NDC was established with the following objectives. 1. LB secure cooperation of states in the execution of the plan. 2. TB strengthen and mobilize the efforts and resources of the nation in support of the plan. 3. LB promote common economic policies in all vital spheres. 4. TB ensure balanced and rapid development of all parts of the country. Functions. LB realize the above objectives. The NDC is assigned with the following functions. 1. LB prescribe guidelines for preparation of the national plan. 2. LB consider the national plan as prepared by the Planning Commission, now NITI Aayog. 3. LB make an assessment of the resources required for implementing the plan and to suggest measures for augmenting them. 4. IB consider important questions of social and economic policy affecting national development. 5. LB review the working of the national plan from time to time. 6. LB recommend measures for achievement of the aims and targets set out in the national plan. Chapter 57 National Human Rights Commission. T. Establishment. The National Human Rights Commission is a statutory, and not a constitutional, body. It was established in 1993 under a legislation enacted by the Parliament, namely, the Protection of Human Rights Act, 1993. The Commission is the watchdog of human rights in the country, that is, the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants 1 and enforceable by courts in India. The specific objectives of the establishment of the Commission are 2. A. LB strengthen the institutional arrangements through which human rights issues could be addressed in their entirety in a more focused manner. B. To look into allegations of excesses, independently of the government, in a manner that would underline the government's commitment to protect human rights. And C. LB complement and strengthen the efforts that have already been made in this direction. T. Composition. The Commission is a multi-member body consisting of a chairperson and 5 members. The chairperson should be a retired Chief Justice of India or a judge of the Supreme Court, and members should be a serving or retired judge of the Supreme Court, a serving or retired Chief Justice of a High Court, and 3 persons, out of which at least one should be a woman, having knowledge or practical experience with respect to human rights. In addition to these full-time members, the Commission also has 7 ex officio members: the chairpersons of the National Commission for Minorities, the National Commission for SCs, the National Commission for S1K, the National Commission for Women, the National Commission for BCs, and the National Commission for Protection of Child Rights, and the Chief Commissioner for Persons with Disabilities. The chairperson and members are appointed by the President on the recommendations of a 6-member committee consisting of the Prime Minister as its head, the Speaker of the Lok Sabha, the Deputy Chairman of the Rajya Sabha, leaders of the opposition in both the Houses of Parliament, and the Central Home Minister. Further, a sitting judge of the Supreme Court or a sitting Chief Justice of a High Court can be appointed. International covenants means the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights adopted by the General Assembly of the United Nations on December 16, 1966, and such other covenant or convention adopted by the General Assembly of the UN as the central government may specify. The Indian government acceded to these 2 international covenants on April 10, 1979. H.X. Thompson, Human Rights Commission, Cochin University Law Review, Volume 17, Nos. 1 and 2, March-June 1993, pp. 67-68. 474 Indian Polity. Only after consultation with the Chief Justice of India. The chairperson and members hold office for a term of 3 years or until they attain the age of 70 years, whichever is earlier. They are eligible for reappointment. After their tenure, the chairperson and members are not eligible for further employment under the central or a state government. The President can remove the chairperson or any member from the office under the following circumstances: A. If Hisha is adjudged insolvent. Or B. If Hisha engages, during Hisha term of office, in any paid employment outside the duties of Hisha office. Or C. If Hisha is unfit to continue in office by reason of an infirmity of mind or body. Or D. If Hisha is of unsound mind and stands so declared by a competent court. Or E. If Hisha is convicted and sentenced to imprisonment for an offense. In addition to these, the President can also remove the chairperson or any member on the ground of proved misbehavior or incapacity. However, in these cases, the President has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, then the President can remove the chairperson or member. The salaries, allowances, and other conditions of service of the chairperson or a member are determined by the central government. But they cannot be varied to his or her disadvantage after Hisha appointment. All the above provisions are aimed at securing autonomy, independence, and impartiality in the functioning of the Commission. T. Functions. The functions of the Commission are: A. LB inquire into any violation of human rights or negligence in the prevention of such violation by a public servant, either sua motu, or on a petition presented to it, or on an order of a court. B. LB intervene in any proceeding involving allegation of violation of human rights pending before a court. C. LB visit jails and detention places to study the living conditions of inmates and make recommendations thereon. D. To review the constitutional and other legal safeguards for the protection of human rights and recommend measures for their effective implementation. E. LB review the factors including acts of terrorism that inhibit the enjoyment of human rights and recommend remedial measures. F. LB study treaties and other international instruments on human rights and make recommendations for their effective implementation. G. LB undertake and promote research in the field of human rights. H. To spread human rights literacy among the people and promote awareness of the safeguards available for the protection of these rights. I. To encourage the efforts of non-governmental organizations, NGOs, working in the field of human rights. J. LB undertake such other functions as it may consider necessary for the promotion of human rights. In pursuit of its primary goal of protection and promotion of human rights, the Commission has been making concerted efforts at enhancing awareness about human rights in the country. In this task, the Commission has been receiving full support both from civil society and human rights activists and the media. The camp sittings and open hearings organized by the Commission in different parts of the country to provide justice at the doorsteps of the victims of the human rights violations have proved to be of immensely useful. 2. 1. The complaints received by the Commission cover a wide range of issues such as alleged human rights violations due to negligence by public servants in the prevention. 2. A Annual Report 2019-20, National Human Rights Commission, Government of India, p. 16. OI such violations, alleged custodial deaths, torture, fake encounters, police high-handedness, violations committed by security forces, conditions relating to prisons, atrocities committed on women and children and other vulnerable sections, communal violence, bonded and child labor, non-payment of retirement benefits, negligence by public authorities and atrocities on scheduled castes, scheduled tribes, etc. The Commission also took cognizance of the intimations received regarding deaths in police encounters and police custody, judicial custody, and in the custody of defense paramilitary forces. The suamotu cognizance of many incidents based on reports in print and electronic media was taken, including those cases which came to the notice of chairperson, members, special rapporteurs, and senior officers of the Commission during their visits to different parts of the country. 215. 2b Ibid. Justice vs. Mali Math. Role of Human Rights Commission. Human Rights in India. Problems and Perspectives. B.P. Singh Sehgal, ed. J. Deep Publications, 1995, pp. 17-20. F. Working. The Commission's headquarters is in Delhi, and it can also establish offices in other places in India. It is vested with the power to regulate its own procedure. It has all the powers of a civil court, and its proceedings have a judicial character. It may call for information or report from the central and state governments or any other authority subordinate thereto. The Commission has its own nucleus of investigating staff for investigation into complaints of human rights violations. Besides, it is empowered to utilize the services of any officer or investigation agency of the central government or any state government for the purpose. It has also established effective cooperation with the NGOs with first-hand information about human rights violations. The Commission is not empowered to inquire into any matter after the expiry of 1 year from the date on which the act constituting violation of human rights is alleged to have been committed. In other words, National Human Rights Commission VJ 475 can look into a matter within 1 year of its occurrence. The Commission may take any of the following steps during or upon the completion of an inquiry. A. It may recommend to the concerned government or authority to make payment of compensation or damages to the victim. B. It may recommend to the concerned government or authority the initiation of proceedings for prosecution or any other action against the guilty public servant. C. It may recommend to the concerned government or authority for the grant of immediate interim relief to the victim. D. It may approach the Supreme Court or the High Court concerned for the necessary directions, orders, or writs. F. Role. From the above, it is clear that the functions of the Commission are mainly recommendatory in nature. It has no power to punish the violators of human rights, nor to award any relief, including monetary relief, to the victim. Notably, its recommendations are not binding on the concerned government or authority. But it should be informed about the action taken on its recommendations within 1 month. In this context, a former member of the Commission observed 3. The government cannot wash away the recommendations made by the Commission. The Commission's role may be recommendatory, advisory, yet the government considers the cases forwarded by it. It is, therefore, improper to say that the Commission is powerless. It enjoys great material authority, and no government can ignore its recommendation. Moreover, the Commission has a limited role, powers, and jurisdiction with respect to the violation of human rights by the members 476 Indian Polity of the Armed Forces 4. In this sphere, the Commission may seek a report from the central government and make its recommendations. The central government should inform the Commission of the action taken on the recommendations within 3 months. The Commission submits its annual or special reports to the central government and to the state government concerned. These reports are laid before the respective legislatures, along with a memorandum of action taken on the recommendations of the Commission and the reasons for non-acceptance of any of such recommendations. T. Problems. The Commission itself identified the various problems faced by it in its effective functioning and explained them in the following way. 5. 1. Administrative constraints. The Commission is compliant with Paris Principles, which states that the national human rights institutions shall have an infrastructure which is suited for the smooth conduct of its activities, in particular adequate funding and staff. The purpose of this funding should be to enable it to have its own staff and premises, in order to be independent of the government and not to be subject to financial control which might affect its independence from the perspective of human rights. The role of the Commission is expanding day by day, and it is handling more or less 1 lakh complaints every year, reflecting the growing trust reposed by the citizens of India. This necessitates devolution of powers to the chairperson. For under the Protection of Human Rights Act, 1993, the armed forces means the naval, military, and air forces, and includes any other armed forces of the Union. 5. Annual Report 2019-20, National Human Rights Commission, Government of India, pp. 233-234. Of the Commission in administrative as well as financial matters. 2. Financial constraints. The Commission receives grants and aid every year from the Government of India, Ministry of Home Affairs. It may spend such sums as it thinks fit for performing its functions, and such sums shall be treated as expenditure payable out of these grants. With this financial independence, the Commission functions efficiently to fulfill its mandate. However, the Commission wishes to have financial autonomy to purchase vehicles, as the same has not been delegated. Z. Manpower constraints. Since its inception, the Commission has never had the full sanctioned strength as compared to the available strength. As a result, due to voluminous complaints, it is compelled to engage retired government officers as consultants on a contract basis. The Commission struggles to cope up with the expectations of the victims of human rights violations throughout the country and is unable to fulfill its mandate of protecting and promoting human rights. It requires creation of various posts for effectively and efficiently discharging its mandate. Shortage of experienced investigating officers who are required to be provided by the government, affected to some extent conducting spot inquiries on custodial deaths, torture, illegal detentions, etc., for which sufficient number of experienced staff are required. The Law Division, which is the backbone of the Commission, also faces a lot of problems in performing its pivotal role in disposing of a large number of complaints due to shortage of manpower. In 2017, the Supreme Court expressed its concern over the shortage of manpower in the Commission and directed the Government of India to take note of the concerns of the Commission and remedy them at the earliest with a positive outlook. Chapter 58 State Human Rights Commission. I.T. Establishment. The Protection of Human Rights Act of 1993 provides for the creation of not only the National Human Rights Commission, but also a State Human Rights Commission at the state level. Accordingly, a State Human Rights Commission may be constituted by the state government. 1. The headquarters of the State Human Rights Commission shall be at such place as the state government may, by notification, specify. 2. The Jammu and Kashmir Reorganization, Adaptation of Central Laws, Order, 2020. 3. The Union Territory of Ladakh Reorganization, Adaptation of Central Laws, Order, 2020. A State Human Rights Commission can inquire into violation of human rights only in respect of subjects mentioned in the State List, List 2, and the concurrent list, List IL, of the 7th Schedule of the Constitution. However, if any such case is already being inquired into by the National Human Rights Commission or any other statutory commission, then the State Human Rights Commission does not inquire into that case. The central government may confer upon the State Human Rights Commissions the functions relating to human rights in the Union territories, except the Union Jammu and Kashmir 2 and Ladakh 3. The functions relating to human rights in case of Union territories of Delhi are to be dealt with by the National Human Rights Commission. X composition *F. The State Human Rights Commission is a multi-member body consisting of a chairperson and 2 members. The chairperson should be a retired Chief Justice or a judge of a high court, and members should be a serving or retired judge of a high court or a district judge in the state, with a minimum of 7 years' experience as district judge and a person having knowledge or practical experience with respect to human rights. The chairperson and members are appointed by the governor on the recommendations of a committee consisting of the Chief Minister as its head, the Speaker of the Legislative Assembly, the State Home Minister, and the Leader of the Opposition in the Legislative Assembly. In the case of a state having legislative council, the chairman of the council and the leader of the opposition in the council would also be the members of the committee. Further, a sitting judge of a high court or a sitting district judge can be appointed only after consultation with the Chief Justice of the High Court of the concerned state. The chairperson and members hold office for a term of 3 years or until they attain the age of 70 years, whichever is earlier. They are eligible for reappointment. After their tenure, the chairperson and members are not eligible for further employment under a state government or the central government. Although the chairperson and members of a State Human Rights Commission are appointed by the governor, they can be removed only by the president and not by Indian Polity. The governor. The president can remove them on the same grounds and in the same manner as Husha can remove the chairperson or a member of the National Human Rights Commission. Thus, Husha can remove the chairperson or a member under the following circumstances: A. If Husha is adjudged an insolvent. Or B. If Husha engages, during his term of office, in any paid employment outside the duties of his office. Or C. If Husha is unfit to continue in office by reason of infirmity of mind or body. Or D. If Husha is of unsound mind and stands so declared by a competent court. Or E. If Husha is convicted and sentenced to imprisonment for an offense. In addition to these, the president can also remove the chairperson or a member on the ground of proved misbehavior or incapacity. However, in these cases, the president has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, then the president can remove the chairperson or a member. The salaries, allowances, and other conditions of service of the chairperson or a member are determined by the state government. But they cannot be varied to his disadvantage after his appointment. All the above provisions are aimed at securing autonomy, independence, and impartiality in the functioning of the Commission. F. Functions. The functions of the Commission are: A. To inquire into any violation of human rights or negligence in the prevention of such violation by a public servant, either suo motu, or on a petition presented to it, or on an order of a court. B. To intervene in any proceeding involving allegation of violation of human rights pending before a court. C. To visit jails and detention places to study the living conditions of inmates and make recommendation thereon. D. To review the constitutional and other legal safeguards for the protection of human rights and recommend measures for their effective implementation. E. TB review the factors including acts of terrorism that inhibit the enjoyment of human rights and recommend remedial measures. F. TB undertake and promote research in the field of human rights. G. TB spread human rights literacy among the people and promote awareness of the safeguards available for the protection of these rights. H. To encourage the efforts of non-governmental organizations, NGOs, working in the field of human rights. I. To undertake such other functions as it may consider necessary for the promotion of human rights. F. Working. The Commission is vested with the power to regulate its own procedure. It has all the powers of a civil court, and its proceedings have a judicial character. It may call for information or report from the state government or any other authority subordinate thereto. The Commission is not empowered to inquire into any matter after the expiry of 1 year from the date on which the act constituting violation of human rights is alleged to have been committed. In other words, it can look into a matter within 1 year of its occurrence. The Commission may take any of the following steps during or upon the completion of an inquiry. A. It may recommend to the state government or authority to make payment of compensation or damages to the victim. B. It may recommend to the state government or authority the initiation of proceedings for prosecution or any other action against the guilty public servant. C. It may recommend to the state government or authority for the grant of immediate interim relief to the victim. State Human Rights Commission 479. D. It may approach the Supreme Court or the State High Court for the necessary directions, orders, or writs. From the above points, it is clear that the functions of the Commission are mainly recommendatory in nature. It has no power to punish the violators of human rights, nor to award any relief, including monetary relief, to the victim. Notably, its recommendations are not binding on the state government or authority. But it should be informed about the action taken on its recommendations within 1 month. The Commission submits its annual or special reports to the state government. These reports are laid before the state legislature, along with a memorandum of action taken on the recommendations of the Commission and the reasons for non-acceptance of any of such recommendations for before each house of state legislature where it consists of 2 houses, or where such legislature consists of 1 house, before that house. T. Human Rights Courts. The Protection of Human Rights Act, 1993, also provides for the establishment of human rights court in every district for the speedy trial of violation of human rights. These courts can be set up by the state government only with the concurrence of the Chief Justice of the High Court of that state. For every human rights court, the state government specifies a public prosecutor or appoints an advocate, who has practiced for 7 years, as a special public prosecutor for the purpose of conducting cases in that court. T. 2019 Amendment Act. The various provisions or features of the Protection of Human Rights Amendment Act, 2019, are as follows. 1. It provided that a person who has been a judge of the Supreme Court is also made eligible to be appointed as chairperson of the National Human Rights Commission, in addition to the person who has been the Chief Justice of India. 2. It increased the number of members of the National Human Rights Commission, who are to be appointed from amongst persons having knowledge or practical experience with respect to human rights, from 2 to 3, out of which at least 1 has to be a woman. 3. It made the chairpersons of the National Commission for BCs and the National Commission for Protection of Child Rights, as well as the Chief Commissioner for Persons with Disabilities, as the ex officio members of the National Human Rights Commission. 4. It reduced the term of the chairperson and members of the National Human Rights Commission, as well as the State Human Rights Commission, from 5 to 3 years. It also made them eligible for reappointment. 5. It provided that a person who has been a judge of a high court is also made eligible to be appointed as chairperson of the State Human Rights Commission, in addition to the person who has been the Chief Justice of a high court. 6. It provided that the central government may confer upon the State Human Rights Commissions the functions relating to human rights in the Union Territories, except the Union Territory of Delhi. The functions relating to human rights in case of Union Territory of Delhi are to be dealt with by the National Human Rights Commission. 7. It provided that the Secretary-General of the National Human Rights Commission shall exercise all administrative and financial powers, except judicial functions, and the power to make regulations, subject to control of the chairperson. 8. It provided that the Secretary of the State Human Rights Commission shall exercise all administrative and financial powers of the Commission, subject to control of the chairperson. Chapter 59 National Commission for Women. T. Establishment. The Committee on Status of Women in India, set up by the Government of India, in 1974, recommended the constitution of a National Commission for Women to fulfill the surveillance functions and to facilitate redressal of grievances and accelerate the socio-economic development of women. Again, the successive women-related committees, commissions, and plans, including the National Perspective Plan for Women, 1988, have also recommended the constitution of such an apex body for women. Accordingly, the National Commission for Women was constituted in 1992 for protecting, promoting, and safeguarding the interests and rights of women. The Commission is an autonomous statutory, and not a constitutional, body. It was established under a legislation enacted by the Parliament, namely the National Commission for Women Act, 1990. The Ministry of Women and Child Development of the Government of India is the nodal ministry for the Commission. 2. This act came into force on January 31, 1992. 2. The Department of Women and Child Development, Government of India came into existence as a separate ministry in 2006. Earlier, since 1985, it was a department under the Ministry of Human Resource Development. The Commission has a wide mandate covering almost all aspects of women's development and empowerment. Its specific objectives are as follows. 1. IB review the constitutional and legal safeguards for women. 2. To recommend remedial legislative measures. 3. LB facilitate the redressal of grievances. 4. To advise the government on all policy matters affecting women. T. Composition. The Commission is a multi-member body consisting of a chairperson, 5 members, and a member secretary. The chairperson should be someone who is committed to the cause of women. The 5 members should be from amongst persons of ability, integrity, and standing who have had experience in law or legislation, trade unionism, management of an industry or an organization committed to increasing the employment potential of women, women's voluntary organizations, including women activists, administration, economic development, health, education, or social welfare. However, at least 1 member each should belong to the scheduled castes and scheduled tribes, respectively. The member secretary should be I. An expert in the field of management, organizational structure, or sociological movement, or 2. An officer who is a member of a civil service of the Union or an All India service or holds a civil post under the Union. The chairperson, members, and member secretary are all nominated by the central government, Ministry of Women and Child Development. Their salaries, allowances, and other service conditions are also prescribed by the central government. The chairperson and members hold office for 3 years. However, they 3 can relinquish their office at any time by addressing their resignation to the central government. Other than the member secretary who is a member of a civil service of the Union or an All India service or holds a civil post under the Union, without obtaining leave of absence from the Commission. Further, the central government can also remove the chairperson or a member from the office before the expiry of his term under the following circumstances. 1. If the individual becomes an undischarged insolvent. 2. If the individual gets convicted and sentenced to imprisonment for an offense which, in the opinion of the central government, involves moral turpitude. 3. If the individual is declared of unsound mind by a competent court. 4. If the individual refuses to act or becomes incapable of acting. 5. If the individual absents himself or herself from 3 consecutive meetings of the Commission. 4. 6. If individual has abused one's official position which, in the opinion of the central government, renders one's continuance in the office as detrimental to the public interest. Functions. The Commission is provided with a 14-point mandate. 1. 1b. Investigate and examine all matters relating to the safeguards provided for women under the Constitution and other laws. 2. 1b. Present to the central government annually and at such other times as it may deem fit, reports upon the working of those safeguards. 3. 1b. Make recommendations for the effective implementation of those safeguards. 481. For improving the conditions of women by the Union or any state. 4. 1b. Review the existing provisions of the Constitution and other laws affecting women and recommend amendments to meet any inadequacies in such laws. 5. LB. Take up the cases of violation of the provisions of the Constitution and other laws relating to women with the appropriate authorities. 6. 1b. Look into complaints and take suo motu notice of matters relating to I. Deprivation of women's rights. 2. Non-implementation of laws enacted to provide protection to women and also to achieve the objective of equality and development. And 3. Non-compliance of policy decisions or instructions aimed at mitigating hardships and ensuring welfare and providing relief to women. 7. 1b. Call for special studies or investigations into specific problems or situations arising out of discrimination and atrocities against women and to identify the constraints so as to recommend strategies for their removal. 8. LB. Undertake promotional and educational research so as to suggest ways of ensuring due representation of women in all spheres and to identify factors responsible for impeding their advancement, such as lack of access to housing and basic services, inadequate support services and technologies for reducing drudgery and occupational health hazards, and for increasing their productivity. 9. LB. Participate and advise on the planning process of socio-economic development of women. 10. LB. Evaluate the progress of the development of women under the Union and any state. 11. 1b. Inspect any jail, remand home, women's institution, or other place of TJ. SK. National Commission for Women. 4. 82 plus or minus L. Indian Polity. Custody where women are kept as prisoners or otherwise, and take up with the concerned authorities for remedial action. 12. LB. Fund litigation involving issues affecting a large body of women. 13. LB. Make periodical reports to the government on any matter pertaining to women and in particular various difficulties under which women toil. 14. TB. Look into any other matter referred to it by the central government. The Commission presents an annual report to the central government. It can also submit a report as and when it thinks necessary. The central government places all such reports before each House of Parliament, along with a memorandum explaining the action taken on the recommendations made by the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. If any such report is related to any matter with which any state government is concerned, the Commission forwards a copy of such report to such state government. The state government places it before the state legislature, along with a memorandum explaining the action taken on the recommendations of the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. Powers the Commission can appoint the committees necessary for dealing with the special issues taken up by it from time to time. It is also empowered to co-opt as members of any such committee the persons from outside the Commission, i.e. those who are not members of the Commission. The co-opted persons can attend the meetings of the committee and take part in its proceedings, but without the right to vote. The Commission shall regulate its own procedure and also the procedure of its committees. The Commission, while investigating any matter or inquiring into any complaint, has all the powers of a civil court trying a suit and in particular in respect of the following matters. 1. Summoning and enforcing the attendance of any person from any part of India and examining him or on oath. 2. Requiring the discovery and production of any document. 3. Receiving evidence on affidavits. 4. Requisitioning any public record from any court or office. 5. Issuing summons for the examination of witnesses and documents. And 6. Any other matter which may be prescribed by the central government. The central government should consult the Commission on all major policy matters affecting women. Working 43. This information is obtained from the official website of the National Commission for Women. The Commission processes the complaints received verbally or in writing. It also takes into account suo motu notice of cases related to women. The complaints received by the Commission relate to various categories of crimes against women. These complaints are registered under the following 23 heads. 1. Rape attempt to rape. 2. Acid attack. 3. Sexual assault. 4. Sexual harassment. 5. Stalking voyeurism. 6. Trafficking prostitution of women. 7. Outraging modesty of women. Molestation. 8. Cybercrimes against women. 9. Police apathy against women. 10. Harassment of married women. Dowry harassment. 11. Dowry death. 12. Bigamy polygamy. 13. Protection of women against domestic violence. National Commission for Women. 483. 14. Women's right of custody of children. Divorce. 15. Right to exercise choice in marriage. Honor crimes. 16. Right to live with dignity. 17. Sexual harassment of women at workplace. 18. Denial of maternity benefits to women. 19. Gender discrimination, including equal right to education and work. 20. Indecent representation of women. 21. Sex-selective abortions. Female foeticide. Amniocentesis. 22. Traditional practices derogatory to women rights like sati pratha, devdasi pratha, and witch hunting. 23. Free legal aid for women. The complaints are acted upon in the following manner. 1. Specific cases of police apathy are sent to the police authorities for investigation and cases are monitored. 2. Family disputes are resolved or compromises struck through counseling. 3. Disaggregated data are made available to various state authorities to facilitate action. 4. In sexual harassment complaints, the concerned organizations are urged to expedite cases and the disposal is monitored. 5. According to the landmark judgment of the Supreme Court on sexual harassment at workplace delivered in the Vishaka vs. State of Rajasthan, 1997, every employer is required to provide for effective complaints, procedures, and remedies including awarding of compensation to women victims. 5. For serious crimes, the Commission constitutes an inquiry committee to provide immediate relief and justice to the victims of violence and atrocities. Parivarik Mahila Lok Adalat 5a. The Commission has evolved an innovative concept of Parivarik Mahila Lok Adalat (PMLA), which in turn supplements the efforts of the District Legal Service Authority for redressal and speedy disposal of the matters related to marriage and family affairs pending in various courts. The Parivarik Mahila Lok Adalat functions on the model of the Lok Adalat. The Commission provides financial assistance to NGOs or state women commissions or state legal service authority to organize the Parivarik Mahila Lok Adalat. The objectives of Parivarik Mahila Lok Adalat are as follows. 1. 7b provide speedy and cost-free dispensation of justice to women. 2. TB generate awareness among the public regarding conciliatory mode of dispute settlement. 3. TB gear up the process of organizing the Lok Adalats and to encourage the public to settle their disputes outside the formal setup. 4. TB empower public, especially women, to participate in justice delivery mechanism. 5. This information is obtained from the official website of the National Commission for Women. Chapter E60. National Commission for Protection of Child Rights. Establishment. The National Commission for Protection of Child Rights is a statutory, and not a constitutional, body. It was set up in 2007 under a legislation enacted by the Parliament, namely the Commissions for Protection of Child Rights Act, 2005.1. The Commission has to protect, promote, and defend child rights in the country. Under the Act, the child rights includes the children's rights adopted in the United Nations Convention on the Rights of the Child on November 20, 1989 and ratified by the Government of India on December 11, 1992. Under this convention, a child has been defined as a human being below the age of 18 years. The Commission would deal with the effective implementation of laws and programs relating to children. The objectives of the Commission are as follows: 2. 1b. Take cognizance and redress matters pertaining to violation of the rights of the child. 2. TB. Ensure that all laws, policies, programs, and administrative mechanisms are in consonance with the child rights perspective as enshrined in the Constitution of India as well as the United Nations Convention on the Rights of the Child. The Commission is an autonomous body. It operates under the administrative control. This act came into force on February 5, 2007. Annual Report 2020-21, National Commission for Protection of Child Rights, p. 10. Of the Ministry of Women and Child Development, Government of India 3. F. Composition. The Commission is a multi-member body consisting of a chairperson and 6 members. Out of the 6 members, at least 2 should be women. The chairperson should be a person of eminence who has done outstanding work for promoting the welfare of children. The 6 members should be from amongst persons of eminence, ability, integrity, standing, and experience in the following fields. 1. Education. 2. Child health care, welfare, or child development. 3. Juvenile justice or case of neglected or marginalized children or children with disabilities. 4. Elimination of child labor or children in distress. 5. Child psychology or sociology. 6. Laws relating to children. The chairperson and other members are appointed by the central government. However, the chairperson is appointed on the recommendation of a 3-member selection committee constituted by the central government under the chairmanship of the minister in charge. The Department of Women and Child Development, Government of India, came into existence as a separate ministry in 2006. Earlier, since 1985, it was a department under the Ministry of Human Resource Development. 2. Z. 4. 5. 6. 7. 8. 9. The case of the chairperson, it is years. The case of the members, it is years. National Commission for Protection of Child Rights 485. Of the Ministry or the Department of Women and Child Development. 4. For before the Commissions for Protection of Child Rights Amendment, Act 2006, it was the minister in charge of the Ministry of Human Resource Development. 5. Without obtaining leave of absence from the Commission. The salaries, allowances, and other service conditions of the chairperson and members are also prescribed by the central government. However, they cannot be varied to their disadvantage after their appointment. The chairperson and members hold office for a term of 3 years. They are not eligible for appointment for more than 2 terms. Further, the upper age limit for holding the office is as follows. 1. In 65. 2. In 60, the chairperson or a member can relinquish the office at any time by addressing the resignation to the central government. The central government can remove the chairperson from the office on the ground of proven misbehavior or incapacity. Further, it can also remove the chairperson or any member from the office under any of the following circumstances. 1. Adjudged as insolvent. 2. Engages, during the term of office, in any paid employment outside the duties of the office. 3. Refuses to act or becomes incapable of acting. 4. Declared of unsound mind by a competent court. 5. Abused the office which renders the continuance in the office as detrimental to the public interest. 6. Convicted and sentenced to imprisonment for an offense which, in the opinion of the central government, involves moral turpitude. 7. Absents himself or herself from 3 consecutive meetings of the Commission. 5. T. Functions. The functions of the Commission are as follows. ID. Examine and review the safeguards provided by the laws for the protection of child rights and recommend measures for their effective implementation. LB. Present to the central government, annually and at such other intervals as it may deem fit. Reports upon the working of those safeguards. LB. Inquire into violation of child rights and recommend initiation of proceedings in such cases. LB. Examine all factors that inhibits the enjoyment of rights of children affected by terrorism, communal riots, natural disaster, domestic violence, heavates, trafficking, exploitation, and prostitution, and recommend remedial measures. TB. Look into matters relating to children in need of special care, including children in distress, marginalized children, children in conflict with the law, juveniles, children without family, and children of prisoners, and recommend remedial measures. TB. Study treaties and other international instruments and undertake periodical review of existing policies, programs, and other activities on child rights and make recommendations for their effective implementation. TB. Undertake and promote research in the field of child rights. TB. Spread child rights literacy among various sections of the society and promote awareness of the safeguards available for protection of these rights. TB. Inspect any juvenile custodial home or any other place of residence or institution under the control of the central government or any state government or any other authority, including any institution run by a social organization, where children are detained or lodged for the purpose of treatment, reformation. 486 Indian Polity, or protection, and take up with these authorities for remedial action. 10. To inquire into complaints and take so modo notice of matters relating to I. Deprivation and violation of child rights. 2. Non-implementation of laws providing for protection and development of children. 2. Non-compliance of policy decisions or instructions aimed at mitigating hardships and ensuring welfare and providing relief to children. 11. 7b. Perform such other functions as it may consider necessary for the promotion of child rights. It must be noted here that the Commission is prohibited from inquiring into any matter which is pending before a State Commission for Protection of Child Rights or any other statutory commission. 7 powers underscore the Commission, while inquiring into any matter, has all the powers of a civil court trying a suit, and in particular in respect of the following matters. 1. Summoning and enforcing the attendance of any person and examining him or on oath. 2. Requiring the discovery and production of any document. 3. Receiving evidence on affidavits. 4. Requisitioning any public record from any court or office. And 5. Issuing summons for the examination of witnesses or documents. 7. Working. The Commission may take any of the following steps upon the completion of an inquiry. 1. It may recommend to the concerned government or authority the initiation of proceedings for prosecution or such other suitable action against the concerned person. 2. It may approach the Supreme Court or the High Court concerned for the necessary directions, orders, or writs. 3. It may recommend to the concerned government or authority for the grant of necessary interim relief to the victim. The Commission submits its annual or special reports to the central government and to the state government concerned. These reports are laid before the respective legislatures, along with a memorandum of action taken on the recommendations of the Commission and the reasons for non-acceptance of any of such recommendations within 1 year. 7 functions under other acts. In addition to the above functions, the Commission has been assigned the additional functions under 3 acts relating to the children. These are as follows. 1. The Right of Children to Free and Compulsory Education, RTE, Act, 2009. According to this act, the Commission has to perform the following functions. I. To examine and review the safeguards for rights provided by or under this act and recommend measures for their effective implementation. 2. TB. Inquire into complaints relating to child's right to free and compulsory education. 3. TB. Take necessary steps after completion of an inquiry. Further, the Commission shall, while inquiring into any matter relating to a child's right to free and compulsory education, have the same powers as assigned to it under the Commissions for the Protection of Child Rights Act, 2005. 2. The Protection of Children from the Sexual Offenses (POCSO) Act, 2012. This act makes the following provisions with respect to the additional functions of the Commission. I. The Commission shall monitor the implementation of the provisions of this act in such manner as may be prescribed. I. National Commission for Protection of Child Rights 487. 2. The Commission shall, while inquiring into any matter relating to any offense under this act, have the same powers as are vested in it under the Commissions for the Protection of Child Rights Act, 2005. 3. Entire Commission shall also include its activities under this act in the annual report referred to in the Commissions for the Protection of Child Rights Act, 2005. 3. The Juvenile Justice, Care and Protection Act, 2015. With regard to the additional functions of the Commission, the following provisions are contained in this act. I. The Commission shall monitor the implementation of the provisions of this act in such manner as may be prescribed. 2. The Commission shall, while inquiring into any matter relating to any offense under this act, have the same powers as are vested in it under the Commissions for the Protection of Child Rights Act, 2005. 3. The Commission shall also include its activities under this act in the annual report referred to in the Commissions for the Protection of Child Rights Act, 2005. State Commission for Protection of Child Rights. The Commissions for Protection of Child Rights Act of 2005 provides for the creation of not only the National Commission for Protection of Child Rights but also a State Commission for Protection of Child Rights at the state level. Accordingly, a state government may constitute a State Commission for Protection of Child Rights through an official Gazette notification. Composition. The State Commission is a multi-member body consisting of a chairperson and 6 members. Out of the 6 members, at least 2 should be women. The chairperson should be a person of eminence who has done outstanding work for promoting the welfare of children. The 6 members should be from amongst persons of eminence, ability, integrity, standing, and experience in the following fields. I. Education. The 2nd. Child health, care, welfare, or child development. 3. Juvenile justice or care of neglected or marginalized children or children with disabilities. 4. Elimination of child labor or children in distress. V. Child psychology or sociology. And 6. Laws relating to children. The chairperson and other members are appointed by the state government. However, the chairperson is appointed on the recommendation of a 3-member selection committee constituted by the state government under the chairmanship of the minister in charge of the department dealing with children. The salaries, allowances, and other service conditions of the chairperson and members are also prescribed by the state government. However, they cannot be varied to their disadvantage after their appointment. The chairperson and members hold office for a term of 3 years. They are not eligible for appointment for more than 2 terms. Further, the upper age limit for holding the office is as follows. A. In the case of the chairperson, it is 65 years. And B. In the case of the members, it is 60 years. The chairperson or a member can relinquish his office at any time by addressing his or her resignation to the state government. The state government can remove the chairperson from their office on the ground of proved misbehavior or incapacity. Further, it can also remove the chairperson or any member from their office under the following circumstances. I. If his is adjudged an insolvent. Or 2. If Hisha engages, during their term of office, in any paid employment outside the duties of Hisha office. Or 3. If Hisha refuses to act or becomes incapable of acting. Or, for 88 Indian Polity. 4. If Hisha is declared of unsound mind by a competent court. Or v. If Hisha has so abused Hisha office which renders Hisha continuance in the office as detrimental to the public interest. Or 6. If Hisha is convicted and sentenced to imprisonment for an offense which, in the opinion of the state government, involves moral turpitude. Or 7. If Hisha absents himself or herself from 3 consecutive meeting of the Commission. 6. Without obtaining leave of absence from the State Commission. Functions of the Commission. The functions of the State Commission are as follows. 1. To examine and review the safeguards provided by the laws for the protection of child rights and recommend measures for their effective implementation. 2. Be present to the state government, annually and at such other intervals as it may deem fit, reports upon the working of those safeguards. 3. Inquire into violation of child rights and recommend initiation of proceedings in such cases. 4. Examine all factors that inhibits the enjoyment of rights of children affected by terrorism, communal riots, natural disaster, domestic violence, HIV/AIDS, trafficking, exploitation, and prostitution and recommend remedial measures. 5. To look into the matters relating to children in need of special care including children in distress, marginalized children, children in conflict with law, juveniles, children without family and children of prisoners and recommend remedial measures. 6. Study treaties and other international instruments and undertake periodical review of existing policies, programs, and other activities on child rights and make recommendations for their effective implementation. 7. Undertake and promote research in the field of child rights. 8. Spread child rights literacy among various sections of the society and promote awareness of the safeguards available for protection of these rights. 9. Inspect any juvenile custodial home or any other place of residence or institution under the control of the state government or any other authority, including any institution run by a social organization, where children are detained or lodged for the purpose of treatment, reformation, or protection, and take up with these authorities for remedial action. 10. Inquire into complaints and take suo motu notice of matters relating to the following and take up the issues arising out of these matters with appropriate authorities. I. Deprivation and violation of child rights. 2. Non-implementation of laws providing for protection and development of children. And 3. Non-compliance of policy decisions or instructions aimed at mitigating hardships and ensuring welfare and providing relief to children. 11. Performs such other functions as it may consider necessary for the promotion of child rights. Powers. The State Commission, while inquiring into any matter, has all the powers of a civil court trying a suit and in particular in respect of the following matters. A. Summoning and enforcing the attendance of any person and examining him or her on oath. B. Requiring the discovery and production of any document. C. Receiving evidence on affidavits. National Commission for Protection of Child Rights 489. D. Requisitioning any public record from any court or office. And E. Issuing summons for the examination of witnesses or documents. Working. The State Commission may take any of the following steps upon the completion of an inquiry. I. It may recommend to the state government or authority the initiation of proceedings for prosecution or such other suitable action against the concerned person. 2. It may approach the Supreme Court or the State High Court for the necessary directions, orders, or writs. 3. It may recommend to the state government or authority for the grant of necessary interim relief to the victim. The State Commission submits its annual or special reports to the state government. These reports are laid before the state legislature, along with a memorandum of action taken on the recommendations of the State Commission, and the reasons for non-acceptance of any of such recommendations. 7. Before each house of state legislature where it consists of 2 houses, or where such legislature consists of 1 house, before that house. Children's Courts. The Commissions for Protection of Child Rights Act 2005 also provides for the establishment of children's courts for the speedy trial of offenses against children or of violation of child rights. Thus, the state government may specify at least a court in the state or specify for each district a court of session to be a children's court. These courts can be set up by the state government only with the concurrence of the Chief Justice of the High Court of that state. For every children's court, the state government specifies a public prosecutor or appoints an advocate who has practiced for 7 years as a special public prosecutor for the purpose of conducting cases in that court. Chapter National Commission for Minorities. Establishment. In 1978, the Government of India vetoed an Executive Resolution 1, set up a Minorities Commission to safeguard the interests of the minorities. The resolution explained the reasons for the establishment of the Minorities Commission in the following way. Despite the safeguards provided in the Constitution and the laws in force, there persists among the minorities a feeling of inequality and discrimination. In order to preserve secular traditions and to promote national integration, The Government of India attaches the highest importance to the enforcement of the safeguards provided for the minorities and is of firm view that effective institutional arrangements are urgently required for the enforcement and implementation of all the safeguards provided for the minorities in the Constitution, in the central and state laws, and in the government policies and administrative schemes enunciated from time to time. Later, it was felt that the Minorities Commission be given statutory status so that it may infuse confidence among the minorities about the working and the effectiveness of the Commission. It would then also carry more weight with the state governments, union territory administrations, and the ministries. Resolution dated January 12, 1978, issued by the Ministry of Home Affairs, departments, and the other organizations of the central government. With the enactment of the National Commission for Minorities Act, 19922, the Minorities Commission became a statutory body and was renamed the National Commission for Minorities. The first statutory commission was constituted in 1993. The Commission is an autonomous body. It works under the administrative control of the Ministry of Minority Affairs 3, Government of India. The Act does not define the term minority, but enables the central government to notify minorities for the purposes of the Act. Accordingly, the Centre in 1993 notified 5 religious communities, viz. Muslims, Christians, Sikhs, Buddhists, and Zoroastrians, Parsis, as minority communities. In 2014, the Jain community was added to this list. F. Composition. The Commission is a multi-member body consisting of a chairperson, a vice-chairperson, and 5 members. They are nominated. This act came into force on May 17, 1993. The Ministry of Minority Affairs was carved out of the Ministry of Social Justice and Empowerment in 2006. Notification dated January 27, 2014, issued by the Ministry of Minority Affairs. Before the National Commission for Minorities Amendment Act, 1995, the Commission consisted of a chairperson and 6 members. National Commission for Minorities 491. By the central government from amongst persons of eminence, ability, and integrity. However, 5 members including the chairperson should be from amongst the minority communities. The salaries, allowances, and other service conditions of the chairman and members are also prescribed by the central government, Ministry of Minority Affairs. Notably, members include the vice-chairperson. The chairperson and members hold office for a period of 3 years. However, they can relinquish their office at any time by addressing their resignation to the central government. Further, the central government can also remove the chairperson or a member from the office before the expiry of the term, under any of the following circumstances. 1. Becomes an undischarged insolvent. 2. Gets convicted and sentenced to imprisonment for an offense which, in the opinion of the central government, involves moral turpitude. 3. Declared of unsound mind by a competent court. 4. Refuses to act or becomes incapable of acting. 5. Absents from 3 consecutive meetings of the Commission. 7. 6. Abused official position that, in the opinion of the central government, renders continuance in the office as detrimental to the interests of minorities or the public interest. 6. Added by the National Commission for Minorities Amendment Act, 1995. Without obtaining leave of absence from the Commission. F. Functions. The Commission is provided with the following 9-point mandate. 1. TB evaluate the progress of the development of minorities under the Union and States. 2. To monitor the working of the safeguards for minorities provided in the Constitution and in laws enacted by Parliament and the state legislatures. 3. TB make recommendations for the effective implementation of safeguards for the protection of the interests of minorities by the central government or the state governments. 4. TB look into specific complaints regarding deprivation of rights and safeguards of minorities and take up such matters with the appropriate authorities. 5. TB cause studies to be undertaken into the problems arising out of any discrimination against minorities and recommend measures for their removal. 6. TB conduct studies, research, and analysis on the issues relating to socio-economic and educational development of minorities. 7. To suggest appropriate measures in respect of any minority to be undertaken by the central government or the state governments. 8. TB make periodical or special reports to the central government on any matter pertaining to minorities and in particular the difficulties confronted by them. 9. TB look into any other matter referred to it by the central government. The Commission, while evaluating auditing any matter or inquiring into any complaint, has all the powers of a civil court trying a suit and in particular in respect of the following matters. 1. Summoning and enforcing the attendance of any person from any part of India and examining him or on oath. 2. Requiring the discovery and production of any document. 3. Receiving evidence on affidavits. 4. Requisitioning any public record from any court or office. 5. Issuing summons for the examination of witnesses and documents. 492 Indian Polity. 6. Any other matter which may be prescribed by the central government. T. Report. The Commission presents an annual report to the central government. It can also submit a report as and when it thinks necessary. The central government places all such reports before each House of Parliament, along with a memorandum explaining the action taken on the recommendations made by the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. If any such report is related to any matter with which any state government is concerned, then the Commission forwards a copy of such report to such state government. The state government places it before the state legislature, along with a memorandum explaining the action taken on the recommendations of the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. Chapter ___ Central Information Commission. Central Information Commission was established by the central government in 2005. It was constituted under the provisions of the Right to Information Act, 2005. Hence, it is not a constitutional body. The Central Information Commission is a high-powered independent body which inter alia looks into the complaints made to it and decide the appeals. It entertains complaints and appeals pertaining to offices, financial institutions, public sector undertakings, etc. under the central government and the union territories. Composition. The Commission consists of a Chief Information Commissioner and not more than 10 Information Commissioners. They are appointed by the President on the recommendation of a committee consisting of the Prime Minister as chairperson, the Leader of Opposition in the Lok Sabha, and a Union Cabinet Minister nominated by the Prime Minister. They should be persons of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism, mass media, or administration and governance. They should not be a member of Parliament or member of the legislature of any state or, where the Leader of Opposition in the Lok Sabha has not been recognized as such, the leader of the single largest group in opposition of the government in the Lok Sabha shall be deemed to be the leader of the opposition. Union territory. They should not hold any other office of profit or connected with any political party or carrying on any business or pursuing any profession. Tenure and service conditions. The Chief Information Commissioner and an Information Commissioner shall hold office for such term as prescribed by the central government or until they attain the age of 65 years, whichever is earlier. They are not eligible for reappointment too. The Information Commissioner is eligible for appointment as Chief Information Commissioner, but cannot hold office for more than a total of 5 years including his short term as Information Commissioner. The President can remove the Chief Information Commissioner or any Information Commissioner from the office under the following circumstances. A. If his is adjudged and insolvent. Or B. If he has been convicted of an offense which, in the opinion of the President, involves a moral turpitude. Or C. If his engages during his short term of office in any paid employment outside the duties of his office. Or D. If his is, in the opinion of the President, unfit to continue in office due to infirmity of mind or body. Or E. If his has acquired such financial or other interest as is likely to affect prejudicially his official functions. In addition to these, the President can also remove the Chief Information Commissioner or any Information Commissioner on the ground of proved misbehavior or incapacity. 3. However, in these cases, the President has to refer the matter to the Supreme Court for an inquiry. If Supreme Court, after the inquiry, upholds the cause of removal and advises so, then the President can remove him or her. The salary, allowances, and other service conditions of the Chief Information Commissioner and an Information Commissioner shall be such as prescribed by the central government. But they cannot be varied to his disadvantage during service. Powers and functions. The powers and functions of the Central Information Commission are: I. It is the duty of the Commission to receive and inquire into a complaint from any person, A. who has not been able to submit an information request because of non-appointment of a public information officer. B. Who has been refused information that was requested. C. Who has not received response to his or her information request within the specified time limits. D. Who thinks the fees charged are unreasonable. E. Who thinks information given is incomplete, misleading, or false. And F. Any other matter relating to obtaining information. 3. Husha is deemed to be guilty of misbehavior. If Husha is concerned or interested in any contract or agreement made by the central government or participates in any way in the profit of such contract or agreement or in any benefit or emolument arising therefrom otherwise than as a member, and in common with the other members of an incorporated company. 2. The Commission can order inquiry into any matter if there are reasonable grounds, suo motu power. 3. While inquiring, the Commission has the powers of a civil court in respect of the following matters. A. Summoning and enforcing attendance of persons and compelling them to give oral or written evidence on oath and to produce documents or things. B. Requiring the discovery and inspection of documents. C. Receiving evidence on affidavit. D. Requisitioning any public record from any court or office. E. Issuing summons for examination of witnesses or documents. And F. Any other matter which may be prescribed. 4. During the inquiry of a complaint, the Commission may examine any record which is under the control of the public authority and no such record may be withheld from it on any grounds. In other words, all public records must be given to the Commission during inquiry for examination. 5. The Commission has the power to secure compliance of its decisions from the public authority. This includes A. Providing access to information in a particular form. B. Directing the public authority to appoint a public information officer where none exists. C. Publishing information or categories of information. D. Making necessary changes to the practices relating to management, maintenance, and destruction of records. E. Enhancing training provision for officials on the right to information. F. Seeking an annual report from the public authority on compliance with this Act. Central Information Commission 495. G. Requiring the public authority to compensate for any loss or other detriment suffered by the applicant. H. Imposing penalties under this Act. And 4. I. Rejecting the application. For the Commission can impose a penalty on the Public Information Officer at the rate of $250 per day up to a maximum of $25,000. It can also recommend for disciplinary action against the errant official. 6. The Commission submits an annual report to the central government on the implementation of the provisions of this Act. The central government places this report before each House of Parliament. 7. When a public authority does not conform to the provisions of this Act, the Commission may recommend to the authority steps which ought to be taken for promoting such conformity. Chapter State Information. Commission. The Right to Information Act of 2005 provides for the creation of not only the Central Information Commission but also a State Information Commission at the state level. Accordingly, all the states have constituted the State Information Commissions. The State Information Commission is a high-powered independent body which inter alia looks into the complaints made to it and decide the appeals. It entertains complaints and appeals pertaining to offices, financial institutions, public sector undertakings, etc. Under the concerned state government. Composition. The Commission consists of a State Chief Information Commissioner and not more than 10 State Information Commissioners. 1. They are appointed by the Governor on the recommendation of a committee consisting of the Chief Minister as chairperson, the Leader of Opposition in the Legislative Assembly, and a State Cabinet Minister nominated by the Chief Minister. 2. They should be persons of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism. The number of State Information Commissioners varies from one state to another state. 2. Where the Leader of Opposition in the Legislative Assembly has not been recognized as such, the leader of the single largest group in opposition of the government in the Legislative Assembly shall be deemed to be the Leader of the Opposition. 3. The State Information Commissioner is eligible for appointment as State Chief Information Commissioner, but cannot hold office for more than a total of 5 years including his short term as State Information Commissioner. Mass media or administration and governance. They should not be a member of Parliament or member of the legislature of any state or union territory. They should not hold any other office of profit or connected with any political party or carrying on any business or pursuing any profession. Tenure and service conditions. The State Chief Information Commissioner and a State Information Commissioner shall hold office for such term as prescribed by the central government or until they attain the age of 65 years, whichever is earlier. They are not eligible for reappointment. 3. The Governor can remove the State Chief Information Commissioner or any State Information Commissioner from the office under the following circumstances. A. If Isha is adjudged and insolvent. Or B. If Fesh has been convicted of an offense which, in the opinion of the Governor, involves a moral turpitude. Or C. If Hishu engages during Hishu term of office in any paid employment outside the duties of Hishu office. Or D. If Hishu is, in the opinion of the Governor, unfit to continue in office due to infirmity of mind or body. Or E. If Hishu has acquired such financial or other interest as is likely to affect prejudicially Hishu official functions. In addition to these, the Governor can also remove the State Chief Information Commissioner or any State Information Commissioner on the ground of proved misbehavior or incapacity. 4. However, in these cases the Governor has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, then the Governor can remove him. For Husha is deemed to be guilty of misbehavior. If Husha is concerned or interested in any contract or agreement made by the state government or participates in any way in the profit of such contract or agreement or in any benefit or emolument arising therefrom otherwise than as a member in common with the other members of an incorporated company. The salary, allowances, and other service conditions of the State Chief Information Commissioner and a State Information Commissioner shall be such as prescribed by the central government. But they cannot be varied to Hishu disadvantage during service. T. Powers and functions. The powers and functions of the State Information Commission are 1. It is the duty of the Commission to receive and inquire into a complaint from any person, A. who has not been able to submit an information request because of non-appointment of a public information officer, B. who has been refused information that was requested, C. who has not received response to his or her information request within the specified time limits, D. who thinks the fees charged are unreasonable, E. who thinks information given is incomplete, misleading, or false, and State Information Commission 497. F. Any other matter relating to obtaining information. 2. The Commission can order inquiry into any matter if there are reasonable grounds, sua motu power. 3. While inquiring, the Commission has the powers of a civil court in respect of the following matters. A. Summoning and enforcing attendance of persons and compelling them to give oral or written evidence on oath and to produce documents or things. B. Requiring the discovery and inspection of documents. C. Receiving evidence on affidavit. D. Requisitioning any public record from any court or office. E. Issuing summons for examination of witnesses or documents. And F. Any other matter which may be prescribed. 4. During the inquiry of a complaint, the Commission may examine any record which is under the control of the public authority and no such record may be withheld from it on any grounds. In other words, all public records must be given to the Commission during inquiry for examination. 5. The Commission has the power to secure compliance of its decisions from the public authority. This includes a. Providing access to information in a particular form. B. Directing the public authority to appoint a public information officer where none exists. C. Publishing information or categories of information. D. Making necessary changes to the practices relating to management, maintenance, and destruction of records. E. Enhancing training provision for officials on the right to information. F. Seeking an annual report from the public authority on compliance with this act. $498 Indian Polity. G. Requiring the public authority to compensate for any loss or other detriment suffered by the applicant. H. Imposing penalties under this Act 3. And I. Rejecting the application. 6. The Commission submits an annual report to the state government on the implementation of the provisions of this Act. The state government places this report before the state legislature. 7. When a public authority does not conform to the provisions of this Act, the Commission may recommend to the authority steps which ought to be taken for promoting such conformity. TRTI Amendment ACT 2019. The various features or provisions of the Right to Information Amendment Act 2019 are as follows. 1. It provided that the Chief Information Commissioner and an Information Commissioner shall hold office for such term as prescribed by the central government. Before this amendment, their term was fixed for 5 years. 2. It provided that the salary, allowances, and other service conditions of the Chief Information Commissioner and an Information Commissioner shall be such as prescribed by the central government. Before this amendment, the salary, allowances, and other service conditions of the Chief Information Commissioner were similar to those of the Chief Election Commissioner, and that of an Information Commissioner were similar to those of an Election Commissioner. 3. It provided that the State Chief Information Commissioner and a State Information Commissioner shall hold office for such term as prescribed by the central government. Before this amendment, their term was fixed for 5 years. 4. It provided that the salary, allowances, and other service conditions of the State Chief Information Commissioner and a State Information Commissioner shall be such as prescribed by the central government. Before this amendment, the salary, allowances, and other service conditions of the State Chief Information Commissioner were similar to those of an Election Commissioner, and that of a State Information Commissioner were similar to those of the Chief Secretary of the state government. 5. It removed the provisions regarding deductions in salary of the Chief Information Commissioner, an Information Commissioner, the State Chief Information Commissioner, and a State Information Commissioner due to pension or any other retirement benefits received by them for their previous government service. The Commission can impose a penalty on the Public Information Officer at the rate of $250 per day up to a maximum of T25,000. It can also recommend for disciplinary action against the errant official. Chapter F. Establishment. The Central Vigilance Commission, CVC, is NET 7RN. 8. Sci-F degree are happy-facing corruption in U1 government was established in 1964 by an executive resolution of the central government. Its establishment was recommended by the Santhanam Committee on Prevention of Corruption 1, 1962-641. Where the leader of opposition in the Lok Sabha has not been recognized as such, the leader of the single largest group in opposition of the government in the Lok Sabha shall be deemed to be the leader of the opposition. Thus, originally the CVC was neither a constitutional body nor a statutory body etere. It was conferred statutory status by CVC A-20V038 Elon Sukhan, Mission Act 2003. The CVC has been designated as the agency to receive and act on complaints or disclosure on any allegation of corruption or misuse of ICE from whistleblowers under the Public Interest Disclosure and Protection of Informers Resolution PIDP 2004, which is popularly known as Whistleblowers Resolution. The CVC is also empowered as the only designated agency to take action against complainants making motivated or vexatious complaints. 2. The CVC is conceived to be the apex vigilance institution, free of control from any executive authority, monitoring all vigilance activity under the central government and advising various authorities and central government organizations in planning, executing Rex Lewing, and reforming their vigilance work. The Committee on Prevention of Corruption with P. Lamontan and K. Santhanam as the chairman, 5 other MPs and 2 senior officers as member apt to be the Government of India in L962. Annual Report 2021, Central Vigilance Commission. Central Vigilance Commission. T. Composition. The CVC is a multi-member body consisting of a Central Vigilance Commissioner, chairperson, and not more than 2 vigilance commissioners. They are appointed by the President by warrant under his hand and seal on the recommendation of a 3-member committee consisting of the Prime Minister as its head, the Union Minister of Home Affairs, and the leader of the Opposition in the Lok Sabha. They hold office for a term of 4 years or until they attain the age of 65 years, whichever is earlier. After their tenure, they are not eligible for further employment under the central or a state government. J16 President can remove the Central Vigilance Commissioner or any Vigilance Commissioner from the office under the following circumstances. A. If Hisha is adjudged and insolvent. Or B. If Fesh has been convicted of an offense which, in file opinion of the central government, involves a moral turpitude. Or C. If Hisha engages, during his term of office, in any paid employment outside the duties of his office. Or D. If Hisha is, in the opinion of the President, unfit to continue in office by reason of infirmity of mind or body. Or E. If Hisha has acquired such financial or other interest as is likely to affect prejudicially Hisha official functions. 500p Indian Polity. In addition to these, the President can also remove the Central Vigilance Commissioner or any Vigilance Commissioner on the ground of proved misbehavior or incapacity. However, in these cases, the President has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, then the President can remove him or her. Hisha is deemed to be guilty of misbehavior if Hisha A. is concerned or interested in any contract or agreement made by the central government, or B. participates in any way in the profit of such contract or agreement or in any benefit or emolument arising therefrom otherwise than as a member and in common with the other members of an incorporated company. The salary, allowances, and other conditions of service of the Central Vigilance Commissioner are similar to those of the chairman of UPSC, and that of the Vigilance Commissioner are similar to those of a member of UPSC. But they cannot be varied to his or her disadvantage after his appointment. F. Organization. The CVC has its own Secretariat, Chief Technical Examiners Wing (CTE), and a wing of Commissioners for Departmental Inquiries (CDIs). Secretariat. The Secretariat consists of a Secretary, Joint Secretaries, Deputy Secretaries, Under-Secretaries, and Office Staff. Chief Technical Examiners Wing. The Chief Technical Examiners Organization constitutes the technical wing of the CVC. It consists of Chief Engineers, designated as Chief Technical Examiners, and supporting engineering staff. The main functions assigned to this organization are as follows. I. Technical audit of construction works of government organizations from a vigilance angle. 2. Investigation of specific cases of complaints relating to construction works. 3. Extension of assistance to CB1 in their investigations involving technical matters and for evaluation of properties in Delhi. 4. Tendering of advice assistance to the CVC and chief vigilance officers in vigilance cases involving technical matters. 211. 2H. The chief vigilance officer is the head of the vigilance division of the ministries, departments, organizations of the central government. Hisha assists and advises the secretary head in all vigilance matters. The authorities of the central government include a corporation established by or under any central act and government company, society, and any local authority owned or controlled by the central government. The All India services include Indian Administrative Service (IS), Indian Police Service (IPS), and Indian Forest Service (IFOS). Commissioners for Departmental Inquiries. The CDIs function as inquiry officers to conduct oral inquiries and departmental proceedings initiated against public servants. F. Functions. The functions of the CVC are 1. LB inquire or cause an inquiry or investigation to be conducted on a reference made by the central government wherein it is alleged that a public servant being an employee of the central government or its authorities 3. has committed an offense under the Prevention of Corruption Act, 1988. 2. TB inquire or cause an inquiry or investigation to be conducted into any complaint against any official belonging to the below-mentioned category of officials wherein it is alleged that he/she has committed an offense under the Prevention of Corruption Act, 1988. 8. Members of all India services serving in the Union and Group, officers of the central government. And B. Specified level of officers of the authorities of the central government. 3. ID exercise superintendence over the functioning of the Delhi Special Police Establishment, CBI, insofar as it relates to the investigation of offences under the Prevention of Corruption Act, 1988. 4. LB give directions to the Delhi Special Police Establishment, CBI, for superintendence insofar as it relates to the investigation of offences under the Prevention of Corruption Act, 1988. 5. ID review the progress of investigations conducted by the Delhi Special Police Establishment into offences alleged to have been committed under the Prevention of Corruption Act, 1988. 6. LB review the progressive applications pending with the competent authorities for sanction of prosecution under the Prevention of Corruption Act, 1988. 7. 1B tender advise to the central government and its authorities on such matters as are referred to it by them. 8. 1B exercise superintendence over the vigilance administration in the ministries of the central government or its authorities. 9. 1B undertake or cause an inquiry into complaints received under the Public Interest Disclosure and Protection of Informers Resolution and recommend appropriate action. 10. The central government is required to consult the CVC in making rules and regulations governing the vigilance and disciplinary matters relating to the members of central services and all India services. Jurisdiction. The jurisdiction of the CVC extends to the following. 5. Annual Report 2021, Central Vigilance Commission, pp. 10-11. 1. Members of all India services serving in connection with the affairs of the Union and Group A officers of the central government. Central Vigilance Commission 501. 2. Officers of the rank of Scale V and above in the public sector banks. 3. Officers in Grade D and above in Reserve Bank of India, NABARD and SIDBI. 4. Chief executives and executives on the board and other officers of E8 and above in schedule, and B. Public sector undertakings. 5. Chief executives and executives on the board and other officers of E7 and above in Schedule C and D. Public sector undertakings. 6. Managers and above in general insurance companies. 7. Senior divisional managers and above in life insurance corporation. 8. Officers drawing salary of $8,700 per month pre-revised and above on central government DA pattern as may be revised from time to time in societies and local authorities owned or controlled by the central government. F. Working. The CVC conducts its proceedings at its headquarters, New Delhi. It is vested with the power to regulate its own procedure. It has all the powers of a civil court and its proceedings have a judicial character. It may call for information or report from the central government or its authorities so as to enable it to exercise general supervision over the vigilance and anti-corruption work in them. The CVC, on receipt of the report of the inquiry undertaken by any agency on a reference made by it, advises the central government or its authorities as to the further course of action. The central government or its authorities shall consider the advice of the CVC and take appropriate action. However, where the central government or any of its authorities do not agree with the advice of the CVC, it shall communicate the reasons to be recorded in writing to the CVC. The CVC has to present annually to the President a report on its performance. The President places this report before each House of Parliament. 502 or Indian Polity. Whistleblowers Protection Act 2014. The salient features of the Whistleblowers Protection Act 2014, 6 are as follows. 5. Originally, the year of the Act was 2011. Later, it was changed to 2014. 7. The Indian Express Whistleblowers Protection Act gets President's nod, May 13, 2014. 1. The Act provides a mechanism for protecting the identity of whistleblowers, a term given to people who expose corruption. People who expose corruption in government or irregularities by public functionaries can now be free of any fear of victimization. 2. The Act also provides for a system to encourage people to disclose information about corruption or the willful misuse of power by public servants, including ministers. 3. As per the Act, a person can make a public interest disclosure on corruption before a competent authority, which is at present the Central Vigilance Commission, CVC. The government, by notification, can appoint any other body also for receiving such complaints about corruption. 4. The Act, however, lays down punishment of up to 2 years in prison and a fine of up to 30,000 for false or frivolous complaints. 5. The Act says that every disclosure shall be made in good faith, and the person making the disclosure shall provide a personal declaration stating that Husha reasonably believes that the information disclosed by him/her and the allegation contained therein is substantially true. 6. Disclosures can be made in writing or by email message in accordance with the procedure as may be prescribed and contain full particulars and be accompanied by supporting documents or other material. 7. However, no action shall be taken on a disclosure if it does not indicate the identity of the complainant or public servant, or if the identity of the complainant or public servant is found to be incorrect. 8. The Act is not applicable to the Special Protection Group. Chapter Central Bureau of Investigation. F. Establishment. The Central Bureau of Investigation, CBI, traces its origin to the Special Police Establishment, which was set up in 1941 by the Government of India. The functions of the Special Police Establishment then were to investigate cases of bribery and corruption in transactions with the War and Supply Department of India during World War II. The superintendence of the Special Police Establishment was vested with this War and Supply Department. Even after the end of the war, the need for a central government agency to investigate cases of bribery and corruption by central government employees was felt. Therefore, the Delhi Special Police Establishment Act was brought into force in 1946. This act transferred the superintendence of the Special Police Establishment to the Home Department, and its functions were enlarged to cover all departments of the Government of India. 1. This information is obtained from the official website of the Central Bureau of Investigation Government of India. TNE-CBI functions under the administrative control of the Department of Personnel and TNE, DUPT, of the Ministry of Personnel. The CBI was established in 1963 by a resolution of the Ministry of Home Affairs, Government of India. The Delhi Special Police Establishment was also merged with the CBI and was made one of the divisions of the CBI. Later, the CBI was transferred to the Ministry of Personnel 13. The CBI is not a statutory body. It derives its powers from the Delhi Special Police Establishment Act, 1946. The CBI is the main investigating agency of the central government. It plays an important role in the prevention of corruption and maintaining integrity in administration. It also provides assistance to the Central Vigilance Commission and Lokpal. There is a difference between the nature of cases investigated by the National Investigation Agency, NIA, and the CBI. The NIA has been constituted after the Mumbai terror attack in 2008 mainly for investigation of incidents of terrorist attacks, funding of terrorism, and other terror-related crime, whereas the CBI investigates crime of corruption, economic offenses, and serious and organized crime other than terrorism. It must be noted here that the provisions of the Delhi Special Police Establishment Act, 1946, does not enable the CBI to exercise its powers and jurisdiction in any area in a state, not being a railway area, without the consent of the government of that state. In other words, the jurisdiction of the CBI can be extended to the states only with the consent of the state government concerned. T motto, mission, and vision. The motto, mission, and vision of the CBI are as follows too. Motto: industry, impartiality, and integrity. This information is obtained from the official website of the Central Bureau of Investigation, Government of India. $504 Indian Polity. Mission: to uphold the Constitution of India and law of the land through in-depth investigation and successful prosecution of offenses. To provide leadership and direction to police forces and to act as the nodal agency for enhancing interstate and international cooperation in law enforcement. Vision: based on its motto, mission, and the need to develop professionalism, transparency, adaptability to change, and use of science and technology in its working, the CBL will focus on 1. Combating corruption in public life, curbing economic and violent crimes through meticulous investigation and prosecution. 2. Evolving effective systems and procedures for successful investigation and prosecution of cases in various law courts. 3. Helping fight cyber and high-technology crime. 4. Creating a healthy work environment that encourages team building, free communication, and mutual trust. 5. Supporting state police organizations and law enforcement agencies in national and international cooperation, particularly relating to inquiries and investigation of cases. 6. Playing a lead role in the war against national and transnational organized crime. 7. Upholding human rights, protecting the environment, arts, antiques, and heritage of our civilization. 8. Developing a scientific temper, humanism, and the spirit of inquiry and reform. 9. Striving for excellence and professionalism in all spheres of functioning so that the organization rises to high levels of endeavor and achievement. Composition: the CBL is headed by a director. SHESH is assisted by special directors and additional directors. Additionally, it has a number of joint directors, deputy inspector generals, superintendents of police, and all other usual ranks of police personnel, as well as forensic scientists and law officers. The director of CBL as Inspector General of Police, Delhi Special Police Establishment, is responsible for the administration of the organization. With the enactment of CVC Act, 2003, the superintendents of Delhi Special Police Establishment vests with the central government save investigations of offenses under the Prevention of Corruption Act, 1988, in which the superintendents vests with the Central Vigilance Commission. The Lokpal and Lokayuktas Act, 2013, amended the Delhi Special Police Establishment Act, 1946, and made the following changes with respect to the composition of the CBL. 1. The central government shall appoint the director of CBL on the recommendation of a 3-member committee consisting of the Prime Minister as chairperson, the Leader of Opposition in the Lok Sabha, and the Chief Justice of India or Judge of the Supreme Court nominated by an 2. There shall be a Directorate of Prosecution headed by a director for conducting the prosecution of cases under the Lokpal and Lokayuktas Act, 2013. The Director of Prosecution shall function under the overall supervision and control of the Director of CBL. Husha shall be appointed by the central government on the recommendation of the Central Vigilance Commission. 3. The central government shall appoint officers of the rank of SP and above in the CBL on the recommendation of a committee consisting of the Central Vigilance Commissioner as chairperson, the Vigilance Commissioners, the Secretary of the Home Ministry, and the Secretary of the Department of Personnel. Later, the Delhi Special Police Establishment Amendment Act, 2014 made a change in the composition of the committee related to the appointment of the director of CBL. It states that where there is no recognized leader of opposition in the Lok Sabha, then the leader of the single largest opposition party in the Lok Sabha would be a member of that committee. Again, the Delhi Special Police Establishment Amendment Act, 2021 provides for the extension of the tenure of the director of CBL under the CVC Act, 2003. Hisha has a fixed 2-year tenure. But the amendment allowed the central government to extend Hisha tenure from 2 years to up to 5 years. However, the extension can be given up to 1 year at a time, and no such extension is possible after the completion of a period of 5 years in total, including the 2-year period of initial appointment. This means that Hisha can be given 3 annual extensions. Further, such extensions may be granted in public interest, on the recommendation of the committee related to the initial appointment and for the reasons to be recorded in writing. Functions. The functions of CBI are 3. 3 IBIT. For the Hindu, no sanction needed for CBI to probe bureaucrats, SC, May 7, 2014. I. Investigating cases of corruption, bribery, and misconduct of central government employees. 2. Investigating cases relating to infringement of fiscal and economic laws, that is, breach of laws concerning export and import control, customs and central excise, income tax, foreign exchange regulations, and so on. However, Such cases are taken up either in consultation with or at the request of the department concerned. 3. Investigating serious crimes, having national and international ramifications, committed by organized gangs of professional criminals. 4. Coordinating the activities of the anti-corruption agencies in the various state police forces. Taking up, on the request of a state government, any case of public importance for investigation. Central Bureau of Investigation 505. 6. Maintaining crime statistics and disseminating criminal information. The CBI is a multidisciplinary investigation agency of the Government of India and undertakes investigation of corruption-related cases, economic offences and cases of conventional crime. It normally confines its activities in the anti-corruption field to offences committed by the employees of the central government and union territories in their public sector undertakings. It takes up investigation of conventional crimes like murder, kidnapping, rape, etc. on reference from the state governments or when directed by the Supreme Court High Courts. The CBI acts as the National Central Bureau of Interpol in India. The Interpol wing of the CBI coordinates requests for investigation-related activities originating from Indian law enforcement agencies in the member countries of the Interpol. Provision of prior permission. The CBI is required to obtain the prior approval of the central government before conducting any inquiry or investigation into an offense committed by officers of the rank of Joint Secretary and above in the central government and its authorities. However, in 2014, the Supreme Court held as invalid the legal provision that makes prior sanction mandatory for the CBI to conduct a probe against senior bureaucrats in corruption cases under the Prevention of Corruption Act. For a Constitution bench held that Section 6A of the Delhi Special Police Establishment Act, which granted protection to Joint Secretary and above officers from facing even a preliminary inquiry by the CBI in corruption cases, was violative of Article 14. Writing the judgment, the CJI said, "Corruption is an enemy of the nation and tracking down a corrupt public servant, howsoever high 506 Indian Polity he may be, and punishing such person is a necessary mandate under the PG Act, 1988. The status or position of a public servant does not qualify the person from exemption from equal treatment. The decision-making power does not segregate corrupt officers into two classes as they are common crime doers and have to be tracked down by the same process of inquiry and investigation." FCBI vs. State Police. The role of the Delhi Special Police Establishment, a division of CBI, is supplementary to that of the state police forces. Along with state police forces, the Delhi Special Police Establishment, DSP, enjoys concurrent powers of investigation and prosecution for offences under the Delhi Special Police Establishment Act, 1946. However, to avoid duplication and overlapping of cases between these two agencies, the following administrative arrangements have been made. The DSP shall take up such cases which are essentially and substantially concerned with the central government's affairs or employees, even if they also involve certain state government employees. 2. The state police force shall take up such cases which are substantially concerned with the state government's affairs or employees, even if they also involve certain central government employees. 3. The DSP shall also take up cases against employees of public undertakings or statutory bodies established and financed by the central government. Scan the QR code to access the conceptual video on discussion of CAG, AGI, CBI, and NIA, their autonomy and limitation, and other important topics on EDGE Chapter 66 Lokpal and Lokayuktas. Global scenario. Modern democratic states are characterized by a welfare orientation. Hence, the government has come to play an important role in the socio-economic development of a nation. This has resulted in the expansion of bureaucracy and the multiplication of administrative process, which in turn increased the administrative power and discretion enjoyed by the civil servants at different levels of the government. The abuse of this power and discretion by civil servants opens up scope for harassment, malpractices, maladministration, and corruption. Such a situation gives rise to citizens' grievances against administration. 1. According to the Chambers Dictionary, grievance means a ground of complaint, a condition felt to be oppressive or wrongful. The success of democracy and the realization of socio-economic development depends on the extent to which the citizens' grievances are redressed. Therefore, the following institutional devices have been created in different parts of the world to deal with the redressal of these grievances. 1. The Ombudsman System. 2. The Administrative Court System. 3. The Procurator System. The earliest democratic institution created in the world for the redressal of citizens' grievance is the Scandinavian Institution of Ombudsman. Donald C. Rowat, an international expert on the institution of Ombudsman, calls it a uniquely appropriate institution for dealing with the average citizen's complaints about unfair administrative actions. The institution of Ombudsman was first created in Sweden in 1809. Ombud is a Swedish term and refers to a person who acts as the representative or spokesman of another person. According to Donald C. Rowat, Ombudsman refers to an officer appointed by the legislature to handle complaints against administrative and judicial action. The Swedish Ombudsman deals with the citizens' grievances in the following matters. Abuse of administrative discretion, that is, misuse of official power and authority. 2. Maladministration, that is, inefficiency in achieving the targets. 3. administrative corruption, that is, demanding bribery for doing things. 4. Nepotism, that is, supporting one's own kith and kin in matters like providing employment. V. Discourtesy, that is, misbehavior of various kinds, for instance. Use of abusive language. The Ombudsman is a constitutional authority and enjoys the powers to supervise the compliance of laws and regulations by the public officials and see that they discharge their duties properly. In other words, the authority keeps a watch over all public officials, civil, judicial, and military, so that they function impartially, objectively, and legally, that is, in accordance with the law. However, the authority has no power to reverse or quash a decision and has no direct control over administration or the courts. $508 Indian Polity. The Ombudsman can act either on the basis of a complaint received from the citizen against unfair administrative action or suo moto, i.e. on his own initiative. The authority can prosecute any erring official, including the judges. However, it cannot inflict any punishment. It only reports the matter to the higher authorities for taking the necessary corrective action. From Sweden, the institution of Ombudsman spread to other Scandinavian countries: Finland, 1919, Denmark, 1955, and Norway, 1962. New Zealand is the first Commonwealth country in the world to have adopted the Ombudsman system in the form of a Parliamentary Commissioner for Investigation in 1962. The United Kingdom adopted Ombudsman-like institution called Parliamentary Commissioner for Administration in 1967. Since then, many other counties of the world have adopted Ombudsman-like institutions with different nomenclature and functions. The Ombudsman in India is called Lokpal and Lokayuktas. Donald C. Rowat says that the institution of Ombudsman is a bulwark of democratic government against the tyranny of officialdom. While Gerald E. Caden, a scholar of public administration, described the Ombudsman as institutionalized public conscience. Another unique institutional device created for the redressal of citizens' grievances against administrative authorities is the French system of administrative courts. Due to its success in France, the system has gradually spread to various other countries of the world. The socialist countries like the former USSR, now Russia, and China have created their own institutional device for the redressal of citizens' grievances. It is called procurator system in these countries. Position in India. The existing legal and institutional framework to check corruption and redress citizens' grievances in India consists of the following: Public Servants Inquiries Act, 1850, Indian Penal Code, 1860. Special Police Establishment. 1941, Delhi Special Police Establishment Act. 1946, Prevention of Corruption Act. 1988, Benami Transactions Prohibition Act. 1988, Commissions of Inquiry Act. 1952, Against Political Leaders and Eminent Public Men, All India Services Conduct Rules. 1968, All India Services Discipline and Appeal Rules. In this innovative scheme, the administrator goes to the village area and hears public grievances and takes immediate action wherever possible. Whistleblowers Protection Act, 2014, Department of Administrative Reforms and Public Grievances, Centralized Public Grievance Redress and Monitoring System, 2007 Lokpal and Lokayuktas M509. T. Lokpal _ the First Administrative Reforms Commission, ARC, of India, 1966 to 1970, recommended the setting up of two special authorities designated as Lokpal and Lokayuktas for the redressal of citizens' grievances too. These institutions were to be set up on the pattern of the institution of Ombudsman in Scandinavian countries and the Parliamentary Commissioner for Investigation in New Zealand. The Lokpal would deal with complaints against ministers and secretaries at central and state levels, and the Lokayuktas, one at the center and one in every state, would deal with complaints against other specified higher officials. The ARC kept the judiciary outside the purview of Lokpal and Lokayuktas as in New Zealand. But in Sweden, the judiciary is within the purview of Ombudsman. The first ARC of India, headed by Morarthi Desai, submitted a special interim report on the problems of redressal of citizens' grievances in 1966. 3. Press Information Bureau, Government of India, December 23, 2013. According to the ARC, the Lokpal would be appointed by the President after consultation with the Chief Justice of India, the Speaker of Lok Sabha, and the Chairman of the Rajya Sabha. The ARC also recommended that the institutions of Lokpal and Lokayuktas should have the following features. 1. They should be demonstratively independent and impartial. 2. Their investigations and proceedings should be conducted in private and should be informal in character. 3. Their appointment should be, as far as possible, non-political. 4. Their status should compare with the highest judicial functionaries in the country. 5. They should deal with matters in the discretionary field involving acts of injustice, corruption, or favoritism. 6. Their proceedings should not be subject to judicial interference. 7. They should have the maximum latitude and powers in obtaining information relevant to their duties. 8. They should not look forward to any benefit or pecuniary advantage from the executive government. The Government of India accepted the recommendations of ARC in this regard. So far, 10 official attempts have been made to bring about legislation on this subject. Bills were introduced in the Parliament in the following years. 1. In May 1968, by the Congress government headed by Indira Gandhi. 2. In April 1971, again by the Congress government headed by Indira Gandhi. 3. In July 1977, by the Janata government headed by Morarji Desai. 4. In August 1985, by the Congress government headed by Rajiv Gandhi. 5. In December 1989, by the National Front government headed by VP Singh. 6. In September 1996, by the United Front government headed by Deve Gowda. 7. In August 1998, by the BJP-led coalition government headed by A.B. Vajpayee. 8. In August 2001, by the NDA government headed by A.B. Vajpayee. 9. In August 2011, by the UPA government headed by Manmohan Singh. 10. In December 2011, by the UPA government headed by Manmohan Singh. The first 4 bills lapsed due to the dissolution of Lok Sabha, while the 5th one was withdrawn by the government. The 6th and 7th bills also lapsed due to the dissolution of the 11th and 12th Lok Sabha. Again, the 8th bill, 2001, lapsed due to the dissolution of the 13th Lok Sabha in 2004. The 9th bill, 2011, was withdrawn by the government. The 10th bill, the Lokpal and Lokayuktas Bill, 2011, was enacted as the Lokpal and Lokayuktas Act, 2013. 7 Lokpal and Lokayuktas Act, 2013. Features. The salient features of the Lokpal and Lokayuktas Act, 2013, are as follows. 510 Indian Polity. 1. It seeks to establish the institution of the Lokpal at the center and the Lokayukta at the level of the state, and thus seeks to provide a uniform vigilance and anti-corruption roadmap for the nation both at the center and at the states. The jurisdiction of Lokpal includes the Prime Minister, ministers, members of Parliament, and Groups A, B, C, and D officers and officials of the central government. 2. The Lokpal to consist of a chairperson with a maximum of 8 members, of which 50% shall be judicial members. 3. 50% of the members of the Lokpal shall come from amongst the SCs, the STs, the OBCs, minorities, and women. 4. The selection of the chairperson and the members of Lokpal shall be through a selection committee consisting of the Prime Minister, the Speaker of the Lok Sabha, the Leader of the Opposition in the Lok Sabha, the Chief Justice of India or a sitting Supreme Court judge nominated by the Chief Justice of India, and an eminent jurist to be nominated by the President of India on the basis of recommendations of the first 4 members of the selection committee. 5. A search committee will assist the selection committee in the process of selection. 50% of the members of the search committee shall also be from amongst the SCs, the STS, the OBCs, minorities, and women. 6. The Prime Minister has been brought under the purview of the Lokpal with subject matter exclusions and specific process for handling complaints against the Prime Minister. 7. Lokpal's jurisdiction will cover all categories of public servants, including Group A, Group B, Group C, and Group D officers and employees of government. On complaints referred to the CVC by the Lokpal, the CVC will send its report of preliminary inquiry in respect of Group A and Group B officers back to the Lokpal for further decision. With respect to categories of employees from Group C and Group D, the CVC will proceed further in exercise of its own powers under the CVC Act subject to reporting and review by the Lokpal. 8. The Lokpal will have the power of superintendence and direction over any investigating agency, including the CBI, for cases referred to them by the Lokpal. 9. A high-powered committee chaired by the Prime Minister will recommend the selection of the Director of CBI. 10. It incorporates provisions for attachment and confiscation of property of public servants acquired by corrupt means, even while the prosecution is pending. 11. It lays down clear timelines. For preliminary inquiry, it is 3 months extendable by 3 months. For investigation, it is 6 months which may be extended by 6 months at a time. For trial, it is 1 year extendable by 1 year, and to achieve this, special courts to be set up. 12. It enhances maximum punishment under the Prevention of Corruption Act from 7 years to 10 years. The minimum punishment under Sections 7, 8, 9, and 12 of the Prevention of Corruption Act will now be 3 years, and the minimum punishment under Section 15, punishment for attempt, will now be 2 years. 13. Institutions which are financed fully or partly by government are under the jurisdiction of Lokpal, but institutions aided by government are excluded. 14. It provides adequate protection for honest and upright public servants. 15. Lokpal conferred with power to grant sanction for prosecution of public servants in place of the government or competent authority. 16. It contains a number of provisions aimed at strengthening the CBI, such as I. Setting up of a Directorate of Prosecution headed by a Director of Prosecution under the overall control of the Director of CBI. 2. Appointment of the Director of Prosecution on the recommendation of the CVC. 3. Maintenance of a panel of advocates by CBI other than government advocates with the consent of the Lokpal for handling Lokpal-referred cases. 4. Transfer of officers of CBI investigating cases referred by Lokpal with the approval of Lokpal. V. Provision of adequate funds to CBI for investigating cases referred by Lokpal. 17. All entities receiving donations from foreign source in the context of the Foreign Contribution Regulation Act, FORA, in excess of 10 locks per year are brought under the jurisdiction of Lokpal. 18. It contains a mandate for setting up of the institution of Lokayukta through enactment of a law by the state legislature within a period of 365 days from the date of commencement of this act. Thus, the act provides freedom to the states to decide upon the contours of the Lokayukta mechanism in their respective states. Drawbacks. The following are the drawbacks shortcomings of the Lokpal and Lokayuktas Act, 20134. For Tixman's Guide to Lokpal and Lokayuktas Act 2013, pp. 1-9 to I-11. 1. Lokpal cannot suo motu proceed against any public servant. 2. Emphasis on form of complaint rather than substance. 3. Heavy punishment for false and frivolous complaints against public servants may deter complaints being filed to Lokpal. 4. Anonymous complaints not allowed. Can't just make a complaint on plain paper and drop it in a box with supporting documents. 5. Legal assistance to public servant against whom complaint is filed. Lokpal and Lokayuktas 511. 6. Limitation period of 7 years to file complaints. 7. Very non-transparent procedure for dealing with complaints against the PM. F. Lokayuktas. Even much before the enactment of the Lokpal and Lokayuktas Act 2013 itself, many states had already set up the institution of Lokayuktas. It must be noted here that the institution of Lokayukta was established first in Maharashtra in 1971. However, Odisha had passed the act in this regard in 1970. The various aspects of the institution of Lokayukta are: 1. The structure of the Lokayukta is not same in all the states. Some states have created the Lokayukta as well as a Palokayukta, while some others have created only the Lokayukta. 2. The Lokayukta and a Palokayukta are appointed by the governor of the state. 3. Judicial qualifications are prescribed for the Lokayukta in some states, but no specific qualifications are prescribed in other states. 4. In most of the states, the term of office fixed for Lokayukta is of 5 years duration or 65 years of age, whichever is earlier. 5. There is no uniformity regarding the jurisdiction of Lokayukta in all the states. The following points can be noted in this regard. A. The chief minister is included within the jurisdiction of Lokayukta in some states, while Hisha is excluded from the purview of Lokayukta in other states. B. Ministers and higher civil servants are included in the purview of Lokayukta in almost all the states. C. Members of state legislatures are included in the purview of Lokayukta in some states. D. THQ, authorities opound the L bodies, corporations, companies and societies 512 Indian Polity, are included in the jurisdiction of the Lokayukta in most of the states. 6. In most of the states, the Lokayukta can initiate investigations either on the basis of a complaint received from the citizen against unfair administrative action or suo motu. 7. The Lokayukta can consider the cases of grievances as well as allegations in some states. But, in other states, the job of Lokayuktas is confined to investigating allegations corruption and not grievances maladministration. 8. The Lokayukta presents, annually, to the governor of the state a consolidated report on Hisha performance. The governor places this report along with an explanatory memorandum before the state legislature. 9. The recommendations made by the Lokayukta are only advisory and not binding on the state government. Chapter 67 National Investigation KV Agency. T. Establishment. The National Investigation Agency, NIA, was constituted in 2009 under the provisions of the National Investigation Agency Act, 2008, NIA Act. It is the central counterterrorism law enforcement agency in the country. The NIA was established in the backdrop of the 2008 Mumbai terror attacks, popularly known as the 26/11 incident. This national horror led to the realization of the need for a separate federal agency to deal with terror-related crimes in the country. The headquarters of the NIA is in New Delhi. The branch offices of the NIA are located in different states of India. In addition, the NIA has a separate specialized cell known as TFC cell dealing with the subjects of fake currency notes and terror funding. The NIA is headed by a Director General. Hisha is appointed by the central government. Hisha powers are similar to the powers exercisable by a Director General of Police in respect of the police force in a state. The NIA works under the administrative control of the Ministry of Home Affairs, Government of India. The state government extends all assistance and cooperation to the NIA for investigation of the offences specified under the NIA Act. T. Rationale. While introducing the NIA Bill, 2008, in the Parliament, the Government of India gave the following reasons for creating the NIA. 1. Over the past several years, India has been the victim of large-scale terrorism, sponsored from across the borders. There have been innumerable incidents of terrorist attacks, not only in the militancy and insurgency-affected areas and areas affected by left-wing extremism, but also in the form of terrorist attacks and bomb blasts, etc. in various parts of the hinterland and major cities, etc. 2. A large number of such incidents are found to have complex interstate and international linkages and possible connection with other activities like the smuggling of arms and drugs, pushing in and circulation of fake Indian currency, infiltration from across the borders, etc. 3. Keeping all these in view, it was felt that there was a need for setting up of an agency at the central level for the investigation of offenses related to terrorism and certain other acts, which have national ramifications. 4. Several expert committees and the Second Administrative Reforms Commission of India have also made recommendations for establishing such an agency. T. Functions. The NIA is mandated to investigate and prosecute offenses under the various acts mentioned in the schedule of the NIA Act. In pursuance of its mandate, the NIA collects, collates, and analyses counterterrorism investigation. It also shares inputs with its sister intelligence. The Second Administrative Reforms Commission of India, Chairman, Veerappa Moily, 2005-2009, in its report entitled Combating Terrorism 2008. 514 are Indian Polity. Agencies and law enforcement units both at central and state governments level. In more detail, the functions assigned to the NIA are as follows: 2. A. To investigate and prosecute offenses in respect of the act specified in the schedule of the NIA Act. B. TB provide assistance to and seek assistance from other intelligence and investigation agencies of the central government and state governments. C. 7b. Take other such measures which may be necessary for speedy and effective implementation of the provisions of the NIA Act. T. Vision. The following points highlight the vision of the NIA. 3. 1. The NIA aims to be a thoroughly professional investigative agency matching the best international standards. 2. The NIA aims to set the standards of excellence in counterterrorism and other national security-related investigations at the national level by developing into a highly trained, partnership-oriented workforce. 3. The NIA aims at creating deterrence for existing and potential terrorist groups and individuals. 4. The NIA aims to develop as a storehouse of all terrorist-related information. T. Mission. The mission of the NIA is as follows: 4. 1. In-depth professional investigation of scheduled offenses using the latest scientific methods of investigation and setting up such standards as to ensure that all cases entrusted to the NIA are detected. The National Investigation Agency, Manner of Constitution, Rules, 2008. This information is obtained from the official website of the National Investigation Agency, Government of India. For IBID. 2. Ensuring effective and speedy trial. 3. Developing into a thoroughly professional, result-oriented organization, upholding the Constitution of India and laws of the land, giving prime importance to the protection of human rights and dignity of the individual. 4. Developing a professional workforce through regular training and exposure to the best practices and procedures. 5. Displaying scientific temper and progressive spirit while discharging the duties assigned. 6. Inducting modern methods and the latest technology in every sphere of activities of the agency. 7. Maintaining professional and cordial relations with the governments of states and union territories and other law enforcement agencies in compliance with the legal provisions of the NIA Act. 8. Assisting all states and other investigating agencies in investigation of terrorist cases. 9. Building a database on all terrorist-related information and sharing the available database with the states and other agencies. 10. Studying and analyzing laws relating to terrorism in other countries and regularly evaluating the adequacy of existing laws in India and proposing changes as and when necessary. 11. Winning the confidence of the citizens of India through selfless and fearless endeavors. The NIA has concurrent jurisdiction to investigate and prosecute the offenses affecting the sovereignty, security, and integrity of India, security of state, friendly relations with foreign states, and offenses under various acts enacted to implement international treaties, agreements, conventions, and resolutions of the UNO, its agencies, and other international organizations. National Investigation Agency 515. The NIA is empowered to probe terror attacks including bomb blasts, hijacking of aircrafts and ships, attacks on nuclear installations, and use of weapons of mass destruction. In 2019, the jurisdiction of the NIA was extended 5. Consequently, the NIA is also empowered to probe the offenses relating to human trafficking, counterfeit currency or banknotes, manufacture or sale of prohibited arms, cyberterrorism, and explosive substances. 5e. The NIA Amendment Act, 2019. 6. Based on the Statement of Objects and Reasons appended to the NIA Amendment Bill, 2019. 7. NIA Amendment Act, 2019. The various features or provisions of the amendment are as follows. 6. 1. It applied the provisions of the NIA Act also to persons who commit a scheduled offense beyond India against Indian citizens or affecting the interest of India. 2. It provided that the officers of the NIA shall have the similar powers, duties, privies, and liabilities being exercised by the police officers in connection with the investigation of offenses, not only in India but also outside India. 3. It empowered the central government, with respect to a scheduled offense committed outside India, to direct the NIA to register the case and take up investigation as if such offense has taken place in India. 4. It provided that the central government and the state governments may designate sessions courts as special courts for conducting the trial of offenses under the NIA Act. 5. It inserted certain new offenses in the schedule of the NIA Act. Scan the QR code to access the conceptual video on discussion of CAG, AGL, CBI, and NIA, their autonomy and limitations and other important topics on EDGE Chapter 1 II National Disaster Management Authority. T. Establishment. The Government of India, recognizing the importance of disaster management as a national priority, had set up a high-powered committee in 1999 and a national committee in 2001 after the Gujarat earthquake, to make recommendations on the preparation of disaster management plans and suggest effective mitigation mechanisms. However, after the Indian Ocean tsunami of 2004, the Government of India took a defining step in the legislative history of the country by enacting the Disaster Management Act, 2005 foot. The act provided for the creation of the National Disaster Management Authority, NDMA, to spearhead and implement a holistic and integrated approach to disaster management in the country. Initially, the NDMA was constituted in 2005 by an executive order of the Government of India. Subsequently, the NDMA was notified in 2006 under the provisions of the Act *2. Annual Report 2020-21, National Disaster Management Authority, Government of India, p. 2. 2 IBID. The NDMA consists of a chairperson and other members, not exceeding 9. The Prime Minister is the ex officio chairperson of the NDMA. The other members are nominated by the chairperson of the NDMA. The chairperson of the NDMA designates one of the members as the vice chairperson of the NDMA. The vice chairperson has the status of a cabinet minister, while the other members have the status of a minister of state. The NDMA is the apex body for disaster management in the country. It works under the administrative control of the Union Ministry of Home Affairs. The NDMA was established with this vision: build a safer and disaster-resilient India by a holistic, proactive, technology-driven, and sustainable development strategy that involves all stakeholders and fosters a culture of prevention, preparedness, and mitigation. Objectives. The objectives of the NDMA are as follows: 3. 1. Promote a culture of prevention, preparedness, and resilience at all levels through knowledge, innovation, and education. 2. Encourage mitigation measures based on technology, traditional wisdom, and environmental sustainability. 3. Mainstream disaster management into the developmental planning process. 4. Establish institutional and techno-legal frameworks to create an enabling regulatory environment and a compliance regime. 5. Ensure an efficient mechanism for identification, assessment, and monitoring of disaster risks. 6. Develop contemporary forecasting and early warning systems backed by responsive and fail-safe communication with information technology support. IBID, p. K. National Disaster Management Authority *4 517. 7. Ensure efficient response and relief with a caring approach towards the needs of the vulnerable sections of the society. 6. Undertake reconstruction as an opportunity to build disaster-resilient structures and habitat for ensuring safer living. 9. Promote a productive and proactive partnership with the media for disaster management. X functions. The NDMA has the responsibility for laying down the policies, plans, and guidelines for disaster management for ensuring timely and effective response to disaster. The functions of the NDMA are as follows: 1. To lay down policies on disaster management. 2. 1. Approve the national plan. 3. Approve plans prepared by the ministries or departments of the Government of India in accordance with the national plan. 4. Lay down guidelines to be followed by the State Disaster Management Authorities, SDMAs, for in drawing up the state plan. 5. Lay down guidelines to be followed by the different ministries or departments of the Government of India for the purpose of integrating the measures for prevention of disaster or the mitigation of its effects in their development plans and projects. 6. Coordinate the enforcement and implementation of the policy and plan for disaster management. 7. Recommend provision of funds for the purpose of mitigation. 8. Provide such support to other countries affected by major disasters as may be determined by the central government. 9. Take other such measures for the prevention of disaster, or the mitigation, or preparedness and capacity building for. 5. The National Institute of Disaster Management is located in New Delhi. The Act also provided for the establishment of the State Disaster Management Authorities and the District Disaster Management Authorities, dealing with the threatening disaster situation or disaster as it may consider necessary. 10. Lay down broad policies and guidelines for the functioning of the National Institute of Disaster Management. 7 additional functions underscore: in addition to the above, the NDMA also performs the following functions. 1. It recommends guidelines for the minimum standards of relief to be provided to persons affected by disaster. 2. It recommends, in cases of disasters of severe magnitude, relief and repayment of loans or grant of fresh loans on concessional terms to the persons affected by such disasters. 3. It exercises the general superintendence, direction, and control of the National Disaster Response Force, NDRF. This force has been constituted for the purpose of specialist response to a threatening disaster situation or disaster. 4. It authorizes the concerned department or authority to make the emergency procurement of provisions or materials for rescue or relief in any threatening disaster situation or disaster. In such cases, the standard procedure requiring inviting of tenders is deemed to be waived. 5. It prepares an annual report on its activities and submits it to the central government. The central government causes it to be laid before both houses of parliament. 7. State Disaster Management Authority under the Disaster Management Act, 2005. Every state government should establish a State Disaster Management Authority, SDMA, for the state. Big M Indian Polity. Composition in SDMA consists of a chairperson and other members, not exceeding 9. The Chief Minister of the state is the ex officio chairperson of the SDMA. The chairperson of the State Executive Committee is the ex officio member of the SDMA. The other members, not exceeding 8, are nominated by the chairperson of the SDMA. The chairperson of the SDMA designates one of the members as the vice chairperson of the SDMA. The chairperson of the State Executive Committee acts as the ex officio chief executive officer of the SDMA. Functions in SDMA has the responsibility for laying down policies and plans for disaster management in the state. Its functions include the following. 1. To lay down the state disaster management policy. 2. To approve the state plan in accordance with the guidelines laid down by the NDMA. 3. To approve the disaster management plans prepared by the departments of the government of the state. 4. To lay down guidelines to be followed by the departments of the government of the state for the purposes of integration of measures for the prevention of disasters and mitigation in their development plans and projects and provide necessary technical assistance thereof. 5. To coordinate the implementation of the state plan. 6. To recommend the provision of funds for mitigation and preparedness measures. 7. To review the development plans of the different departments of the state and ensure that prevention and mitigation measures are integrated therein. 8. To review the measures being taken for mitigation, capacity building, and preparedness by the departments of the government of the state and issue such guidelines as may be necessary. 9. To prepare an annual report on its activities and submit it to the state government. The state government causes it to be laid before the state legislature 1 foot. District Disaster Management Authority. Under the Disaster Management Act, 2005, every state government should establish a District Disaster Management Authority, DDMA, for every district in the state. Composition A DDMA consists of a chairperson and other members, not exceeding 7. The collector, or district magistrate or deputy commissioner, of the district is the ex officio chairperson of the DDMA. The elected representative of the local authority is the ex officio co-chairperson of the DDMA. But, in case of tribal areas as referred to in the 6th Schedule to the Constitution of India, the chief executive member of the District Council of Autonomous District is the ex officio co-chairperson of the DDMA. The chief executive officer of the DDMA, the superintendent of police, and the chief medical officer of the district are the ex officio members of the DDMA. Not more than 2 other district-level officers are appointed by the state government as the members of a DDMA. In case of a district where Zilla Parishad exists, the chairperson of that Zilla Parishad is the co-chairperson of the DDMA. The chief executive officer of the DDMA is appointed by the state government. Functions. The DDMA acts as the district planning, coordinating, and implementing body for disaster management and takes all measures for the purposes of disaster management in the district in accordance with the guidelines. Before each house of the state legislature where it consists of 2 houses, or where such legislature consists of 1 house, before that house. National Disaster Management Authority 519. Laid down by the NDMA and the SDMA. Its functions are as follows. 1. Prepare a disaster management plan including district response plan for the district. 2. To coordinate and monitor the implementation of the national policy, national plan, state plan, and district plan. 3. To ensure that the areas in the district vulnerable to disasters are identified and measures for the prevention of disasters and the mitigation of its effects are undertaken by the departments of the government at the district level as well as by the local authorities. 4. To ensure that the guidelines for prevention of disasters, mitigation of its effects, preparedness and response measures as laid down by the NDMA and the SDMA are followed by all departments of the government at the district level and the local authorities in the district. 5. Organize and coordinate specialized training programs for different levels of officers, employees, and voluntary rescue workers in the district. 6. Facilitate community training and awareness programs for prevention of disaster or mitigation with the support of local authorities, governmental and non-governmental organizations. 7. Set up, maintain, review, and upgrade the mechanism for early warnings and dissemination of proper information to the public. 8. To advise, assist, and coordinate the activities of the departments of the government at the district level, statutory bodies, and other governmental and non-governmental organizations in the district engaged in disaster management. 9. Identify buildings and places which could, in the event of any threatening disaster situation or disaster, be used as relief centers or camps and make arrangements for water supply and sanitation in such buildings or places. 10. Perform such other functions as the state government or SDMA may assign to it or as it deems necessary for disaster management in the district. Chapter. Bar Council of India. Establishment. The Bar Council of India, BCI, was established under a legislation enacted by the Parliament, namely, the Advocates Act, 1961. Hence, it is a statutory, and not a constitutional, body. In 1951, the Government of India appointed an All India Bar Committee under the chairmanship of Justice S.R. Das of the Supreme Court. The mandate of the committee was to examine and report on the issue of reorganization of the bar and legal profession in the country. The committee submitted its report in 1953. It recommended, inter alia, the establishment of an All India Bar Council and State Bar Councils, SBCs, to regulate legal profession at the national and state level. Later, in 1958, the Law Commission of India once again repeated and endorsed the above recommendation of the Das Committee. Consequently, the Advocates Act, 1961 was passed by the Parliament to provide for, inter alia, the creation of the BCI and SBCs. The BCI is an autonomous body. It works under the Department of Legal Affairs of the Union Ministry of Law and Justice. 14th Report on the subject of reform of judicial administration. The Union Ministry of Law and Justice comprises of 3 departments, namely, the Department of Legal Affairs, the Department of Justice, and the Legislative Department. T. Composition. The BCI consists of the elected members as well as the ex officio members. They are as follows. 1. One member elected by each SBC from amongst its members. 2. The Attorney General of India and the Solicitor General of India are the ex officio members. The BCI shall have a chairman and a vice-chairman. They are elected by the council from amongst its members. They hold office for a period of 2 years. The term of office of a member of the BCI, elected by a SBC, shall be for the period for which he holds office as a member of that SBC. The BCI consists of the following committees. I. Disciplinary Committee, 1 or more. 2. Legal Aid Committee, 1 or more. 3. Executive Committee. 4. Legal Education Committee. V. Other committees, if necessary. T. Functions. The functions of the BCI are as follows. 1. TB lay down standards of professional conduct and etiquette for advocates. 2. LB lay down the procedure to be followed by its disciplinary committee and the disciplinary committee of each SBC. 3. TB safeguard the rights, privileges, and interests of advocates. Bar Council of India 521. 4. LB promote and support law reform. 5. 1B deal with and dispose of any matter which is referred to it by SBC. 6. 1B exercise general supervision and control over SBC. 7. LB promote legal education and to lay down standards of legal education in consultation with the universities in India imparting legal education and the SBCs. 8. 1B recognize universities whose degree in law shall be a qualification for enrollment as an advocate and for that purpose to visit and inspect universities. The BCI can also cause the SBCs to visit and inspect universities in accordance with the directions issued by it. 9. LB conduct seminars and organize talks on legal topics by eminent jurists and publish journals and papers of legal interest. 10. 1B organize legal aid to the poor people. 11. LB recognize on a reciprocal basis foreign qualifications and law obtained outside India for the purpose of admission as an advocate under this Act. 12. 1B manage and invest its funds. 13. 1B provide for the election of its members. 14. LB perform all other functions conferred on it under this Act. 15. LB do all other things necessary for discharging the above functions. The BCI may establish funds for the following purposes. A. Giving financial assistance to organize welfare schemes for indigent, disabled, or other advocates. B. Giving legal aid or advice. C. Establishing law libraries. Further, the BCI may also receive grants, donations, gifts, and benefactions for the above purposes. The BCI can become a member of international legal bodies, such as the International Bar Association or the International Legal Aid Association. T. State Bar Councils _111 Establishment. The Advocates Act, 1961 provides for the establishment of a SBC for each state or a common SBC for 2 or more states or for a state and a union territory. At present, there are 24 SBCs. The name and the jurisdiction of all the 24 SBCs are mentioned in THB 69.1. Composition. Any state bar council consists of the elected members as well as the ex officio members. This is explained below. 1. In the case of a SBC with an electorate of 5,015 members. In the case of a SBC with an electorate of 5 to 10,020 members. And in the case of SBC with an electorate of more than 10,025 members. They are elected in accordance with the system of proportional representation by means of the single transferable vote from amongst advocates on the electoral roll of the SBC. But 1/2 of such elected members shall be persons who have for 10 years been advocates on a state roll. 2. In case of any SBC, the Advocate General of the state is the ex officio member. Similarly, in case of a common SBC, the Advocate General of each of the states is the ex officio member. Further, in case of the SBC of Delhi, the Additional Solicitor General of India is the ex officio member. Each SBC shall have a chairman and a vice-chairman. They are elected by the council amongst its members. The term of office of an elected member of any SBC is 5 years. But if any SBC fails to provide for the election of its members before the expiry of said term, then the BCI may extend the said term for a period of 6 months. 2. 522 Indian Polity. A state bar council consists of the following committees. I. Disciplinary Committee, 1 or more. 2. Legal Aid Committee, 1 or more. 3. Executive Committee, 4. Enrollment Committee, v. Other committees, if necessary. EB functions. The functions of a state bar council are as follows. 1. IB admit persons as advocates on its roll. 2. LB prepare and maintain such roll. 3. LB entertain and determine cases of misconduct against advocates on its roll. 4. TB safeguard the rights, privileges, and interests of advocates on its roll. 5. To promote the growth of bar associations for the purposes of effective implementation of the welfare schemes for the indigent, disabled, or other advocates. 6. 7B promote and support law reform. 7. TB conduct seminars and organize talks on legal topics by eminent jurists and publish journals and papers of legal interest. 8. TB organize legal aid to the poor. 9. TB manage and invest its funds. 10. TB provide for the election of its members. 11. TB visit and inspect universities in accordance with the directions issued by the BCI. 12. TB perform all other functions conferred on it under this Act. 13. TB do all other things necessary for discharging the above functions. A. SBC may establish funds for the following purposes. A. Giving financial assistance to organize welfare schemes for the indigent, disabled, or other advocates. B. Giving legal aid or advice. C. Establishing law libraries. Further, a SBC may also receive grants, donations, gifts, and benefactions for the above purposes. F. Types of advocates. 23. 2A. Indian Judiciary. Annual Report 2021-22, The Supreme Court of India, pp. 107-109. The Advocates Act, 1961 provides for 2 categories of advocates, viz. Senior advocates and other advocates, who are entitled to practice law before the courts. The exercise of powers vested in the Supreme Court and the High Courts to designate an advocate as a senior advocate is circumscribed by the requirement of due satisfaction that the advocate concerned fulfills the qualifications prescribed under the Advocates Act, 1961. In terms of the Advocates Act, 1961, an advocate may, with his or consent, be designated as senior advocate if the Supreme Court or a High Court is of opinion that by virtue of his or ability, standing at the bar, or special knowledge or experience in law, Husha is deserving of such distinction. There are 3 categories of advocates who are entitled to practice law before the Supreme Court. These are explained as follows. N. Senior advocate. A senior advocate means any advocate so designated under the Advocates Act, 1961, and all such advocates whose names were borne on the roll of the senior advocates of the court immediately before the commencement of the Advocates Act, 1961. The Supreme Court Rules, 2013, deals with designation of advocates as senior advocates. These rules provide that the Chief Justice of India and the judges may, with the consent of the advocate, designate an advocate as senior advocate, if in their opinion, by virtue of his or ability, standing at the bar, or special knowledge or experience in law, the said advocate is deserving of such distinction. Apart from the designation of advocates as senior advocates, retired Chief Justices judges of the High Courts are also considered for designation as senior advocates in the Supreme Court. A senior advocate is Bar Council of India, not entitled to appear in the Supreme Court without an advocate on record. A permanent committee has been constituted by the Chief Justice of India to deal with all matters relating to designation of senior advocates in the Supreme Court. The composition of the committee is as under. A. Chief Justice of India Chairperson. B. 2 senior-most judges of the Supreme Court members. C. Attorney General for India member. And D. A member of the bar is nominated by the chairperson and members of this committee. Al advocate on record. An advocate on record means an advocate who is entitled under the Supreme Court Rules, 2013 to act, as well as to plead for a party in the Supreme Court. No advocate other than an advocate on record is entitled to file an appearance or act for a party in the Supreme Court. The Supreme Court at the time of its inception in 1950 inherited the jurisdiction of the Federal Court and the Privy Council. The rules prevalent in the Federal Court were continued in the beginning. The practice and procedure of the Supreme Court has undergone enormous changes ever since. Originally, the rules of the Supreme Court, as then adopted, recognized the system of agents. The practice and procedure was substantially modified in the year 1954, and advocates on record replaced the system of agents. When introduced in 1954, apart from the then registered agents, an advocate of 7 years standing was entitled to get himself/herself registered as an advocate on record, provided Husha fulfilled the conditions prescribed. In 1959, the rules were amended, introducing the advocate on record examination conducted by the Supreme Court. The Registry of the Supreme Court conducts advocation record examination periodically with approval of the Examination Committee and under the supervision of Secretary, Board of Examiners, appointed by the Chief Justice of India. The examination maintains high standards to ensure that best of the talent come in as advocate on record. A regulation pertaining to the examination states that no advocate shall be eligible to appear in the examination unless Husha has received training from an advocate on record of not less than 10 years standing for a continuous period of 1 year commencing from the end of the 4th year of date of his enrollment. Q. Other advocates. These are advocates whose names are entered on the roll of any state bar council maintained under the Advocates Act, 1961. They cannot appear, plead, and address the court in any matter on behalf of a party in the Supreme Court unless instructed by an advocate on record or permitted by the court. Continued. Table 69.1 Name and jurisdiction of state bar councils. SI. No. Name states and UTs covered. 1. Bar Council of Andhra Pradesh, Andhra Pradesh. 2. Bar Council of Bihar, Bihar, WWW. 3. Bar Council of Gujarat, Gujarat. 4. Bar Council of Jharkhand, Jharkhand. 5. Bar Council of Madhya Pradesh, Madhya Pradesh. Bar Council of Chhattisgarh, Chhattisgarh. I. Added by the Jammu and Kashmir Reorganization Act, 2019. A 524 Indian Polity. SI. No. Name states and UTs covered. 7. Bar Council of Karnataka, Karnataka. 8. Bar Council of Orissa, Odisha. 9. Bar Council of Rajasthan, Rajasthan. 10. Bar Council of Telangana, Telangana. 11. Bar Council of Uttar Pradesh, Uttar Pradesh. 12. Bar Council of Uttarakhand, Uttarakhand. 13. Bar Council of Meghalaya, Meghalaya. 14. Bar Council of Manipur, Manipur. 15. Bar Council of Tripura, Tripura. 16. Bar Council of Arunachal Pradesh, Assam, Mizoram, Arunachal Pradesh, Assam, Mizoram, and in Nagaland, Nagaland. 17. Bar Council of Kerala, Kerala, and Lakshadweep. 18. Bar Council of Madras, Tamil Nadu, and Puducherry. 19. Bar Council of Maharashtra and Goa, Maharashtra, Goa, and Dadra and Nagar Haveli, and Daman and Diu. 20. Bar Council of Punjab and Haryana, Punjab, Haryana, and Chandigarh. 21. Bar Council of Himachal Pradesh, Himachal Pradesh. 22. Bar Council of West Bengal, West Bengal, and Andaman and Nicobar Islands. UMRVVX, asterisk, ML. M. RT15RR. I asterisk R. E. 23. Bar Council of Delhi, Delhi. 24. Bar Council of Jammu and Kashmir and Ladakh, Jammu and Kashmir, and Ladakh. Chapter 170 Law Commission of India. TE Law Commission of India is a non-statutory advisory body. It is established by the order of the central government one from time to time for a fixed tenure. Its function is to recommend legislative measures for the purpose of consolidation and codification of laws. However, its recommendations are not binding on the government. F. Historical background. During the British regime, law commissions were established in the 19th century. They made a significant contribution towards the enrichment of the Indian statute book. They recommended a variety of legislations on the pattern of the then prevailing English laws adopted to Indian conditions. The Indian Penal Code, the Criminal Procedure Code, the Civil Procedure Code, the Indian Contract Act, the Indian Evidence Act, the Transfer of Property Act, and some other laws are the products of these 4 commissions. The names of these commissions, the years in which they were constituted, and the names of their chairmen are mentioned in FLE 70.1. Commissions constituted so far. After independence, the Constitution of India with separate chapters on fundamental rights and directive principles of state policy gave a new direction to law reform in the country. Article 372 of the Constitution provides that the pre-Constitution laws shall remain in force until they are amended or repealed. However, there had been demands in Parliament and outside for the establishment of a new law commission to recommend the revision and updation of the outmoded and outdated laws to serve the changing needs of the nation. The government reacted favorably to this demand and established the first Law Commission of Independent India in 1955. The term of this commission was 3 years and it was headed by M.C. Setlavad, the then Attorney General of India. Table 70.1 Pre-Independence Law Commissions. Name Establishment Year Chairman First Law Commission 1834 Lord Macaulay, Second Law Commission 1853 Sir John Romilly, Third Law Commission 1861 Sir John Romilly F. Fourth Law Commission 1879 Dr. Whitney Stokes. The order is issued by the Department of Legal Affairs, Ministry of Law and Justice. Indian Polity. Composition. The composition of the commission is not fixed. It varies from one commission to another. Generally, it consists of a chairman, some full-time members, a member secretary, and some part-time members depending. Since then, 1955, 21 more law commissions have been constituted, each with a 3-year term and with different terms of reference. The name of these commissions, their duration, and the name of their chairman are given in Table 70.2. Table 70.2 Law Commissions appointed so far. Law Commission Duration Chairman. First 1955-1958 Mobile C. Setlavad, former Attorney General of India. Second 1958 to 1961 Justice T. V. Venkatrama Iyer. Third 1961 to 1964 Justice J. L. Kapoor. 4th 1964 to 1968 Justice J. L. Kapoor. 5th 1968 to 1971 KVK Sundaram, ICS. 6th 1971 to 1974 Justice P. B. Gajendra Dukkar. 7th 1974 to 1977 Justice P. B. Gajendra Dukkar. 8th 1977 to 1979 Justice H. R. Khanna. 9th 1979 to 1980 Justice P. V. Dixit. 10th 1981 to 1985 Justice K. K. Matthew. 11th 1985 to 1988 Justice D. A. Desai. 12th 1988 to 1991 Justice M. P. Thakur. 13th 1991 to 1994 Justice K. N. Singh. 14th 1995 to 1997 Justice K. Jayachandra Reddy. 15th 1997 to 2000 Justice B. P. Jeevan Reddy. 16th 2000 to 2003 Justice B. P. Jeevan Reddy. 2000 to 2001 Justice M. Jagannatha Rao. 2002 to 2003. 17th 2003 to 2006 Justice M. Jagannatha Rao. 18th 2006 to 2009 Justice A. R. Laxmikanth. 19th 2009 to 2012 Justice P. Venkatrama Reddy. 20th 2012 to 2015 Justice D. K. Jain. 2012 to 2013 Justice A. P. Shah. 2013 to 2015. 21st 2015 to 2018 Justice B. S. Chauhan. 22nd 2020-2024 Justice Rita Raj Awasthi. 23. 2. The 22nd Law Commission of India was constituted on February 21, 2020 for a term of 3 years. Its term ended on February 20, 2023. The Union Cabinet on February 22, 2023 approved the extension of the term of the Commission up to August 31, 2024. Though the 22nd Law Commission of India was constituted in February 2020, its chairman and members were appointed after 2.5 years in November 2022. Law Commission of India 527. Upon the nature of topics referred to it for consideration. The chairman and full-time members are either serving or retired judges of the Supreme Court or High Courts, or legal experts, jurists or professors of law in any university of India. The member secretary belongs to the Indian Legal Service and holds the rank of either additional secretary or secretary to the Government of India. The part-time members are appointed from among the eminent members of the bar or eminent scholars in the academic field or persons having specialized knowledge in a particular branch of law. The Commission's regular staff consists of about a dozen research personnel of different ranks and varied experiences. A small group of secretarial staff looks after the administration side of the Commission's operations. T. Functions. The functions of the Commission are as follows. 1. TB identify laws which are no longer needed or relevant and can be immediately repealed. 2. LB examine the existing laws in the light of directive principles of state policy and suggest ways of improvement and reform, and also suggest such legislations as might be necessary to implement the directive principles and to attain the objectives set out in the preamble of the Constitution. 3. LB consider and convey to the government its views on any subject relating to law and judicial administration that may be specifically referred to it by the government. 4. TB consider the requests for providing research to any foreign countries as may be referred to it by the government. 5. TB take all such measures as may be necessary to harness law and the legal process in the service of the poor. 6. TB revise the central acts of general importance so as to simplify them and remove anomalies, ambiguities, and inequities. T. Working. The working of the Commission consists of the following stages. 1. The projects undertaken by the Commission are initiated in its meetings. 2. Priorities are discussed, topics are identified, and preparatory work is assigned to the members. 3. Different methodologies for collection of data and research are adopted, keeping in view the scope of the proposed reform. 4. A working paper, outlining the problem and suggesting matters deserving reform, emerges as the outcome. 5. This paper is sent out for circulation in the public and concerned interest groups with a view to eliciting reactions and suggestions. 6. Responses are evaluated and the information is organized for proper incorporation in the report. 7. The report is subjected to close scrutiny by the full Commission in prolonged meetings for its finalization. 8. The final report is forwarded to the Government, Ministry of Law and Justice. The reports of the Commission are considered by the Ministry of Law and Justice in consultation with the concerned administrative ministries and are submitted to Parliament from time to time. Till now, the Commission submitted 277 reports on different subjects. The reports submitted by the 2SD Commission are mentioned in Table 70.3. Role. The following points highlight the role of the Commission. 1. The government gets the benefit of recommendations from a specialized body, 528 Indian Polity, on different aspects of law which are entrusted to the Commission for its study and recommendations, as per its terms of reference. 2. The Commission, on a reference made to it by the central government or Sumodu, undertakes research in law and reviews existing laws in India for making reforms therein and enacting new legislations. 3. The Commission undertakes studies and research for bringing reforms in the justice delivery systems for the elimination of delay in procedures, speedy disposal of cases, reduction in the cost of litigation, etc. 4. The various commissions have been able to make an important contribution towards the progressive development and codification of law of the country. Table 70.3 reports submitted by the 21st Law Commission of India, 2015 to 2018. Report no. Year of submission subject of the report _263 2016. The Protection of Children, Inter-Country Removal and Retention, Bill, 2016. 264-2017 The Criminal Law, Amendment, Bill. 2017, Provisions Dealing with Food. Adulteration. 265-2017 Prospects of Exempting Income Arising Out of Maintenance Money of Minor 266-2017 The Advocates Act, 1961, Regulation of Legal Profession, 267-2017 The Hate Speech 268-2017 Amendments to Criminal Procedure Code, 1973, Provisions Relating to Bail 269-2017 Transportation and Housekeeping of Egg-Laying Hens, Layers, and Broiler Chickens. 270-2017 Compulsory Registration of Marriages 271-2017 Human DNA Profiling, a draft bill for the use and regulation of DNA-based technology. 272-2017 Assessment of Statutory Framework of Tribunals in India 273-2017 Implementation of United Nations Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment through Legislation. 274-2018 Review of the Contempt of Courts Act, 1971, 275-2018 Legal Framework, BCCI Vis-a-Vis Right to Information Act, 2005-276, 2018 Legal Framework, Gambling and Sports Betting including in Cricket in India 277-2018 Wrongful Prosecution, Miscarriage of Justice Legal Remedies. This information is obtained from the official website of the Law Commission of India. Chap 71 Delimitation Commission of India. The word delimitation literally means the act or process of fixing limits or boundaries of territorial constituencies in a country or a province having a legislative body. The job of delimitation is assigned to a high-powered body. Such a body is known as Delimitation Commission or Boundary Commission 1. Sushil Chandra, Delimitation Report 2022, p. 7. For this observation was made by the Supreme Court in R.C. Pudiyal vs. Union of India case, 1993. T. Rationale of delimitation. Periodic delimitation and elections constitute the pillars of the Indian parliamentary democracy. The following points clearly bring out the importance of delimitation. 1. Free and fair elections are the hallmark of a truly democratic state. What makes a parliamentary democracy the preferred system of governance is that it allows people to choose their representatives by using the electoral process. Elections are integral to the parliamentary democracy and therefore delimitation of constituencies assumes great importance. Delimitation exercise conducted following the legal provisions and accepted norms secures to the people fair elections. Periodic drawing of electoral boundaries, which is what the delimitation process does, is therefore a legally mandated exercise in a representative system where single-member constituencies are used for electing political representatives too. Changing Face of Electoral India, Delimitation 2008, Delimitation Commission of India, p. 1. 2. Ranjana Prakash Desai, Delimitation Report 2022, p. I. 2. Delimitation is a complex matter and needs to be approached sensitively as this provides foundation to democratic exercise of public representations through elections in modern times. Theoretically, delimitation is a stepping stone for creation of a body polity to govern the affairs of public at large through territorial concept of elected representation. It is imperative that such exercises are taken on periodic intervals to reflect the changing ground realities. 3. The principle of one man, one vote envisages that there should be parity in the value of votes of electors. Such a parity, though ideal for a representative democracy, is difficult to achieve. There is some departure in every system following this democratic path. In the matter of delimitation of constituencies, it often happens that the population of the one constituency differs from that of the other constituency. As a result, although both the constituencies elect one member, the value of the vote of the elector in the constituency having lesser population is more than the value of the vote of the elector of the constituency having a larger population. 530 Indian Polity. Commissions established so far. The Delimitation Commission of India is a statutory, and not a constitutional, body. It is established by the central government under the provisions of a law enacted by the Parliament. Its function is to demarcate the boundaries of the parliamentary and assembly constituencies in the country. The Commission is a powerful body. Its orders have the force of law and cannot be challenged in any court. The orders come into force on a date specified by the President of India. They are laid before the Lok Sabha and the state legislative assembly concerned. but modifications are not permissible therein by them. So far, for such commissions have been constituted. The names of these commissions, the year in which they were established, and the name of the act under which they were established are mentioned in Table 71.1. 2. The total number of existing seats in the legislative assemblies of all states as fixed on the basis of 1971 census shall also remain unaltered till the first census to be taken after the year 2026. 6. 3. The number of seats to be reserved for the scheduled castes and scheduled tribes in the Lok Sabha and state legislative assemblies shall be reworked out on the basis of 2001 census. 4. Each state shall be redelimited into territorial parliamentary and assembly constituencies on the basis of 2001 census, and the extent of such constituencies as delimited now shall remain frozen till the first census to be taken after the year 2026. 5. The constituencies shall be so redelimited that population on the basis of 2001 census of each parliamentary and assembly constituency in a state shall, so far as practicable, be the same throughout the state. This information is adopted from the official website of the Election Commission of India. State here does not include the erstwhile state of Jammu and Kashmir, but includes the National Capital Territory of Delhi and the Union Territory of Puducherry. The Delimitation Act, 2002 was amended in 2003, 2008, and 2016. F. Constitutional Provisions. Articles 81, 82, 170, 330, and 332 of the Constitution of India deal with the delimitation of the parliamentary and assembly constituencies. These articles were amended by the 84th Constitutional Amendment Act of 2001 and the 87th Constitutional Amendment Act of 2003. The cumulative effect of these two amendments to the Constitution is as follows. 1. The total number of existing seats as allocated to various states in the Lok Sabha on the basis of 1971 census shall remain unaltered till the first census to be taken after the year 2026. 4th Delimitation Commission in pursuance of the above-mentioned provisions of the Constitution, the Parliament enacted the Delimitation Act, 2002, and provided for the establishment of a Delimitation Commission. The Commission's task under the Constitution and the Delimitation Act of 2002 was to readjust the parliamentary and assembly constituencies in all the states of Table 71.1. Delimitation Commissions constituted so far. Delimitation Commission established under the Act. First, 1952, the Delimitation Commission Act. 1952, second, 1963, the Delimitation Commission Act. 1962, third, 1973, the Delimitation Act. 1972. 4th, 2002, the Delimitation Act. 2002, Delimitation Commission of India. 531. India, except the erstwhile state of Jammu and Kashmir, on the basis of 2001 census. The 4th Delimitation Commission of 2002 was a 3-member body. It consisted of the following. 1. The chairperson, who was to be either a serving or a retired judge of the Supreme Court. 2. The Chief Election Commissioner or an election commissioner nominated by the Chief Election Commissioner was an ex officio member. 3. The State Election Commissioner of concerned state or union territory was the other ex officio member. Additionally, the Commission had 10 associate members in respect of each state. Out of them, 5 were members of the Lok Sabha elected from that state, and another 5 were members of the State Legislative Assembly. Where the number of members of the Lok Sabha in a state was less than 5, all such members were the associate members for that state. These associated members were nominated by the speakers of the Lok Sabha and state legislative assemblies concerned. However, these associated members did not have the right to vote or to sign any order of the Commission. Justice Kuldip Singh, a retired judge of the Supreme Court, was appointed as the chairperson of the Commission. Implementation of the recommendations. The 2009 general elections to the Lok Sabha for 499 out of 543 parliamentary constituencies in all the states, National Capital Territory of Delhi and Union Territory of Puducherry, except Assam, Arunachal Pradesh, Manipur, Nagaland, Jharkhand, and erstwhile Jammu and Kashmir, were held on the basis of the newly delimited constituencies. Delimitation Commission, 2020. In February 2020, the Government of India rescinded its earlier, 2008, notifications which had deferred the delimitation exercise in the 4 northeastern states of Assam, Arunachal Pradesh, Manipur, and Nagaland on the grounds of a likely threat to the unity and integrity of India as well as a serious threat to the peace and public order in these states. The government had said that there was a significant improvement in the security situation in these states. Further, there was also reduction in insurgency incidents and improvement in law and order of these states, making the situation conducive for carrying out the delimitation exercise. Therefore, it appeared that the circumstances that led to the deferring of the delimitation exercise in these states have ceased to exist, and that the delimitation of the constituencies as envisaged under the Delimitation Act, 2002 could be carried out now. Subsequently, in March 2009, the Government of India set up a Delimitation Commission for the purpose of delimitation of parliamentary and assembly constituencies in these 4 northeastern states in the Union Territory of Jammu and Kashmir, UT of J.RK. This commission consisted of the following members. The commission submitted its recommendations to the government in 2007. The President of India signed the notification for implementing the recommendations of the commission in 2008, thereby redefining parliamentary and assembly constituencies. High recommendations of the Commission are not applicable to 5 states, i.e. Assam, Arunachal Pradesh, Manipur, Nagaland, and Jharkhand. The Government of India deferred the delimitation exercise in the 4 northeastern states and nullified the final order of the Commission for the state of Jharkhand. Order dated February 28, 2020 issued by the Ministry of Law and Justice. Notification dated March 6, 2020 issued by the Ministry of Law and Justice. I. Justice Ranjana Prakash Desai, a retired judge of the Supreme Court, as the chairperson. 532 Indian Polity. 2. Sushil Chandra, Election Commissioner, as the ex officio member. 3. The State Election Commissioner of the concerned state or UT, as the other ex officio member. The appointment of Justice Ranjana Prakash Desai was for a period of 1 year or till further orders, whichever was earlier. The Commission was assigned the following task. I. To delimit the constituencies in the above 4 northeastern states in accordance with the provisions of the Delimitation Act, 2002. 2. LB. Delimit the constituencies in the UT of J&K in accordance with the provisions of the J&K Reorganization Act, 2019 and the Delimitation Act, 2002. However, in March 2021 the Government of India removed the above 4 northeastern states from the Commission's purview. Further, the term of the Commission was also extended by 1 year, i.e., till March 2022, to enable it to continue with its delimitation work in the UT of J&K. Again, in February 2022-11, the Commission was given another 2 months extension, i.e., till May 2022. Notification dated March 3, 2021 issued by the Ministry of Law and Justice. Notification dated February 21, 2022 issued by the Ministry of Law and Justice. L2. This information is adopted from the Delimitation Report 2022. The Commission also associated in its work 5 members of Lok Sabha elected from the UT of J&K. They were nominated by the Speaker of Lok Sabha, but they had no voting rights. The Commission completed its task in May 2022. The report of the Commission is entitled as Delimited Landscape of Union Territory of Jammu and Kashmir. T. Delimitation in J and K-12. Delimitation exercise conducted in J&K in the past has been different from the ones conducted in the rest of the country because of the region's special status, which was withdrawn by the J&K Reorganization Act, 2019. Until then, delimitation of Lok Sabha seats in J&K was governed by the Constitution of India. But the delimitation of state legislative assembly seats was governed by the Constitution of J&K and the J&K Representation of People Act, 1957. The assembly seats in J&K were delimited in 1957, 1966, 1975, and 1995. The last exercise was conducted on the basis of 1981 census. It formed the basis of the state elections in 1996. There was no census in the state in 1991, and no delimitation commission was set up by the state government after 2001 as the state assembly passed a law putting a freeze on fresh delimitation of seats until the relevant figures for the first census taken after the year 2026 have been published. The J&K assembly at that time had 111 seats, which included 4 seats in Ladakh. Also, 24 seats off these were kept reserved for Pakistan-occupied J&K. The J&K Reorganization Act, 2019 has provided for the creation of the UT of J&K. This act has provided for a legislative assembly for the UT of J&K, and the total number of seats in the assembly to be filled by direct elections has been fixed as 114. There is also a beneficent provision for nomination of 2 women members to the assembly by the lieutenant governor, if in his opinion women are not adequately represented. Further, this act has also provided that for the area of the UT of J&K under occupation of Pakistan, 24 seats in the assembly shall remain vacant, and the said area and seats shall be excluded in delimiting the territorial constituencies. Thus, there is an increase of 7 seats in the Legislative Assembly of the UT of J&K. The present Delimitation Commission was entrusted with the work of delimiting the parliamentary and assembly constituencies in the UT of J&K on the basis of 2011 census and in accordance with the provisions of the J&K Reorganization Act, 2019, and the provisions of the Delimitation Act, 2002. The 2011 census population had increased more than 100% over the 1981 census population of J&K. Since the last delimitation was based on 1981 census, the nature of constituencies had to a large extent become malapportioned. Having regard to the relevant provisions of the Constitution of India, Article 330 and Article 332, the provisions of the J&K Reorganization Act, 2019, and the provisions of the Delimitation Act, 2002, the number of seats to be reserved for the SCs and the STS in the Legislative Assembly of the UT of J&K has been worked out on the basis of 2011 census. It is worthwhile to mention here that the Constitution of the erstwhile state of J&K did not provide for reservation of seats for the STC in the Legislative Assembly. T. Order of the Commission. In May 2022-13, the Commission made the final order in respect of the delimitation of parliamentary and assembly constituencies in the UT of J&K. The various provisions of this order are as follows. 14. This information is adopted from the official website of the Election Commission of India. 15. Persons displaced from PJLK during 1947 to 48, 1965, and 1971. 1. The Commission has treated the J&K as a single entity for the purpose of delimitation. Consequently, all 5 parliamentary constituencies now have equal number of 18 assembly constituencies. 2. Anantnag, Rajouri parliamentary constituency has been carved out by combining Anantnag area of the Kashmir region and Rajouri and Pinch area of the Jammu region. 3. Out of the total 90 assembly constituencies in the J-K, 43 are for the Jammu region and 47 are for the Kashmir region. 4. Creation of 6 new assembly constituencies for the Jammu region and 1 new assembly constituency for the Kashmir region. 5. Reservation of 9 assembly constituencies for the SR. Out of these, 6 are in the Jammu region and 3 are in the Kashmir region. Notification dated May 5, 2022 issued by the Delimitation Commission. Delimitation Commission of India 533. 6. Reservation of 7 assembly constituencies for the SCs. 7. The Commission has also changed the names of some assembly constituencies. 1 assembly constituency is named as Sri Mata Vaishno Devi. Recommendations of the Commission 14. During the public hearing, the Commission received number of representations from the Kashmiri migrants and the displaced persons from Pakistan-occupied Jammu and Kashmir, PJ and K 15. The delegations of Kashmiri migrants represented before the Commission that they were persecuted and forced to live in exile as refugees in their own country for the last 3 decades. It was urged that in order to preserve their political rights, seats may be reserved for them in the J-RK Assembly and Parliament. The displaced persons from PJ and K also requested the Commission to reserve few seats for them in the J&K Assembly. Accordingly, the Commission made the following recommendations to the central government. 1. Kashmiri migrants. Provision of at least 2 members, one of them must be a female, from the community of Kashmiri migrants in the J&K Assembly. Such members may be given power at par with the power of nominated members of the Assembly of UT of Puducherry. 2. Displaced persons from PJ and K. The central government may consider giving the displaced persons from PJ and K some representation in the J&K Assembly. This may be done by way of nomination of representatives of the displaced persons from PJ and K. 534X Indian Polity. Table 71.2 National Commission Central Bodies and their Nodal Ministries. 1. Central Information Commission Ministry of Personnel 2. Finance Commission Ministry of Finance 3. Union Public Service Commission Ministry of Personnel 4. Interstate Council Ministry of Home Affairs 5. Staff Selection Commission Ministry of Personnel 6. National Commission for SC's Ministry of Social Justice and Empowerment 7. National Commission for ST's Ministry of Tribal Affairs 8. Central Vigilance Commission Ministry of Personnel S. Zonal Council's Ministry of Home Affairs 10. Central Bureau of Investigation Ministry of Personnel 11. National Investigation Agency Ministry of Home Affairs 12. Commissioner for Linguistic Minorities Ministry of Minority Affairs 13. National Commission for Protection of Child Rights Ministry of Women and Child Development 14. National Commission for Backward Classes Ministry of Social Justice and Empowerment 15. Chief Commissioner for Disabled Persons Ministry of Social Justice and Empowerment 16. Central Social Welfare Board Ministry of Women and Child Development 17. Northeastern Council Ministry of Development of the North Eastern Region 18. Central Administrative Tribunal Ministry of Personnel 19. National Commission for Minorities Ministry of Minority Affairs 20. National Human Rights Commission Ministry of Home Affairs 21. National Commission for Women Ministry of Women and Child Development 22. Good and Services Tax Council Ministry of Finance 23. Lokpal Ministry of Personnel 24. National Disaster Management Authority Ministry of Home Affairs 25. Attorney General of India Ministry of Law and Justice 26. Solicitor General of India Ministry of Law and Justice 27. Law Commission of India Ministry of Law and Justice 28. Election Commission of India Ministry of Law and Justice 29. Delimitation Commission of India Ministry of Law and Justice 30. National Consumer Disputes Redressal Commission Ministry of Consumer Affairs 31. Bar Council of India Ministry of Law and Justice 32. NITI Aayog Ministry of Planning 33. Comptroller and Auditor General of India Ministry of Finance Part X Other Constitutional Dimensions 72. Cooperative Societies 73. Official Language 74. Public Services 75. Rights and Liabilities of the Government 76. Special Provisions Relating to Certain Classes 77. Special Provisions for Some States. Chapter 72 Cooperative Societies. The 97th Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. In this context, it made the following 3 changes in the Constitution. 1. It made the right to form cooperative societies a fundamental right, Article 191. 2. It included a new directive principle of state policy on promotion of cooperative societies, Article 43, B2. 3. It added a new Part 9b in the Constitution which is entitled the Cooperative Societies, Articles 243 H to 243 T. In Part 3 of the Constitution, in Article 19, in Clause 1, in Subclause C, the words Cooperative Societies were inserted. 2 inches Part 4 of the Constitution, a new Article 43b was inserted, which says, the state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. 3. The board means the board of directors or the governing body of a cooperative society, by whatever name called, to which the direction and control of the management of the affairs of a society is entrusted to. 4. An office bearer means a president, vice president, chairperson, vice chairperson, secretary or treasurer of a cooperative society, and includes any other person to be elected by the board of any cooperative society. T. Constitutional provisions. Part AXB of the Constitution contains the following provisions with respect to the cooperative societies. Incorporation of cooperative societies. The state legislature may make provisions for the incorporation, regulation, and winding up of cooperative societies based on the principles of voluntary formation, democratic member control, member economic participation, and autonomous functioning. Number and term of members of board and its office bearers. The board shall consist of such number of directors as may be provided by the state legislature. 3. But the maximum number of directors of a cooperative society shall not exceed 21. The state legislature shall provide for the reservation of 1 seat for the scheduled castes or the scheduled tribes and 2 seats for women on the board of every cooperative society having members from such a category of persons. The term of office of elected members of the board and its office bearers shall be 5 years from the date of election. 4. 536, in caret, and p degree W. The Shite legislature shall make provisions for co-option of persons having experience in the field of banking, management, finance, or specialization in any other related field, as members of the board. But the number of such co-opted members shall not exceed 2, in addition to 21 directors. Further, the co-opted members shall not have the right to vote in any election of the cooperative society or be eligible to be elected as office bearers of the board. The functional directors of a cooperative society shall also be the members of the board, and such members shall be excluded for the purpose of counting the total number of directors, that is, 21. Election of members of board. The election of a board shall be conducted before the expiry of the term of the board so as to ensure that the newly elected members assume office immediately on the expiry of the term of the office of members of the outgoing board. The superintendence, direction, and control of the preparation of electoral rolls and the conduct of elections to a cooperative society shall vest in such body, as may be provided by the state legislature. Supersession and suspension of board and interim management. No board shall be superseded or kept under suspension for a period exceeding 6 months. 3. The board may be superseded or kept under suspension in case I. Of its persistent default. 2. Of negligence in the performance of its duties. 3. Of committing any act prejudicial to the interests of the cooperative society or its members. 4. Of there being a stalemate in the constitution or functions of the board. V. Of the election body having failed to conduct elections in accordance with the provisions of the State Act. However, the board of any such cooperative society shall not be superseded or kept under suspension where there is no government shareholding or loan or financial assistance or any guarantee by the government. In case of supersession of a board, the administrator appointed to manage the affairs of such a cooperative society shall arrange for conduct of elections within the period of 6 months and hand over the management to the elected board. Audit of accounts of cooperative societies. The state legislature may make provisions for the maintenance of accounts by the cooperative societies and the auditing of such accounts at least once in each financial year. It shall lay down the minimum qualifications and experience of auditors and auditing firms that shall be eligible for auditing the accounts of the cooperative societies. Every cooperative society shall be audited by an auditor or auditing firm, appointed by the general body of the cooperative society. But such an auditor or auditing firm shall be appointed from a panel approved by the state government or a body authorized by the state government on this behalf. The accounts of every cooperative society shall be audited within 6 months of the close of the financial year. The audit report of the accounts of an apex cooperative society shall be laid before the state legislature. Convening of general body meetings. The state legislature may provide that the annual general body meeting of every cooperative society shall be convened within a period of 6 months of the close of the financial year. Right of a member to get information. The state legislature may provide for access to every member of a cooperative society to the books, information, and accounts of the cooperative society. It may also make provisions to ensure the participation of members in the management of the cooperative society. Further, it may provide for cooperative education and training for its members. 5L in case of cooperative banks, other than multi-state cooperative banks, this period cannot exceed 1 year. Cooperative Societies 537. Returns. Every cooperative society shall file returns within 6 months of the close of every financial year to the authority designated by the state government. These returns shall include the following matters: A. Annual report of its activities. B. Its audited statement of accounts. C. Plan for surplus disposal as approved by the general body of the Cooperative Society. D. List of amendments to the bylaws of the Cooperative Society. E. Declaration regarding date of holding of its general body meeting and conduct of elections when due. F. Any other information required by the Registrar in pursuance of any of the provisions of the State Act. 6. The Registrar means the central registrar appointed by the central government in relation to the multi-state cooperative societies, and the registrar for cooperative societies appointed by the state government under the law made by the legislature of a state in relation to cooperative societies. Offenses and penalties. The state legislature may make provisions for the offenses relating to the cooperative societies and penalties for such offenses. Such a law shall include the commission or omission of the following acts as offenses. A. A cooperative society willfully makes a false return or furnishes false information. B. Any person willfully disobeys any summon, requisition, or order issued under the State Act. C. Any employer who, without sufficient cause, fails to pay to a cooperative society the amount deducted from its employee within a period of 14 days. D. Any officer who willfully fails to hand over custody of books, accounts, documents, records, cash, security, and other property belonging to a cooperative society to an authorized person. E. Any person who adopts corrupt practices before, during, or after the election of members of the board or office bearers. Application to multi-state cooperative societies. The provisions of this part shall apply to the multi-state cooperative societies subject to the modification that any reference to the state legislature, state act, or state government shall be construed as a reference to Parliament, Central Act, or central government, respectively. Application to union territories. The provisions of this part shall apply to the union territories. But the President may direct that the provisions of this part shall not apply to any union territory or part thereof as HUSHA may specify in the notification. Continuance of existing laws. Any provision of any law relating to cooperative societies in force in a state immediately before the commencement of the Constitution, 97th Amendment, Act, 2011, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed or until the expiration of 1 year from such commencement, whichever is less. 7. Reasons for 97th Amendment. While introducing this amendment bill in the Parliament, the Government of India gave the following reasons for making this amendment to the Constitution of India. The cooperative sector, over the years, has made significant contribution to various sectors of national economy and has achieved voluminous growth. However, it has shown weaknesses in safeguarding the interests of the members and fulfillment of objects for which these institutions were organized. There have been instances where elections have been postponed indefinitely and nominated office bearers. February 15, 2012, is the date of commencement of the Constitution, 97th Amendment, Act, 2011. The Center has asked state governments to amend their respective State Cooperative Society Act in tune with the Constitution, 97th Amendment, Act, 2011 before February 14, 2013. 538 Indian Polity. Or administrators have remained in charge of these institutions for a long time. This reduces the accountability in the management of cooperative societies to their members. Inadequate professionalism and management in many of the cooperative institutions has led to poor services and low productivity. Cooperatives need to run on well-established democratic principles and elections held on time and in a free and fair manner. Therefore, there was a need to initiate fundamental reforms to revitalize these institutions in order to ensure their contribution to the economic development of the country and serve the interests of members and public at large, and also to ensure their autonomy, democratic functioning, and professional management. 2. The cooperative societies is a subject enumerated in Entry 32 of the State List of the 7th Schedule of the Constitution, and the state legislatures have accordingly enacted legislations on cooperative societies. Within the framework of state acts, growth of cooperatives on large scale was envisaged as part of the efforts for securing social and economic justice and equitable distribution of the fruits of development. It has, however, been experienced that in spite of considerable expansion of cooperatives, their performance in qualitative terms has not been up to the desired level. Considering the need for reforms in the Cooperative Societies Acts of the states, consultations with the state governments have been held at several occasions and in the conferences of state cooperative ministers. A strong need has been felt for amending the Constitution so as to keep the cooperatives free from unnecessary outside interferences and also to ensure their autonomous organizational setup and their democratic functioning. 3. The central government was committed to ensure that the cooperative societies. 8. Rajendra N. Shah vs. Union of India 2013. 9. Union of India vs. Rajendra N. Shah 2021. In the country function in a democratic, professional, autonomous, and economically sound manner. With a view to bring the necessary reforms, it was proposed to incorporate a new part in the Constitution so as to provide for certain provisions covering the vital aspects of working of cooperative societies like democratic, autonomous, and professional functioning. It was expected that these provisions will not only ensure the autonomous and democratic functioning of cooperatives, but also ensure the accountability of management to the members and other stakeholders and shall provide for deterrence for violation of the provisions of the law. Constitutional validity of 97th Amendment in Rajendra Shah Case 8, 2013, the Gujarat High Court declared that the 97th Constitutional Amendment Act, 2011, inserting Part 9b is ultra vires the Constitution of India for want of the requisite ratification by the states under Article 368. Further, the court also held that this judgment will not impact amendment made in Article 19, L.C., fundamental right to form the cooperative societies, in the insertion of Article 43b, directive principle on promotion of cooperative societies, in the Constitution of India. On an appeal made by the Union of India against the above judgment, the Supreme Court, in 20219, upheld the judgment of the Gujarat High Court except to the extent that it strikes down the entirety of Part 9b of the Constitution of India. Further, the Supreme Court also declared that Part 9b of the Constitution of India is operative only insofar as it concerns multi-state cooperative societies both within the various states and in the Union territories. Cooperative Societies 539. Article No. Subject Matter. 243 ZT Continuance of existing laws. Table 72.1 Articles related to cooperative societies at a glance. 243 ZH Definitions. 243 ZI Incorporation of cooperative societies. 243 ZJ Number and term of members of board and its office bearers. 243 Zambian Kwacha Election of members of board. 243 ZLR. Supersession and suspension of board and interim management. 243 ZM Audit of accounts of cooperative societies. 243 ZN Convening of general body meetings. 243 ZO Right of a member to get information. 243 ZP Returns. 243 ZQ Offenses and penalties. 243 ZRR, R-P Application to multi-state cooperative societies. 243 ZS Application to union territories. I Chapter Official Language. P. Art 17 of the Constitution deals with the official language in Articles 343 to 351. Its provisions are divided into four heads: language of the Union, regional languages, language of the Judiciary, and text of laws and special directives. F. Language of the Union. The Constitution contains the following provisions in respect of the official language of the Union. 1. Hindi written in Devanagari script is to be the official language of the Union. But the form of numerals to be used for the official purposes of the Union has to be the international form of Indian numerals and not the Devanagari form of numerals. 2. However, for a period of 15 years from the commencement of the Constitution, i.e., from 1950 to 1965, the English language would continue to be used for all the official purposes of the Union for which it was being used before 1950. 3. Even after 15 years, the Parliament may provide for the continued use of English language for the specified purposes. 4. At the end of 5 years, and again at the end of 10 years, from the commencement of the Constitution, the President should appoint a commission to make recommendations with regard to the progressive use of the Hindi language, restrictions on the use of the English language, and other related issues. 5. A committee of Parliament is to be constituted to examine the recommendations of the Commission and to report its views on them to the President. Accordingly, in 1955, the President appointed an official language commission under the chairmanship of B.G. Kerr. The commission submitted its report to the President in 1956. The report was examined by a committee of Parliament constituted in 1957 under the chairmanship of Gobind Ballabh Pant. However, another official language commission, as envisaged by the Constitution, was not appointed in 1960. Subsequently, the Parliament enacted the Official Languages Act in 1963. The Act provides for the continued use of English, even after 1965, in addition to Hindi, for all official purposes of the Union and also for the transaction of business in Parliament. Notably, this Act enables the use of English indefinitely, without any time limit. Further, this Act was amended in 1967 to make the use of. The Commission was to consist of a chairman and other members representing the different languages specified in the 8th Schedule of the Constitution. 2. The committee was to consist of 30 members, 20 from Lok Sabha and 10 from Rajya Sabha. Official language 541. English, in addition to Hindi, compulsory in certain cases. 3. F. Regional languages. The Constitution does not specify the official language of different states. In this regard, it makes the following provisions. 1. The legislature of a state may adopt any one or more of the languages in use in the state or Hindi as the official language of that state. Until that is done, English is to continue as official language of that state. Under this provision, most of the states have adopted the major regional language as their official language. Notably, the choice of the state is not limited to the languages enumerated in the 8th Schedule of the Constitution. 2. For the time being, the official language of the Union, i.e., English, would remain the link language for communications between the Union and the states or between various states. But 2 or more states are free to agree to use Hindi instead of English for communication between themselves. The Official Languages Act, 1963, lays down that English should be used for purposes of communication between the Union and the non-Hindi states, that is, the states that have not adopted Hindi as their official language. Further, where Hindi is used for communication between a Hindi and a non-Hindi state, such communication in Hindi should be accompanied by an English translation. 3. These include A. Resolutions, general orders, rules, notifications, administrative or other reports or press communications issued by the central government. B. Administrative and other reports and official papers laid before Parliament. And C. Contracts and agreements executed, licenses, permits, notices, etc., issued by the central government or by a corporation or a company owned by the central government. 3. When the President, on a demand being made, is satisfied that a substantial proportion of the population of a state desire the use of any language spoken by them to be recognized by that state, then he may direct that such language shall also be officially recognized in that state. This provision aims at protecting the linguistic interests of minorities in the states. Language of the judiciary and texts of laws. The constitutional provisions dealing with the language of the courts and legislation are as follows. 1. Until Parliament provides otherwise, the following are to be in the English language only. A. All proceedings in the Supreme Court and in every High Court. B. The authoritative texts of all bills, acts, ordinances, orders, rules, regulations, and bylaws at the central and state levels. 2. However, the governor of a state, with the previous consent of the President, can authorize the use of Hindi or any other official language of the state in the proceedings in the High Court of the state, but not with respect to the judgments, decrees, and orders passed by it. In other words, the judgments, decrees, and orders of the High Court must continue to be in English only, until Parliament otherwise provides. 3. Similarly, a state legislature can prescribe the use of any language, other than English, with respect to bills, acts, ordinances, orders, rules, regulations, or bylaws, but a translation of the same in the English language is to be published. The Official Languages Act of 1963 lays down that Hindi translation of acts, ordinances, orders, regulations, and bylaws published under the authority of the President are deemed to be authoritative texts. Further, every bill introduced in the Parliament is 542 Indian Polity, to be accompanied by a Hindi translation. Similarly, there is to be a Hindi translation of state acts or ordinances in certain cases. The Act also enables the governor of a state, with the previous consent of the President, to authorize the use of Hindi or any other official language of the state for judgments, decrees, and orders passed by the High Court of the state, but they should be accompanied by an English translation. However, the Parliament has not made any provision for the use of Hindi in the Supreme Court. Hence, the Supreme Court hears only those who petition or appeal in English. The Authorized Translations, Central Laws, Act of 1973 lays down that a translation in any regional language specified in the 8th Schedule to the Constitution, other than Hindi, of any central act, ordinance, order, rule, regulation, and bylaw published under the authority of the President in the Official Gazette is deemed to be the authoritative text thereof in such language. T. Special Directives. The Constitution contains certain special directives to protect the interests of linguistic minorities and to promote the development of Hindi language. There are protection of linguistic minorities in this regard. The Constitution makes the following provisions. 1. Every aggrieved person has the right to submit a representation for the redress of any grievance to any officer or authority of the Union or a state in any of the languages used in the Union or in the state, as the case may be. This means that a representation cannot be rejected on the ground that it is not in the official language. 2. Every state and local authority in the state should provide adequate facilities for instruction in the mother tongue at the primary stage of education for the children belonging to linguistic minority groups. The President can issue necessary directions for this purpose. 4. This provision was added by the 7th Amendment Act of 1956 on the recommendation of the States Reorganization Commission. 5. Ibid. B. The 96th Amendment Act of 2011 substituted idea for oriya. 3. The President should appoint a special officer for linguistic minorities to investigate all matters relating to the constitutional safeguards for linguistic minorities and to report to him or her. The President should place all such reports before the Parliament and send to the state government concerned. 5. Development of Hindi language. The Constitution imposes a duty upon the center to promote the spread and development of the Hindi language so that it may become the lingua franca of the composite culture of India. Further, the center is directed to secure the enrichment of Hindi by assimilating the forms, style, and expressions used in Hindustani and in other languages specified in the 8th Schedule, and by drawing its vocabulary, primarily on Sanskrit and secondarily on other languages. At present, the 8th Schedule of the Constitution specifies 22 languages, originally 14 languages. These are Assamese, Bengali, Bodo, Dogri, Dongri, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Mathili, Maithili, Malayalam, Manipuri, Marathi, Nepali, Adiya**, Punjabi, Sanskrit, Santhali, Sindhi, Tamil, Telugu, and Urdu. Sindhi was added by the 21st Amendment Act of 1967. Konkani, Manipuri, and Nepali were added by the 70th Amendment Act of 1992. And Bodo, Dongri, Maithili and Santhali were added by the 92nd Amendment Act of 2003. In terms of the constitutional provisions, there are two objectives behind the specification of the above regional languages in the 8th Schedule. A. The members of these languages are to be given representation in the Official Language Commission. An official language, M. 543. B. The forms, style, and expression of these languages are to be used for the enrichment of the Hindi language. T. Committee of Parliament, on Official Language 7. 7. This information is downloaded from the website of the Committee of Parliament on Official Language, Ministry of Home Affairs, Government of India. The Official Languages Act, 1963, provided for the setting up of a Committee of Parliament on Official Language to review the progress made in the use of Hindi for the official purpose of the Union. Under the Act, this committee was to be constituted after 10 years of the promulgation of the Act, i.e., January 26, 1965. Accordingly, this committee was set up in 1976. This committee comprises of 30 members of Parliament, 20 from Lok Sabha and 10 from Rajya Sabha. It shall be the duty of the committee to review the progress made in the use of Hindi for the official purposes of the Union and submit a report to the President making recommendations thereon. The President shall cause the report to be laid before each House of Parliament and send it to all the state governments. The President may, after consideration of the report and the views expressed by the state governments thereon, issue directions in accordance with the whole or any part of the report. The chairman of the committee is elected by the members of the committee. As a convention, the Union Home Minister has been elected as chairman of the committee from time to time. The progressive use of Hindi in the central government offices is being reviewed by the committee in the background of the provisions relating to official language as provided by the Constitution. The Official Languages Act, 1963 and the rules framed thereunder. The committee also takes note of the circulars, instructions, etc. issued by the government in this regard from time to time. The terms of reference of the committee being comprehensive, it has also been examining other relevant aspects like the medium of instructions in schools, colleges, and the universities, mode of recruitment to central government services, and medium of departmental examination, etc. The Secretariat of the committee is headed by the Secretary of the committee. For administrative purposes, this office is subordinate office of Department of Official Language, Ministry of Home Affairs. T. Classical language status. In 2004, the Government of India decided to create a new category of languages called as classical languages. So far, 6 languages are granted the classical language status. This is shown in IBL 73.1. Benefits. The following benefits shall be available to the languages declared or notified as classical languages. 8. 2 major international awards for scholars of eminence in classical Indian languages are awarded annually. 2. A Center of Excellence for Studies in Classical Languages is set up. 3. The University Grants Commission be requested to create, to start with at least in the central universities, a certain. His information is obtained from the official of the Ministry of Culture, Government of India. Table 73.1 Languages conferred with classical language status ISI. No. Languages Year of Declaration 1. Tamil 2004. 2. Sanskrit 2005. 3. Telugu 2008. 4. Kannada 2008. 5. Malayalam 2013. 6. Odia 2014. 544p Indian Polity. Number of professional chairs for classical languages for scholars of eminence in classical Indian languages. Criteria. The Government of India laid down the following criteria to determine the eligibility of languages to be considered for classification as a classical language. 9. IBIT. Website. High antiquity of its early text recorded history over a period of 1,500 to 2,000 years. 2. A body of ancient literature texts, which is considered a valuable heritage by generations of speakers. 3. The literary tradition be original and not borrowed from another speech community. 4. The classical language and literature being distinct from modern, there may also be a discontinuity between the classical language and its later forms or its offshoots. Table 73.2 Articles related to official language at a glance. Article No. Subject matter. Language of the Union. 343. Official language of the Union. 344. Commission and Committee of Parliament on Official Language. Regional languages. 345. Official language or languages of a state. 346. Official language for communication between one state and another or between a state and the Union. 347. Special provision relating to language spoken by a section of the population of a state. Language of the Supreme Court, High Courts, etc. 348. Language to be used in the Supreme Court and in the High Courts and for acts, bills, etc. 349. Special procedure for enactment of certain laws relating to language. Special directives. 350. Language to be used in representation for redress of grievances. 350A. Facilities for instruction in mother tongue at primary stage. 3508. Special Officer for Linguistic Minorities. 351. Directive for Development of the Hindi Language, Chapter 74 Public Services. T. Classification of services. The public services, civil services, or government services in India are classified into three categories: All India Services, Central Services, and State Services. Their meaning and composition are explained below. All India Services. All India Services are those services which are common to both central and state governments. The members of these services occupy top positions or key posts under both the center and the states and serve them by turns. At present, there are three All India Services. They are 1. Indian Administrative Service, IS, 2. Indian Police Service, IPS, 3. Indian Forest Service, IFOS. In 1947, the Indian Civil Service, ICS, was replaced by IAS, and the Indian Police, IP, was replaced by IPS and were recognized by the Constitution as All India Services. In 1966, the Indian Forest Service was established as the third All India Service 1. Article 312 of the Constitution authorizes the Parliament of India to create new All India Services based on a resolution passed by Rajya Sabha to that effect. Thus, a new All India Service can be created only by an. In 1963, a provision was made for the creation of three more All India Services. They were Indian Forest Service, Indian Medical and Health Service, and Indian Service of Engineers. However, out of these three, only the Indian Forest Service came into existence in 1966. Act of Parliament, and not by a resolution of Rajya Sabha. However, the Parliament cannot do so without the recommendation of Rajya Sabha. This power is given to the Rajya Sabha to protect the interests of states in the Indian federal system. Interestingly, the drafting committee of the Constituent Assembly did not provide a constitutional status to the All India Services. Accordingly, the draft constitution did not make any mention of the All India Services. However, the Constituent Assembly included provisions with respect to the All India Services, which were approved. These provisions, under Article 312, not only gave a constitutional status to the All India Services, but also provided for the creation of new All India Services. Sardar Vallabhbhai Patel was the chief protagonist of All India Services in the Constituent Assembly. Hence, he came to be regarded as the father of All India Services. The All India Services Act of 1951 authorized the central government to make rules in consultation with the state governments for the regulation of recruitment and service conditions of the members of All India Services. The members of these services are recruited and trained by the central government, but are assigned to different states for work. They are born on different state cadres. The center having no cadre of its own in this regard. They serve the central government on deputation, and after completing their fixed tenure, they go back to their respective states. The central government obtains the services of these officers on deputation under the well-known tenure system. It must be mentioned here that 546F Indian Polity. Irrespective of their division among different states, each of these All India Services form a single service with common rights and status and uniform scales of pay throughout the country. All the three All India Services are Class I, Group A, services. The All India Services have three categories. They are Super Time Scale, Senior Scale, Junior Scale. In the beginning, the officers are appointed in the junior scale. In the course of time, they are placed in the senior scale and the super time scale. The three All India Services are managed and controlled by three different ministries of the central government. They are IS by the Ministry of Personnel, Public Grievances and Pensions, IPS by the Ministry of Home Affairs, IFOS by the Ministry of Environment, Forest and Climate Change. It must be mentioned here that the All India Services are controlled jointly by the central and state governments. The ultimate control lies with the central government, while the immediate control vests with the state governments. Their salaries and pensions are met by the states. However, the disciplinary action, imposition of penalties, against these officers can only be taken by the central government. Presently, there are 26 state cadres in all for the All India Services. This includes 2 joint cadres, I, Assam Meghalaya, and 2, Arunachal Pradesh, Goa, Mizoram, and the Union Territories, AGMT. Central Services. The personnel of central services work under the exclusive jurisdiction of the central government. They man specialized, functional, and technical positions in various departments of the central government. Most of them are controlled and managed by their respective ministries' departments, while a few of them are controlled and managed by the Ministry of Personnel. Ministry of Personnel, also determines the general policies pertaining to all the central services. In fact, the Ministry of Personnel is the central personnel agency in the Government of India. Before independence, the central services were classified into Class 1, Class 2, subordinate, and inferior services. After independence, the nomenclature of subordinate and inferior services was replaced by Class 3 and Class 4 services on the recommendation of the First Pay Commission, 1946 to 1947. Again in 1974, the classification of central services into Class 1, Class 2, Class HI, and Class 4 was changed to Group A, Group B, Group C, and Group D, respectively. This was done on the recommendation of the Third Pay Commission, 1970 to 1973. Thus, as of now, the central services are classified into 4 categories. They are Central Services, Group A Central Services, Group B Central Services, Group C Central Services, Group D. The number of Group A Central Services has been increasing over the years. At present, there are 66 Group A Central Services. Some of them are listed below. 1. Indian Foreign Service 2. Indian P&T Accounts and Finance Service 3. Indian Postal Service 4. Indian Railway Accounts Service 5. Indian Railway Personnel Service 6. Indian Railway Traffic Service 7. Indian Audit and Accounts Service 8. Indian Information Service 9. Indian Defense Accounts Service 10. Indian Civil Accounts Service 11. Indian Revenue Service, Income THX 12. Indian Revenue Service, Customs and Indirect Seas 13. Indian Railway Service of Mechanical Engineers 14. Indian Railway Service of Electrical Engineers 15. Indian Railway Service of Engineers 16. Indian Telecommunication Service 17. Indian Trade Service Public Services 547. 18. Indian Defense Estate Service 19. Indian Supply Service 20. Indian Inspection Service 21. Central Health Service 22. Indian Railway Medical Service 23. Indian Ordnance Factories Health Service 24. Indian Economic Service 25. Indian Statistical Service 26. Indian Cost Accounts Service 27. Defense Quality Assurance Service 28. Indian Legal Service 29. Indian Corporate Law Service 30. Central Labor Service. Most of the above cadres of Group A Central Services have also corresponding Group B services. The Group C Central Services consist of clerical personnel while Group D consists of manual personnel. Thus Group A and Group B comprises of gazetted officers while Group C and Group D are non-gazetted class. It must also be mentioned here that the Indian Foreign Service, IFS, is the topmost central service in terms of prestige, status, pay, and emoluments. In fact, it, though a central service, competes with the All India services in position, status, and pay scales. It comes next to the S in ranking and its pay scale is higher than the IPS. It is managed by the Ministry of External Affairs. Its recruits serve the Indian missions and embassies abroad. State Services. The personnel of state services work under the exclusive jurisdiction of the state government. They hold different positions, general, functional, and technical, in the departments of the state government. However, they occupy lower positions in the administrative hierarchy of the state than those held by the members of the All India Services, IS, IPS, and IFOS. The number of services in a state differ from state to state. The services that are common to all the states are 1. Civil Service 2. Police Service 3. Forest Service 4. Agricultural Service 5. Medical Service 6. Veterinary Service 7. Fisheries Service 8. Judicial Service 9. Public Health Service 10. Educational Service 11. Cooperative Service 12. Registration Service 13. Sales Tax Service 14. Jail Service 15. Service of Engineers. Each of these services is named after the state, that is, name of the state is added as a prefix. Among all the state services, the civil service, also known as the administrative service, is the most prestigious. Like the central services, the state services are also classified into 4 categories: Class I, Group I or Group A, Class 2, Group 2 or Group B, Class 3, Group 3 or Group C, and Class 4, Group 4 or Group D. Further, the state services are also classified into gazetted class and non-gazetted class. Usually, Class 1, Group A, and Class 2, Group B, services are gazetted classes while Class I, Group C, and Class 4, Group D, services are non-gazetted classes. The names of the members of gazetted class are published in the Government Gazette for appointment, transfer, promotion, and retirement, while those of the non-gazetted are not published. Further, the members of the gazetted class enjoy some privileges which are denied to the members of non-gazetted class. Also, the members of the gazetted class are called officers, while those of non-gazetted are called employees. The All India Services Act of 1951 specifies that senior posts not exceeding 33 1/3% in the Indian Administrative Service, IS, Indian Police Service, IPS, and Indian Forest Service, IFOS, are required to be filled in by promotion of officers employed in the state services. Such promotions are made on the recommendation of selection committee constituted for this purpose in each state. Such a committee is presided over by the chairman or a member of UPSC. 548 Indian Polity. T. Constitutional Provisions. Articles 308 to 314 and Part 14 of the Constitution contain provisions with regard to all India services, central services, and state services. High Recruitment and Service Conditions Article 309 empowers the Parliament and the state legislatures to regulate the recruitment and the conditions of service of the persons appointed to public services and posts under the center and the states, respectively. Until such laws are made, the President or the Governor can make rules to regulate these matters. Recruitment includes any method provided for inducting a person in public service like appointment, selection, deputation, promotion, and appointment by transfer. The conditions of service of a public servant includes pay, allowances, periodical increments, leave, promotion, tenure or termination of service, transfer, deputation, various types of rights, disciplinary action, holidays, hours of work and retirement benefits like pension, provident fund, gratuity, and so on. Under this provision, the Parliament or the state legislature can impose reasonable restrictions on the fundamental rights of public servants in the interests of integrity, honesty, efficiency, discipline, impartiality, secrecy, neutrality, anonymity, devotion to duty, and so on. Such restrictions are mentioned in the conduct rules like central services, conduct, rules, railway services, conduct, rules, and so on. A tenure of office, doctrine of pleasure. According to Article 310, members of the defense services, the civil services of the center, and the All India services or persons holding military posts or civil posts 2 under. 2A civil post means an appointment or office or employment on the civil side of the administration as distinguished from the military side. The center hold office during the pleasure of the President. Similarly, members of the civil services of a state or persons holding civil posts under a state hold office during the pleasure of the Governor of the state. However, there is an exception to this general rule of dismissal at pleasure. The President or the Governor may, in order to secure the services of a person having special qualifications, provide for the payment of compensation to him/her in 2 cases. I. If the post is abolished before the expiration of the contractual period, or 2. If his/her is required to vacate that post for reasons not connected with misconduct on his/her part. Notably, such a contract can be made only with a new entrant, that is, a person who is not already a member of a defense service, a civil service of the center, an All India service, or a civil service of a state. L. Safeguards to civil servants. Article 311 places 2 restrictions on the above doctrine of pleasure. In other words, it provides 2 safeguards to civil servants against any arbitrary dismissal from their posts. A. A civil servant cannot be dismissed or removed by an authority subordinate to that by which his/her was appointed. 3. B. A civil servant cannot be dismissed or removed or reduced in rank except after an inquiry in which his/her has been informed of the charges against him/her and given a reasonable opportunity of being heard in respect of those charges. The above 2 safeguards are available only to the members of the civil services of the center, the All India services, the civil services of a state, or to persons holding civil posts under the center or a state, and not to. The difference between dismissal and removal is that the former disqualifies for future employment under the government while the latter does not disqualify for future employment under the government. Public services. The members of defense services or persons holding military posts. However, the second safeguard, holding inquiry, is not available in the following 3 cases. A. Where a civil servant is dismissed or removed or reduced in rank on the ground of conduct which has led to his/her conviction on a criminal charge. Or B. Where the authority empowered to dismiss or remove a civil servant or to reduce him/her in rank is satisfied that for some reason, to be recorded in writing, it is not reasonably practicable to hold such inquiry. Or C. Where the President or the Governor is satisfied that in the interest of the security of the state, it is not expedient to hold such inquiry. Originally, the opportunity of being heard was given to a civil servant at 2 stages, at the inquiry stage and at the punishment stage. But the 42nd Amendment Act of 1976 abolished the provision for second opportunity, that is, the right of a civil servant to make representation against the punishment proposed as a result of the findings of the inquiry. Hence, the present position is that where it is proposed, after inquiry, to impose upon a civil servant the punishment of dismissal, removal, or reduction in rank, it may be imposed on the basis of the evidence adduced at the inquiry without giving him/her any opportunity of making representation on the penalty proposed. The Supreme Court held that the expression, reasonable opportunity of being heard, envisaged to a civil servant, in the second safeguard mentioned above, includes A. An opportunity to deny his/her guilt and establish his/her innocence which he/she can only do if his/her is told what the charges leveled against him/her are and the allegations on which such charges are based. B. An opportunity to defend himself/herself by cross-examining the witnesses produced against him/her and by examining himself/herself or any other witnesses in support of his/her defense. And C. The disciplinary authority must supply a copy of the inquiry officer's report to the delinquent civil servant for observations and comments before the disciplinary authority considers the report. All India services. Article 312 makes the following provisions in respect of All India services. A. The Parliament can create new All India services, including an All India judicial service, if the Rajya Sabha passes a resolution declaring that it is necessary or expedient in the national interest to do so. Such a resolution in the Rajya Sabha should be supported by 2/3 of the members present and voting. This power of recommendation is given to the Rajya Sabha to protect the interests of states in the Indian federal system. 1. Parliament can regulate the recruitment and conditions of service of persons appointed to all India services. Accordingly, the Parliament has enacted the All India Services Act, 1951 for the purpose. C. The services known at the commencement of the Constitution, that is, January 26, 1950, as the Indian Administrative Service and the Indian Police Service are deemed to be services created by Parliament under this provision. D. The All India Judicial Service should not include any post inferior to that of a district judge. A law providing for the creation of this service is not to be deemed as an amendment of the Constitution for the purposes of Article 368. Though the 42nd Amendment Act of 1976 made the provision for the creation of All India Judicial Service, no such law has been made so far. Indian Polity. BL. Other provisions. Article 312A, inserted by the 28th Amendment Act of 1972, confers powers on the Parliament to vary or revoke the conditions of service of persons who were appointed to a civil service of the Crown in India before 1950. Article 313 deals with transitional provisions and says that, until otherwise provided, all the laws in force before 1950 and applicable to any public service would continue. Article 314, which made provision for protection of existing officers of certain services, was repealed by the 28th Amendment Act of 1972. Table 74.1 Articles related to public services at a glance. Article No. Subject Matter. 308. Interpretation. 309. Recruitment and conditions of service of persons serving the Union or State. 310. Tenure of office of persons serving the Union or State. 311. Dismissal, removal or reduction in rank of persons employed in civil capacities under the Union or State. 312. All India Services. 312A. Power of Parliament to vary or revoke conditions of service of officers of certain services. 313. Transitional Provisions. 314. Provision for protection of existing officers of certain services repealed. Chapter 75 Rights and Liabilities of the Government. Articles 294 to 300 in Part 12 of the Constitution deal with the property, contracts, rights, liabilities, obligations and suits of the Union and the states. In this regard, the Constitution makes the Union or the states as juristic, legal persons. Property of the Union and the states high succession all property and assets that were vested in the Dominion of India or a province or an Indian princely state, before the commencement of the present Constitution, became vested in the Union or the corresponding state. Similarly, all rights, liabilities and obligations of the government of the Dominion of India or a province or an Indian state would now be the rights, liabilities and obligations of the government of India or the corresponding state. His cheat, lapse and bona vacantia any property in India that would have accrued to the King of England or ruler of the Indian state princely, by cheat, death of a person inte state without any heir, lapse. Termination of rights through disuse or failure to follow appropriate procedures, or bona vacantia property found without any owner, for want of a rightful owner, would now vest in the state if the property is situated there, and in the Union. In any other case. In all these three cases, the property accrues to the government as there is no rightful owner, claimant. Sea wealth. All lands, minerals, and other things of value under the waters of the ocean within the territorial waters of India, the continental shelf of India, and the exclusive economic zone of India vest in the Union. Hence, a state near the ocean cannot claim jurisdiction over these things. India's territorial waters extend to a distance of 12 nautical miles from the appropriate baseline. Similarly, India's exclusive economic zone extends up to 200 nautical miles. 1. A compulsory acquisition by law. The Parliament as well as the state legislatures are empowered to make laws for the compulsory acquisition and requisitioning of private property by the governments. Further, the 44th Amendment Act, 1978, has also abolished the constitutional obligation to pay compensation in this regard except in two cases. A. When the government acquires the property of a minority educational institution. And B. When the government acquires the land held by a person under his personal. Under the Territorial Waters, Continental Shelf, Exclusive Economic Zone and Other Maritime Zones Act, 1976, passed by the Parliament after the 40th Constitutional Amendment Act, 1976. 552 Indian Polity. Cultivation in the land is within the statutory ceiling limits too. The first provision was added by the 44th Amendment Act, 1978. This amendment abolished the fundamental right to property and made it a legal right. The second provision was added by the 17th Amendment Act, 1964. Acquisition under executive power. The Union or a state can acquire, hold, and dispose of property under the exercise of its executive power. Further, the executive power of the Union or a state extends to the carrying on any trade or business within and in other states also. 5. Suits by or against the government. Article 300 of the Constitution deals with the suits by or against the government in India. It lays down that the government of India may sue or be sued by the name of the Union of India, and government of a state may sue or be sued by the name of that state, e.g., State of Andhra Pradesh or State of Uttar Pradesh, and so on. Thus, The Union of India and states are legal entities, juristic personalities, for purposes of suits and proceedings, not the government of the Union or the government of states. Regarding the extent of the governmental liability, the Constitution, Article 300, declares that the Union of India or states can sue or be sued in relation to their respective affairs in the like cases as the Dominion of India and the corresponding provinces or Indian states might have sued or been sued before the Constitution. This provision is subject to any law made by Parliament or a state legislature. But no such law has been enacted so far. Hence, at present, the position in this respect remains the same as it existed before the Constitution. In the pre-Constitution period, i.e., from the days of the East India Company up to the commencement of the Constitution in 1950, the government was suable for contracts but not for torts. Wrongs committed by its servants, in respect of its sovereign functions. This is explained in detail as follows. NI liability for contracts under the exercise of its executive power, the Union or a state can enter into contracts for the acquisition, holding, and disposal of property, or to carry on any trade or business, or for any other purpose. But the Constitution lays down 3 conditions which must be fulfilled by such contracts. A. They must be expressed to be made by the President or Governor, as the case may be. B. They must be executed on behalf of the President or Governor, as the case may be. And C. They must be executed by such a person or in such a manner as the President or Governor may direct or authorize. These conditions are mandatory and not merely directory in nature. Failure to comply with them nullifies the contracts and renders them void and unenforceable in the courts. Further, the President or the Governor is not personally liable in respect of any contract executed in his name. Similarly, the officer executing the contract is also not personally liable. This immunity is purely personal and does not immunize the government from contractual liability, making the government suable in contracts. This means that the contractual liability of the Union government and the state governments is the same as that of an individual under the ordinary law of contract, which has been the position in India since the days of the East India Company. 31 Liability for torts. In the beginning, the East India Company was only a trading body. Gradually, it acquired territories in India and became a sovereign authority. The company was suable for its functions as a trader but not as a sovereign. This immunity of the company in respect of its sovereign functions was based on the English common law maxim that the king can do no wrong, which means that the king was not liable for the wrongs of his servants. This traditional immunity of the state, i.e., Crown, in Britain from any legal liability for any action has been done away with by the Crown Proceedings Act, 1947. However, the position in India still remains the same. Therefore, the government, union or states, in India can be sued for torts, civil wrongs, committed by its officials only in the exercise of its non-sovereign functions, but not in the sovereign functions like administering justice, constructing a military road, commandeering goods during war, etc. This distinction between the sovereign and non-sovereign functions of the government in India and the immunity of the government in respect of its sovereign functions was established in the famous P&O Steam Navigation Company Case 3, 1861. This was reaffirmed by the Supreme Court in the post-independence era in the Castorlo Case 4, 1964. However, after this case, the Supreme Court started giving a restrictive interpretation of sovereign functions of the government and awarded compensation to victims in a large number of cases. 3 Peninsular and Oriental Steam Navigation Company vs. Secretary of State for India, 1861. For Castorlo vs. State of UP, 1964. For W. Nagendra Rao and Company vs. State of Andhra Pradesh, 1994. In Nagendra Rao Case 4A, 1994, the Supreme Court criticized the doctrine of sovereign immunity of the state and adopted a liberal approach with respect to the tortuous liability of the state. It ruled that when a citizen suffers any damage due to the negligent act of the servants of the state would be liable to pay compensation for it, and the state cannot avoid this liability on the ground of sovereign immunity. It held that in the modern sense, the distinction between sovereign and non-sovereign functions does not exist. Rights and liabilities of the government 553. It laid down the proposition that barring a few functions, the state cannot claim any immunity. Its observations, in this case, are as follows. 1. No civilized system can permit an executive to play with the people of its country and claim that it is entitled to act in any manner as it is sovereign. The concept of public interest has changed with structural change in the society. No legal or political system today can place the state above law, as it is unjust and unfair for a citizen to be deprived of his property illegally by negligent act of officers of the state without any remedy. 2. The modern social thinking of progressive societies and the judicial approach is to do away with archaic state protection and place the state or the government at par with any other juristic legal entity. Any watertight compartmentation of the functions of the state as sovereign and non-sovereign, or governmental and non-governmental, is not sound. It is contrary to modern jurisprudential thinking. 3. The need of the state, the duty of its officials and right of the citizens are required to be reconciled so that the rule of law in a welfare state is not shaken. In a welfare state, the functions of the state are not only the defense of the country or administration of justice or maintaining law and order, but it extends to regulating and controlling the activities of the people in almost every sphere: educational, commercial, social, economic, political, and even marital. 4. The demarcating line between sovereign and non-sovereign powers for which no rational basis survives has largely disappeared. Therefore, barring functions such as administration of justice, maintenance of law and order, and repression of crime, etc., which are among the primary and inalienable functions of a constitutional government, the state cannot claim any immunity. 554 Indian Polity. In the above case, the Supreme Court did not overrule its judgment in the Casturalo case, 1964. However, it said that it is applicable to rare and limited cases. In Common Cause Case 4B, 1999, the Supreme Court again examined the whole doctrine and rejected the sovereign immunity rule. The court held that the rule of state liability as laid down in P&O Steam Navigation Company case is very outmoded. It said that in modern times, when the state activities have been considerably increased, it is very difficult to draw a line between its sovereign and non-sovereign functions. The increased activities of the state have made a deep impression on all facets of citizens' life, and therefore, the liability of the state must be made coextensive with the modern concept of a welfare state. The state must be liable for all tortuous acts of its employees, whether done in exercise of sovereign or non-sovereign powers. Finally, the court observed that the efficacy of Casturalo case as a binding precedent has been eroded. In the prisoner's murder case 111-2000, the Supreme Court ruled that in the process of judicial advancement, Casturalo case has paled into insignificance and is no longer of any binding value. 5L in Britain, the ministers are required to countersign the official acts of the Crown and are held liable in the courts for those acts. Suits against public officials, NI President and Governor. The Constitution confers certain immunities to the President of India and Governor of States with regard to their official acts and personal acts. These are: A. Official acts. The President and the Governors cannot be sued during the term of their office or thereafter for any act done by them. Common Cause, Registered Society vs. Union of India, 1999. For C.J. N. Pandey, The Constitutional Law of India, 49th edition, Central Law Agency, p. 682. For T.I. State OFA, p. vs. Challa Ramkrishna Reddy, 2000. In the exercise and performance of their official powers and duties. However, the official conduct of the President can be reviewed by a court, tribunal, or any other body authorized by either House of Parliament to investigate charges for impeachment. Further, the aggrieved person can bring appropriate proceedings against the Union of India instead of the President, and the state instead of the Governor of that state. B. Personal acts. No criminal proceedings can be started against the President and the Governors in respect of their personal acts, nor can they be arrested or imprisoned. This immunity is limited to the period of the term of their office only and does not extend beyond that. However, civil proceedings can be started against them during their term of office in respect of their personal acts after giving 2 months advance notice. A ministers. The Constitution does not grant any immunity to the ministers for their official acts. But, since they are not required to countersign, as in Britain, the official acts of the President and the Governors, they are not liable in the courts for those acts. 5. Moreover, they are not liable for the official acts done by the President and the Governors on their advice, as the courts are debarred from inquiring into such advice. However, the ministers do not enjoy any immunity for their personal acts and can be sued for crimes as well as torts in the ordinary courts like common citizens. Judicial officers. The judicial officers enjoy immunity from any liability in respect of their official acts and hence cannot be sued. The Judicial Officers Protection Act, 1850, lays down that no judge, magistrate, justice of peace, collector, or other person acting judicially shall be liable to be sued in any civil court for any act done by him in the discharge of his official duty. ESI Civil servants. Under the Constitution, the civil servants are conferred personal immunity from legal liability for official contracts. This means that the civil servant who made a contract in his official capacity is not personally liable in respect of that contract, but it is the government, central or state, that is liable for the contract. But if the contract is made without complying the conditions specified in the Constitution, then the civil servant who made the contract is personally liable. Further, the civil servants also enjoy immunity from legal liability for their tortious acts in respect of the sovereign functions of the government. In other cases, the liability of the civil servants for torts or illegal acts is the same as of any rights and liabilities of the government. 555. Ordinary citizen. Civil proceedings can be instituted against them for anything done in their official capacity after giving a 2 months advance notice. But no such notice is required when the action is to be brought against them for the acts done outside the scope of their official duties. Criminal proceedings can be instituted against them for acts done in their official capacity, with the prior permission of the President or the Governor, where necessary. 6. Criminal Procedure Code says where a public servant who is not removable from his office save by, or with the sanction of the central or state government is accused of an offense committed by him while acting or purporting to act in the discharge of his official duty, no court can take cognizance of such offense without the previous sanction of the central government or the state government, as the case may be. Article No. Subject Matter. Table 75.1 Articles related to rights and liabilities of the government at a glance. 294. Succession to property, assets, rights, liabilities and obligations in certain cases. 295. Succession to property, assets, rights, liabilities and obligations in other cases. 296. Property accruing by escheat or lapse or as bona vacantia. 297. Things of value within territorial waters or continental shelf and resources of the exclusive economic zone to vest in the Union. 298. Power to carry on trade, etc. 299. Contracts. 300. Suits and proceedings. 361. Protection, immunities, of President and Governors. Chapter 76. Special provisions relating to certain classes. Rationale of special provisions. In order to realize the objectives of equality and justice as laid down in the preamble, the Constitution makes special provisions for the scheduled castes, 8CS, the scheduled tribes, STS, the backward classes, BCs, and the Anglo-Indians. These special provisions are contained in Part 16 of the Constitution from Articles 330 to 342A. They are related to the following. 1. Reservation in legislatures. 2. Special representation in legislatures. 3. Reservation in services and posts. 4. Educational grants. 5. Appointment of national commissions. 6. Appointment of commissions of investigation. These special provisions can be classified into the following broad categories. A. Permanent and temporary. Some of them are a permanent feature of the Constitution, while some others continue to operate only for a specified period. B. Protective and developmental. Some of them aim at protecting these classes from all forms of injustice and exploitation, while some others aim at promoting their socio-economic interests. F. Specification of classes. The Constitution does not specify the castes or tribes which are to be called the SCs or the SLK. It leaves to the President the power to specify as to what castes or tribes in each state and union territory are to be treated as the SCs and STs. Thus, the list of the SCs or SITs vary from state to state and union territory to union territory. In case of the states, the President issues the notification after consulting the governor of the state concerned. But any inclusion or exclusion of any caste or tribe from presidential notification can be done only by the Parliament and not by a subsequent presidential notification. Presidents have issued several orders specifying the SCs and SITs in different states and union territories, and these have also been amended by the Parliament. Similarly, the Constitution has not specified the classes of citizens who are to be called the socially and educationally backward classes, also known as other backward classes, OBCs. The 102nd Amendment Act of 2018 provided that the President may, with respect to any state or union territory, specify the socially and educationally backward classes which shall, for the purposes of the Constitution, be deemed to be socially and educationally backward classes in relation to that state or union territory. Later, the 105th Amendment Act of 2021 modified the above provision by providing that the President may, with respect to any state or union territory. These are the Constitution, Scheduled Castes, Order, 1950. The Constitution, Scheduled Castes, Union Territories, Order, 1951. The Constitution, Scheduled Tribes, Order, 1950. The Constitution, Scheduled Tribes, Union Territories, Order, 1951, and so on. The Parliament modified the presidential orders by enacting the Scheduled Castes and Scheduled Tribes Orders, Amendment, Act in 1956 and 1976 and in the subsequent years. Specify the socially and educationally backward classes in the central list which shall, for the purposes of the central government, be deemed to be socially and educationally backward classes in relation to that state or union territory. In case of a state, the President issues the notification after consultation with the governor of the state concerned. But any inclusion in or exclusion from the central list of socially and educationally backward classes specified in a presidential notification can be done only by the Parliament and not by a subsequent presidential notification too. The 105th Amendment Act of 2021 also explained that the expression central list means the list of socially and educationally backward classes prepared and maintained by and for the central government. 3. The 8th Amendment Act of 1959 extended the period of 10 years to 20 years, the 23rd Amendment Act of 1969 to 30 years, the 45th Amendment Act of 1980 to 40 years, the 62nd Amendment Act of 1989 to 50 years, the 79th Amendment Act of 1999 to 60 years, the 95th Amendment Act of 2009 to 70 years, and the 104th Amendment Act of 2019 to 80 years, that is, until the year 2030. Further, the 105th Amendment Act of 2021 empowered a state or union territory to prepare and maintain a list of socially and educationally backward classes for its own purposes. The entries in a state list or union territory list may be different from the central list. However, this can be done by a state or union territory only by law. Unlike in the case of SCs, STK, and OBCs, the Constitution has defined the persons who belong to the Anglo-Indian community. Accordingly, An Anglo-Indian means a person whose father or any of whose other male progenitors in the male line is or was of European descent, but who is domiciled within the territory of India and is or was born within such territory of parents habitually resident therein and not established there for temporary purposes only. T. Special provisions for SCs, L, and STs. 1. Reservation for SCs and STs in legislatures. Seats are to be reserved for the SCs and STs in the Lok Sabha and the state. The 102nd Amendment Act of 2018 inserted a new Article 342A in the Constitution. Later, this Article, 342A, was amended by the 105th Amendment Act of 2021. Special provisions relating to certain classes 557. Legislative assemblies on the basis of population ratios. Originally, this provision of reservation was to operate for 10 years, i.e., up to 1960, only. But this duration has been extended continuously since then by 10 years each time. Now, under the 104th Amendment Act of 2019, this provision of reservation is to last until 2030.32. Claims of SCs and STs to services and posts. The claims of the SCs and STs are to be taken into consideration while making appointments to the public services of the center and the states, without sacrificing the efficiency of administration. However, the 82nd Amendment Act of 2000 provides for making of any provision in favor of the SCs and SLK for relaxation in qualifying marks in any examination or lowering the standards of evaluations, for reservation in matters of promotion to the public services of the center and the states. 3. National commissions for SCs and STs. The President should set up a national commission for the SCs to investigate all matters relating to the constitutional safeguards for the SCs and to report to him/her. Article 338. Similarly, the President should also set up a national commission for the STs to investigate all matters relating to the constitutional safeguards for the SLK and to report to him/her. Article 338a. The President should place all such reports before the Parliament, along with the action taken memorandum. Previously, the Constitution provided for a combined national commission for SCs and STs. The 89th Amendment Act of 2003 558 Indian Polity bifurcated the combined commission into two separate bodies. 4. Control of the Union over the administration of scheduled areas and the welfare of STs. The President is required to appoint a commission to report on the administration of the scheduled areas and the welfare of the STs in the states. He can appoint such a commission at any time, but compulsorily after 10 years of the commencement of the Constitution. Hence, a commission was appointed in the year 1960. It was headed by U.N. Debar and submitted its report in 1961. After 4 decades, the second commission was appointed in 2002 under the chairmanship of Dilip Singh Bhuria. It submitted its report in 2004. Further, the executive power of the center extends to the giving of directions to a state with respect to the drawing up and execution of schemes for the welfare of the 81K in the state. Steps to improve their condition. The report of the commission is to be placed before the Parliament, along with action taken memorandum. Under the above provision, the President has appointed 2 commissions so far. The first Backward Classes Commission was appointed in 1953 under the chairmanship of Kaka Kalelkar. It submitted its report in 1955. But no action was taken on it as the recommendations were considered to be too vague and impractical, and also there was a sharp division among the members on the criterion of backwardness. The second Backward Classes Commission was appointed in 1979 with B.P. Mundal as chairman. It submitted its report in 1980. Its recommendations were also lying unattended till 1990 when the V.P. Singh government declared reservation of 27% government jobs for the OBCs. T. Special provisions for BCs. 1. National Commission for BCs. The National Commission for BCs was set up in 1993 by an Act of Parliament. Later, the 102nd Amendment Act of 2018 conferred a constitutional status on the Commission. For this purpose, the amendment inserted a new Article 338b in the Constitution. Accordingly, the President should set up a National Commission for the socially and educationally BCs to investigate all matters relating to the constitutional safeguards for the socially and educationally BCs and to report to him/her. The President should place all such reports before the Parliament, along with the action taken memorandum. 2. Appointment of a commission to investigate the conditions of BCs. The President may appoint a commission to investigate the conditions of socially and educationally backward classes and to recommend the special provisions for Anglo-Indians. 1. Special representation for Anglo-Indians in legislatures. Before 2020, the President nominated 2 members from the Anglo-Indian community to the Lok Sabha, if the community was not adequately represented. Similarly, before 2020, the governor of a state also nominated 1 member from the Anglo-Indian community to the state legislature assembly, if the community was not adequately represented. Originally, this provision of special representation was to operate for 10 years, i.e., up to 1960, only. But this duration has been extended continuously since then by 10 years each time. The last extension up to 2020 was made by the 95th Amendment Act, 2009. However, the 104th Amendment Act, 2019, has not extended further the operation of this provision. In other special provisions relating to certain classes 559. words, the amendment discontinued this provision of special representation of the Anglo-Indian community in the legislatures, Lok Sabha and Assembly, by nomination. Consequently, this provision ceased to have effect on the January 25, 2020. 2. Special provision in services and educational grants for Anglo-Indians. Before independence, certain posts were reserved for the Anglo-Indians in the railway, customs, postal, and telegraph services of the Union. Similarly, the Anglo-Indian educational institutions were given certain special grants by the center and the states. Both these benefits were allowed to continue under the Constitution on a progressive diminution basis and finally came to an end in 1960. 3. National Commission for SCs vis avis Anglo-Indians. The National Commission for SCs is also required to discharge similar functions with regard to the Anglo-Indian community as it does with respect to the SCs. In other words, the Commission has to investigate all matters relating to the constitutional and other legal safeguards for the Anglo-Indian community and report to the President upon their working. 4. For Clause 10 of Article 338 reads as follows. In this article, reference to the scheduled caste shall be construed as including references to the Anglo-Indian community. Table 76.1 Articles related to special provisions for certain classes at a glance. Article No. Subject Matter. 3D1 Representation of the Anglo-Indian community in the House of the People. Reservation of seats for scheduled castes and scheduled tribes in the House of the People. 337 Special provision with respect to educational grants for the benefit of Anglo-Indian community. 338 National Commission for Scheduled Castes. 338A National Commission for Scheduled Tribes. 338B National Commission for Backward Classes. 339 Control of the Union over the administration of scheduled areas and the welfare of scheduled tribes. 340 Appointment of a commission to investigate the conditions of backward classes. 341 Scheduled castes. 342 Scheduled tribes. 342A Socially and educationally backward classes. 332 Reservation of seats for scheduled castes and scheduled tribes in the legislative assemblies of the states. 333 Representation of the Anglo-Indian community in the legislative assemblies of the states. 334 Reservation of seats and special representation to cease after certain period. Hunar, asterisk. R. JJB claims of scheduled castes and scheduled tribes to services and posts. 336 Special provision for Anglo-Indian community in certain services chapter special provisions. For some states. Articles 371 to 371, J and Part 21 of the Constitution contains special provisions for 12 states viz. Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa, and Karnataka. The intention behind them is to meet the aspirations of the people of backward regions of the states or to protect the cultural and economic interests of the tribal people of the states or to deal with the disturbed law and order condition in some parts of the states or to protect the interests of the local people of the states. Originally, the Constitution did not make any special provisions for these states. They have been incorporated by the various subsequent amendments made in the context of reorganization of the states or conferment of statehood on the Union territories. Provisions for Maharashtra and Gujarat. Under Article 371, the President is authorized to provide that the Governor of Maharashtra and that of Gujarat would have special responsibility for *2. Part 21 is entitled as Temporary, Transitional, and Special Provisions. This article was amended by the 7th Constitutional Amendment Act of 1956 and the Bombay Reorganization Act of 1960. Andhra Pradesh was taken out of this article by the 32nd Constitutional Amendment Act of 1973 and provided for separately in two new Articles 371d and 371e. 1. The establishment of separate development boards for I. Vidarbha, Marathwada and the rest of Maharashtra, 2. Saurashtra, Kutch and the rest of Gujarat. 2. Making a provision that a report on the working of these boards would be placed every year before the State Legislative Assembly. 3. The equitable allocation of funds for developmental expenditure over the above-mentioned areas. And 4. An equitable arrangement providing adequate facilities for technical education and vocational training and adequate employment opportunities in the state services in respect of the above-mentioned areas. Provisions for Nagaland. Article 371. A makes the following special provisions for Nagaland 3. 1. The Acts of Parliament relating to the following matters would not apply to Nagaland unless the State Legislative Assembly so decides. I. Religious or social practices of the Nagas. 2. Naga customary law and procedure. 3. Administration of civil and criminal justice involving decisions according to Naga customary law. And 4. Ownership and transfer of land and its resources. 2. The Governor of Nagaland shall have special responsibility for law and order in. This article was added by the 13th Constitutional Amendment Act of 1962. Special provisions for some states 561. The states so long as internal disturbances caused by the hostile Nagas continue. In the discharge of this responsibility, the governor, after consulting the Council of Ministers, exercises his individual judgment and his decision is final for. This special responsibility of the governor shall cease when the president so directs. 6. This article was added by the 22nd Constitutional Amendment Act of 1969. The tribal areas of Assam are specified in the 6th Schedule of the Constitution. They are North Kutcher Hills District, Karbi Along District, and Bodoland Territorial Areas District. 3. The governor has to ensure that the money provided by the central government for any specific purpose is included in the demand for a grant relating to that purpose and not in any other demand moved in the State Legislative Assembly. 4. A regional council consisting of 35 members should be established for the Tunsang district of the state. The governor should make rules for the composition of the council, manner of choosing its members, their qualifications, term, salaries, and allowances, the procedure and conduct of business of the council, the appointment of officers and staff of the council and their service conditions, and any other matter relating to the constitution and proper functioning of the council. 5. For a period of 10 years from the formation of Nagaland, or for such further period as the governor may specify on the recommendation of the regional council, the following provisions would be operative for the Tunsang district. I. The administration of the Tunsang district shall be carried on by the governor. 2. The governor shall in his discretion arrange for equitable. For the validity of anything done by the governor shall not be called in question on the ground that Husha ought or ought not to have acted in the exercise of his individual judgment. The deputy commissioner of the Tunsang district shall be the ex officio chairman of the regional council and the vice chairman shall be elected by the members of the council from amongst themselves. Distribution of money provided by the center between Tunsang district and the rest of Nagaland. 3. Any act of Nagaland legislature shall not apply to Tunsang district unless the governor so directs on the recommendation of the regional council. 4. The governor can make regulations for the peace, progress, and good government of the Tunsang district. Any such regulation may repeal or amend an act of parliament or any other law applicable to that district. V. There shall be a minister for Tunsang affairs in the State Council of Ministers. Husha is to be appointed from amongst the members representing Tunsang district in the Nagaland Legislative Assembly. 6. The final decision on all matters relating to Tunsang district shall be made by the governor in his discretion. 7. Members in the Nagaland Legislative Assembly from the Tunsang district are not elected directly by the people but by the regional council. Provisions for Assam and Manipur. Assam. Under Article 371, B6, the President is empowered to provide for the creation of a committee of the Assam Legislative Assembly consisting of the members elected from the tribal areas of the state and such other members as Husha may specify. 7. 562 Indian Polity. Manipur. Article 371, C makes the following special provisions for Manipur 8. 8. This article was added by the 27th Constitutional Amendment Act of 1971. 9 inches. This article, the expression hill areas means such areas as the President may, by order, declare to be hill areas. 10. Both the articles were added by the 32nd Constitutional Amendment Act of 1973. 1. The President is authorized to provide for the creation of a committee of the Manipur Legislative Assembly consisting of the members elected from the hill areas of the state. 9.10.2. The President can also direct that the governor shall have special responsibility to secure the proper functioning of that committee. 3. The governor should submit an annual report to the President regarding the administration of the hill areas. 4. The central government can give directions to the state government as to the administration of the hill areas. Provisions for Andhra Pradesh or Telangana. Articles 371, D, and 371, E contain the special provisions for Andhra Pradesh 1 inch. In 2014, Article 371, D has also been extended to the state of Telangana by the Andhra Pradesh Recurrent Organization Act of 2014. Under Article 371, D, the following are mentioned. 1. The President is empowered to provide for equitable opportunities and facilities for the people belonging to different parts of the state in the matter of public employment and education, and different provisions can be made for various parts of the state. 2. For the above purpose, the President may require the state government to organize civil posts and local cadres for different parts of the state and provide for direct recruitment to posts in any local cadre. Husha may specify parts of the state which shall be regarded as the local area for admission to any educational institution. Husha may also specify the extent and manner of preference or reservation given in the matter of direct recruitment to posts in any such cadre or admission to any such educational institution. 3. The President may provide for the establishment of an administrative tribunal in the state to deal with certain disputes and grievances relating to appointment, allotment, or promotion to civil posts in the state. The tribunal is to function outside the purview of the state high court. No court, other than the Supreme Court, is to exercise any jurisdiction in respect of any matter subject to the jurisdiction of the tribunal. The President may abolish the tribunal when Husha is satisfied that its continued existence is not necessary. Article 371. E empowers the Parliament to provide for the establishment of a central university in the state of Andhra Pradesh. Provisions for Sikkim. The 36th Constitutional Amendment Act of 1975 made Sikkim a full-fledged state of the Indian Union. It included a new Article 371F containing special provisions with respect to Sikkim. These are as follows. 1. The Sikkim Legislative Assembly is to consist of not less than 30 members. 2. One seat is allotted to Sikkim in the Lok Sabha, and Sikkim forms one parliamentary constituency. 3. For the purpose of protecting the rights and interests of the different sections of the Sikkim population, the Parliament is empowered to provide for the number of seats in the Sikkim Legislative Assembly which may be filled by candidates belonging to such sections. And the tribunal has been set up by the Andhra Pradesh Administrative Tribunal Order, 1975. 2. Delimitation of the Assembly constituencies from which candidates belonging to such sections alone may stand for election to the Assembly. 4. The governor shall have special responsibility for peace and for an equitable arrangement for ensuring the social and economic advancement of the different sections of the Sikkim population. In the discharge of this responsibility, the governor shall act and issue discretion subject to the directions issued by the president. 5. The president can extend, with restrictions or modifications, to Sikkim any law which is in force in a state of the Indian Union. T. Provisions for Mizoram. Article 371G specifies the following provisions for Mizoram. 12. This article was added by the 56th Constitutional Amendment Act of 1987. Hyderabad, Karnataka region includes the 6 backward districts of northern Karnataka, viz. Gulbarga, Bidar, Rajchur, Koppal, Yajur and Bellary. Special. The Acts of Parliament relating to the following matters would not apply to Mizoram unless the State Legislative Assembly so decides, greater than sign, religious or social practices of the Mizos. 2. Mizo customary law and procedure. M. Administration of civil and criminal justice involving decisions according to Mizo customary law. And 4. Ownership and transfer of land. The Mizoram Legislative Assembly is to consist of not less than 40 members. Provisions for Arunachal Pradesh and Goa. Arunachal Pradesh. Under Article 371H, the following special provisions are made for Arunachal Pradesh. 13. The Governor of Arunachal Pradesh shall have special responsibility for law and this article was added by Constitutional Amendment Act of 1986. This article was added by the 55th Constitutional Amendment Act of 1986. Special provisions for some states. M553. Order in the state. In the discharge of this responsibility, the governor, after consulting the Council of Ministers, exercises his individual judgment and his decision is final. This special responsibility of the governor shall cease when the president so directs. 2. The Arunachal Pradesh Legislative Assembly is to consist of not less than 30 members. Goa. Article 371-1 provides that the Goa Legislative Assembly is to consist of not less than 30 members. Provisions for Karnataka. Under Article 371J, the President is empowered to provide that the Governor of Karnataka would have special responsibility for 1. The establishment of a separate development board for Hyderabad Karnataka region. 2. Making a provision that a report on the working of the board would be placed every year before the State Legislative Assembly. 3. The equitable allocation of funds for developmental expenditure over the region. 4. The reservation of seats in educational and vocational training institutions in the region for students who belong to the region. 5. The reservation in state government posts in the region for persons who belong to the region. Article 371-3, which provided for special provisions for the Hyderabad Karnataka region of the state of Karnataka, was inserted in the Constitution by the 98th Constitutional Amendment Act of 2012. The Special 564 Indian Polity. Provisions aim to establish an institutional mechanism for equitable allocation of funds to meet the development needs over the region, as well as to enhance human resources and promote employment from the region by providing for local cadres in service and reservation in educational and vocational training institutions. In 2010, the Legislative Assembly as well as the Legislative Council of Karnataka passed separate resolutions seeking special provisions for the Hyderabad Karnataka region of the state of Karnataka. The government of Karnataka also endorsed the need for special provisions for the region. The resolution sought to accelerate development of the most backward region of the state and promote inclusive growth with a view to reducing inter-district and inter-regional disparities in the state. Table 77.1 Articles related to special provisions for some states at a glance. Article No. Subject Matter. 371. Special provision with respect to the states of Maharashtra and Gujarat. 371A. Special provision with respect to the state of Nagaland. 3718. Special provision with respect to the state of Assam. 371C. Special provision with respect to the state of Manipur. 371V. Special provisions with respect to the state of Andhra Pradesh or the state of Telangana. 3718. Establishment of Central University in Andhra Pradesh. 3715. Special provisions with respect to the state of Sikkim. 3716. Special provision with respect to the state of Mizoram. 371H. Special provision with respect to the state of Arunachal Pradesh. 371-1. Special provision with respect to the state of Goa. 371J. Special provisions with respect to the state of Karnataka, Part 10, Political Dynamics. In this part. 78. Political parties. 79. Role of regional parties. 8. T. Meaning and types. Political parties are voluntary associations or organized groups of individuals who share the same political views and who try to gain political power through constitutional means and who desire to work for promoting the national interest. There are 4 types of political parties in the modern democratic states, viz. I. Reactionary parties which cling to the old socio-economic and political institutions. 2. Conservative parties which believe in the status quo. 3. Liberal parties which aim at reforming the existing institutions. And 4. Radical parties which aim at establishing a new order by overthrowing the existing institutions. In their classification of political parties on the basis of ideologies, the political scientists have placed the radical parties on the left and the liberal parties in the center and reactionary and conservative parties on the right. In other words, they are described as the leftist parties, centrist parties, and the rightist parties. In India, the CPI and CPM are quiet face. See examples of leftist parties. The Congress of centrist parties and the BJP is an example of rightist parties. There are 3 kinds of party systems in the world, viz. I. One-party system in which only one ruling party exists and no opposition is permitted, as for example, in the former communist countries like the USSR and other East European countries. 2. Two-party system in which 2 major parties exist, as for example, in USA and Britain 1. And 3. Multi-party system in which there are a number of political parties, as for example, in France, Switzerland, and Italy. T-party system in India. The Indian party system has the following characteristic features. Multi-party system, the continental size of the country, the diversified character of Indian society, the adoption. The 2 parties in the US are Democratic and Republican, and in Britain are Conservative and Labour. 566. Our Indian polity. Of universal adult franchise, the peculiar type of political process, and other factors have given rise to a large number of political parties. In fact, India has the largest number of political parties in the world. Further, India has all categories of parties: left parties, centrist parties, right parties, communal parties, non-communal parties, and so on. Consequently, the hung parliaments, hung assemblies, and coalition governments have become a common phenomena. One dominant party system. In spite of the multi-party system, the political scene in India was dominated for a long period by the Congress. Hence, Rajni Kothari, an eminent political analyst, preferred to call the Indian party system as one-party dominant system or the Congress system too. The dominant position enjoyed by the Congress has been declining since 1967 with the rise of regional parties and other national parties like Janata, 1977, Janata Dal, 1989, and the BJP, 1991, leading to the development of a competitive multi-party system. 2. Rajni Kothari, Congress System in India, Asian Survey, Volume 4, No. 12, December, 1964, pp. 1-18. Lack of clear ideology except the BJP and the 2 communist parties, CPI and CPM, all other parties do not have a clear-cut ideology. They, i.e., all other parties, are ideologically closer to each other. They have a close resemblance in their policies and programs. Almost every party advocates democracy, secularism, socialism, and Gundaism. More than this, every party, including the so-called ideological parties, is guided by only one consideration: power capture. Thus, politics has become issue-based rather than the ideology, and pragmatism has replaced the commitment to the principles. Personality cult. Quite often, the parties are organized around an eminent leader who becomes more important than the party and its ideology. Parties are known by their leaders rather than by their manifesto. Hence, it is said that there are political personalities rather than political parties in India. Based on traditional factors. In the Western countries, the political parties are formed on the basis of socio-economic and political program. On the other hand, a large number of parties in India are formed on the basis of religion, caste, language, culture, race, and so on. These parties generally work for the promotion of communal and sectional interests and thereby undermine the general public interest. Emergence of regional parties. Another significant feature of the Indian party system is the emergence of a large number of regional parties and their growing role. They have become the ruling parties in various states. In the beginning, they were confined to the regional politics only. But, of late, they have come to play a significant role in the national politics due to coalition governments at the center. Factions and defections. Factionalism, defections, splits, mergers, fragmentation, polarization, and so on have been an important aspect of the functioning of political parties in India. Lust for power and material considerations have made the politicians to leave their party and join another party or start a new party. The practice of defections gained greater currency after the 4th general elections, 1967. This phenomenon caused political instability both at the center and in the states and led to disintegration of the parties. Political parties. H. 567. Lack of effective opposition. And effective opposition is very essential for the successful operation of the parliamentary democracy prevalent in India. It checks the autocratic tendencies of the ruling party and provides an alternative government. However, since the first general elections, an effective, strong, organized, and viable national opposition could never emerge except in flashes. The opposition parties have no unity and very often adopt mutually conflicting positions with respect to the ruling party. They have failed to play a constructive role in the functioning of the body politic and in the process of nation building. The formation of various political parties, in the chronological order, is given in Table 78.1. Recognition of national and state parties. The Election Commission registers political parties for the purpose of elections and grants them recognition as national or state parties on the basis of their poll performance. The other parties are simply declared as registered unrecognized parties. The recognition granted by the Commission to the parties determines their right to certain privileges like allocation of the party symbols, provision off time for political broadcast on the state-owned television and radio stations, and access to electoral rolls. Every national party is allotted a symbol exclusively reserved for its use throughout the country. Similarly, every state party is allotted a symbol exclusively reserved for its use in the state or states in which it is so recognized. A registered unrecognized party, on the other hand, can select a symbol from a list of free symbols. In other words, the Commission specifies certain symbols as reserved symbols which are meant for the candidates set up by the recognized parties and others as free symbols which are meant for other candidates. Conditions for recognition as a national party. At present, a party is recognized as a national party if any of the following conditions is fulfilled. 3. The election symbols, reservation and allotment, Order, 1968, as amended from time to time. Prohibit. 1. If it secures 6% of valid votes polled in any 4 or more states at a general election to the Lok Sabha or to the Legislative Assembly. And, in addition, it wins 4 seats in the Lok Sabha from any state or states. Or 2. If it wins 2% of seats in the Lok Sabha at a general election, and these candidates are elected from 3 states. Or 3. If it is recognized as a state party in 4 states. Conditions for recognition as a state party. At present, a party is recognized as a state party in a state if any of the following conditions is fulfilled. 4. 1. If it secures 6% of the valid votes polled in the state at a general election to the Legislative Assembly of the state concerned. And, in addition, it wins 2 seats in the Assembly of the state concerned. Or 2. If it secures 6% of the valid votes polled in the state at a general election to the Lok Sabha from the state concerned. And, in addition, it wins 1 seat in the Lok Sabha from the state concerned. Or 3. If it wins 3% of seats in the Legislative Assembly at a general election to the Legislative Assembly of the state concerned, or 3 seats in the Assembly, whichever is more. Or 4. If it wins 1 seat in the Lok Sabha for every 25 seats or any fraction thereof allotted to the state at a general election to the Lok Sabha from the state concerned. Or Indian Polity. 5. If it secures 8% of the total valid votes polled in the state at a general election to the Lok Sabha from the state or to the Legislative Assembly of the state. The number of recognized parties keeps on changing on the basis of their performance in the general elections. The national parties and state parties are also known as All India parties and regional parties respectively. At the time of first Lok Sabha general elections, 1952, there were 14 national parties. 5 Bharatiya Jansan, BJS, Bolshevik Party of India, BP1, Communist Party of India, CPI, Forward Bloc, Marxist Group, FBLMG, Forward Bloc, Rooker Group, FB-Largi, Hindu Mahasabha, and 39 state parties in the country. On the eve of 17th Lok Sabha general elections 2019, there were 7 national parties, 6 and 52 state parties in the country. HMS, Indian National Congress, Inc., Krishikar Lok Party, KLP, Kisan Mazdoor Praja Party, KMPP, Revolutionary Communist Party of India, RCPI, Ram Rajya Parishad, RRP, Revolutionary Socialist Party, RSP, Scheduled Caste Federation, SCF, and Socialist Party, SP. Bahujan Samaj Party, BSP, Bharatiya Janata Party, BJP, Communist Party of India, CPI, Communist Party of India, Marxist, CPM, Indian National Congress, Inc., Nationalist Congress Party, NCP, and All India Trinamool Congress, ADC. Table 78.1 Formation of Political Parties, Chronological Order, ISI. No. Name of the party, abbreviation, founder year of format on 1. Indian National Congress, Inc., Hume 1885-2. Shomi Akali Dao, SAD, 1923. Communist Party of India, CPI, M.N. Roy 1925-4. Jammu and Kashmir National Conference, JKNC, Sheikh Abdullah 1939-5. Dravida Munnetra Kazhagam, DMK, C.N. Annaduri 1949. 6. Communist Party of India, Marxist, CPM, 1964-7. Shiv Sena, SHS, Bal Thackeray 1966-8. All India Anna Dravida Munnetra Kazhagam, AIDMK, M.G. Ramachandran 1972-9. Bharatiya Janata Party, BJP, A.B. Vajpayee and L.K. Advani 1980-10. Telugu Desam Party, TDP, Intu Rama Rao 1982-11. Bahujan Samaj Party, BSP, Kanchi Ram 1984-12. Assam Gana Parishad, AGP, PK Mahanta 1985-13. Samajwadi Party, SP, Mulayam Singh Yadav 1992-14. Rashtriya Janata Dal, RJD, Lala Prasad Yadav 1997-15. Biju Janata Dal, BJD, Naveen Patnaik 1997-16. All India Trinamool Congress, AITC, Mamata Banerjee 1998-17. Jammu and Kashmir People's Democratic Party, PDP, Mufti Muhammad Saeed 1999-18. Janata Dal, United, JD, U, Shared Yadav 1999-19. Janata Dal, Secular, JD, S, HD Dev Gowda 1999-20. Nationalist Congress Party, NCP, Sharad Pawar, PA Sangama. And Tariq Anwar. 1999. 21. Lok Jan Shakti Party, LJP, Ram Vilas Pawan 2000. 22. Telangana Rashtra Samiti, TRS, now, Bharat Rashtra Samiti, BRS. K. Chandrasekhar Rao 2001. 23. Yuvajana Sramika Ritha Congress Party, YSRCP, YS Jagan Mohan Reddy 2011-24. AAM Admi Party, AAP, Arvind Kejriwal 2012-25. National People's Party, NPP, PA Sangama 2013 Chapter 79 Role of Regional Parties. The presence of a large number of regional parties is an important feature of the Indian political system. They have come to play a vital role in Indian politics at all levels, i.e. local, state, and national. This is more so in the context of the new era of coalition politics. T features. Following are the features of a regional party. 1. It generally operates within a particular state or specific region. Its electoral base is limited to a single region. 2. It articulates regional interests and identifies itself with a particular cultural, religious, linguistic, or ethnic group. 3. It is primarily concerned with exploiting the local resources of discontent or preserving a variety of primordial demands based on language, caste, or community or region. 1. 4. It focuses on local or regional issues and aims to capture political power at the state level. 5. It has a political desire for greater regional autonomy of states in the Indian Union. 2. Observation made by Stanley A. Koknak and Ram Reddy, G. And Sharma, B.V., Regionalism in India, A Study of Telangana, Concept Publishers, New Delhi, 1979, pp. 87-88. Brass, P.R., The Politics of India Since Independence, 2nd edition, Cambridge University Press, Cambridge, UK, 1993, p. 89. T. Classification. The various regional parties in India can be classified into the following 4 categories. 1. Those regional parties which are based on the regional culture or ethnicity. These include Shromani Akali Dal, National Conference, DMK, Telugu Desam, Shiv Sena, Assam Gana Parishad, and so on. 2. Those regional parties which have an all-India outlook but lack a national electoral base. The examples are Samajwadi Party, Nationalist Congress Party, and so on. 3. Those regional parties which have been formed by a split in national parties. For example, Biju Janata Dal, Rashtriya Janata Dal, Trinamool Congress, YSR Congress, and so on. 4. Those regional parties which have been formed by individual leaders on the basis of their charismatic personality. These are called as personalized parties and they are short-lived. Frise. There are multiple reasons for the emergence of regional parties in India. These are as follows. 1. Cultural and ethnic pluralism of the Indian society. 2. Economic disparities and regional imbalances in the development. 3. Desire of certain sections or areas to maintain separate identity due to historical factors. 4. Self-interest of the deposed Maharajas and dispossessed Zamindars. Indian Polity. 5. Failure of national parties to meet the regional aspirations. 6. Reorganization of states on the basis of language. 7. Charismatic personality of the regional leaders. 8. Factional fights within the larger parties. 9. Centralizing tendencies of the Congress Party. 10. Absence of a strong opposition party at the central level. 11. Role of caste and religion in the political process. 12. Alienation and discontentment among the tribal groups. F-role. The following points highlight the role played by the regional parties in Indian politics. 1. They have provided better governance and a stable government at the regional level. 2. They have posed a challenge to the one-party dominant system in the country and led to a decline in the domination of the Congress Party. 3. They have made a strong impact on the nature and course of center-state relations. The tension areas in center-state relations and the demand for the grant of greater autonomy made the central leadership more responsive to the needs of the regional actors. 4. They have made politics more competitive and popular participation in the political process more extensive at the grassroots. 5. They have widened the choice for voters in both the parliamentary and assembly elections. The voters can vote for that party which aims to promote the interest of their state region. B. Savach, J.R., Dynamics of Indian Government and Politics, 2nd edition, Sterling Publishers Private Limited, New Delhi, 1990, p. 865. 7 Ibid. Ibid. 3 Baumwall, K.R., Regional Parties in Indian Politics, A Preview. In Bhatnagar, S. In Kumar, p. eds. Regional Political Parties in India, ESS Publications, Delhi, 1988, pp. 1-16. For Ibid. 5 Ibid. T. Dysfunctions. 6. They have increased the political consciousness of the people and also their interest in politics. They bring into focus the local or regional issues which immediately attract the attention of the masses. 7. They provided a check against the dictatorial tendencies of the central government. They opposed the ruling Congress party at the center on certain issues and forced the dominant party to be more reasonable in its approach to the process of conflict resolution. 6.78. They have made a significant contribution for the successful functioning of parliamentary democracy. In a parliamentary democracy, the minority must have its say, the majority must have its way, and the regional parties have played this role successfully by being ruling parties in some states and opposition parties at the center. 9. They have succeeded in exposing the partisan role of the governors in the appointment and dismissal of the chief minister, in issuing of ordinances and reservation of bills for the consideration of the president. 8. 10. After the dawn of the era of coalition politics, the regional parties have assumed an important role in national politics. They have joined the coalition governments formed at the center and shared power with the national parties. However, there are also negative points in the role of regional parties. These are as follows. 1. They have given more importance to regional interests rather than national interests. They have neglected the implications and consequences of their narrow approach to the resolution of national issues. 2. They have encouraged regionalism, casteism, linguism, communalism, and tribalism, which have become hurdles to national integration. 3. They are responsible for the unresolution of the interstate water disputes, interstate border disputes, and other interstate issues. 4. They have also indulged in corruption, nepotism, favoritism, and other forms. Role of regional parties. 571. Of misutilization of power in order to promote their self-interest. 5. They have focused more on the populist schemes and measures to expand and strengthen their electoral base. This has adversely affected the state economy and development. 6. They bring in regional factors in the decision-making and the policy-making by the coalition government at the center. They force the central leadership to yield to their demands. Chapter 80 Elections. F. Electoral System. Articles 324 to 329 and Part 15 of the Constitution make the following provisions with regard to the electoral system in our country. 1. The Constitution, Article 324, provides for an independent election commission in order to ensure free and fair elections in the country. The power of superintendence, direction, and conduct of elections to the Parliament, the state legislatures, the office of the President, and the office of the Vice President is vested in the Commission. 2. There is to be only one general electoral roll for every territorial constituency for election to the Parliament and the state legislatures. Thus, the Constitution has abolished the system of communal representation and separate electorates which led to the partition of the country. 3. No person is to be ineligible for inclusion in the electoral roll on grounds only of religion, race, caste, sex, or any of them. Further, no person can claim to be included in any special electoral roll for any constituency on grounds only of religion, race, caste, or sex, or any of them. Thus, the Constitution has accorded equality to every citizen in the matter of electoral franchise. 4. The elections to the Lok Sabha and the state assemblies are to be on the basis of adult franchise. Thus, every person who. The 61st Amendment Act of 1988 has reduced the voting age from 21 to 18 years. This came into force on March 28, 1989. There is a separate state election commission to deal with elections to the panchayats and municipalities in the state. Is a citizen of India and who is 182 years of age is entitled to vote at the election provided Husha is not disqualified under the provisions of the Constitution or any law made by the appropriate legislature, Parliament, or state legislature, on the ground of non-residence, unsound mind, crime, or corrupt or illegal practice. 5. Parliament may make provision with respect to all matters relating to elections to the Parliament and the state legislatures, including the preparation of electoral rolls, the delimitation of constituencies, and all other matters necessary for securing their due constitution. 6. The state legislatures can also make provision with respect to all matters relating to elections to the state legislatures, including the preparation of electoral rolls and all other matters necessary for securing their due constitution. But they can make provision for only those matters which are not covered by the Parliament. In other words, they can only supplement the parliamentary law and cannot override it. 7. The Constitution declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. Consequently, the orders issued by the Delimitation Commission become final and cannot be challenged in any court. Elections 573. 8. The Constitution lays down that no election to the Parliament or the state legislature is to be questioned except by an election petition presented to such authority and in such manner as provided by the appropriate legislature. Since 1966, the election petitions are triable by high courts alone. But the appellate jurisdiction lies with the Supreme Court alone. Article 323b empowers the appropriate legislature, parliament, or state legislature to establish a tribunal for the adjudication of election disputes. It also provides for the exclusion of the jurisdiction of all courts, except the special leave appeal jurisdiction of the Supreme Court, in such disputes. So far, no such tribunal has been established. It must be noted here that in Chandrakumar Case 3, 1997, the Supreme Court declared this provision as unconstitutional. Consequently, if at any time an election tribunal is established, an appeal from its decision lies to the High Court. 3L. Chandrakumar vs. Union of India, 1997. Clause 3d of Article 323b was declared as unconstitutional. 3. This information is obtained from the official website of the Election Commission of India. For Handbook for Media, General Elections to the 17th Lok Sabha 2019, Election Commission of India, pp. 95-96. Election Machinery 33_Election Commission of India, ECI. Under Article 324 of the Constitution of India, the Election Commission of India is vested with the power of superintendence, direction and control of conducting the elections to the Lok Sabha and state legislative assemblies. The Election Commission of India is a 3-member body, with 1 Chief Election Commissioner and 2 Election Commissioners. The President of India appoints the Chief Election Commissioner and the Election Commissioners. Chief Electoral Officer, CEO. The Chief Electoral Officer of a state union territory is authorized to supervise the election work in the state union territory subject to the overall superintendence, direction and control of the Election Commission of India. The Election Commission of India nominates or designates an officer of the government of the state union territory as the Chief Electoral Officer in consultation with that state government union territory administration. District Election Officer, DO. The District Election Officer supervises the election work in a district. The Election Commission of India nominates or designates an officer of the state government as the District Election Officer in consultation with the state government. Returning Officer, RO. The returning officer of a parliamentary or assembly constituency is responsible for the conduct of elections in the parliamentary or assembly constituency concerned. The Election Commission of India nominates or designates an officer of the government or a local authority as the returning officer for each of the assembly and parliamentary constituencies in consultation with the state government union territory administration. Electoral Registration Officer, ERO. The Electoral Registration Officer is responsible for the preparation of electoral rolls for a parliamentary assembly constituency. The Election Commission of India, in consultation with the state UT government, appoints an officer of the government or the local authorities as the Electoral Registration Officer. Presiding Officer. The presiding officer, with the assistance of polling officers, conducts the poll at a polling station. The District Election Officer appoints the presiding officers and the polling officers. In the case of union territories, such appointments are made by the returning officers. Observers. The Election Commission of India nominates officers of government as observers for parliamentary and assembly constituencies. These observers are of various kinds. 4. 1. General observers. The Commission deploys general observers in adequate Indian polity. Number to ensure smooth conduct of elections. These observers are asked to keep a close watch on every stage of the electoral process to ensure free and fair elections. 2. Expenditure observers. The Commission appoints expenditure observers and assistant expenditure observers who will exclusively monitor the election expenditure of the contesting candidates. 3. Police observers. The Commission deploys IPS officers as police observers at state and district levels, depending upon the sensitivity of the constituency, wherever required. They will monitor all activities relating to force deployment, law and order situation, and coordinate between the civil and police administration to ensure free and fair election. 4. Micro-observers. In addition to general observers, the Commission also deploys micro-observers to observe the poll proceedings on the poll day in critical vulnerable polling stations. They are chosen from central government central PSUs officials. They observe the proceedings at the polling stations on the poll day right from the mock poll to the completion of poll and the process of sealing of EVMs and VVPA-TET and other documents to ensure that all instructions of the Commission are complied with by the polling parties and the polling agents. They also report to the general observers directly about any vitiation of the poll proceedings in their allotted polling stations. Election Process 5. General Elections 2009. Reference Handbook, Press Information Bureau, Government of India, p. 189. Time of elections. Elections for the Lok Sabha and every state legislative assembly have to take place every 5 years, unless called earlier. The President can dissolve Lok Sabha and call a general election before 5 years is up, if the government can no longer command the confidence of the Lok Sabha. 5. This information is downloaded from the official website of the Election Commission of India. And if there is no alternative government available to take over. Schedule of elections. When the 5-year limit is up, or the legislature has been dissolved and new elections have been called, the Election Commission puts into effect the machinery for holding an election. The Constitution states that there can be no longer than 6 months between the last session of the dissolved Lok Sabha and the recalling of the new House, so elections have to be concluded before then. The Election Commission normally announces the schedule of elections in a major press conference a few weeks before the formal process is set in motion. The Model Code of Conduct for Guidance of Candidates and Political Parties comes immediately into effect after such announcement. The formal process for the election starts with the notification or notifications calling upon the electorate to elect members of a House. As soon as notifications are issued, candidates can start filing their nominations in the constituencies from where they wish to contest. The candidates are given a week to put forward their nominations. These are scrutinized by the returning officers, and if not found to be in order, can be rejected after a summary hearing. Validly nominated candidates can withdraw within 2 days after nominations have been scrutinized. Oath or affirmation. It is necessary for a candidate to make and subscribe an oath or affirmation before an officer authorized by the Election Commission. For any particular election, the authorized persons are, principally, the returning officer and the assistant returning officer for the constituency. The candidate, in person, is required to make the oath or affirmation immediately after presenting his nomination papers, and in any case not later than the day previous to the date of the scrutiny. 6. Election campaign and model code. The campaign is the period when the political parties put forward their candidates and arguments with which they hope to persuade people to vote for their candidates and parties. The official campaign lasts at least 2 weeks from the drawing up of the list of nominated candidates and officially ends 48 hours before polling closes. During the election campaign, the political parties and contesting candidates are expected to abide by a model code of conduct evolved by the Election Commission on the basis of a consensus among political parties. The model code lays down broad guidelines as to how the political parties and candidates should conduct themselves during the election campaign. It is intended to maintain the election campaign on healthy lines, avoid clashes and conflicts between political parties or their supporters, and to ensure peace and order during the campaign period and thereafter, until the results are declared. The model code also prescribes guidelines for the ruling party either at the center or in the state to ensure that a level field is maintained and that no cause is given for any complaint that the ruling party has used its official position for the purposes of its election campaign. Once an election has been called, parties issue manifestos detailing the programs they wish to implement if elected to government, the strengths of their leaders, and the failures of opposing parties and their leaders. Rallies and meetings where the candidates try to persuade, cajole, and enthuse supporters and denigrate opponents are held throughout the constituencies. Polling days. Polling is normally held on a number of different days in different constituencies to enable the security forces and those monitoring the election to keep law and order and ensure that voting during the election is fair. Elections. M. 575. Ballot papers and symbols. After nomination of candidates is complete, a list of competing candidates is prepared by the returning officer, and ballot papers are printed. Ballot papers are printed with the names of the candidates, in languages set by the Election Commission, and the symbols allotted to each of the candidates. Candidates of recognized parties are allotted their party symbols. Since 1998, the Commission has increasingly used electronic voting machines (EMVs) instead of ballot boxes. In 2003, all state elections and by-elections were held using EVMs. Encouraged by this, the Commission took a historic decision to use only EVMs for the Lok Sabha election in 2004. More than 9 million EVMs were used in this election. Electronic voting machine. An electronic voting machine (EVM) is a simple electronic device used to record votes in place of ballot papers and boxes which were used earlier in conventional voting system. The advantages of the EVM over the traditional ballot paper ballot box system are given here. It eliminates the possibility of invalid and doubtful votes which, in many cases, are the root causes of controversies and election petitions. 2. It makes the process of counting of votes much faster than the conventional system. 3. It reduces to a great extent the quantity of paper used, thus saving a large number of trees, making the process eco-friendly. 4. It reduces cost of printing almost nil, as only one sheet of ballot paper is required for each polling station. 8. The Model Code of Conduct was agreed to by all the political parties in 1968. The Election Commission first effectively put to use the Model Code of Conduct in the year 1991 to ensure fair elections and a level playing field. Voting procedure. Voting is by secret ballot. Polling stations are usually set up in public institutions, such as schools and community halls. TB enable as many electors as. General Elections 2009, Reference Handbook, Press Information Bureau, Government of India, p. 181. 576, p. Indian Polity. Possible to vote. The officials of the Election Commission try to ensure that there is a polling station within 2 kilometers of every voter, and that no polling stations should have to deal with more than 1,200 voters. Each polling station is open for at least 8 hours on the day of the election. On entering the polling station, the elector is checked against the electoral roll. An identity document is verified. Indelible ink is applied on the left forefinger, and a voter slip is issued, and the voter is allowed to cast his vote by activating the ballot button in the control unit by the presiding officer. Supervising elections. The Election Commission appoints a large number of observers to ensure that the campaign is conducted fairly and that people are free to vote as they choose. Election expenditure observers keeps a check on the amount that each candidate and party spends on the election. Media coverage. In order to bring as much transparency as possible to the electoral process, the media are encouraged and provided with facilities to cover the election, although subject to maintaining the secrecy of the vote. Media persons are given special passes to enter polling stations to cover the poll process and the counting halls during the actual counting of votes. Media are also free to conduct opinion polls. The Election Commission has stipulated that the results of opinion polls cannot be published between 2 days before the start of polling and after the close of poll in any of the constituencies. Similarly, the results of exit polls can only be published after half an 9. The electoral roll is a list of all people in the constituency who are registered to vote in Indian elections. Only those people with their names on the electoral roll are allowed to vote. The electoral roll is normally revised every year to add the names of those who are to turn 18 on the January 1st of that year or have moved into a constituency, and to remove the names of those who have died or moved out of a constituency. Hour of the end of polling hours on the last day of poll. Counting of votes. After the polling has finished, the votes cast in the EVM are counted under the supervision of returning officers and observers appointed by the Election Commission. After the counting of votes is over, the returning officer declares the name of the candidate to whom the largest number of votes have been given as the winner and as having been returned by the constituency to the concerned house. Elections to the Lok Sabha are carried out using a first-past-the-post electoral system. The country is split up into separate geographical areas, known as constituencies, and the electors can cast one vote each for a candidate, the winner being the candidate who gets the maximum votes. Elections to the state assemblies are carried out in the same manner as for the Lok Sabha election, with the states and union territories divided into single-member constituencies and the first-past-the-post electoral system used. The Election Commission compiles the complete list of members elected and issues an appropriate notification for the due constitution of the House. With this, the process of elections is complete, and the President, in case of the Lok Sabha, and the governors of the concerned states, in case of state assemblies, can then convene their respective houses to hold their sessions. Election petitions. Any elector or candidate can file an election petition if he or she thinks there has been malpractice during the election. An election petition is not an ordinary civil suit, but treated as a contest in which the whole constituency is involved. Election petitions are tried by the High Court of the state involved, and if upheld, can even lead to the restaging of the election in that constituency. Till now, 17 general elections have been held to the Lok Sabha. The results of these elections are summarized in Table 80.1. Elections 577. Table 80.1 Results of Lok Sabha elections. General elections, year, elective seats won by parties. First, 1952, 489 Congress 364, Communist 16, Socialist 12, Camp PP 9, Janison 3. Second, 1957, 494 Congress 371, Communist 27, Praja Socialist 19, Janison 4. Third, 1962, 494 Congress 361, Communist 29, Svatantra 18, Janison 14. Praja Socialist 12, Socialist 6. Fourth, 1967, 520 Congress 283, Svatantra 44, Janison 35, CPI 23, CPM 19. Sangyupta Socialist 23, Praja Socialist 13. Fifth, less than 1971, 51 Congress 352, CPM 25, CPI 24, DMK 23, Janison 21, Svatantra 7. Socialist 5. Sixth, 1977, 542 Janata 298, Congress 154, CPM 22, CPI 7, DMK 18. Seventh, 1980, 542 Congress 353, Janata, Secular, 41, Janata 31, CPM 36, CPI 11, DMK 16. J. R. versus 8, 1984, 542 Congress 415, Top 28. CPM 22, CPI 6, Janata 10, DMK 12, BJP 2. 9th, 1989, 543 Congress 197, Janata Dal 141, BJP 86, CPM 32, CPI 12, DMK 11. TDP 2. 10th, 1991, 543 Congress 232, BJP 119, Janata Dal 59, CPM 35, CPI 13, TDP 13. DMK 11. 11th, 1996, 543 BJP 161, Congress 140, Janata Dal 46, CPM 32, TMCM 20, DMK 17. SP 17, TDP 16, SS 15, CPI 12, BSB 11. 12th, 1998, 543. BJP 182, Congress 141, CPM 32, DMK 18, TDP 12, SP 20, Samata 12, RJD 17. 13th, 1999, 543 BJP 182, Congress 114, CPM 33, TDP 29, SP 26, JD, U 20, SS 15. BSP 14, DMK 12, BJD 10, LA DMK 10. 14th, 2004, 543 Congress 145, BJP 138, CPM 43, SP 36. RJD 24, BSP 19, DMK 16. Shiv Sena 12, BJD 11, CPI 10. 15th, 2009, 543 Congress 206, BJP 116, SP 23, BSP 21, JD, U 20, Trinamool 19, DMK 18, CPM 16, BJD 14, Shiv Sena 11, NCP 9, LADMK 9, TDP 6, RLD 5, CPI 4, RJD 4, SAD 4. 16th, 2014, 543 BJP 282, Congress 44, LADMK 37, Trinamool 34, BJD 20, Shiv Sena 18, TDP 16, TRS 11, CPM 9, YSR Congress 9, NCP 6, LJP 6, SP 5, AAP 4, RJD 4, SAD 4. 17th, 2019, 543 BJP 303, Congress 52, DMK 23, Trinamool 22, YSR Congress 22. Shiv Sena 18, JD, U 16, BJD 12, BSP 10, TRS 9, LJP 6, NCP 5, SP 5. Note: the seats won by other smaller parties and independents are not included in this table. $578 Indian Polity. Table 80.2 Articles related to elections at a glance. 324. Superintendence, direction, and control of elections to be vested in an election commission. 325. No person to be ineligible for inclusion in, or to claim to be included in a special electoral roll on grounds of religion, race, caste, or sex. 326. Elections to the House of the People and to the legislative assemblies of states to be on the basis of adult suffrage. 327. Power of Parliament to make provision with respect to elections to legislatures. 328. Power of legislature of a state to make provision with respect to elections to such legislature. 329. Bar to interference by courts in electoral matters. 329a. Special provision as to elections to Parliament in the case of Prime Minister and Speaker, repealed, Chapter 81 Election Laws. Representation of the People Act. 1950 Articles 81 and 170 of the Constitution of India laid down the maximum number of seats in Parliament and in legislative assemblies of states and also certain principles to be followed in allocating seats in the House of People among the states and in the state legislative assemblies, but have left the actual allocation of such seats to be provided by the law. Similarly, Article 171 of the Constitution of India lays down the maximum and minimum number of seats in the Legislative Council of a state, and also specify the various methods in which the seats shall be filled. But the actual number of seats to be filled by each such method has been left to be provided by law. Therefore, the Representation of the People Act, 1950, was enacted to provide for the allocation of seats in the House of the People and in the legislative assemblies and legislative councils of states. The Act also sought to confer on the President the powers to delimit, after consultation with the Election Commission, the various constituencies for the purpose of elections to fill seats in the House of the People and in the legislative assemblies and legislative councils of states. The Act further provided for the registration of electors for parliamentary constituencies and for the assembly and council constituencies, and the qualifications and disqualifications for such registration. The Act also makes the following other provisions relating to the elections. 1. Election officers like chief electoral officers, district election officers, electoral registration officers, and so on. 2. Manner of filling seats in the Council of States to be filled by representatives of Union territories. 3. Local authorities for purposes of elections to the state legislative councils. 4. Barring the jurisdiction of civil courts. Representation of the People Act, 1951. The Representation of the People Act, 1950 did not contain all the provisions relating to elections but merely provided for the allocation of seats in and the delimitation of constituencies for the purpose of elections to the House of People and legislatures of states, the qualifications of voter at such election, and the preparations of electoral rolls. The provisions for the actual conduct of elections to the Houses of Parliament and to the House or Houses of the legislature of each state, the qualifications and disqualifications for the membership of these houses, the corrupt practices and other election offenses, and the decision of election disputes were all left to be made in a subsequent measure. In order to provide for these provisions, the Representation of the People Act, 1951 was enacted. Broadly speaking, this act contains provisions relating to the following electoral matters. 1. Qualifications and disqualifications for membership of Parliament and state legislatures. 2. Notification of general elections. 3. Administrative machinery for the conduct of elections. 4. Registration of political parties. 5. Conduct of elections. The conduct of elections include the following matters. A. Nomination of candidates. B. Candidates and their agents. C. General procedure at elections. D. The poll. E. Counting of votes. K. Multiple elections. G. Publication of election results and nominations. H. Declaration of assets and liabilities. I. Election expenses. 6. Free supply of certain material to candidates of recognized political parties. 7. Disputes regarding elections. The provisions of the Act with respect to disputes regarding elections are related to the following matters. I. Presentation of election petitions to High Court. T. All of election petitions. 3. Withdrawal and abatement of election petitions. 4. Appeals to Supreme Court. V. Costs and security for costs. 8. Corrupt practices and electoral offenses. 9. Powers of Election Commission in connection with inquiries as to disqualifications of members. 10. By-elections and time limit for filling vacancies. 11. Miscellaneous provisions relating to elections. 12. Barring the jurisdiction of civil courts. Delimitation. ACT 2002 Articles 82 and 170 of the Constitution of India provide for readjustment and the division of each state into territorial constituencies, parliamentary constituencies, and assembly constituencies, on the basis of the 2001 census by such authority and in such manner as Parliament may, by law, determine. Further, Articles 330 and 332 of the Constitution of India provide for refixing the number of seats reserved for the scheduled castes and the scheduled tribes in the House of the People and legislative assemblies of the states on the basis of the 2001 census. The previous delimitation of parliamentary and assembly constituencies is based on the 1971 census. The uneven growth of population in different constituencies in different parts of the country as well as within the same state, as also continuous migration of people electorate from one place to other, especially from rural areas to urban areas, have resulted in strikingly differing sizes of electoral constituencies even within the same state. Therefore, the Delimitation Act, 20021, was enacted to set up a delimitation commission for the purpose of effecting delimitation on the basis of the 2001 census so as to correct the aforesaid distortion in the sizes of electoral constituencies. Other acts relating to elections. 1. Parliament, Prevention of Disqualification, Act, 1959 declares that certain offices of profit under the government shall not disqualify the holders thereof for being chosen as, or for being, members of Parliament. 2. Scheduled Castes and Scheduled Tribes Orders, Amendment, Act, 1976 provides for the inclusion in, and the exclusion from, the list of scheduled castes and scheduled liabs of certain castes and tribes for the readjustment. Earlier, the Delimitation Acts were enacted in 1952, 1962, and 1972. Election Laws 581. Of Representation of Parliamentary and Assembly Constituencies. 3. Government of Union Territories Act, 1963. 4. Government of National Capital Territory of Delhi Act, 1991. 5. Presidential and Vice Presidential Elections Act, 1952 regulates certain matters relating to or connected with elections to the offices of the President and Vice President of India. Rules relating to elections. 1. Registration of Electors Rules, 1960 provide for the preparation and publication of electoral rolls. 2. Conduct of Elections Rules, 1961 facilitates conduct of fair and free elections to the Parliament and state legislatures. 3. Prohibition of Simultaneous Membership Rules, 1950. 4. Members of Lok Sabha Disqualification on Ground of Defection, Rules, 1985. 5. Members of Rajya Sabha Disqualification on Ground of Defection, Rules, 1985. 6. Presidential and Vice Presidential Elections Rules, 1974. 7. Members of Lok Sabha Declaration of Assets and Liabilities, Rules, 2004. 8. Members of Rajya Sabha Declaration of Assets and Liabilities, Rules, 2004. Orders relating to elections. 1. Election Symbols, Reservation and Allotment, Order, 1968 provides for the specification, reservation, choice, and allotment of symbols at elections in parliamentary and assembly constituencies, for the recognition of political parties in relation thereto. 2. Registration of political parties, furnishing of additional particulars, Order. 1992 provides for furnishing of additional particulars by associations or bodies of individual citizens of India seeking registration as a political party with the Election Commission of India. These rules repealed the earlier presidential and vice presidential elections rules, 1952. Chapter Electoral Reforms. T. Committees related to electoral reforms underscore the various committees and commissions which have examined our electoral system, election machinery as well as the election process, and suggested reforms are mentioned here. 1. Joint Parliamentary Committee on Amendments to Election Laws, 1971-72. 2. The Committee was appointed in 1974 by Jaya Prakash Narayan, J.P., during his Tal Revolution movement. This unofficial committee submitted its report in 1975. 3. Dinesh Goswami Committee on Electoral Reforms, 1994. Vora Committee on the Nexus Between Crime and Politics, 1993. 5. Election Commission of India Recommendations on Electoral Reforms, 1998. 6. Indra Gupta Committee on State Funding of Elections, 1998. 17. Law Commission of India 170th Report on Reform of the Electoral Laws, 1999. G. National Commission to Review the Working of the Constitution, 2000 to 2002. It was headed by M.N. Venkatachalaya. In 1998, the BJP-led government appointed an 8-member committee on state funding of elections under the chairmanship of Indra Gupta, a former Home Minister. The committee submitted its report in 1999. It upheld the argument for introduction of state funding of elections. It stated that state funding of elections is constitutionally and legally justified and is in public interest. 9. Election Commission of India Report on Proposed Electoral Reforms, 2004. 10. Second Administrative Reforms Commission of India Report on Ethics and Governance, 2007. It was headed by Veerappa Moily. 11. Thunka Committee, Core Committee, was appointed in 2010 to look into the whole gamut of the election laws and electoral reforms. 12. J.S. Varma Committee Report on Amendments to Criminal Law, 2013. 13. Law Commission of India 244th Report on Electoral Disqualifications, 2014. 14. Law Commission of India 255th Report on Electoral Reforms, 2015. Based on the recommendations made by the above committees and commissions, various reforms have been introduced in our electoral system, election machinery, and election process. These can be studied under the following 4 heads. Electoral reforms before 1996, electoral reforms of 1996, electoral reforms after 1996, electoral reforms since 2010. Electoral reforms before 1996, lowering of voting age. The 61st Constitutional Amendment Act of 1988 reduced the voting age from 21 years to 18 years for the Lok Sabha as well as the Assembly elections. This was done in order to provide to the unrepresented youth of the country an opportunity to express their feelings and help them become a part of political process. Deputation to Election Commission in 19892. A provision was made that the officers and the staff engaged in preparation, revision, and correction of electoral rolls for elections are deemed to be on deputation to the Election Commission for the period of such employment. These personnel, during that period, would be under the control, superintendence, and discipline of the Election Commission. Representation of the People, Amendment, Act of 1988, with effect from 1989. 3 Ibid. 4 Ibid. 5 Ibid. 6 Annual Report 2013-14, Ministry of Law and Justice, Government of India, p. 67. Representation of the People, Amendment, Act, 1996. Increase in number of proposers in 19893. The number of electors who are required to sign as proposers and nomination papers for elections to the Rajya Sabha and State Legislative Council has been increased to 10% of the electors of the constituency or 10 such electors, whichever is less. This was done in order to prevent non-serious candidates from contesting frivolously. Electronic voting machines in 198945. A provision was made to facilitate the use of electronic voting machines (EVMs) in elections. The EVMs were used for the first time in 1998 on experimental basis in selected constituencies in the elections to the assemblies of Rajasthan, Madhya Pradesh, and Delhi. The EVMs were used for the first time in the general elections, entire state, to the Assembly of Goa in 1999. Booth capturing in 1989's, a provision was made for adjournment of poll or countermanding of elections in case of booth capturing. Booth capturing includes seizure of a polling station and making polling authorities surrender ballot papers or voting machines. 2. Taking possession of polling station and allowing only one's own supporters to exercise their franchise. 3. Threatening and preventing any elector from going to polling station. And 4. Seizure of the place being used for counting of votes. Electoral Reforms 583. Elector's Photo Identity Card, EPIC. The use of electors' photo identity cards by the Election Commission is surely making the electoral process simple, smoother, and quicker. A decision was taken by the Election Commission in 1993 to issue photo identity cards to electors throughout the country to check bogus voting and impersonation of electors at elections. The electoral roll is the basis for issue of EPICs to the registered electors. 6. Electoral Reforms of 1996. In 1990, the National Front government, headed by VP Singh, appointed a committee on electoral reforms under the chairmanship of Dinesh Goswami, the then law minister. The committee was asked to study the electoral system in detail and suggest measures for remedying the drawbacks within it. The committee, in its report submitted in 1990 itself, made a number of proposals on electoral reforms. Some of these recommendations were implemented in 19967. These are explained here. Listing of names of candidates. The candidates contesting elections are to be classified into 3 categories for the purpose of listing of their names. They are candidates of recognized political parties. The second, candidates of registered unrecognized political parties. 3. Other, independent candidates. Their names in the list of contesting candidates and in the ballot papers has to appear separately in the above order, and in each category these have to be arranged in the alphabetical order. Disqualification for insulting the National Honor Act. A person who is convicted for the following offenses under the Prevention of Insults to National Honor Act of 1971 is disqualified to contest in the elections to the Parliament and state legislature for 6 years. 584 Indian Polity. I. Offense of insulting the national flag. 2. Offense of insulting the Constitution of India. 3. Offense of preventing the singing of national anthem. Prohibition on the sale of liquor. No liquor or other intoxicants are to be sold or given or distributed at any shop, eating place, hotel, or any other place, whether public or private, within a polling area during the period of 48 hours ending with the hour fixed for the conclusion of poll. Number of proposers. The nomination of a candidate in a parliamentary or assembly constituency should be subscribed by 10 registered electors of the constituency as proposers, if the candidate is not sponsored by a recognized political party. In the case of a candidate sponsored by a recognized political party, only one proposer is required. This was done in order to discourage non-serious people from contesting the elections. Death of a candidate earlier. In case of death of a contesting candidate before the actual polling, the election used to be countermanded. Consequently, the election process had to start all over again in the concerned constituency. But now, the election would not be countermanded on the death of a contesting candidate before the actual polling. However, if the deceased candidate belonged to a recognized political party, the party concerned would be given an option to propose another candidate within 7 days. Time limit for by-elections. Now, by-elections are to be held within 6 months of occurrence of the vacancy in any House of Parliament or a state legislature. But this condition is not applicable in 2 cases. I. Where the remainder of the term of the member whose vacancy is to be filled is less than 1 year. Or 2. When the Election Commission, in consultation with the central government, certifies that it is difficult to hold the by-elections within the said period. Holiday-dated employees. On the polling day, the registered voters employed in any trade, business, industry, or any other establishment are entitled to a paid holiday on the polling day. This rule applies even to the daily wagers. However, this rule is not applicable in the case of a voter whose absence may cause danger or substantial loss in respect of the employment in which he is engaged. Contestants restricted to 2 constituencies. A candidate would not be eligible to contest for more than 2 parliamentary or assembly constituencies at a general election or at the by-elections, which are held simultaneously. Similar restrictions are imposed for biennial elections and by-elections to the Rajya Sabha and the state legislative councils. Prohibition of arms. Entering into the neighborhood of a polling station with any kind of arms is to be considered a cognizable offense. But these provisions are not applicable to the returning officer, presiding officer, any police officer, or any other person appointed to maintain peace and order at the polling station. Effective campaigning period. Reduce. The minimum gap between the last date for withdrawal of candidature and the polling date has been reduced from 20 to 14 days. Electoral reforms after 1996. Presidential and vice presidential elections in 1997. The number of electors as proposers and seconders for contesting election to the office of the president was increased from 10 to 50 and to the office of the vice president from 5 to 20. Further, the amount of security deposit was increased from $2, 500 to 15,000 for contesting election to both the offices of president and vice president to discourage frivolous candidates. The Presidential and Vice Presidential Elections Amendment Act, 1997. Requisitioning of staff for election duty in 19989. A provision was made whereby the employees of local authorities, nationalized banks, universities, LIC, government undertakings, and other government-aided institutions can be requisitioned for deployment on election duty. 12. Representation of the People Amendment Act, 2003. Election and Other Related Laws Amendment Act, 2003. 14. Ibid. Voting through postal ballot in 199910. A provision was made for voting by certain classes of persons through postal ballot. Thus, any class of persons can be notified by the Election Commission in consultation with the government, and the persons belonging to such notified class can give their votes by postal ballot and not in any other manner at elections in their constituency or constituencies. Facility to opt to vote through proxy in 200311. The facility to opt to vote through proxy was provided to the service voters belonging to the armed forces and members belonging to a force to which provisions of the Army Act apply. Such service voters who opt to vote through proxy have to appoint a proxy in a prescribed format and intimate the returning officer of the constituency. Declaration of criminal antecedents, assets, etc. By candidates in 2003, the Election Commission issued an order directing every candidate seeking election to the Parliament or a state legislature to furnish on his or her nomination paper the information on the following matters. I. Whether the candidate has been convicted or acquitted or discharged in any criminal offense in the past. Whether Husha was imprisoned or fined. 2. Prior to 6 months of filing nomination, whether the candidate is accused of any pending case, of any offense punishable with imprisonment for 2 years or more, and in which charges were framed. 9. Representation of the People Amendment Act, 1998. I-0 Representation of the People Amendment Act, 1999. Election Laws Amendment Act, 2003 and Conduct of Elections Amendment Rules, 2003. Electoral Reforms 585. Or cognizance was taken by a court. If so, the details thereof. 3. The assets, immovable, movable, bank balances, etc. of a candidate and his/her spouse, and that of dependents. 4. Liabilities, if any, particularly whether there are any dues of any public financial institution or government dues. V. The educational qualifications of the candidate. Furnishing of any false information in the affidavit is now an electoral offense. Changes in Rajya Sabha elections. In 2003, the following two changes were introduced with respect to elections to the Rajya Sabha. 12. Domicile or residency requirement of a candidate contesting an election to the Rajya Sabha was removed. Prior to this, a candidate had to be an elector in the state from where Husha was to be elected. Now, it would be sufficient if Husha is an elector in any parliamentary constituency in the country. 2. Introducing open ballot system instead of secret ballot system for elections to the Rajya Sabha. This was done to curb cross-voting and to wipe out the role of money power during Rajya Sabha elections. Under the new system, an elector belonging to a political party has to show the ballot paper after marking his/her vote to a nominated agent of that political party. Exemption of traveling expenditure as per a provision of 200,313. The traveling expenditure incurred by the campaigning leaders of a political party shall be exempted from being included in the election expenses of the candidate. Free supply of electoral rolls, etc. According to a 2003 Provision 14, the government should supply, free of cost, the copies of the Electoral 586 Indian Polity, royals and other prescribed material to the candidates of recognized political parties for the Lok Sabha and Assembly elections. Further, the Election Commission should supply specified items to the voters in the constituencies concerned or to the candidates set up by the recognized political parties. Parties entitled to accept contribution in 200315. The political parties were entitled to accept any amount of contribution from any person or company other than a government company. They have to report any contribution in excess of 20,000 to the Election Commission for making any claim to any income tax relief. Besides, the companies would get income tax exemption on the amount contributed. 18. Representation of the People Amendment Act 2009 with effect from February 1, 2010. 19 IBIT. 20 IBIT. 21 IBIT. Allocation of time on electronic media under a 2003 Provision 6. The Election Commission should allocate equitable sharing of time on the cable television network and other electronic media during elections to display or propagate any matter or to address public. This allocation would be decided on the basis of the past performance of a recognized political party. Introduction of Braille signage features in EVMs. The Commission received representations from the various associations of visually impaired persons for introduction of Braille signage features in the EVMs to facilitate the visually impaired voters to cast their votes without the help of attendant. The Commission considered the proposal in detail and tried the Braille signage feature in the EVMs during the by-election to the Asifnagar Assembly constituency of Andhra Pradesh held in 2004. In 2008, it was tried in all the Assembly constituencies of NCT of Delhi during Assembly elections. The Commission introduced similar Braille signage features on the electronic voting machines during the general elections to the 15th Lok Sabha, 2009, and simultaneous Assembly elections in some states. 1715 IBIT. 1B IBIT. Election Commission of India Circular dated February 12, 2009. F. Electoral reforms since 2010. Restrictions imposed on exit polls according to a 2009 Provision 18. Conducting exit polls and publishing results of exit polls would be prohibited during the election to Lok Sabha and state legislative assemblies. Thus, no person shall conduct any exit poll and publish or publicize by means of the print or electronic media or disseminate in any other manner the result of any exit poll during the period notified by the Election Commission in this regard. Exit poll is an opinion survey regarding how electors have voted at an election or how all the electors have performed with regard to the identification of a political party or candidate in an election. Time limit for submitting a case for disqualification in 2009-1920. A provision was made for the simplification of the procedure for disqualification of a person found guilty of corrupt practices. It provided for a 3-month time limit within which the specified authority will have to submit the case of a person found guilty of corrupt practice to the President for determination of the question of disqualification. All officials included in corrupt practice in 2009. A provision was made for the inclusion of all officials, whether in the government service or not, appointed or deputed by the Election Commission in connection with the conduct of elections, within the scope of corrupt practice of obtaining any assistance by a candidate for the furtherance of the prospects of his election. Increase in security deposit in 2009-21. The amount of security deposit to be paid by the candidates contesting elections to the Lok Sabha was increased from T10,000 to T25,000 for the general candidates and from 5,000 to 12,500 for SC and ST candidates. Similarly, The security deposit in the case of elections to the State Legislative Assembly was increased from $5,000 to $10,000 for the general candidates and from $2,500 to $5,000 for the SC and ST candidates. This was done in order to check the multiplicity of non-serious candidates. Appellate authority within the district in 200922. A provision was made for appointment of an appellate authority within the district against the orders of the electoral registration officers, instead of the chief electoral officer of the state. Thus, an appeal against any order of the electoral registration officer of a constituency during continuous updation of the electoral roll will now lie before the district magistrate or additional district magistrate or executive magistrate or district collector or an officer of equivalent rank. A further appeal against any order of the district magistrate or additional district magistrate will now lie before the chief electoral officer of the state. 22 Ibid. 23 Representation of the People Amendment Act 2010. Voting rights to citizens of India living abroad in 201023. A provision was made to confer voting rights to the citizens of India residing outside India due to various reasons. Accordingly, every citizen of India, A, whose name is not included in the electoral roll, B, who has not acquired the citizenship of any other country, C, who is absent from his place of ordinary residence in India owing to his employment, education, or otherwise outside India, whether temporarily or not, shall be entitled to have his name registered in the electoral roll in the Parliamentary Assembly constituency in which his place of residence in India as mentioned in his passport is located. Online enrollment in the electoral roll in 2013. A provision was made for online filing of applications for enrollment in the electoral roll. For this purpose, the central government, after consulting the Election Commission, made the rules known as the Electoral Reforms 587. Registration of the Electors Amendment Rules, 2013. These rules made certain amendments in the Registration of Electors Rules, 1960. Introduction of Nota Option 24. According to the directions of Supreme Court, the Election Commission made provision in the ballot papers EVMs for none of the above Nota options so that the voters who come to the polling booth and decide not to vote for any of the candidates in the fray are able to exercise their right not to vote for such candidates while maintaining the secrecy off-tier ballot. The provision for Nota has been made since general elections to state legislative assemblies in 2013 and continued in the general elections to state legislative assemblies in 2014 along with the general elections to the 16th Lok Sabha 2014. Even if the number of electors opting for Nota options is more than the number of votes polled by any of the candidates, the candidate who secures the largest number of votes has to be declared elected. Introduction of VPT 25. The Voter Verifiable Paper Audit Trail is an independent system attached with the EVMs that allows the voters to verify that their votes are cast as intended. When a vote is cast, a slip is printed and remains exposed through a transparent window for 7 seconds, showing the serial number, name, and symbol of the candidate. Thereafter, the receipt automatically gets cut and falls into the sealed drop box of the VPT. The system allows a voter to challenge his vote on the basis of the paper receipt. The law for using WPAs was amended in 2013. In 2013, the Supreme Court of India had permitted the ECI to introduce VPT in a phased manner, calling it an indispensable requirement of free and fair elections. The court had felt that introducing VPT would ensure the accuracy of the voting system and electoral statistics. Pocketbook 2015, Election Commission of India, p. 96. 25 India Votes, the General Elections 2014, Election Commission of India, p. 18. 588 v-Indian Polity. Also help in manual counting of votes in case of dispute. The PATs were first used in by-election to the Naxon Assembly constituency of Nagaland held in 2013. Persons in jail or police custody can contest elections in 2013. 2. When the Supreme Court upheld an order of the Patna High Court declaring that a person who has no right to vote by reason of being in jail or in police custody is not an elector and is, therefore, not qualified to contest the elections to the Parliament or the state legislature. In order to negate this order of the Supreme Court, the following two new provisions 267 have been included in the Representation of the People Act, 1951. 26 Chief Election Commissioners. Jan Chakadar, 2013. 27 v. The Representation of People, Amendment and Validation, Act, 2013. 26 Lily Thomas vs. Union of India, 2013. The first provision expressly provides that by reason of the prohibition to vote, either due to in jail or in police custody, a person whose name has been entered in the electoral roll shall not cease to be an elector. 2. The second provision expressly provides that a member of Parliament or the state legislature shall be disqualified only if Husha is so disqualified under the provisions contained in the Act and on no other ground. Consequently, the persons in jail or in police custody are allowed to contest the elections. Immediate disqualification of convicted MPs and MLAs in 2013. 28 *. The Supreme Court held that charge-sheeted members of Parliament and MLAs, on conviction for offences, will be immediately disqualified from holding membership of the House without being given 3 months' time for appeal, as was the case before. The concerned bench of the court struck down as unconstitutional Section 8(4) of the Representation of the People Act, 1951, that allows convicted lawmakers a 3-month period for filing appeal to the higher court and to get a stay of the conviction in 29 sentences. In order to nullify the above ruling of the Supreme Court, the Representation of the People Second Amendment Invalidation Bill 2013 was introduced in the Parliament. However, the bill was later withdrawn by the government. Photos of candidates on EVMs and ballot papers 30 according to an Election Commission order, in any election being held after May 1, 2015. The ballot papers and EVMs will carry the picture of the candidate with his or her name and party symbol to avoid confusion among the electorates in constituencies where namesakes are contesting. The Commission has noted that there are many cases where candidates with same or similar names contest from the same constituency. Although appropriate suffixes are added to the names of candidates in the event of 2 or more candidates having same name, the Commission considers that additional measures are required for removing confusion in the minds of electors at the time of voting. The Commission explained that if a candidate fails to provide the photograph, it shall not be a ground for the rejection of the nomination of the candidate. Ceiling on cash donations lowered. In 2017 budget, the limit for anonymous cash donations by any individual to a political party has been lowered from $20,000 to $2,000. This means that now the political parties cannot receive more than $2,000 as cash donations. However, they are not required to inform the Election Commission of India the details of persons who donate under $2,000. They must keep records of persons making above $2,000 donations. 29. The Hindu MPs, MLAs to be disqualified on date of criminal conviction, July 10, 2013. The Economic Times, electronic voting machines to carry photos of candidates, CEC, September 9, 2015. Cap on corporate contributions lifted. In 2017 budget, the limit on corporate contributions from 7.5% of the net profit of a company's past 3 financial years has been removed. This means that now a company can donate any amount of money to any political party. Further, the obligation of the company to report such donations in its profit and loss account has also been lifted. Introduction of electoral bonds. In 2018, the central government notified the electoral bond scheme. This scheme was announced in the 2017 budget. It is touted as an alternative to cash donations made to the political parties. It is aimed at bringing clean money and substantial transparency into the system of political funding. The salient features of the scheme are: The electoral bond means a bond issued in the nature of promissory note, which is a bearer banking instrument and does not carry the name of the buyer or payee. 2. The electoral bonds may be purchased by a citizen of India or entities incorporated or established in India. 3. The electoral bonds can be used for making donations to only those registered political parties which have secured not less than 1% of the votes polled in the last general election to the Lok Sabha or the State Legislative Assembly. 4. The electoral bonds can be encashed by an eligible political party only through a bank account with the authorized bank. The electoral bonds are issued in the denomination of L 000 T 0 000 carat 1 0 0 0 0 carat 10 0 0 0 0 and M 0 0 0 0 0 0. 6. The information furnished by the buyer is treated confidential by the authorized bank and is not to be disclosed to any authority for any purposes, except when demanded by a competent court or upon registration of criminal case by any law enforcement agency. Electoral Reforms 589. Foreign funding allowed. In 2018 budget, the receiving of foreign funds by the political parties has been allowed. In other words, the political parties can now receive funds from the foreign companies. Accordingly, the Foreign Contribution Regulation Act 2010 has been amended. Under this amendment, the definition of a foreign company has been modified. Election Laws Amendment Act 2021. This Amendment Act provided for the following electoral reform. It enabled the linking of electoral roll data with the Aadhaar ecosystem in order to curb the menace of multiple enrollment of the same person in different places. 2. It specified the January 1st, April 1st, July 1st, and October 1st in a calendar year as qualifying dates in relation to the preparation or revision of electoral rolls. Before this, only the January 1st of the year was the qualifying date in this regard. 3. It allowed spouses of service voters to cast their vote in person or through postal ballot. By this effect, it substituted the word wife with the word spouse in order to make the election laws gender neutral. 31. 4. It enabled the requisition of premises that are needed for the purpose of counting, storage of voting machines, including WBTK, and poll-related material after a poll has taken place, and also for the purpose of accommodation of security forces and polling personnel. Before this, the requisition of premises was allowed for the purpose of being used as polling stations or storage of ballot boxes after a poll has taken place. In other words, this Amendment Act has expanded the grounds for the requisition of premises. 31. Service voters include those holding a service qualification, such as members of the armed forces or central government employees posted outside India, registered in their resident constituency, and their spouses living with them. Chapter 83 Voting Behavior. F meaning. Voting behavior is also known as electoral behavior. It is a form of political behavior. It implies the behavior of voters in the context of elections in a democratic political system. Voting behavior, or the study of voting behavior, is defined in the following way: Plano and Riggs. Voting behavior is a field of study concerned with the ways in which people tend to vote in public elections and the reasons why they vote as they do. Gordon Marshall. The study of voting behavior invariably focuses on the determinants of why people vote as they do and how they arrive at the decisions they make. 1. David Robertson, The Penguin Dictionary of Politics, 2nd edition, 1993, p. 485. For K.R. Acharya, ed. Perspectives on Indian Government and Politics, 2nd edition, 1991, S. Chand and Company Ltd. p. 403. Otnam Kalabadu. Voting behavior may be defined as the behavior that explicitly reflects voters' choices, preferences, alternatives, ideologies, concerns, agreements, and programs in respect of various issues, questions pertaining to the society and nation. 2. T. Significance. Psephology, a branch of political science, deals with the scientific study of voting behavior. This is a new term popularized by the Gordon Marshall, Oxford Dictionary of Sociology, 1st Indian edition, 2004, p. 696. 2. Oinam Kalabadu, Electoral Politics in Manipur, 1980 to 1995, unpublished Ph.D. Thesis submitted to the Manipur University, 1998. American political scientists and political sociologists. The recorded history of voting goes back, at least, to the Greek polis. The modern word for the study of voting behavior, psephology, derives from the classical Greek psephos, the piece of pottery on which certain votes, mainly about the banishment of those seen as dangerous to the state, were inscribed. 3. The study of voting behavior is significant for the following reasons. 1. It helps in comprehending the process of political socialization. 2. It helps in examining the internalization of democracy as a value among the elite as well as masses. 3. It emphasizes the real impact of revolutionary ballot box. 4. It enables to throw light as to how far the electoral politics continue or break with the past. 5. It helps to measure whether it is modern or primordial in the context of political development. According to N.G.S. Keeney, voting behavior can be regarded as 1. A mode of legitimizing democratic rule. 2. Instancing participation in the political process involving integration into the political community. 3. Instancing an act of decision-making. 4. A role action involving definite political orientation embedded in a particular type of political culture. Or 5. A direct relation of the individual citizens to the formal government. T. Determinants. Indian society is highly diversified in nature and composition. Hence, voting behavior in India is determined or influenced by multiple factors. These several factors can be divided into 2 broad categories, namely, socioeconomic factors and political factors. These are explained below. 1. Caste. Caste is an important factor influencing the behavior of voters. Politicization of caste and casteism in politics has been a remarkable feature of Indian politics. Rajni Kothari, an eminent political analyst, said Indian politics is casteist and caste is politicized. While formulating their election strategies, the political parties always take into account the factor of caste. Paul Brass has very well explained the role of caste factor in the Indian voting behavior in the following way. At the local level, in the countryside, by far the most important factor in voting behavior remains caste solidarity. Large and important castes in a constituency tend to back either a respected member of their caste or a political party with whom their caste members identify. 5. Paul R. Brass, The Politics of India Since Independence, 2nd edition, Cambridge University Press, pp. 97 to 98. Charisma means exceptional and attractive qualities of a leader. 2. Religion. Religion is another significant factor which influences the electoral behavior. Political parties indulge in communal propaganda and exploit the religious sentiments of the voters. The existence of various communal parties has further added to the politicization of religion. Despite India being a secular nation, no political party ignores the influence of religion in electoral politics. 3. Language. Linguistic considerations of the people influence their voting behavior. Voting behavior 591. During elections, the political parties arouse the linguistic feelings of the people and try to influence their decision-making. The reorganization of states, in 1956 and later, on language basis clearly reflects the significance of language factor in Indian politics. The rise of some political parties like DMK in Tamil Nadu and TDP in Andhra Pradesh can be attributed to the linguism. 4. Region. Regionalism and sub-regionalism play an important role in voting behavior. These parochial feelings of subnationalism led to the emergence and perpetuation of regional parties in various states. These regional parties appeal to the electorate on the ground of regional identities and regional sentiments. Sometimes, the secessionist parties call for the boycott of elections. 5. Personality. The charismatic personality of the party leader plays an important role in electoral behavior. Thus, the towering image of Jawaharlal Nehru, Indira Gandhi, Rajiv Gandhi, Jai Prakash Narayan, Atal Bihari Vajpayee, and Narendra Modi has significantly influenced the electorate to vote in favor of their parties. Similarly, at the state level also, the charismatic personality of the regional party leader has been a significant factor of popular support in the elections. 6. Money. The role of money factor cannot be overlooked in explaining the voting behavior. Despite the limitations on the election expenditures, crores of rupees are spent on elections. The voters seek money or liquor or goods in return for their votes. In other words, votes are freely exchanged for notes. However, money can influence the decisions of the voters only in the normal circumstances and not in a wave election. Paul Brass has very well explained the meaning of a wave election in the following way. A wave election is one in which a clear tendency begins to develop among the electorate in a single direction and in favor of a national party or its leader. It is based upon 592 Indian Polity, an issue or set of issues that transcend local calculations and coalition and draws the bulk of the uncommitted and wavering voters in the same direction as the word spreads from village to village and tea-stall to tea-stall. 7. Performance of the ruling party. On the eve of elections, every political party releases its election manifesto containing the promises made by it to the electorate. The performance of the ruling party is judged by the electorate on the basis of its election manifesto. The defeat of Congress Party in 1977 elections and that of Janata Party in 1980 elections illustrates that the performance of the ruling party influences the voting behavior. Thus, the anti-incumbency factor, which means dissatisfaction with the performance of the ruling party, is a determinant of electoral behavior. 8. Party identification. Personal and emotional association with political parties plays a role in determining voting behavior. People who identify themselves with a particular party will always vote for that party irrespective of its omissions and commissions. 9. Ideology. The political ideology professed by a political party has a bearing on the decision-making of the voters. Some people in the society are committed to certain ideologies like communism, capitalism, democracy, secularism, patriotism, decentralization, and so on. Such people generally support the candidates put up by the parties professing those ideologies. 10. Other factors. In addition to the above-explained factors, there are also various other factors which determine the voting behavior of the Indian electorate. These are mentioned below. I. Political events preceding an election like war, murder of a leader, corruption scandals, etc. 2. Economic conditions at the time of election like inflation, food shortage, unemployment, etc. 3. Factionalism, a feature of Indian politics from bottom to top levels. 4. Candidate orientation, v. Election campaign. 6. Political family background. 7. Role of media. 7. Paul R. Brass, the 1984 parliamentary elections in Uttar Pradesh, Asian Survey, June, 1986. Chapter W84 Coalition Government. F meaning. The term coalition is derived from the Latin word coalitio dash, which means to grow together. Thus, technically, coalition means the act of uniting parts into one body or whole. Politically, coalition means an alliance of distinct political parties. Coalition politics or coalition government has been defined in the following way. When several political parties join hands to form a government and exercise political power on the basis of a common agreed program agenda, we can describe the system as coalition politics or coalition government. 1. Coalitions usually occur in modern parliaments when no single political party can muster a majority of votes. 2 or more parties, who have enough elected members between them to form a majority, may then be able to agree on a common program that does not require too many drastic compromises with their individual policies, and can proceed to form a government too. Coalition denotes a cooperative arrangement under which distinct political parties, or at all events members of such parties, unite to form a government or ministry. 3. Coalition is a direct descendant of the exigencies of multi-party system in a democratic setup. It is a phenomenon of a multi-party government where a number of minority parties join hands for the purpose of running the government. A coalition is formed when many splinter groups in a house agree to join hands on a common platform by sinking their broad differences and form a majority in the House. 4. The features or implications of coalition politics or coalition government are very well summarized by J.C. Johari in the following way. 5. 1. Coalitions are formed for the sake of some reward, material or psychic. 2. A coalition implies the existence of at least two partners. 3. The underlying principle of a coalition system stands on the simple fact of temporary conjunction of specific interest. 4. Coalition politics is not a static but a dynamic affair as coalition players and groups dissolve and form new ones. 5. The keynote of coalition politics is compromise, and rigid dogma has no place in it. 6. A coalition government works on the basis of a minimum program, which Sani, NC, the theory of coalitions. Insani, N.C. ed. Coalition Politics in India, Jalandhar, 1971, pp. 17 to 18. Johari, J.C., Reflections on Indian Politics, New Delhi, 1974, pp. 3 to 5. Guy, K.K., Indian Government and Politics, 8th Carat edition, Kalyani Publishers, Ludhiana, 2012, p. 508. Robertson, D. The Penguin Dictionary of Politics, Carat Penguin Books, London, 1993, p. 73. Ogg, F.A., Encyclopedia of the Social Sciences, Volume 2, New York, 1957, p. 600. May not be ideal for each partner of the coalition. 7. Pragmatism and not ideology is the hallmark of coalition politics. In making political adjustments, principles may have to be set aside. 8. The purpose of a coalition adjustment is to seize power. In our country, we have seen coalitions coming up either before the elections or after the elections. The pre-poll coalition is considerably advantageous because it provides a common platform to the parties in order to woo the electorate on the basis of a joint manifesto. The post-election union is intended to enable constituents to share political power and run the government. T. Formation. In the first 4 Lok Sabha elections, 1952, 1957, 1962, and 1967, the Congress Party secured the required majority to form the government at the center. Even though there was a split in the Congress Party in 1969, the minority government of Indira Gandhi managed to continue with the outside support of the CPI, the DMK, and other parties. Again, the Congress Party won the 1971 elections and formed a single-party government. However, the dominant Congress Party was badly defeated in the 1977 elections. Since then, there have been a number of coalition governments at the center. The details are mentioned in TBLI 84.1. Table 84.1 Formation of coalition governments at the center. Period Coalition Prime Minister, Party Partners. 1. 1977 to 1979 Janata Party Morarji Desai Congress. O. Congress. O. Bharatiya Janasan. Bharatiya Lokdal, Socialist Party, Congress for Democracy, Chandrasekhar Group, former congressman, and others. 2. 1979 to 1980 Janata Party. Secular. Charan Singh Janata, S. Janata, S. and Congress, U. Congress, 1. Supported from outside. 3. 1989 to 1990 National Front VP Singh Janata Dal, TDP, DMK, AGP, and Congress, Socialist, BJP, and Left Party supported from outside. 5. 4. 1990 to 1991 Janata Dal, Socialist, or Samajwadi Janata Party. Chandrasekhar Janata Dal, S, or Samajwadi Janata Party. Janata Dal, S, and Janata Party. Congress, 1, supported from outside. 5. 1996 to 1997 United Front HD Dev Goda Janata Dal. Janata Dal, CPI, Congress, T, DMK, TOP, TMC, AGP, SP, and others. Congress and CPM supported from outside. 6. 1997 to 1998 United Front IK Gujral Janata Dal, CPI, TMC, SP, DMK, AGP, TDP, and others. Congress supported from outside. 7. 1998 to 1999 BJP-led coalition AB Vajpayee, BJP, AIDMK, BJD, Shiv Sena, Lakshakti, Arunachal Congress, Samata, Akal Dal, PMK, TRC, and others. TDP and Trinamool Congress supported from outside. 6. The Journal of Parliamentary Information, September 2000, XLVI 3, p. 394. Coalition Government 595. SI. No. Period Coalition Prime Minister, Party Partners. 8. 1999 to 2004 National Democratic Alliance, NDA. AB Vajpayee, BJP, JD, U, Trinamool Congress, Shiv Sena, BJD, LJP, DMK, PMK, INLD, MDMK, National Conference, Akali Dal, RLD, AGP, and others. 9. 2004 to 2009 United Progressive Alliance, UPA. Manmohan Singh Congress, NCP, DMK, RJD, LJP, PMK, and others. CPI and CPM supported from outside. 10. 2009 to 2014 United Progressive Alliance IL, UPA2. Manmohan Singh Congress, NCP, DMK, Trinamool Congress, National Conference, and others. 11. 2014 to 2019 National Democratic Alliance, NDA. Narendra Modi, BJP, UP, TDP, Shiv Sena, Akali Dal. Rashtriya Lok Samata Party, Apna Dal, S, and others. TDP left NDA in 2018. 12. 2019, till date. National Democratic Alliance, NDA. Narendra Modi, BJP, Akali Dal, LJP, Shiv Sena, and others. Shiv Sena left NDA in 2019 and Akali Dal in 2020. T. Merits. The various advantages or strengths of the coalition governments are as follows. 1. There is an accommodation of diverse interests in the functioning of the government. A coalition government acts as a channel to meet the expectations and redress the grievances of different groups. 2. India is a highly diversified country. There are different cultures, languages, castes, religions, and ethnic groups, and all these get represented in the coalition governments. This means that a coalition government is more representative in nature, and it better reflects the popular opinion of the electorate. In other words, it represents a much more broader spectrum of public opinion than the single-party government. 3. A coalition government comprises different political parties having their own ideologies or agendas. But the governmental policy requires the concurrence of all the coalition partners. Therefore, a coalition government leads to consensus-based politics. In other words, there is consensual decision-making in the coalition governments. 4. Coalition politics strengthens the federal fabric of the Indian political system. This is because a coalition government is more sensitive and responsive to the regional demands and concerns than the single-party government. 5. A coalition government reduces the tyranny of government, despotic rule. This is due to the reduced domination of a single political party in the functioning of the government. All the members of the coalition participate in the political decision-making. In short, the decisions made are more balanced. The various disadvantages or weaknesses of the coalition governments are as follows. 1. They are unstable or prone to instability. The difference of opinion among the coalition partners on policy issues leads to the collapse of the government. 2. Leadership of the Prime Minister is a principle of parliamentary form of government. This principle is curtailed 596, our Indian Polity. In a coalition government, as the Prime Minister is required to consult the coalition partners before taking any major decision. The critics have called them as super prime ministers or ultra prime ministers. 3. The steering committee or the coordination committee of the coalition partners acts as the super cabinet, and thereby it undermines the role and position of the cabinet in the functioning of the governmental machinery. 4. There is a possibility of the smaller constituents of the coalition government playing the role of a kingmaker. They demand more than their strength in the parliament. 5. The leaders of regional parties bring in the regional factors in the national decision-making. They pressurize the central executive to act on their lines. Otherwise, they would threaten to withdraw from the coalition. 6. The size of the Council of Ministers in a coalition government is generally quite large. This is because the ministry has to reflect all the constituents of the coalition. For example, the A.B. Vajpayee Ministry of 1999 had 70-plus ministers, and it was called as Jumbo Ministry. This creates the problem of distribution of portfolios as well as the proper coordination among the members. 7. The members of coalition governments do not assume responsibility for the administrative failures and lapses. They play blame games and thereby escape from both collective responsibility as well as individual responsibility. Chapter Anti-defection Law. The 52nd Amendment Act of 1985 provided for the disqualification of the members of Parliament and the state legislatures on the ground of defection from one political party to another. For this purpose, it made changes in 4 Articles 1 of the Constitution and added a new schedule, the Ninth Schedule, to the Constitution. This act is often referred to as the Anti-defection Law. Later, the 91st Amendment Act of 2003 made one change in the provisions of the TSNTH schedule. It omitted an exception provision, i.e., disqualification on the ground of defection, not to apply in case of a split. Provisions of the Act. The TSNTH schedule contains the following provisions with respect to the disqualification of members of Parliament and the state legislatures on the ground of defection. Disqualification members of political parties. A member of a House belonging to any political party becomes disqualified for being a member of the House, A, if he voluntarily gives up his membership of such political party, or B, if he votes or abstains from voting in such House contrary to any direction issued by his political party without obtaining prior. These are Articles 101, 102, 190, and 191, which relate to the vacation of seats and disqualification from membership of Parliament and the state legislatures. Permission of such party and such act has not been condoned by the party within 15 days. From the above provision, it is clear that a member elected on a party ticket should continue in the party and obey the party directions. Independent members. An independent member of a House elected without being set up as a candidate by any political party becomes disqualified to remain a member of the House if he joins any political party after such election. Nominated members. A nominated member of a House becomes disqualified for being a member of the House if he joins any political party after the expiry of 6 months from the date on which he takes his seat in the House. This means that he may join any political party within 6 months of taking his seat in the House without inviting this disqualification. AI exceptions. The above disqualification on the ground of defection does not apply in the following 2 cases. A. If a member goes out of his party as a result of a merger of the party with another party. A merger takes place when 2/3 of the members of the party have agreed to such merger. B. EFA member, after being elected as the presiding officer of the House, voluntarily gives up the membership of Hisher 598 yards Indian Polity party or rejoins it after Husha ceases to hold that office. This exemption has been provided in view of the dignity and impartiality of this office. It must be noted here that the provision of the 10th schedule pertaining to exemption from disqualification in case of split by 1/3 members of the legislature party has been deleted by the 91st Amendment Act of 2003. It means that the defectors have no more protection on grounds of splits. Deciding authority, any question regarding disqualification arising out of defection is to be decided by the presiding officer of the House. Under the Act, there is no time limit for him/her to decide such a case. Originally, the Act provided that the decision of the presiding officer is final and cannot be questioned in any court. However, in Cohoto-Holohan case 1992, the Supreme Court declared this provision as unconstitutional on the ground that it seeks to take away the jurisdiction of the Supreme Court and the High Courts. It held that the presiding officer, while deciding a question under the 9th schedule, function as a tribunal. Hence, Hisher decision like that of any other tribunal is subject to judicial review on the grounds of mala fides, perversity, etc. But the court rejected the contention that the vesting of adjudicatory powers in the presiding officer is by itself invalid on the ground of political bias. 5. To Cohoto-Holohan vs. Zakilhu, 1992. The court observed, the chairman or speakers hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and do take far-reaching decisions in the functioning of parliamentary democracy. Vestiture of power to adjudicate questions under the TMTH schedule in such constitutional functionaries should not be considered unexceptionable. QI rule-making power. The presiding officer of a House is empowered to make rules to give effect to the provisions of the 10th schedule. All such rules must be placed before the House for 30 days. The House may approve or modify or disapprove them. Further, Hisha may direct that any willful contravention by any member of such rules may be dealt with in the same manner as a breach of privilege of the House. According to the rules made so, the presiding officer can take up a defection case only when Hisha receives a complaint from a member of the House. Before taking the final decision, Hisha must give the member, against whom the complaint has been made, a chance to submit Hisha explanation. Hisha may also refer the matter to the Committee of Privileges for inquiry. Hence, defection has no immediate and automatic effect. The evaluation of the Act. The 10th schedule of the Constitution, which embodies the anti-defection law, is designed to prevent the evil or mischief of political defections motivated by the lure of office or material benefits or other similar considerations. It is intended to strengthen the fabric of Indian parliamentary democracy by curbing unprincipled and unethical political defections. Rajiv Gandhi, the then Prime Minister, described it as the first step towards cleaning up public life. The then Central Law Minister stated that the passing of the 52nd Amendment Bill, Anti-defection Bill, by a unanimous vote by both the Houses of Parliament was a proof, if any, of the maturity and stability of Indian democracy. Advantages. The following can be cited as the advantages of the anti-defection law. A. It provides for greater stability in the body politic by checking the propensity of legislators to change parties. B. It facilitates democratic realignment of parties in the legislature by way of merger of parties. C. It reduces corruption at the political level as well as non-developmental expenditure incurred on irregular elections. D. It gives, for the first time, a clear-cut constitutional recognition to the existence of political parties. Criticism. Though the anti-defection law been hailed as a bold step towards cleansing our political life and started as new epoch in the political life of the country, it has revealed many lacunae in its operation and failed to prevent defections in toto. It came to be criticized on the following grounds. 1. It does not make a differentiation between dissent and defection. It curbs the legislator's right to dissent and freedom of conscience. Thus, it clearly puts party bossism on a pedestal and sanctions tyranny of the party in the name of the party discipline. 4. 2. Its distinction between individual defection and group defection is irrational. In other words, it banned only retail defections and legalized wholesale defections. 5. 3. It does not provide for the expulsion of a legislator from Hisher party for Hishu activities outside the legislature. 4. Its discrimination between an independent member and a nominated member is illogical. If the former joins a party, Hisha is disqualified while the latter is allowed to do the same. 5. Its vesting of decision-making authority in the presiding officer is criticized on 2 grounds. Firstly, Hisha may not exercise this authority in an impartial and objective manner due to political exigencies. Secondly, Hisha lacks the legal knowledge and experience to adjudicate upon the cases. In fact, 2 speakers of the Lok Sabha, Rabi Ray, 1991, and Shivraj Patel, 1993, have themselves expressed. For Soli J. Saurabhji, the remedy should not be worse than disease. The Times of India, Sunday Review, February 1, 1985, p. 1. Madhulamai, Contemporary Indian Politics, 1989, p. 190. Anti-defection Law 599. Doubts on their suitability to adjudicate upon the cases related to defection. 6. T 91st Amendment Act, 2003, Reasons. While introducing this amendment bill in the Parliament, the Government of India gave the following reasons for making this amendment to the Constitution of India. 1. Demands have been made from time to time in certain quarters for strengthening and amending the anti-defection law as contained in the 9th Schedule, on the ground that these provisions have not been able to achieve the desired goal of checking defections. The TB&TH schedule has also been criticized on the ground that it allows bulk defections while declaring individual defections as illegal. The provision for exemption from disqualification in case of splits as provided in the TB&TH schedule has, in particular, come under severe criticism on account of its destabilizing effect on the government. 2. The Committee on Electoral Reforms, Dinesh Goswami Committee, in its report of 1990, the Law Commission of India in its 170th report on Reform of Electoral Laws 1999, and the National Commission to Review the Working of the Constitution, NCRWC, in its report of 2002 have, inter alia, recommended omission of the provision of the TB&TH schedule pertaining to exemption from disqualification in case of splits. 3. The NCRWC was also of the view that a defector should be penalized for hissue action by debarring him or her from holding any public office as a minister or any. Speaker Shivraj Patel stated, the advantages in giving these cases to the judiciary are many. The Speaker or the Chairman may or may not be endowed with legal acumen and proficiency in law. It is more apt to have the cases decided by the Supreme Court or High Court judges. J. 600 Indian Polity. Other remunerative political post for at least the duration of the remaining term of the existing legislature or until the next fresh elections, whichever is earlier. 4. The NCRWC has also observed that abnormally large councils of ministers were being constituted by various governments at center and states, and this practice had to be prohibited by law, and that a ceiling on the number of ministers in a state or the union government be fixed at the maximum of 10% of the total strength of the popular house of the legislature. Provisions. The 91st Amendment Act of 2003 has made the following provisions to limit the size of council of ministers, to debar defectors from holding public offices, and to strengthen the anti-defection law. 1. The total number of ministers, including the Prime Minister, in the Central Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha. 2. A member of either House of Parliament belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. Z. The total number of ministers, including the Chief Minister, in the Council of Ministers in a state shall not exceed 15% of the total strength of the Legislative Assembly of that state. But the number of ministers, including the Chief Minister, in a state shall not be less than 12. 4. A member of either house of a state legislature belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. 5. A member of either House of Parliament or either house of a state legislature belonging to any political party who is disqualified on the ground of defection shall also be disqualified to hold any remunerative political post. The expression, remunerative political post, means any office under the central government or a state government where the salary or remuneration for such office is paid out of the public revenue of the concerned government. Or 2. Any office under a body, whether incorporated or not, which is wholly or partially owned by the central government or a state government, and the salary or remuneration for such office is paid by such body, except where such salary or remuneration paid is compensatory in nature. 6. The provision of the 10th Schedule, Anti-defection Law, pertaining to exemption from disqualification in case of split by one-third members of legislature party has been deleted. It means that the defectors have no more protection on grounds of splits. Chapter 86 Pressure Groups. T meaning and techniques. The term pressure group was originated in the USA. A pressure group is a group of people who are organized actively for promoting and defending their common interests. It is so called as it attempts to bring a change in the public policy by exerting pressure on the government. It acts as a liaison between the government and its members. The pressure groups are also called interest groups or vested groups. They are different from the political parties in that they neither contest elections nor try to capture political power. They are concerned with specific programs and issues, and their activities are confined to the protection and promotion of the interests of tier members by influencing the government. The pressure groups influence the policy making and policy implementation in the government through legal and legitimate methods like lobbying, correspondence, publicity, propagandizing, petitioning, public debating, maintaining contacts with their legislators, and so forth. However, sometimes they resort to illegitimate and illegal methods like strikes, violent activities, and corruption, which damages public interest and administrative integrity. According to Odegaard, pressure groups resort to 3 different techniques in securing their purposes. First, they can try to place in public office persons who are favorably disposed towards the interests they seek to promote. This technique may be labeled electioneering. Second, they can try to persuade public officers, whether they are initially favorably disposed toward them or not, to adopt and enforce the policies that they think will prove most beneficial to their interests. This technique may be labeled lobbying. Third, they can try to influence public opinion and thereby gain an indirect influence over the government, since the government in a democracy is substantially affected by public opinion. This technique may be labeled propagandizing. T. Pressure groups in India. A large number of pressure groups exist in India, but they are not developed to the same extent as in the US or the Western countries like Britain, France, Germany, and so on. The pressure groups in India can be broadly classified into the following categories. BL business groups. The business groups include a large number of industrial and commercial bodies. They are the most sophisticated, the most powerful, and the largest of all pressure groups in India. They include I. Federation of Indian Chamber of Commerce and Industry, FICCI. 2. Associated Chamber of Commerce and Industry of India, ASSOCHAM. G. A. Almond and G. B. Coleman, eds. The Politics of the Developing Areas, Princeton, 1970, p. 185. 3. Federation of All India Food Grain Dealers Association, EAFTA. 4. All India Manufacturers Organization, AMO. FL Trade Unions. The trade unions voice the demands of the industrial workers. They are also known as labor groups. A peculiar feature of trade unions in India is that they are associated either directly or indirectly with different political parties. They include I. All India Trade Union Congress, ATUC, affiliated to CPI. 2. Indian National Trade Union Congress, INTUC, affiliated to the Congress. 3. Hind Mazdoor Sabha, HM8, affiliated to the Socialists. 4. Center of Indian Trade Unions, C2, affiliated to the CPM. V. Bharatiya Mazdoor Sangh, BMS, affiliated to the BJP. First trade union in India, All India Trade Union Congress, ADUC, was founded in 1920 with Lala Lajpat Rai as its first president. Up to 1945, congressmen, socialists and communists worked in the ATUC, which was the central trade union organization of workers of India. Subsequently, the trade union movement got split on political lines. Agrarian groups. The agrarian groups represent the farmers and the agricultural labor class. They include I. Bharatiya Kisan Union, in the wheat belt of North India. 2. All India Kisan Sabha, the oldest and the largest agrarian group. 3. Bharatiya Kisan Sangh, Gujarat. 4. Shetkari Sangatana, Maharashtra. V. All India Kisan Sammelan. 6. United Kisan Sabha, controlled by the CPM. L. Professional associations. These are associations that raise the concerns and demands of doctors, lawyers, journalists, and teachers. Despite various restrictions, these associations pressurize the government by various methods, including agitations for the improvement of their service conditions. They include I. Indian Medical Association, IMA. The 2nd. Bar Council of India, BCI. 3. Indian Federation of Working Journalists, IFWJ. 4. All India Federation of University and College Teachers, AFUCT. Student organizations. Various unions have been formed to represent the student community. However, these unions, like the trade unions, are also affiliated to various political parties. These are I. Akhil Bharatiya Vidyarthi Parishad, ABP, affiliated to BJP. 2. All India Students Federation, ASF, affiliated to CPI. 3. National Students Union of India, NSUI, affiliated to Congress. 4. Students Federation of India, SFI, affiliated to CPM. 3. Religious organizations. The organizations based on religion have come to play an important role in Indian politics. They represent the narrow communal interest. They include I. Rashtriya Swayamsevak Sangh, RSS. 2. Vishwa Hindu Parishad, VHP. 3. Jamaat Islami. 4. All India Conference of Indian Christians, v. Shromani Akali Dal. The Shromani Akali Dal should be regarded as more of a religious pressure group rather than a political party in view of the fact that it has been concerned more with the mission of saving the Sikh community from being absorbed into the ocean of Hindu society than with fighting for the cause of a Sikh homeland. 2. 2J.C. Johari, Indian Government and Politics, Vishal, 13th edition, p. 591. Q. Caste groups. Like religion, caste has been an important factor in Indian politics. The competitive politics in many states of the Indian Union is in fact the politics of caste rivalries. Brahmin versus non-Brahmin in Tamil Nadu and Maharashtra, Rajput versus Jat in Rajasthan, Kama versus Reddy in Andhra, Ahir versus Jat in Haryana, Baniya Brahmin versus Patida in Gujarat, Kayastha versus Rajput in Bihar, Nair versus Azava in Kerala, and Lingayat versus Okaliga in Karnataka. 3. Some of the caste-based organizations are 3. Paul Kalinda, Caste in India Since Independence, and Social and Economic Development in India by Basu and Sisian, p. 110. For G.A. Almond and G.B. Powell, Comparative Politics, 1972, pp. 75-76. I. Nadar Caste Association in Tamil Nadu. 2. Marwari Association. 3. Harijan Savak Sangh. 4. Kshatriya Mahasabha v. Kayastha Sabha. Tribal organizations. The tribal organizations are active in MP, Chhattisgarh, Bihar, Jharkhand, West Bengal, and the northeastern states of Assam, Manipur, Nagaland, and so on. Their demands range from reforms to that of secession from India, and some of them are involved in insurgency activities. The tribal organizations include I. National Socialist Council of Nagaland, NSC, and 2. Tribal National Volunteers, TNU, in Tripura. 3. People's Liberation Army in Manipur. 4. Tribal San of Assam v. United Mizo Freedom Organization L. Linguistic groups. Language has been so important factor in Indian politics that it became the main basis for the reorganization of states. The language along with caste, religion, and tribe have been responsible for the emergence of political pressure groups. 603 parties as well as pressure groups. Some of the linguistic groups are I. Thamil Sangam 2, Anjuman Thraki Irdu 3, Andhra Mahasabha 4, Hindi Sahitya Sammelan v. Nagari Prakarani Sabha 6, Dakshina Bharat Hindi Prakar Sabha 10. Ideology-based groups. In more recent times, the pressure groups are formed to pursue a particular ideology, i.e., a cause, a principle, or program. These groups include I. Environmental protection groups like Narmada Bachao Andolan and Chipko Movement 2. Democratic rights organizations 3. Civil liberties associations 4. Gandhi Peace Foundation v. Women rights organizations. Anomic groups. Ahmed and Powell observed, by anomic pressure groups we mean more or less a spontaneous breakthrough into the political system from the society, such as riots, demonstrations, assassinations, and the like. The Indian government and bureaucratic elite, overwhelmed by the problem of economic development and scarcity of resources available to them, inevitably acquires a technocratic and anti-political frame of mind. Particularistic demands of whatever kinds are denied legitimacy. As a consequence, interest groups are alienated from the political system. 4. Some of the anomic pressure groups are I. Naxalite groups 2. Jammu and Kashmir Liberation Front, JKLF 3. United Liberation Front of Assam, ULFA 4. Dal Khalsa Chapter 87. National integration. India is a land of widespread diversities in terms of religion, language, caste, tribe, race, region, and so on. Hence, the achievement of national integration becomes very essential for the all-around development and prosperity of the country. Meaning definitions and statements on national integration. National integration implies avoidance of divisive movements that would balkanize the nation and presence of attitudes throughout the society that give preference to national and public interest as distinct from parochial interest. 1. Myron Weiner. 3. Rashiduddin Khan, National Integration and Communal Harmony, in National Integration of India, Volume 2, edited by Sinha. National integration is a socio-psychological and educational process through which a feeling of unity, solidarity, and cohesion develops in the hearts of the people, and a sense of common citizenship or feeling of loyalty to the nation is fostered among them. 2. H. A. Ghani. National integration is not a house which could be built by mortar and bricks. It is not an industrial plan, too, which could be discussed and implemented by experts. Integration, on the contrary, is a thought which must go into the heads of the people. It is the consciousness which must awaken the people at large. Drive S. Radhakrishna. Myron Weiner, Politics of Scarcity, Public Pressure, and Political Response in India, 1963. Z.H. A. Ghani, Muslim Political Issues and National Integration, p. 3. National integrations means, and ought to mean, cohesion not fusion, unity but not uniformity, reconciliation but not merger, agglomeration but not assimilation of the discrete segments of the people constituting a political community or state. 3. Rashiduddin Khan. I.B. Sum up. The concept of national integration involves political, economic, social, cultural, and psychological dimensions in the interrelations between them. Obstacles. Among the major obstacles to national integration include regionalism. Regionalism refers to subnationalism and subterritorial loyalty. It implies the love for a particular region or state in preference to the country as a whole. There is also subregionalism, that is, love for a particular region in preference to the state of which the region forms a part. Regionalism is a subsidiary process of political integration in India. It is a manifestation of those residual elements which do not find expression in the national polity and national culture, and being excluded from the centrality of the new polity, express national integration. 605. Themselves in political discontent and political exclusionism. 4. Furkasar J. Azam, Political Aspects of National Integration, p. 82. Regionalism is a countrywide phenomenon which manifests itself in the following forms. Demand of the people of certain states for secession from the Indian Union, like Khalistan, Dravid Nad, Mizos, Nagas, and so on. 2. Demand of the people of certain areas for separate statehood, like Bodoland, Vidarbha, Gorkhaland, and so on. 3. Demand of people of certain union territories for full-fledged statehood, like Puducherry, Delhi, and so on. 4. Interstate boundary disputes, like Chandigarh and Belgaum, and riverwater disputes, like Kaveri, Krishna, Ravi Bias, and so on. Sons of the Soil Theory, which advocates preference to local people in government jobs, private jobs, hermits, and so on. Their slogan will be Assam for Assamese, Maharashtra for Maharashtrians, and so on. A communalism. Communalism means love for one's religious community in preference to the nation and a tendency to promote the communal interest at the cost of the interest of other religious communities. It has its roots in the British rule where the 1909, 1919, and 1935 Acts had introduced communal representation for the Muslims, Sikhs, and others. The communalism got accentuated with the politicization of religion. Its various manifestations are formation of political parties based on religion, like Akali Dal, Muslim League, Shiv Sena, and so on. 2. Emergence of pressure groups, non-political entities, based on religion, like RSS, Vishwa Hindu Parishad, Jamaat-e-Islami, and so on. 3. Communal riots, between Hindus and Muslims, Hindus and Sikhs, Hindus and Christians and so on. Varanasi, Mathura, Hyderabad, Aligarh, Amritsar, and some other places are affected by communal violence. 4. Dispute over religious structures like temples, mosques, and others. The dispute over Ram Janmabhoomi in Ayodhya, where the Karsavaks had demolished a disputed structure on December 6, 1992. The reasons for the persistence of communalism include religious orthodoxy of Muslims, the role of Pakistan, Hindu chauvinism, government inertia, the role of political parties and other groups, electoral compulsions, communal media, socio-economic factors, and so on. A casteism. Casteism implies love for one's own caste group and preference to the general national interest. It is mainly an outcome of the politicization of caste. Its various manifestations include I. Formation of political parties on the basis of caste, like Justice Party in Madras, Republican Party, Bahujan Samaj Party, and so on. 2. Emergence of pressure groups, non-political entities, based on caste, like Nader Association, Harijan Savak San, Kshatriya Mahasabha, and so on. 3. Allotment of party tickets during elections and the formation of Council of Ministers in the states on caste lines. 4. Caste conflicts between higher and lower castes or between dominant castes in various states like Bihar, Uttar Pradesh, Madhya Pradesh, and so on. V. Violent disputes and agitations over the reservation policy. B.K. Nehru observed, the communal electorates of the British days, in a vestigial form, still remain in the shape of reservations for the scheduled castes and scheduled tribes. They serve to emphasize caste origin in 606 Indian Polity. Make people conscious of the caste in which they were born. This is not conducive to national integration. 5. 7. Tamil Nadu government opposed the three-language formula and continued to teach only two languages, that is, English and Ikmil, in the educational institutions of the state. At the state level, the politics is basically a fight between the major caste groups like Kama versus Reddy in Andhra Pradesh, Lingayat versus Vokaliga in Karnataka, Nayar versus Azava in Kerala, Kania versus Patida in Gujarat, Bhumir versus Rajput in Bihar, Jat versus Ahir in Haryana, Jat versus Rajput in Uttar Pradesh, Kalida versus Aham in Assam, and so on. QI linguism means love for one's language and language-speaking people. The phenomena of linguism, like that of regionalism, communalism, or casteism, is also a consequence of political process. It has two dimensions: A. The reorganization of states on the basis of language, and B. The determination of the official language of the Union. The creation of the first linguistic state of Andhra out of the then Madras state in 1953 led to the countrywide demand for the reorganization of states on the basis of language. Consequently, the states were reorganized on a large scale in 1956 on the basis of the recommendations made by the States Reorganization Commission 6, 1953 to 1955. Even after this, the political map of India underwent a continuous change due to the pressure of popular agitations and the political conditions, which resulted in the bifurcation of existing states like Bombay, Punjab, Assam, and so on. The enactment of the Official Languages Act, 1963, making Hindi as the official language of the Union, led to the rise of anti-Hindi agitation in South India and West Bengal. Then, 5B.K. Nehru, the Indira Gandhi Memorial Lectures delivered at the University of Kerala in January 1988. It was a three-member commission headed by Fazal Ali. Its other two members were Kam Panikkar and H.N. Kunzwer. The central government assured that English would continue as an associate, official language so long as the non-Hindi-speaking states desire it. Moreover, the three-language formula, English, Hindi, and a regional language, for school system is still not being implemented in Tamil Nadu 7. Consequently, Hindi could not emerge as the lingua franca of the composite culture of India as desired by the framers of the Constitution. The problem of linguism got accentuated with the rise of some regional parties like the TDP, AGP, Shiv Sena, and so on. T. National Integration Council. In 1961, the central government convened the National Integration Conference to find ways and means to combat the evils of communalism, casteism, regionalism, linguism, and narrow-mindedness, and to formulate definite conclusions in order to give a lead to the country. This conference decided to set up a National Integration Council, NIC, to review all matters pertaining to national integration and to make recommendations thereon. Accordingly, the NIC was constituted in 1961 and held its first meeting in 1962. The NIC consists of Prime Minister as chairman, union ministers, leaders of the opposition in the Lok Sabha and the Rajya Sabha, the chief ministers of all states and union territories with legislatures. It also includes leaders of national and regional political parties, chairpersons of national commissions, eminent journalists, public figures, and representatives of business and women's organizations. The meetings of the NIC are convened as per requirement from time to time. There is no regular or specified time interval for convening meeting of the NIC. So far, National Integration 607. 16 meetings of the NIC have been held since its inception. The 16th meeting of the NIC was held on September 23, 2013. A resolution was passed in the meeting to condemn violence, take all measures to strengthen harmonious relationship between all communities, to resolve differences and disputes among the people within the framework of law, to condemn atrocities on scheduled castes and scheduled tribes, to condemn sexual abuse and ensure that all women enjoy the fruits of freedom to pursue their social and economic development with equal opportunities, and to safeguard their right of movement in the public space, at any time of the day or night. National Foundation for Communal Harmony. The activities undertaken by the NFCH are mentioned below. 8. The National Foundation for Communal Harmony, NFCH, was set up in 1992. It is an autonomous body under the administrative control of the Union Home Ministry. It promotes communal harmony, fraternity, and national integration. 1. LB provide financial assistance to the child victims of societal violence for their care, education, and training, aimed at their effective rehabilitation. 2. TB promote communal harmony and national integration by organizing variety of activities either independently or in association with educational institutions, NCOs, and other organizations. 3. TB conduct studies and grant scholarships to institution scholars for conducting studies. 4. LB confer awards for outstanding contribution to communal harmony and national integration. 5. TB involves central state governments, UT administrations, industrial commercial organizations, NCOs, and others in promoting the objectives of the Foundation. 6. TB provide information services, publish monographs and books, etc. on the subject. This information is obtained from the official website of the National Foundation for Communal Harmony, Government of India. A. Chapter 88 Foreign Policy. Foreign policy of India regulates India's relations with other states of the world in promoting its national interests. It is determined by a number of factors, viz. geography, history and tradition, social structure, political organization, international milieu. 1. Economic position, military strength, public opinion, and leadership. 2. India again re-established full diplomatic relations with South Africa in 1994 when the policy of racial discrimination was finally given up and democratic government under Nelson Mandela came into existence. F. Principles. The various principles, or features, of Indian foreign policy are explained below. In I. Promotion of world peace. India's foreign policy aims at the promotion of international peace and security. Article 51 of the Constitution, Directive Principles of State Policy, directs the Indian state to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations, and encourage settlement of international disputes by arbitration. Besides, peace is necessary to promote the economic development of nations. 2. Anti-colonialism. The foreign policy of India opposes colonialism and imperialism. India views that the colonialism and imperialism leads to exploitation of the weaker nations by the imperialist. It includes world political climate, world public opinion, and world organizations. Powers and affects the promotion of international peace. India advocated the liquidation of colonialism in all forms and supported the liberation movement in Afro-Asian countries like Indonesia, Malaya, Tunisia, Algeria, Ghana, Namibia, and so on. Thus, India expressed her solidarity with the people of Afro-Asian nations in their struggle against colonial and imperialist forces like Britain, France, Holland, Portugal, and so on. The present neo-colonialism and neo-imperialism is also opposed by India. ESI anti-racialism. Opposition to racialism in all its forms is an important aspect of Indian foreign policy. According to India, racialism, i.e., discrimination between people on the basis of race, like colonialism and imperialism, leads to exploitation of the blacks by the whites, social inequity, and hinders the promotion of world peace. India strongly criticized the policy of apartheid, racial discrimination, being followed by the white minority racist regime of South Africa. It even snapped diplomatic relations with South Africa in 1954 as a protest against the policy of apartheid too. Similarly, India played an important role in the liberation of Zimbabwe, earlier Rhodesia, and Namibia from the white domination. Non-alignment. When India became independent in 1947, the world was divided into two blocks on ideological basis, namely, the capitalist bloc headed by USA and the communist bloc headed by the former USSR. In such a situation of Cold War, India refused to join any of these two blocs and adopted a policy of non-alignment. In this context, Jawaharlal Nehru observed, "We propose to keep away from the power politics of groups aligned against one another, which have led in the past to world wars and which may again lead to disasters on an even vaster scale. I feel that India can play a big part, and perhaps an effective part, in helping to avoid war. Therefore, it becomes all the more necessary that India should not be lined up with any group of power which for various reasons are full of fear of war and prepare for war." When we say that India follows a policy of non-alignment, it means, that India has no military alliances with countries of either bloc or indeed with any nation. 2. India has an independent approach to foreign policy. And 3. India attempts to maintain friendly relations with all countries. 3. 3a.s. Narang. Indian Government and Politics, Gitanjali, 2000 edition, p. 602. Foreign Policy 609. Non-alignment are the greatest contributions of India to the theory and practice of international relations. 31. Afro-Asian bias. Even though the foreign policy of India stands for maintaining friendly relations with all the countries of the world, it has always exhibited a special bias towards the Afro-Asian nations. It aims at promoting unity among them and tries to secure for them a voice and an influence in the international bodies. India has been seeking international assistance for the economic development of these countries. In 1947, India called the first Asian Relations Conference in New Delhi. In 1949, India brought together the Asian countries on the burning issue of Indonesian freedom. India played an active role in the Afro-Asian Conference at Bandung, Indonesia, in 1955. India also played an important role in the formation of Group of 77, 1964, Group of 15, 1990, Indian Ocean Rim Association, 1997, BIMSTEC, 1997, and SARC, 1985. India earned the name of Big Brother from many of the neighboring countries. Panchsheel. Panchsheel implies the 5 principles of conduct in international relations. It was embodied in the preamble of the Indochina Treaty on Tibet, signed in 1954 by Jawaharlal Nehru and Zhou Enlai, the Chinese premier. The 5 principles were: I. Mutual respect for each other's territorial integrity and sovereignty. 2. Non-aggression. 3. Non-interference in each other's internal affairs. 4. Equality and mutual benefit. And V. Peaceful coexistence. Panchsheel became very popular and many countries of the world like Burma, Yugoslavia, Indonesia, and so on adopted it. Panchsheel. And 5. Q links with Commonwealth. In 1949 itself, India declared the continuation of her full membership of the Commonwealth of the Nations and the acceptance of the British Crown as the head of the Commonwealth. But this extra-constitutional declaration does not affect India's sovereignty in any manner, as the Commonwealth is a voluntary association of independent nations. It also does not affect India's republican character, as India neither pays final allegiance to the British Crown nor the latter has any functions to discharge in relation to India. India remained a member of the Commonwealth because of pragmatic reasons. It thought that the membership in the Commonwealth would be beneficial to her in the economic, political, cultural, and other spheres. It has been playing an important role at the CHOM Commonwealth Head 610V * Indian Polity of Government meeting, also known as the Commonwealth Summit. India hosted the CHOM at New Delhi in 1983. Huge support to the UNO. India became a member of the UNO in 1945 itself. Since then, it has been supporting the activities and programs of UNO. It has expressed full faith in the objectives and principles of UNO. Some of the facets of India's role in UNO are: It is through the UNO that India embarked on the policy of fighting against the colonialism, imperialism, and racialism, and now neo-colonialism, neo-imperialism, and terrorism. 2. In 1953, Vijay Laxmikanth of India was elected as the President of the UN General Assembly. 3. India actively participated in the UN peacekeeping missions in Korea, Congo, El Salvador, Cambodia, Angola, Somalia, Mozambique, Sierra Leone, Yugoslavia, and so on. 4. India continued to participate actively in the open-ended working groups of the UNO. India was the co-chairman of the Working Group on the Strengthening of the UN, which submitted its report in 1997. Several times, India has been a non-permanent member of the UN Security Council. Now, India is demanding a permanent seat in the Security Council. A disarmament. The foreign policy of India is opposed to arms race and advocates disarmament, both conventional and nuclear. This is aimed at promoting world peace and security by reducing or ending tensions between power blocs, and to accelerate economic development of the country by preventing the unproductive expenditure on the manufacture of arms. India has been using the UNO platform to check the arms race and to achieve disarmament. India took the initiative of holding a Six-Nation Summit at New Delhi in 1985 and made concrete proposals for nuclear disarmament. By not signing the Nuclear Non-Proliferation Treaty, NPT, of 1968 and the Comprehensive TBSD Ban Treaty, CTBT, of 1996, India has kept its nuclear options open. India opposes NPT and CTBT due to their discriminatory and hegemonistic nature. They perpetuate an international system in which only 5 nations, USA, Russia, China, UK, and France, can legitimately possess nuclear weapons. Gujral Doctrine. The Gujral Doctrine is a milestone in India's foreign policy. It was propounded and initiated in 1996 by I.K. Gujral, the then foreign minister in the Deve Gowda government. The doctrine advocates that India, being the biggest country in South Asia, should extend unilateral concessions to the smaller neighbors. In other words, the doctrine is formulated on India's accommodating approach towards its smaller neighbors on the basis of the principle of non-reciprocity. It recognizes the supreme importance of friendly and cordial relations with India's neighbors. The doctrine is a 5-point roadmap to guide the conduct of India's foreign relations with its immediate neighbors. These 5 principles are as follows. 1. With the neighbors like Bangladesh, Bhutan, Maldives, Nepal, and Sri Lanka, India should not ask for reciprocity, but give to them what it can in good faith. 2. No South Asian country should allow its territory to be used against the interest of another country of the region. 3. No country should interfere in the internal affairs of another country. 4. All South Asian countries should respect each other's territorial integrity and sovereignty. 5. All South Asian countries should settle all their disputes through peaceful bilateral negotiations. Gujral himself explained, the logic behind the Gujral Doctrine was that since we had to foreign policy M611 faced two hostile neighbors in the north and the west, we had to be at total peace with all other immediate neighbors in order to contain Pakistan's and China's influence in the region. T. Nuclear Doctrine of India. India's nuclear doctrine can be summarized as follows. 4. 5 Based on keynote address delivered by Minister of State for External Affairs, E. Ahmed, at the first India-Central Asia Dialogue, June 12, 2012 at Bishkek, Kyrgyzstan. 1. Building and maintaining a credible minimum deterrent. 2. A posture of no first use. Nuclear weapons will only be used in retaliation against a nuclear attack on Indian territory or on Indian forces anywhere. 3. Nuclear retaliation to a first strike will be massive and designed to inflict unacceptable damage. 4. Nuclear retaliatory attacks can only be authorized by the civilian political leadership through the Nuclear Command Authority. 5. Non-use of nuclear weapons against non-nuclear weapon states. 6. However, in the event of a major attack against India or Indian forces anywhere by biological or chemical weapons, India will retain the option of retaliating with nuclear weapons. 7. A continuance of strict controls on export of nuclear and missile-related materials and technologies, participation in the Fissile Material Cutoff Treaty negotiations, and continued observance of the moratorium on nuclear tests. 8. Continued commitment to the goal of a nuclear weapon-free world through global, verifiable, and non-discriminatory nuclear disarmament. The Nuclear Command Authority comprises a political council and an executive council. The political council is chaired by the Prime Minister. It is the sole body which can authorize the use of nuclear weapons. 4 Press Information Bureau, Government of India, January 4, 2003. The Executive Council is chaired by the National Security Advisor. It provides inputs for decision-making by the Nuclear Command Authority and executes the directives given to it by the Political Council. T. Connect Central Asia I Policy of India. India launched the Connect Central Asia policy in 2012. This policy is aimed at strengthening and expanding of India's relations with the Central Asian countries. These countries include Kazakhstan, Kyrgyzstan, Tajikistan, Turkmenistan, and Uzbekistan. India's Connect Central Asia policy is a broad-based approach including political, security, economic, and cultural connections. Its features, or elements, are as follows. 5. 1. India will continue to build on its strong political relations through the exchange of high-level visits. 2. India will strengthen its strategic and security cooperation. The focus will be on military training, joint research, and counterterrorism coordination. 3. India will step up multilateral engagement with Central Asian partners using the synergy of joint efforts through existing fora like the SCO, Eurasian Economic Community, EEC, and the Custom Union. 4. India looks to Central Asia as a long-term partner in energy and natural resources. 5. The medical field is another area that offers huge potential for cooperation. 6. India's higher education system delivers at a fraction of the fees charged by Western universities. Keeping this in mind, India would like to assist in the setting up of a Central Asian University in Bishkek. 7. India is working on setting up a Central Asian e-network with its hub in India to 612 Indian Polity. Deliver teleeducation and telemedicine connectivity, linking all the 5 Central Asian states. 8. Indian companies can showcase India's capability in the construction sector and build world-class structures at competitive rates. 9. As for land connectivity, India has reactivated the International North-South Transport Corridor, INSTC. 10. Absence of a viable banking infrastructure in the region is a major barrier to trade and investment. Indian banks can expand their presence if they see a favorable policy environment. 11. India and Central Asian nations will jointly work to improve air connectivity between them. 12. Connections between the people are the most vital linkages to sustain the deep engagement. India and Central Asian nations will encourage regular exchanges of scholars, academics, civil society, and youth delegations to gain deeper insights into each other's cultures. India's Connect Central Asia policy is consonant with its overall policy of deepening engagement in Eurasia, its policy of strengthening relations with China, with Pakistan, and building on its traditional relationship with Russia. India hopes that its membership in numerous regional forums, including at the SCO, would bolster India's renewed linkages with the region. Act East Policy of India. In 2014, the Modi government upgraded India's Look East policy and renamed it as the Act East policy. The Look East policy was first initiated in 1992 by the then Prime Minister P.V. Narasimha Rao. The features or elements of India's Act East policy are as follows. 6. 1. India's Act East policy focuses on the extended neighborhood in the 6th Press Information Bureau, Government of India, December 23, 2015. Asia-Pacific region. The policy, which was originally conceived as an economic initiative, has gained political, strategic, and cultural dimensions, including establishment of institutional mechanisms for dialogue and cooperation. 2. Act East policy has placed emphasis on India-ASEAN cooperation in our domestic agenda on infrastructure, manufacturing, trade, skills, urban renewal, smart cities, Make in India, and other initiatives. 3. The objective of Act East policy is to promote economic cooperation, cultural ties, and develop strategic relationship with countries in the Asia-Pacific region through continuous engagements at bilateral, regional, and multilateral levels. 4. The Northeast of India has been a priority in our Act East policy. The policy provides an interface between Northeast India, including the state of Arunachal Pradesh, and the ASEAN region. 5. On the civilizational front, Buddhist and Hindu links are being energized to develop new contacts and connectivity between people. 6. On connectivity, special efforts are being made to develop a coherent strategy, particularly for linking ASEAN with Northeast India. 7. India's economic engagement with ASEAN has been stepped up. The ASEAN and India Agreement on Trade and Service and Investments has entered into force for India and 7 ASEAN countries from July 1, 2015. 8. On strategic issues, India has increased convergence on security interests with key partners both in bilateral and multilateral format. Closer cooperation in combating terrorism, collaborating for peace and stability in the region, and promotion of maritime security based on international norms and laws are being pursued. Part Y Working of the Constitution, INRM. In this part. 89. National Commission to Review the Working of the Constitution CHAPB. 89. National Commission to Review the Working of the Constitution. TH National Commission to Review the Working of the Constitution, NCRWC, was set up by a resolution of the Government of India in 2000. It was an 11-member commission headed by M.N. Venkatacharya, the former Chief Justice of India. 1. It submitted its report in 2002. 2. Report of the Commission, Volume 1, Chapter 1. Terms of Reference. According to the terms of reference, the Commission was required to examine, in the light of the experience of the past 50 years, as to how far the existing provisions of the Constitution are capable of responding to the needs of efficient, smooth, and effective. The other members of the Commission were B.P. Jeevan Reddy, Chairman of the Law Commission, R.S. Sarkaria, former Judge of the Supreme Court, K. Punia, former Judge of the Andhra Pradesh High Court, Soli Sorabji, Attorney General of India, K. Parasuran, former Attorney General of India, Subhash Kashyap, former Secretary General of Lok Sabha, C.R. Irani, Chief Editor and MD of The Statesman, Abid Hussain, former Ambassador of India to the USA, SMT. Sumitra Kulkarni, former MP, and P.A. Sangama, former Speaker of the Lok Sabha. P.A. Sangama resigned 3 months before the submission of the report by the Commission. System of governance and socio-economic development of modern India, and to recommend changes, if any. The terms of reference clearly specify that the Commission should recommend changes that are required to be made in the Constitution within the framework of parliamentary democracy and without interfering with the basic structure, or basic features of the Constitution. The Commission clarified that its task was to review the working of the Constitution and not to rewrite it, and its function was only recommendatory and advisory in nature. It was left to the Parliament to accept or reject any of the recommendations. The Commission had no agenda before it. On its own, it identified the 11 areas of study and proposed to examine them. They included the following 2. 1. Strengthening the institutions of parliamentary democracy, working of the legislature, the executive, and the judiciary. Their accountability. Problems of administrative, social, and economic cost of political instability. Exploring the possibilities of stability within the discipline of parliamentary democracy. 0614 v. Indian Polity. 2. Electoral reforms. Standards in political life. 3. Pace of socio-economic change and development under the Constitution, assurance of social and economic rights. How fair? How fast? How equal? 4. Promoting literacy. Generating employment. Ensuring social security. Alleviation of poverty. 5. Union-state relations. 6. Decentralization and devolution. Empowerment and strengthening of Panchayati Raj institutions. 7. Enlargement of fundamental rights. 8. Effectuation of fundamental duties. 9. Effectuation of directive principles and achievement of the preambular objectives of the Constitution. 10. Legal control of fiscal and monetary policies. Public audit mechanism. 11. Administrative system and standards in public life. T. Areas of concern. The following are the important areas of concern according to the perception of the Commission. 1. Report of the Commission, Volume 1, Chapter 2. 1. There is a fundamental breach of the constitutional faith on the part of governments, and their method of governance lies in the neglect of the people who are the ultimate source of all political authority. Public servants and institutions are not alive to the basic imperative that they are servants of the people meant to serve them. The dignity of the individual enshrined in the Constitution has remained an unredeemed pledge. There is, thus, a loss of faith in the governments and governance. Citizens see their governments besieged by uncontrollable events and are losing faith in institutions. Society is unable to cope up with current events. 2. The foremost area of concern is the present nature of the Indian state and its inability to anticipate and provide for the great global forces of change ushered in by the pace of scientific and technological developments. 3. The next and equally important dimension is the increasing cost of government and fiscal deficits, which are alarming. 4. There is a pervasive impurity of the political climate and of political activity. Pre-initialization of politics, political corruption, and the politician-criminal bureaucratic nexus have reached unprecedented levels of needing strong systemic changes. 5. Issues of national integrity and security have not received adequate and thoughtful attention. Mechanisms for the assessment of early warning symptoms of social unrest are absent. Mechanisms for adequate and immediate state responses to emergencies and disaster management are wholly inadequate. Administration, as a system for anticipating coming events and planning responses in advance, has failed. It has become uncoordinated and directionless amalgam of different departments, often with overlapping and even mutually conflicting jurisdictions, powers, and responsibilities, which merely acts as a reaction to problems. There are no clear-cut standards or bases for fixing responsibilities. 6. Though India's overall record and experience as a working democracy, despite many centrifugal forces, are worthy to mention, and though the bases of democratic debate have widened with the 73rd and 74th constitutional amendments, the working of the institutions of parliamentary democracy, however, have thrown up serious fault lines, which might, if unattended, prove destructive of the basic democratic values. 7. There is pervasive misuse of the electoral process, and the electoral system is unable to prevent the entry of persons with criminal record into the portal of lawmaking institutions. 8. The Parliament and the state legislatures, owing to the inherent weakness of the National Commission to Review Electoral System, have failed to acquire adequate representative character. 9. The increasing instability of the elected governments is attributable to opportunistic politics and unprincipled defections. The economic and administrative cost of political instability are unaffordably high, and their impact on the polity is not clearly comprehended and realized. Though just 4 prime ministers ruled the country for 40 years out of the 54 years of independence, and one political party alone was in power for 45 years, however, 1989 onwards the country saw 5 general elections to the Lok Sabha. Costs of this political instability are simply colossal. 10. The state of the Indian economy is disturbing. The economy is gradually sinking into a debt trap. Economic, fiscal, and monetary policies, coupled with administrative inefficiency, corruption, and wasteful expenditure, are increased pushing the society into extra-legal systems, crime syndicates, mob rule, and hoodlum outfits. Black money, parallel economy, and even parallel governments are the overarching economic and social realities. Legitimate governments will, in due course, find it increasingly difficult to confront them. In course of time, these illegal criminal outfits will dictate terms to the legitimate governments. 11. Rural depopulation, urbanization, urban congestion, and social unrest need immediate attention and solutions. Increasing unemployment will prove a serious threat to orderly government. 12. Future of society is increasingly knowledge-based and knowledge-driven. The quality of education and the higher research need urgent repair. The country is engaged in a unilateral and unthinking educational disarmament. 13. System of administration of justice in the country is another area of concern. 14. Criminal justice system is on the verge of collapse. The quality of investigations and prosecutions requires a strong. The working of the Constitution v. 615. Second look. Law's delay and cost of litigation have become proverbial. Victimology, victim protection, and protection of witnesses in sensitive criminal trials need institutional arrangements. Recruitment, training, refresher, and continuing legal education for lawyers, judges, and judicial administrators need immediate attention. The increasing utilization of alternative dispute resolution mechanisms such as mediation, conciliation, and arbitration, as well as mechanisms of auxiliary adjudicative services, need to be stressed. 15. Communal and other intergroup riots in a country like India with its religious, social, and cultural diversity cannot be treated as merely law and order problem. They are manifestations of collective behavioral disorders. Legal and administrative measures are required to be taken to remove the insecurity felt by the minorities and for bringing them into the mainstream of the national fabric. 16. The state of social infrastructure is disturbing. There are 380 million children below the age of 14. The arrangements for their education, health, and well-being are wholly inadequate both qualitatively and quantitatively. 96.4% of the primary education budget goes for salaries alone. 17. rates of infant mortality, blindness, maternal mortality, maternal anemia, child malnutrition, and child immunization, despite significant progress achieved, yet remain at high and disconcerting levels. 18. Public health and hygiene have not received adequate attention. There is an alarming increase in infectious diseases such as tuberculosis, malaria, hepatitis, HIV, etc. T. Recommendations. In all, the Commission made 249 recommendations. Of them, 58 recommendations involve amendments to the Constitution, 86 involve legislative measures, and the remaining 105 recommendations could be accomplished through executive action. 616 Indian Polity. The various recommendations of the Commission are mentioned below in an area-wise manner for. Chapters 3 to 10 in Volume I of the report of the Commission contains the detailed area-wise recommendations. The summary of recommendations is given in Chapter 11 of the report. Present, it is a directive principle under Article 39A. BL on Fundamental Rights 1. The scope of prohibition against discrimination, under Articles 15 and 16, should be extended to include ethnic or social origin, political or other opinion, property, or birth. 2. The freedom of speech and expression, under Article 19, should be expanded to include explicitly the freedom of the press and other media, the freedom to hold opinions and to seek, receive, and impart information and ideas. 3. The following should be added as new fundamental rights. A. Right against torture, cruelty, and inhuman treatment or punishment. B. Right to compensation if a person is illegally deprived of his right to life or liberty. C. Right to leave and to return to India. D. Right to privacy and family life. E. Right to rural wage employment for a minimum of 80 days in a year. F. Right to access to courts and tribunals and speedy justice. G. Right to equal justice and free legal aid. 3. H. Right to care and assistance and protection in case of children. I. Right to safe drinking water, prevention of pollution, conservation of ecology, and sustainable development. 4. The right to education, under Article 21A, should be enlarged to read as, every child shall have the right to free education until he completes the age of 14 years. And in the case of girls and members of the SCs and ST, until they complete the age of 18 years. 5. TiVo changes should be made with respect to preventive detention, under Article 22, namely, I. The maximum period of preventive detention should be 6 months. And 2. The advisory board should consist of a chairman and 2 other members, and they should be serving judges of any high court. 6. Sikhism, Jainism, and Buddhism should be treated as religions separate from Hinduism, and the provisions grouping them together, under Article 25, should be deleted. At present, the word Hindu is defined to include these religions also. 7. The protection from judicial review afforded by Article 31B to the acts and regulations specified in the 9th Schedule should be restricted to only those which relate to I. Agrarian reforms, 2. Reservations, and 3. The implementation of directive principles specified in Clause B or C of Article 39. 8. No suspension of the enforcement of the fundamental rights under Articles 17, 23, 24, 25, and 32 in addition to those under Articles 20 and 21 during the operation of a national emergency, under Article 352. BL on right to property, Article 300, A should be recast as follows. 1. Deprivation or acquisition of property shall be by authority of law and only for a public purpose. 2. There shall be no arbitrary deprivation or acquisition of property. 3. No deprivation or acquisition of agricultural, forest, and non-urban homestead land belonging to or customarily used by the SCs and STs shall take place except by authority of law which provides for suitable rehabilitation scheme before taking possession of such land. In brief, a right to suitable rehabilitation for the SCs and ST, if their land is to be acquired. National Commission to Review the Working of the Constitution 617. QI on Directive Principles 1. The heading of Part LV of the Constitution should be amended to read as Directive Principles of State Policy and Action. 2. A new directive principle on control of population should be added. 3. An independent National Education Commission should be set up every 5 years. 4. An interfaith commission should be established to promote interreligious harmony and social solidarity. 5. There must be a body of high status to review the level of implementation of the directive principles. 6. A strategic plan of action should be initiated to create a large number of employment opportunities in 5 years. 7. Implementation of the recommendations contained in the report of the National Statistical Commission, 2001. 31 on fundamental duties. Consideration should be given to the ways and means by which fundamental duties could be popularized and made effective. 2. The recommendations of the Justice Varma Committee on operationalization of fundamental duties should be implemented at the earliest. 6. 3. The following new fundamental duties should be included in Article 51A. The Government of India appointed the committee to operationalize the suggestions to teach fundamental duties to the citizens of India in the year 1998 under the chairmanship of Justice J.S. Varma. The committee submitted its report in October 1999. A. Duty to vote at elections, actively participate in the democratic process of governance, and to pay taxes. B. TB foster a spirit of family values and responsible parenthood in the matter of education, physical and moral well-being of children. C. Duty of industrial organizations to provide education to children of their employees. On Parliament and State Legislatures 1. The privileges of legislators should be defined and delimited for the free and independent functioning of Parliament and state legislatures. 2. Article 105 may be amended to clarify that the immunity enjoyed by members under parliamentary privileges does not cover corrupt acts committed by them in connection with their duties in the House or otherwise. Further, no court would take cognizance of any offense arising out of a member's action in the House without prior sanction of the Speaker-Chairman. Article 194 may also be similarly amended in relation to the members of state legislatures. 3. The domiciliary requirement for eligibility to contest elections to Rajya Sabha from the concerned state should be maintained. This is essential to ensure the federal character of the Rajya Sabha. 4. The MP Local Area Development Scheme should be discontinued. 5. The Election Commission should be empowered to identify and declare the various offices under the central and state governments to be offices of profit for the purposes of being chosen and for being a member of the appropriate legislature. 6. Immediate steps be taken to set up a nodal standing committee on national economy. 7. A standing constitution committee of the two houses of Parliament for a priori scrutiny of constitutional amendment proposals should be set up. 8. A new legislation committee of Parliament to oversee and coordinate legislative planning should be constituted. 618 Indian Polity. 9. The existing parliamentary committees on estimates, public undertakings, and subordinate legislation may not be continued. 10. The parliamentarians must voluntarily place themselves open to public scrutiny through a parliamentary ombudsman. 11. The state legislatures with less than 70 members should meet for at least 50 days in a year and other state legislatures for at least 90 days. Similarly, the minimum number of days for sittings of Rajya Sabha and Lok Sabha should be fixed at 100 and 120 days respectively. 12. A study group outside Parliament for study of procedural reforms should be set up. 31 on executive and administration. 1. In case of hung Parliament, the Lok Sabha may elect the leader of the House. Husha may then be appointed as the Prime Minister by the President. The same procedure could be followed at the state level also. 2. A motion of no confidence against a Prime Minister must be accompanied by a proposal of alternative leader to be voted simultaneously. This is called as the system of constructive vote of no confidence. 3. For a motion of no confidence to be brought out against the government, at least 20% of the total number of members of the House should give notice. 4. The practice of having oversized council of ministers should be prohibited by law. A ceiling on the number of ministers in any state or the union government be fixed at the maximum of 10% of the total strength of the popular house of the legislature. 5. The practice of creating a number of political offices with the position, perks, and privileges of a minister should be discouraged. Their number should be limited to 2% of the total strength of the lower house. 6. The Constitution should provide for appointment of Lokpal keeping the Prime Minister outside its purview and the institution of Lokayuktas in the states. 7. Lateral entry into government jobs above joint secretary level should be allowed. 8. Article 311 should be amended to ensure not only protection to the honest public servants but penalization to dishonest ones. 9. The questions of personnel policy including placements, promotions, transfers, and fast-track advancements should be managed by autonomous civil service boards constituted under statutory provisions. 10. Officials, before starting their career, in addition to the taking of an oath of loyalty to the Constitution, should swear to abide by the principles of good governance. 11. Right to information should be guaranteed and the traditional insistence on secrecy should be discarded. In fact, there should be an oath of transparency in place of an oath of secrecy. 12. Public Interest Disclosure Acts, which are popularly called the Whistleblower Acts, may be enacted to fight corruption and maladministration. 13. A law should be enacted to provide for forfeiture of benami property of corrupt public servants as well as non-public servants. On interstate and interstate relations. 1. The Interstate Council Order of 1990 may clearly specify the matters that should form the parts of consultations. 2. Management of disasters and emergencies, both natural and man-made, should be included in the List 3 concurrent list of the 7th Schedule. 3. A statutory body called the Interstate Trade and Commerce Commission should be established. Notional Commission to review the working of the Constitution 619. 4. The President should appoint the governor of a state only after consultation with the chief minister of that state. 5. Article 356 should not be deleted, but it must be used sparingly and only as a remedy of the last resort. 6. The question whether the ministry in a state has lost the confidence of the Assembly or not should be tested only on the floor of the House. The governor should not be allowed to dismiss the ministry so long as it enjoys the confidence of the House. 7. Even without the state being under a proclamation of emergency, President's rule may be continued if elections cannot be held. Article 356 should be amended to this effect. 8. The State Assembly should not be dissolved before the proclamation issued under Article 356 has been laid before Parliament. Article 356 should be amended to ensure this. 9. River water disputes between states and/or the center should be heard and disposed by a bench of not less than 3 judges and, if necessary, a bench of 5 judges of the Supreme Court for the final disposal of the suit. 10. Parliament should replace the River Boards Act of 1956 with another comprehensive enactment after consultation with all the states. H. When the state bill is reserved for consideration of the President, there should be a time limit, say 3 months, within which the President should take a decision whether to give his assent or to return the bill. FL on Judiciary. 1. A National Judicial Commission under the Constitution should be established to recommend the appointment of judges of the Supreme Court. It should comprise the Chief Justice of India, as chairman, 2 senior-most judges of the Supreme Court, the Union Law Minister, and 1 person nominated by the President. 2. A committee of the National Judicial Commission should examine complaints of deviant behavior of the Supreme Court and High Court judges. 3. The retirement age of the judges of High Courts and Supreme Court should be increased to 65 and 68 respectively. 4. No court other than the Supreme Court and the High Courts should have the power to punish for contempt of itself. 5. Except for the Supreme Court and the High Courts, no other court should have the power to declare the acts of Parliament and state legislatures as being unconstitutional or beyond legislative competence and so ultra vires. 6. A National Judicial Council and judicial councils in states should be set up for the preparation of plans and annual budget proposals. 7. In the Supreme Court and the High Courts, judgments should ordinarily be delivered within 90 days from the conclusion of the case. 8. An award of exemplary costs should be given in appropriate cases of abuse of process of law. 9. Each High Court should prepare a strategic plan for time-bound clearance of arrears in courts within its jurisdiction. No case to remain pending for more than 1 year. 10. The system of plea bargaining should be introduced as part of the process of decriminalization. 11. The hierarchy of the subordinate courts in the country should be brought down to a 2-tier subordinate judiciary under the High Court. L on pace of socio-economic change and development. 1. A way could and should be found to bring a reasonable number of SCs, 81K, and BCs onto the benches of the Supreme Court and High Courts. 620 Indian Polity. 2. Social policy should aim at enabling the SCs, ST, and BCs, and with particular attention to the girls, to compete on equal terms with the general category. 3. Appropriate new institutions should be established to ensure that the resources earmarked for the weaker sections are optimally used. 4. The citizens' charters be prepared by every service-providing department agency to enumerate the entitlements of the citizens, specifically those of the SCs, STK, and other deprived classes. 5. Reservation for SCs, ST, and BCs should be brought under a statute covering all aspects of reservation, including setting up of Arakshan Nyaya Adalats to adjudicate upon all disputes pertaining to reservation. 6. Residential schools for SCs, ST, and BCs should be established in every district in the country. 7. All tribal areas governed by the 5th schedule of the Constitution should be transferred to the 6th schedule. Other tribal areas should also be brought under the 6th schedule. 8. Special courts exclusively to try offenses under the SCs and S1K Prevention of Atrocities Act, 1989, should be established. 9. Prevention of untouchability requires, inter alia, effective punitive action under the Protection of Civil Rights Act, 1955. 10. The employment of manual scavengers and construction of dry latrines Prohibition Act, 1993, should be strictly enforced. 11. Steps should be taken for improvement of educational standards as well as for increasing the political representation of the minority communities. 12. A fully empowered national authority for the liberation and rehabilitation of bonded labor should be set up. Similar authorities should also be established at the state level. 13. As regards women, actions covering reservations, development, empowerment, health and protection against violence should be taken. On decentralization, panchayats and municipalities. 1. The 11th and 12th schedules of the Constitution should be restructured in a manner that creates a separate fiscal domain for panchayats and municipalities. 2. State Panchayat Council should be established under the chairmanship of the Chief Minister. 3. Panchayats and municipalities should be categorically declared to be institutions of self-government, and exclusive functions be assigned to them. For this purpose, Articles 243-0 and 243(w) should be suitably amended. 4. The Election Commission of India should have the power to issue directions to the State Election Commission for the discharge of its functions. The State Election Commission should submit its annual or special reports to the Election Commission of India and to the Governor. This requires the amendment of Articles 243(k) and 243(za). 5. Article 243. He should be amended to the effect that a reasonable opportunity of being heard shall be given to a panchayat before it is dissolved. 6. To ensure uniformity in the practice relating to audit of accounts, the CAG of India should be empowered to conduct the audit or lay down accounting standards for panchayats. 7. Whenever a municipality is superseded, a report stating the grounds for such dissolution should be placed before the state legislature. 8. All provisions regarding qualifications and disqualifications for elections to local authorities should be consolidated in a single law. 9. The functions of delimitation, reservation, and rotation of seats should be vested in 10. National Commission to review the working of the Constitution 621. A delimitation commission and not in the State Election Commission. 10. The concept of a distinct and separate tax domain for municipalities should be recognized. On institutions in Northeast India. 1. Efforts are to be made to give all the states in this region the opportunities provided under the 73rd and 74th constitutional amendments. However, this should be done with due regard to the unique political traditions of the region. 2. The subjects given under the 6th schedule and those mentioned in the 11th schedule could be entrusted to the autonomous district councils, ADCs. 3. Traditional forms of governance should be associated with self-governance because of the present dissatisfaction. 4. A National Immigration Council should be set up to examine a range of issues including a review of the Citizenship Act, the Illegal Migrants Determination by Tribunal Act, the Foreigners Act, and so on. On electoral processes. 1. Any person charged with any offense punishable with imprisonment for a maximum term of 5 years or more should be disqualified from being chosen as or for being a member of Parliament or legislature of a state. 2. Any person convicted for any heinous crime like murder, rape, smuggling, dacoity, etc. should be permanently debarred from contesting for any political office. 3. Criminal cases against politicians pending before courts either for trial or in appeal must be disposed of speedily, if necessary, by appointing special courts. 4. The election petitions should also be decided by special courts. In the alternative, special election benches may be constituted in the high courts and earmarked exclusively for the disposal of election petitions and election disputes. 5. Any system of state funding of elections bears a close nexus to the regulation of working of political parties by law and to the creation of a foolproof mechanism under law with a view to implementing the financial limit strictly. Therefore, proposals for state funding should be deferred till these regulatory mechanisms are firmly in position. 6. Candidates should not be allowed to contest elections simultaneously for the same office for more than one constituency. 7. The election code of conduct should be given the sanctity of law, and its violation should attract penal action. 8. The Commission, while recognizing the beneficial potential of the system of runoff contest electing the representative winning on the basis of 50% plus one vote polled, as against the present first-past-the-post system, for a more representative democracy, recommends that the government and the Election Commission of India should examine this issue of prescribing a minimum of 50% plus one vote for election in all its aspects. 9. An independent candidate who loses election 3 times consecutively should be permanently debarred from contesting election to the same office. 10. The minimum number of valid votes polled should be increased to 25% from the current 16.67% as a condition for the deposit not being forfeited. 11. The issue of eligibility of non-Indian BOM citizens or those whose parents or grandparents were citizens of India to hold high offices in the realm, such as President, Vice President, Prime Minister, and Chief Justice of India should be examined in depth through a political process after a national dialogue. 7. The Commission was deeply divided on this issue, and because of this, P.A. Sangama left the Commission. 12. Indian Polity. 12. The Chief Election Commissioner and the other election commissioners should be appointed on the recommendation of a body consisting of the Prime Minister, Leader of the Opposition in the Lok Sabha, Leader of the Opposition in the Rajya Sabha, the Speaker of the Lok Sabha and the Deputy Chairman of the Rajya Sabha. Similar procedure should be adopted in the case of appointment of state election commissioners. On political parties. 1. A comprehensive law regulating the registration and functioning of political parties or alliances of parties should be made. The proposed law should provide that political party or alliance should keep its doors open to all citizens irrespective of any distinctions of caste, community, or the like. B. Make it compulsory for the parties to maintain accounts of the receipt of funds and expenditure in a systematic and regular way. C. Make it compulsory for the political parties requiring their candidates to declare their assets and liabilities at the time offering their nomination. D. Provide that no political party should provide ticket to a candidate if he/she was convicted by any court for any criminal offense or if the courts have framed criminal charges against him or her. E. Specifically provide that if any party violates the above provision, the candidate involved should be liable to be disqualified and the party deregistered and derecognized. 2. The Election Commission should progressively increase the threshold criterion for eligibility for recognition so that the 13. Proliferation of smaller political parties is discouraged. 3. A comprehensive legislation providing for regulation of contributions to the political parties and towards election expenses should be enacted by consolidating such laws. This new law should, F.A., aim at bringing transparency into political funding. F.B., permit corporate donations within higher prescribed limits. F.C., make donations up to a specified limit tax exempt. F.D., make both donors and donees of political funds accountable. F.A., provide that audited political party accounts should be published yearly. And F.F., provide for derecognition of the party and enforcement of penalties for filing false election returns. On anti-defection law. The provisions of the 10th schedule of the Constitution should be amended to provide the following. 1. All persons defecting, whether individually or in groups, from the party or the alliance of parties on whose ticket they had been elected, must resign from their parliamentary or assembly seats and must contest fresh elections. 2. The defectors should be debarred to hold any public office of a minister or any other remunerative political post for at least the duration of the remaining term of the existing legislature or until the next elections, whichever is earlier. 3. The vote cast by a defector to topple a government should be treated as invalid. 4. The power to decide questions regarding disqualification on ground of defection should vest in the Election Commission instead of in the Speaker-Chairman of the House concerned. 14. Part 12 Judgments and Doctrines. In this part, 90. Landmark Judgments and their Impact. 91. Important Doctrines of Constitutional Interpretation. Chapt. Landmark Judgments and their Impact. Ex Romesh Thapar Case, 1950. Name of the case. Year of judgment. Popular name related to pick issue related article schedule. Romesh Thapar vs. State of Madras 1950. Crossroads Case. Freedom of the Press. 19. Supreme Court Judgment. It held that the freedom of speech and expression under Article 19, L.A., includes freedom of propagation of ideas, and that freedom is ensured by the freedom of circulation. It also ruled that without liberty of circulation, the publication would be of little value. Therefore, the order of the Madras government banning the entry and circulation of the weekly English journal Crossroads published at Bombay was declared as unconstitutional and void. The Madras government had issued the banning order under the provisions of Section 9, 1A of the Madras Maintenance of Public Order Act, 1949. The Supreme Court observed that the freedom of speech and freedom of the press lay at the foundation of all democratic organizations, because without free political discussion no public educations, which is so essential for the proper functioning of the process of popular government, is possible. Impact of the judgment. As a sequel to this judgment, the First Amendment Act, 1951, added public order as a reasonable restriction under Article 19(2) on the freedom of speech and expression. The Supreme Court held that restrictions on the freedom of speech and expression could be imposed only on the grounds mentioned in Article 19(2). Accordingly, the court refused to permit restrictions on the ground of public order because it was not mentioned in Article 19(2). It said that the ordinary or local breaches of public order were no grounds for imposing restrictions on the freedom of speech and expression. It further observed that the term public order has wide connotation and signifies that state of tranquility which prevails among the members of political society as a result of internal regulations enforced by the government which they have established. A. K. Gopalan Case, 1950. Name of the case. Year of judgment. Popular name. Related topic. Issue related article. Schedule. A. K. Gopalan vs. State of Madras 1950. Preventive detention. Case procedure established by Law 21 and 22 Section 24 Indian Polity. Supreme Court judgment. It invalidated Section 14 of the Impugned Preventive Detention Act, 1950, on the ground that it violates the fundamental right guaranteed under Article 22. It said that the omission of this section will not change the nature or the structure or the object of the legislation. Therefore, it declared the rest of the act as valid and effective. Further, it held that the expression personal liberty under Article 21 means liberty of the physical body, i.e., freedom from physical restraint or detention. Moreover, it ruled that Article 21 is a protection only against the executive and not against the legislature. Impact of the judgment. In this judgment, the Supreme Court has taken a narrow, restrictive interpretation of the Article 21. In other words, the Supreme Court has adopted a textualist approach in the interpretation of the Constitution. It held that the word law in Article 21 was used in the sense of state-made law and not in the sense of jus natural, i.e., the principles of natural justice. Hence, it declared that the expression procedure established by law in Article 21 cannot be interpreted to mean the same thing as that of the American expression of the due process of law. This declaration, in effect, amounted to holding that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This judgment held the field for nearly 3 decades, 1950 to 1978. This judicial interpretation reached its logical end in A.D.M. Jabalpur case, 1976. But, in Maneka Gandhi Caseful 978, the Supreme Court overruled the above judgment by taking a wider interpretation of the Article 21. 12. 1. A.D.M. Jabalpur vs. Shivakant Shukla, 1976. This case is popularly known as the habeas corpus case. 2 Maneka Gandhi vs. Union of India, 1978. This case is popularly known as the personal liberty case. Champakam Dora 1 Rajan case, 1951, name of the case. Year of judgment popular name related to PIC issue. Related article schedule. State of Madras vs. Champakam Durarajan, 1951. Communal reservation in admission to educational institutions 15, 29, and 46. Supreme Court judgment. It affirmed the judgment of the Madras High Court. It struck down the order issued by the Madras government, known as the Communal Go, that had provided for the proportionate reservation of seats in the government medical and engineering colleges for different communities with the object of promoting the educational interest of the backward classes under Article 46. It held that the Communal GO was based on religion, race, and caste, and hence was violative of Articles 15, 1, and 29, 2. Further, it declared that the directive principles cannot in any way override or abridge the fundamental rights. It also stated that the directive principles have to conform to and run as subsidiary to the fundamental rights. Impact of the judgment. This judgment led to the insertion of a new clause, 4, in Article 15 by the First Amendment Act, 1951. This clause permits the state to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the SCs and STK. In this way, the effect of this judgment was nullified. Shankari Prasad case, 1951, name of the case, Shankari Prasad vs. Year of judgment popular name related to PIC issue related article schedule. Union of India, 1951. Parliament's power to amend the Constitution 13 and 368 landmark judgments, and their impact 625. Supreme Court judgment. It held that the Parliament's amending power under Article 368 also includes the power to amend the fundamental rights guaranteed in Part 3 of the Constitution. Further, it said that a constitutional amendment act enacted to abridge or take away the fundamental rights is not void under Article 13(2). Therefore, the court upheld the validity of the First Amendment Act, 1951, which curtailed the right to property by inserting Articles 31A and 31B. Impact of the judgment. In this judgment, the Supreme Court made a distinction between the legislative law, ordinary law, and the constituent law, constitutional amendment law. In other words, the court has separated the ordinary legislative power of the Parliament from that of its constituent power. It held that the word law in Article 13(2) refers to an ordinary law and does not include a constituent law made under Article 368. Hence, it laid down that the Parliament can amend any provision of the Constitution and rejected the view that the fundamental rights are inviolable. This judgment held the field for 1.5 decade, 1951 to 1967. The Supreme Court reaffirmed the above judgment in the Sajjan Singh Case 3, 1964. But the court overruled the above stand in the Golok Nath Case 4, 1967. Sajjan Singh vs. State of Rajasthan, 1964. For I.C. Golok Nath vs. State of Punjab, 1967. Referenced by the President of India under Article 143 of the Constitution on the implementation of the Indo-Pak Agreement of 1958, relating to Barabari Union and exchange of Cooch Behar enclaves, 960. Barabari Union Case, 1960. Name of the Barabari Union vs. Case unknown 5 year of I-960 judgment popular name. Related to PIC. Cession of Indian issue territory to a foreign state related Article 3, 368 and First Schedule. Supreme Court judgment. It ruled that the power of Parliament under Article 3 to diminish the area of a state does not cover cession of Indian territory to a foreign country. It stated that Article 3 deals with the internal adjustment inter se of the territories of the constituent states of the Indian Union. Hence, Indian territory can be ceded to a foreign state only by an amendment of the Constitution under Article 368, providing for the alteration of the First Schedule. Further, the court held that the preamble is not a part of the Constitution. Impact of the judgment. This judgment led to the enactment of the Ninth Amendment Act, 1960. This amendment gave effect to the transfer of certain territory known as Barabari Union, West Bengal, to Pakistan. This transfer was done as per the provisions of Indo-Pak Agreement, Nehru Agreement, of 1958, relating to Barabari Union and exchange of Cooch Behar enclaves. Kam Nanavati Case, 1961. Name of the case, Kam Nanavati vs. State of Maharashtra. Year of judgment, 1961 popular name, related to PIC. Jury system of trial issue related article, schedule. Supreme Court judgment. It affirmed the judgment of the Bombay High Court. It held that the conviction of the accused Nanavati under Section 302 of the Indian Penal Code and the sentence of life imprisonment passed on him by the High Court are correct. He was awarded the punishment for the murder of his wife's paramour. $626 Indian Polity. Impact of the judgment. This judgment brought out the shortcomings in the working of jury system and led to its abolition. However, even after this case also, there were some cases of jury trials in the country. Finally, the new Code of Criminal Procedure, 1973 completely removed the system of trial by jury in India. Further, the sentence Nanavati, after spending 3 years in prison, was granted pardon by the governor. L.C. Goloknath case, 1967, name of the case. Year of judgment popular name related topic issue related article schedule. L.C. Goloknath vs. State of Punjab 1967. Parliament's power to amend the Constitution 13 and 368. Supreme Court judgment. It overruled its 2 earlier verdicts delivered in the Shankari Prasad case 6, 1951, and the Sajjan Singh case 7, 1964. It held that the amending power under Article 368 cannot be used to abridge or take away the fundamental rights guaranteed in Part 111 of the Constitution. Further, it said that a Constitutional Amendment Act is a law within the meaning of Article 13 too. But the court ruled that the First Amendment Act, 1951, the Fourth Amendment Act, 1955, and the 17th Amendment Act, 1964, will continue to be valid for the future. In other words, the Supreme Court applied the doctrine of prospective overruling and declared that this judgment will have only prospective operation and not retrospective operation. 6. Shankari Prasad vs. Union of India, 1951. 7. Sajjan Singh vs. State of Rajasthan, 1964. Impact of the judgment. As a sequel to this judgment, the 24th Amendment Act, 1971, was enacted. This amendment provided that the Parliament has the power to amend any part of the Constitution, including the fundamental rights, in accordance with the procedure laid down in Article 368. It also provided that a Constitutional Amendment Act will not be a law within the meaning of Article 13 too. Thus, this amendment was aimed at overriding the above judgment. Kesavananda Bharati case, 1973, name of the case. Year of judgment popular name. Related to pick issue related article schedule. Kesavananda Bharati vs. State of Kerala, 1973, Fundamental Rights Case, Parliament's Power to Amend the Constitution, 13 and 368. Supreme Court judgment. It overruled its earlier verdict delivered in the Goloknath case, 8, 1967. It held that the Parliament, by exercising its constituent power under Article 368, can amend any or all the provisions of the Constitution, including those relating to the fundamental rights, but accept the basic structure of the Constitution. It upheld the validity of the 24th Amendment Act, 1971, which inserted Clause 4 in Article 13 and Clause 3 in Article 368. Further, the court held that Sections 2A and 2B of the 25th Amendment Act, 1971, as valid. On the other hand, it declared the first part of Section 3 of the 25th Amendment Act, 1971, as valid and the second part 9 as invalid. Moreover, the court validated the 29th Amendment Act, 1971. Impact of the judgment. This judgment led to the emergence of the doctrine of basic structure of the Constitution as a limitation on the amending power of the Parliament. The Supreme Court has applied this doctrine in subsequent cases in examining and by C. Goloknath vs. State of Punjab, 1967. 9. The second part said as follows: no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Landmark judgments and their impact. 627. Deciding the validity of amendments to the Constitution. It also enlarged the list of elements of the basic structure in various cases. Further, as a follow-up of this judgment, the 42nd Amendment Act, 1976, gave the Parliament an unlimited and uncontrolled power to amend the Constitution. This is explained below in the next case. Indira Nehru Gandhi T case, 1975, name of the case. Year of judgment, popular name, related topic. Issue related article, schedule. Indira Nehru Gandhi vs. Rajnare 1975 election case, basic structure of the Constitution 329A, repealed, 9. 9A Article 329 it was repealed by the 44th Amendment Act, 1978. Earlier, it was inserted by the 39th Amendment Act, 1975. Supreme Court judgment. It reaffirmed the applicability of the doctrine of basic structure of the Constitution. Accordingly, it struck down Clause 4 of Article 329A that was inserted by the 39th Amendment Act, 1975. This provision had kept the election disputes involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of all courts. The Supreme Court held that this provision was beyond the amending power of the Parliament because it affected the basic structure of the Constitution. Impact of the judgment. Following the above two judgments of the Supreme Court in Kesavananda Bharati and Indira Nehru Gandhi cases, the 42nd Amendment Act, 1976, inserted 2 new clauses 4 and 5 in Article 366. The Clause 4 provided that an amendment of the Constitution, including the provisions relating to the fundamental rights, made under Article 368 shall not be called in question in any court on any ground, while the Clause 5 declared that there shall be no limitation whatever on the constituent power of Parliament under Article 368. Thus, it is clear that these 2 clauses were inserted in order to dilute the above doctrine of basic structure that has been held to be a limitation on the amending power of the Parliament. T. ADM Jabalpur Case, 1976. Name of the case, ADM Jabalpur vs. Shivikant Shukla. Year of judgment, 1976. Popular name, habeas corpus case. Related topic, right to life and per issue personal liberty during the emergency. Related article, 21 and 359 schedule. Supreme Court judgment. It held that Article 21 is the sole repository of the right to life and personal liberty against the state. If the enforcement of that right is suspended by a presidential order under Article 359, then the detainee will have no locus standi to a writ petition for challenging the legality of his detention. In view of the presidential order dated June 27, 1975, no person has any locus standi to move any petition before a high court under Article 226 for a writ of habeas corpus or any other writ to challenge the legality of a detention order on any ground. Accordingly, the court upheld the constitutional validity of Section 16A, 9, of the Maintenance of Internal Security Act, MISA, 1971. Impact of the judgment. In this case, the Supreme Court took a restrictive meaning of right to life and personal liberty under Article 21 and gave a seriously flawed judgment. The court argued that any claim to a writ of habeas corpus on any ground amounted to the enforcement of the right to life and personal liberty, which had been suspended by the presidential order. Consequently, it failed to fulfill its role as the defender and guarantor of the fundamental rights of the citizens during the period of emergency, 1975 to 77. Later, the 44th Amendment Act, 1978, amended Article 359 to 628 Indian Polity. The effect that the enforcement of the right to life and personal liberty under Article 21 cannot be suspended by a presidential order. In view of this amendment, the judgment delivered in this case is no longer a good law and is left only of academic importance. 7. Maneka Gandhi Case, 1978. Name of the case, Maneka Gandhi vs. Union of India. Year of judgment, 1978. Popular name, personal liberty case. Related topic, issue, procedure established by law. Related article, 21 schedule. Supreme Court judgment. It overruled its earlier judgment delivered in the A.K. Gopal and Case 10, 1950. It declared Section 10, 3, C of the Passport Act, 1967, as not violative of Articles 14, 19, 1, A, or G, and 21 and hence valid. But it laid down the following propositions. A. Articles 14, 19, and 21 are not mutually exclusive, which means that a law depriving a person of personal liberty has not only to stand the test of Article 21, but it must also stand the test of Articles 14 and 19. B. The expression personal liberty in Article 21 is of the widest amplitude, and it covers a variety of rights which go to constitute the personal liberty of a man, and some of them have been raised to the status of distinct fundamental rights and given additional protection under Article 19. C. The right to life under Article 21 includes all those aspects of life which go to make a man's life meaningful, complete, and worth living. Further, the right to live is not merely confined to physical existence, but it includes within its ambit the right to live with human dignity. In D. The expression procedure established by law in Article 21 means that the procedure prescribed by law must be just, fair, and reasonable, and not arbitrary, fanciful, or oppressive. In order that the procedure is just, fair, and reasonable. 10A.K. Gopalan vs. State of Madras, 1950. This case is popularly known as the preventive detention case. The procedure should conform to the principles of natural justice. Impact of the judgment. By taking a wider interpretation of the Article 21, this judgment led to the following. It introduced the American concept of due process of law in Indian judicial interpretation. 2. It firmly established the Golden Triangle rule, i.e., interrelation of Articles 14, 19, and 21. And 3. It expanded the scope of Article 21 and paved the way for declaring a number of rights as integral part of Article 21 in the subsequent cases. 7. Bakant Singh Case, 1980. Impact of the judgment. This judgment led to the laying down of the doctrine of constitutional validity of death penalty, 19 and 21. Name of the case, Bakant Singh vs. State of Punjab. Year of judgment, 1980. Popular name related to pick issue related article schedule. Supreme Court judgment. It ruled that the provision of death penalty capital punishment in Section 302 of the Indian Penal Code as an alternative punishment for murder is not unreasonable. Hence, this provision does not violate the letter or the ethos of Article 19. It stated that Article 19, 1, does not guarantee the activity of committing a murder. Further, it held that the provision of death penalty also does not violate Article 21. It observed that Article 21 recognizes the right of the state to deprive a person of his life or personal liberty in accordance with fair, just, and reasonable procedure established by a valid law. However, the court held that the death penalty for murder should be an exception rather than the rule. It said that this penalty must be confined to the rarest of rare cases when the alternative option is unquestionably foreclosed. Further, it said that while making the choice of death penalty, the exceptional and grave circumstances of both the crime as well as the criminal should be taken into consideration. Rarest of rare cases for awarding the death penalty. This doctrine influenced the later judgments delivered by the Supreme Court in various subsequent cases. T. Minerva Mills case, 1980. Name of the case, Minerva Mills versus Union of India. Year of judgment, 1980. Popular name are related to PIC. Basic structure of the issue Constitution related Article 31C and 368 Schedule. Supreme Court judgment. It invalidated clauses 4 and 5 of Article 368 which were inserted by the 42nd Amendment Act, 1976. Similarly, the amendment made to Article 31C by the 42nd Amendment Act, 1976, was also declared as unconstitutional. The court said that the above changes made by the 42nd Amendment Act, 1976, destroyed the basic structure of the Constitution. It held the limited power of Parliament to amend the Constitution, judicial review, and the harmony and balance between fundamental rights and directive principles as basic features of the Constitution. Impact of the judgment. This judgment has nullified the attempt to dilute the doctrine of the basic structure by the 42nd Amendment Act, 1976. This amendment had conferred an unlimited and uncontrolled amending power on the Parliament. The Supreme Court held that the Parliament cannot, under Article 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic features. Further, this amendment also gave precedence to all directive principles over the fundamental rights conferred by Articles 14, 19, and 3111. The Supreme Court, in this regard, held that anything that destroys the balance between the fundamental rights and the directive principles will ipso facto destroy. Article 31 was omitted from Part 3 by the 44th Amendment Act, 1978. Landmark judgments and their impact. 629. An essential element of the basic structure of the Constitution. T. Vaman R. case, 1980. Name of the case. Year of judge. Meant popular name. Related to PIC. Issue related article. Vaman Rao versus Union of India 1980. Judicial review of the 9th Schedule 368 and 9th Schedule. Schedule. Supreme Court judgment. It held that all the amendments to the Constitution which were made before April 24, 1973, the date on which the court delivered its verdict in the Kesavananda Buredi case, and by which the 9th Schedule was amended from time to time by the inclusion of various acts and regulations therein are valid. But all the amendments made after April 24, 1973 are open to challenge on the ground that they are beyond the constituent power of the Parliament, since they damage the basic structure of the Constitution. In other words, the various amendments by which additions were made to the 9th Schedule after April 24, 1973 will be valid only if they do not damage the basic structure of the Constitution. 7 Shah Banu case, 1985. Name of the case, Mohammed Ahmed Khan versus Shah Banu. Year of judgment, 1985. Popular name, related to PIC. Maintenance of a issue divorced Muslim wife related article, Schedule. Supreme Court judgment. It upheld the judgment of the High Court of Madhya Pradesh. It ruled that a Muslim husband is liable to pay maintenance to the divorced wife beyond the period of iddat. It held that Section 125 of the Code of Criminal 630 Indian Polity Procedure, 1973 is secular in character and applies to all religions and communities. It said that this section would prevail over the personal law in case of a conflict between the two. It also said that mahr, or dower, does not absolve a Muslim husband from payment of maintenance to the divorced wife. Further, it also emphasized that a uniform civil code will help the cause of national integration by removing disparate loyalties to laws which have conflicting ideologies. Impact of the judgment. This judgment led to the enactment of a new law called the Muslim Women Protection of Rights on Divorce Act, 1986. This act overturned the above judgment by allowing the payment of maintenance to a divorced wife only during the period of iddat. In Danielle Latify Case 12, 2001, the Supreme Court upheld the constitutional validity of this act but held that a Muslim husband is liable to pay the maintenance to the divorced wife even after the period of iddat. 12 Danielle Latify versus Union of India 2001. TDC Wadhwa Case, 1986. Name of the case. Year of judgment. Popular name related to PIC issue related article Schedule. DC Wadhwa versus State of Bihar 1986. Ordinance making power of the Governor 213. Supreme Court judgment. It pointed out that between 1967 to 1981, the Governor of Bihar promulgated 256 ordinances and all these were kept in force for periods ranging from 1 to 14 years by repromulgation from time to time. It held that the exceptional power under Article 213 cannot be used as a substitute for the lawmaking power of the state legislature. It ruled that such a practice would be a subversion of the democratic process and a fraud on the Constitution. It opined that the ordinance-making power is meant for meeting an extraordinary situation and it cannot be allowed to be perverted to serve political ends. Accordingly, it declared the repromulgated Bihar Intermediate Education Council Ordinance, 1985 as unconstitutional and invalid. Impact of the judgment. This judgment clearly exposed the fact that the ordinance-making power can be misused by the executive government. MC Mehta Case, 1986. Name of the case. Year of judgment. Popular name related to PIC issue. Related article Schedule. MC Mehta versus Union of India, 1986, Oleum gas leak case. Power of the Supreme Court to award compensation, 21 and 32. Supreme Court judgment. It held that its power under Article 32 is not only injunctive in ambit, i.e., preventing the infringement of fundamental right, but also remedial in scope and providing relief against a breach of the fundamental right already committed. It stated that its power to grant such remedial relief may include the power to award compensation in appropriate cases. It clarified that the infringement of the fundamental right must be gross and patent, i.e., incontrovertible and ex facie glaring. It observed that the instant applications for compensation are for the enforcement of the fundamental right to life enshrined in Article 21 and hence, they are maintainable under Article 32. Impact of the judgment. This judgment led to the expansion of the ambit of environmental law in the country. It introduced the new principle of absolute liability, no-fault liability, in the place of the earlier principle of strict liability. Landmark judgments and their impact. 631. T. Kahoto-Holohan case, 1992. Name of the case, Kahoto-Holohan vs. Zakilhu. Year of judgment, 1992. Popular name, defection case related IPIC. Validity of anti-issue defection law related Article 368 and Item Schedule. Supreme Court judgment. It declared paragraph 7 of the TBNTH schedule, which was inserted by the 52nd Amendment Act, 1985, as unconstitutional for violating the provision under Article 368(2). It held that paragraph 7 required to be ratified by at least half of the state legislatures for excluding the jurisdiction of the Supreme Court under Article 136 and the High Courts under Article 226. However, the court upheld the validity of the remaining part of the IBT schedule. F. Indra Soni case, 1992. Name of the case. Year of judgment, popular name, related IPIC, issue related article, schedule. Indra Soni vs. Union of India 1992 Mundal case reservation for OBCs in government jobs 16. Supreme Court judgment. It upheld the validity of the impugned executive order which provided 27% reservation of jobs to the OBCs under the provision of Article 16(4), with certain conditions like exclusion of creamy layer, no reservation in promotions, maximum reservation should not exceed 50%, ceiling of 50% on reservation and backlog vacancies, no relaxation in qualifying marks for promotions and so on. On the other hand, it invalidated another impugned executive order which provided 10% additional reservation of jobs for other economically backward sections who are not covered by any existing schemes of reservation. Impact of the judgment. This judgment led to the following. I. Appointment of the Ram Nandan Committee to identify the creamy layer among the OBCs. 2. Establishment of the Statutory National Commission for BCs 13 to examine the complaints of under-inclusion, over-inclusion, or non-inclusion of any class of citizens in the list of BCs. And 3. Enactment of 5 Amendment Acts, namely, the 76th Amendment Act, 1994 that has placed the Tamil Nadu Reservation Act in the 9th Schedule. The 77th Amendment Act, 1995 that has nullified the ruling with regard to reservation and promotions. The 81st Amendment Act, 2000 that has nullified the ruling with regard to backlog vacancies. The 82nd Amendment Act, 2000 that has provided for relaxations in qualifying marks and standards of evaluation in matters of reservation and promotions. And the 85th Amendment Act, 2001 that has provided for consequential seniority in matters of promotion by virtue of rule of reservation for the SCs and SIM. 13 later, the 102nd Amendment Act, 2018 conferred a constitutional status on the Commission and also enlarged its functions. For this purpose, the amendment inserted a new Article 338(b) in the Constitution. T. Mohini Jain case, 1992. Name of the case, Mohini Jain vs. State of Karnataka. Year of judgment, 1992. Popular name, capitation fee case related IPIC, right to education issue related Article 21 and 41 Schedule. Supreme Court judgment. It ruled that the right to education is a fundamental right under Article 21. In fact, it declared that this right extends up to any level including the professional education like engineering and medicine. It observed that the right to life under Article 21 and the dignity of an individual cannot be assured unless it is accompanied by the right to education. It argued that without making right to education under Article 41 a reality, the fundamental rights enshrined under Part 3632 Indian Polity shall remain beyond the reach of the large majority which is illiterate. It thus declared that the right to education is concomitant to the fundamental rights. It further observed that the state is under a constitutional mandate to provide educational institutions at all levels for the benefit of the citizens. It declared that charging capitation fee for admission amounted to a patent denial of a citizen's right to education and is wholly arbitrary and as such violative of Article 14. It described the capitation fee as nothing but a price for selling education. It opined that the concept of teaching shops is contrary to the constitutional scheme. Impact of the judgment. This judgment formed the basis for the later judgment delivered by the Supreme Court in the Uni Krishnan Case 11, 1993, that led to the passing of the 86th Amendment Act, 2002. In this case, the Supreme Court was asked to examine the correctness of the Mohini-Jain judgment. The petitioners contended that if the Mohini-Jain judgment was followed by the state governments, they would have to close down their engineering and medical colleges. In this later judgment, the Supreme Court party upheld and partly overruled the Mohini-Jain judgment. This is explained below in the next case. 14. Uni Krishnan vs. State OFA. P. 1993. Uni Krishnan case, 1993, name of the case. Year of judgment popular name related to PIC issue, related article schedule. Uni Krishnan vs. State of A.P. 1993. Right to education, 21 and 45. Supreme Court judgment. It held that the right to education is a fundamental right under Article 21 and that this right directly flows from the right to life. But it declared that only children have right to free education until they complete the age of 14 years. After that age, the obligation of the state to provide education depends on its economic capacity and development. The court also said that the state is obliged to follow directions contained in Article 45, which originally, prior to its amendment in 2002, provided for free and compulsory education for all children up to the age of 14 years. The Article 21 is to be construed in the light of Articles 41, 45 and 46 contained in Part 4 dealing with the directive principles of state policy. The obligations created by Articles 41, 45 and 46 can be discharged by the state either by establishing its own institutions or by aiding, recognizing, or granting affiliation to private educational institutions. Further, the court held that the private unaided educational institutions running professional courses like engineering and medical are entitled to charge a higher fee than that of the government institutions. But such a fee cannot exceed the ceiling fixed in this regard, and commercialization of education is not permissible. Impact of the judgment. Subsequent to this judgment, the 86th Amendment Act, 2002, was passed. This amendment added a new Article 21A, which makes the right to education an independent fundamental right. This article declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. To give effect to this article, the Parliament enacted the Right of Children to Free and Compulsory Education, RT, Act, 2009. Supreme Court Advocates and Record Association Case, 1993. Judges. Related article, 124 and 217 schedule. Name of the Supreme Court Advocates Case on Record Association vs. Union of India. Year of judgment, 1993. Popular name, Second Judges Case related to PIC. Appointment of Supreme Issue Court and High Court landmark judgments and their impact 633. Supreme Court judgment. It overruled its earlier judgment delivered in the S.B. Gupta Case 15, 1981, which is popularly known as the First Judges Case. It held that the judges of the Supreme Court and High Courts shall be appointed by the President in accordance with the advice tendered by the Chief Justice of India. But the Chief Justice of India shall tender such advice after taking into consideration the views of 2 of his senior-most colleagues. This means that the court has changed the meaning of the word consultation in Articles 124, 2, and 217, 1, to that of concurrence. Further, it held that the senior-most judge of the Supreme Court should be appointed as the Chief Justice of India. 15s. P. Gupta vs. Union of India, 1981. 6 inches Re-Presidential Reference, 1998. The President sought the Supreme Court's opinion, under Article 143, on certain doubts over the consultation process to be adopted by the Chief Justice of India, as stipulated in the Second Judges Case, 1993. Impact of the judgment. Consequent to this judgment, and also the advisory opinion tendered in the Third Judges Case 16, 1998, a memorandum of procedure for appointment of judges to the Supreme Court and the High Courts was formulated, and is being followed for appointment. This procedure, invented by the Judiciary, is known as the collegium system. S.R. Bommai Case, 1994, name of the case. Year of judgment popular name related to PIC issue, related article schedule. S.R. Bommai vs. Union of India, 1994. President's Rule, 356. Supreme Court judgment. It upheld the constitutional validity of the imposition of President's Rule under Article 356 in Madhya Pradesh, Himachal Pradesh, and Rajasthan in 1992. On the other hand, it declared the imposition of President's Rule in Nagaland in 1988, Karnataka in 1989, and Meghalaya in 1991 as unconstitutional and invalid. Further, it laid down the following propositions with respect to Article 356. A. The validity of the proclamation issued by the President under Article 356, 1, is subject to judicial review. B. Burden lies on the Union government to prove that the relevant material existed to justify the proclamation. C. Article 74, 2, is not a bar against the scrutiny of the material on the basis of which the President had arrived at his satisfaction. D. If the proclamation issued by the President is held invalid, then notwithstanding the fact that it is approved by both the Houses of Parliament, it will be open for the court to restore the Legislative Assembly and the Ministry. And e. Secularism is a part of the basic structure of the Constitution, and hence, the anti-secular acts of a state government can lawfully be deemed to be a ground for the imposition of the President's rule. Impact of the judgment. This judgment placed a check on the arbitrary exercise of power under Article 356 by the Center for the purpose of imposing President's rule in the states. F. Vishaka Case, 1997. Name of the case, Vishaka vs. State of Rajasthan. Year of judgment, 1997. Popular name. Related topic. Sexual harassment of issue women at workplace. Related Article 15 and 21 Schedule. Supreme Court judgment. It held that the sexual harassment of women at the workplace is a violation of Articles 15 and 21. It said that it is the duty of the employer or other responsible person in workplaces or other institutions, whether public or private, to prevent sexual harassment of working women. It gave detailed directions on the subject, whose guidelines are to be strictly observed by all employees, public or private, until suitable legislation is enacted on the subject. 634 Indian Polity. Impact of the judgment. By laying down a set of guidelines, which came to be known as the Vishaka Guidelines, this judgment filled the legislative vacuum on the subject. Till this time, there was no domestic law to address this issue except a few provisions of the Indian Penal Code. Later, the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act, 2013 was enacted to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment. TV1 Neet Nara 1 N Case, 1997. Name of the case, Vineet Narain vs. Union of India. Year of judgment, 1997. Popular name. Jane Hawala Case. Related topic. Autonomy and efficient issue functioning of CBI. Related article. Schedule. Supreme Court judgment. It directed that statutory status should be conferred upon the Central Vigilance Commission, CVC. It also issued directions to make the Central Bureau of Investigation, CBI, an autonomous body so that it can function effectively and efficiently and is viewed as a nonpartisan agency. It issued the similar directions with respect to the Enforcement Directorate, ED. Further, it also struck down the validity of the arbitrary provision of single directive that required the CBI to obtain the prior permission of the central government before conducting an investigation against the officers of the rank of Joint Secretary and above. Impact of the judgment. This judgment led to the enactment of the CVC Act, 2003 that conferred the statutory status upon the CVC. Under this act, the superintendence of the CBI insofar as it relates to the investigation of corruption cases has been vested in the CVC. Further, this act also reinstated the provision of single directive that was again declared invalid by the Supreme Court in 2014 on the ground that it is violative of Article 14. Association for Democratic Reforms Case, 2002. Name of the case. Year of judgment. Popular name. Related to PIC issue. Related article. Schedule. Union of India vs. Association for Democratic Reforms, 2002. Poll Reforms Case. Criminalization of Politics, 19. Supreme Court judgment. It held that a voter has a right to know about the antecedents including criminal past of his candidate as part of his right under Article 19(1)(a), i.e., freedom of speech and expression. Voters' speech or expression in case of election would include casting of votes. That is to say, voter speaks out or expresses by casting vote. For this purpose, information about the candidate to be selected is a must. Democracy cannot survive without free and fair elections, without free and fairly informed voters. Therefore, the court directed the Election Commission to make it mandatory for the candidates to furnish information on the following aspects. A. Whether the candidate is convicted, acquitted, or charged of any criminal offense in the past, if any. Whether he is punished with imprisonment or fine. B. Prior to 6 months falling off nomination, whether the candidate is accused in any pending case of any offense punishable with imprisonment for 2 years or more, and in which charge is framed or cognizance is taken by the court of law. If so, the details thereof. C. The assets, a movable, bank balance, etc. of a candidate and of his or spouse and that of dependents. D. Liabilities, if any, particularly whether there are any overdues of any public financial institution or government dues. And E. The educational qualifications of the candidate. Impact of the judgment. As a sequel to this judgment, the Election Commission issued in 2003 an Order 17 directing every candidate. 1-foot order dated March 27, 2003. Landmark judgments and their impact. 635. Seeking election to the Parliament or a state legislature to furnish on his nomination paper the information on the above A to E matters. Furnishing of any false information in the affidavit is now an electoral offense. Team API Foundation Case, 2002. Name of the case. Year of judgment. Popular name. Related IPIC issue. Related article. Schedule. Religion, race, caste, language, or any of them. In other words, it cannot then give preference to students of its own community. F. In the case of aided professional institutions, it can also be stipulated that passing of common entrance test held by the state agency is necessary to seek admission. In G, a minority institution may have its own procedure and method of admission as well as selection of students. But such procedure must be fair and transparent, and selection of students in professional and higher educational colleges should be on the basis of merit. Impact of the judgment. In order to overcome the effect of this judgment and also the judgment delivered in the Tnamder case 18, 2005, the 93rd Amendment Act 2005 was enacted. This amendment inserted a new Clause 5 in Article 15. This clause empowered the state to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes regarding their admission to educational institutions. This provision also includes private educational institutions, whether aided or unaided by the state, except the minority educational institutions under Article 30. 1. Team API Foundation vs. State of Karnataka, 2002. Rights of Minority Educational Institutions, 29 and 30. Supreme Court Judgment. It laid down the following propositions with respect to the rights of and the permissible restrictions upon minority educational institutions, both aided and unaided. A. Linguistic and religious minorities are covered by the expression minority under Article 30. Since reorganization of the states in India has been on linguistic lines, therefore, for the purpose of determining the minority, the unit will be the state and not the whole of India. Thus, religious and linguistic minorities, who have been put at par in Article 30, have to be considered statewise. B. Article 30. 1. Gives religious and linguistic minorities the right to establish and administer educational institutions of their choice. The use of the words "of their choice" indicates that even professional educational institutions would be covered by Article 30. C. Admission of students to unaided minority educational institutions cannot be regulated by the state government or the university, except for providing the qualifications and minimum conditions of eligibility in the interest of academic standards. D. The right to administer, not being an absolute one, there could be regulatory measures for ensuring educational standards and maintaining excellence thereof. E. The moment aid is received by a minority educational institution, it would be governed by Article 29(2), and would then not be able to refuse admission on grounds of. F. Naveen Jindal case, 2004. Name of the case, Union of India vs. Naveen Jindal. Year of judgment, 2004. Popular name, related to PIC. Right to fly the issue national flag related Article 19 Schedule. Supreme Court judgment. It held that the right to fly the national flag freely with respect and dignity is a fundamental right of a citizen within the meaning of the freedom of speech and expression guaranteed by Article 19. L.A. This right is an expression. APA. Inamdar vs. State of Maharashtra 2005. 636 Indian Polity. And manifestation of a citizen's allegiance and feelings and sentiments of pride for the nation. However, it cannot be used for commercial purpose or otherwise. F. Prakash Singh case 2006. Name of the case, Prakash Singh vs. Union of India. Year of judgment, 2006. Popular name, related to PIC issue, police reforms related article, schedule. Supreme Court judgment. It issued 7 directives to the central government, state governments, and union territories aimed at bringing in police reforms to ensure that the police machinery functions without any political interference. These are: I. Constitution of a State Security Commission. 2. Selection of the DGP from amongst the 3 senior-most officers impaneled by the UPSC for the post, and a minimum tenure of 2 years for the DGP. 3. A minimum tenure of 2 years also for the police officers on operational duties. 4. Separation of the investigation police from the law and order police. V. Setting up a police establishment board. 6. Setting up police complaints authority at state and district levels. And 7. Setting up a national security commission at the central level. Impact of the judgment. This judgment led to the introduction of police reforms in the country, but only partially and not fully. Also, it could not eliminate the political interference in the functioning of the police system, especially in the postings and transfers. Although state security commissions and police establishment boards have been set up in most of the states, they are not very effective in their functioning and lack the authority to make binding recommendations. However, in various cases, the high courts have issued orders asking the state governments to comply with the above directives of the Supreme Court. FM. Nagaraj case 2006. Reservation and promotions for SCs and STs, 16 and 335. Name of the case, M. Nagaraj vs. Union of India. Year of judgment, 2006. Popular name related topic issue related article schedule. Supreme Court judgment. It upheld the constitutional validity of the 77th Amendment Act, 1995, the 81st Amendment Act, 2000, the 82nd Amendment Act, 2000, and the 85th Amendment Act, 2001. It said that the impugned constitutional amendment acts by which Article 16, 4A and Article 16, 4B have been inserted flow from Article 16, 4. They do not alter the structure of Article 16, 4. They retain the controlling factors or the compelling reasons, namely, backwardness and inadequacy of representation which enable the state to provide for reservation keeping in mind the overall efficiency of the state administration under Article 335. These impugned amendments are confined only to scheduled castes and scheduled tribes. They do not obliterate any of the constitutional requirements, namely, ceiling limit of 50%, quantitative limitation, the concept of creamy layer, qualitative exclusion. The subclassification between the OBCs on the one hand and the SCs and the STS on the other hand is held in the Indra Soni case 1 Foot 1, 1992. And the concept of post-based roster with inbuilt concept of replacement is held in the RK Subberwall case 2 inch, 1995. FLR Qualo case 2007. Name of the case, LR Qualo versus State of Tamil Nadu. Year of judgment, 2007. Popular name, 9th schedule case. 19 Indra Soni versus Union of India, 1992. This case is popularly known as the Mundal case. Mr. K. Subberwall versus State of Punjab, 1995. Name of the case, 14, 19, and 21. Judicial review of the 9th schedule, 31B and 9th schedule. Aruna Ramachandra Shambhag versus Union of India, 2011. Judgment, it reaffirmed in the Vaman Rao Supreme Court judgment. It held that Rules 41, 2, and 3, and 49-0 of the Conduct XH of 77S 1961, which Reg 0 characterized the GHT of a voter not to vote, are ultra vires Section 128 of the Representation of the I-Equal Act, 1951, and Article 19, L.A. of the Constitution to the extent they violate secrecy voing. Therefore, it directed the election NZSN 01, T0PR0 v'd necessary provision in the ballot papers EVMs and another button called None of the Above Nota may be provided in EVMs so that the voters, who Vaman Rao versus Union of India, 1980. Kesavananda Bharti versus State of Kerala, 1973, right case 3 is the fundamental landmark judgments in their 637. Laid down by the court. A decision has to be taken to discontinue life support either by parents or the spouse or other close rela. F carried off them. As a 7777 AN when a perso acting as a next friend or by the doctors attending patient. Even if a decision is taken by W if draft 17T, VES degree or D degree CT or S or next friend to withdraw life support, such a decision requires approval from the High Court concerned. High when such an application is filed. The Chief Justice of the High Court should forthwith constitute a bench of at least 2 judges who should decide to grant approval or not. Before doing so, the bench should seek the opinion a committee of 3 reputed doctors to be nominated by the bench. And 4. The High State, Shah, ALS degree asterisk, no carity to L. State and dose relatives e.g. parents, spouse, brothers, sisters, etc. of the patient, and IA. HW cleaned, and suppleth. To X1 foot T, degree F, he D degree C, or C degree min T to them after hearing them, the High Court bench should give its verdict. People's Union for Civil Liberties case, 2013. Supreme Court judgment, it held that TLV euthanasia and assisted death are not permissible and hence continue to be illegal, whereas passive euthanasia is permissible with certain conditions, safeguards, and procedure. Year of judgment. Popular name related to PIC issue. Euthanasia related article, 21 schedule. Related to PIC issue related article schedule. Supreme Court. Case, 1980. Therefore, it held that the amendments to the Constitution made on or after April 24, 1973, i.e., the date offered 7 Hex E. Savananda Bharti case 22, by which the 9th schedule is amended by inclusion of various laws therein, would be open to challenge on the ground that they damage or destroy the basic structure of the Constitution. In addition, it laid down certain tests which are to be applied for deciding the validity of those constitutional BFO ET7 ins. THC Omen Al question before the court was whether on or after April 24, 1973. When basic structure doctrine was propounded, it is permissible for the Parliament under Article 31B to immunize legislations from fundamental rights by inserting them into the 9th schedule and, if so, what SLTS effect on the power of judicial review of the court. Aruna Ramachandra Shambhag case, 2011. Name of the case, People's Union for Civil Liberties versus Year of judgment, P degree P law. Our 2 foot AMC Nota case re-aided TBPDC issue, electoral reforms related Article Schedule 638 Indian Polity. Come to the polling booth and decide not to vote for any of the candidates in the fray, are able to exercise their right not to vote while maintaining their right of secrecy. The court made the following observations. In order to protect the right in terms of Section 79, D, and Rule 49-0, viz. Right not to vote. This court is competent to issue directions that secrecy of a voter who decides not to cast his vote has to be protected in the same manner as the statute has protected the right of a voter who decides to cast his vote in favor of a candidate. 2. This court is also justified in giving such directions in order to give effect to the right of expression under Article 19, 1a, and to avoid any discrimination by directing the Election Commission to provide nota button in the EVMs. 3. Article 19 guarantees all individuals the right to speak, criticize, and disagree on a particular issue. It stands on the spirit of tolerance and allows people to have diverse views, ideas, and ideologies. Not allowing a person to cast vote negatively defeats the very freedom of expression and the right ensured in Article 21, i.e., the right to liberty. And 4. Protection of electors' identity and affording secrecy is integral to free and fair elections, and an arbitrary distinction between the voter who casts his vote and the voter who does not cast his vote is violative of Article 14. Impact of the judgment. Subsequent to this judgment, the Election Commission made provision in the ballot papers EVMs for none of the above, nota, option. The provision for nota has been made since general election to state legislative assemblies of Chhattisgarh, MP, Mizoram, NCT of Delhi and Rajasthan in 2013 and continued in the general election to state legislative assemblies of Andhra Pradesh, Arunachal Pradesh, Odisha and Sikkim in 2014 along with the general elections to the 16th Lok Sabha 2014, 23. 23E1 Electoral Statistics, Pocketbook 2015, Election Commission of India, p. 96. Lily Thomas Case 2013, Name of the case. Year of judgment Popular name related to pick issue. Lily Thomas vs. Union of India, 2013. Criminalization of politics. Related article schedule, 102 S191. Supreme Court judgment. It held that the members of the Parliament and the state legislatures who have been convicted for offenses will lose their membership of the House immediately, i.e., the disqualification takes place from the date of conviction. It struck down Section 8(4) of the Representation of the People Act, 1951, and declared the same as unconstitutional. Under this section, the convicted members of the Parliament and the state legislatures are given 3 months' time to appeal in the higher court and get a stay on their conviction and sentence by the trial court. The court ruled that the Parliament does not have the power under Articles 102 and 191 to make different laws for a person to be disqualified for being chosen as a member and for a person to be disqualified for continuing as a member of the Parliament or the state legislature. Hence, the above Section 8(4), which carved out a saving in the case of a sitting member from disqualification, is beyond the powers conferred on the Parliament and is ultra vires the Constitution. Impact of the judgment. This judgment led to the immediate disqualification of a number of convicted members of the Parliament and the state legislatures. In order to nullify this ruling of the Supreme Court, the Representation of the People Second Amendment and Validation Bill 2013 was introduced in the Parliament. However, this bill was later withdrawn by the government. T. Sir Subramanian Case 2013. Name of the case, T. Sir Subramanian vs. Union of India. Year of judgment, 2013. Popular name, Landmark Judgments and their Impact 639. Related IPIC, Civil Service Reforms Issue Related Article, Schedule. Supreme Court judgment. It issued various directions to the central government, state governments, and union territories aimed at bringing in civil service reforms for the effective, efficient, and transparent administration as well as the accountability and stability of civil servants. These are Constitution of the Civil Service Boards to guide and advise the governments on transfers, postings, disciplinary action, and other service matters. 2. Providing a fixed minimum tenure of service to various civil servants. And 3. Mandating that the civil servants should not act on the basis of verbal or oral instructions, orders, suggestions, proposals, and directions, and these should be in writing and also formally recorded if given orally. Impact of the judgment. This judgment led to the making of amendments in Rule 7 of the IS, IPS, and IFOS cadre rules via notification issued in 2014. For the central services, the respective cadre controlling authorities have been directed to implement the above directions of the Supreme Court. However, the civil service boards in the states UIC are not functioning effectively. T. National Legal Services Authority Case 2014. Name of the case, National Legal Services Authority vs. Union of India. Year of judgment, 2014. Popular name, Related IPIC, Rights of Transgender Issue Persons Related Article, 14 and 21 Schedule. Supreme Court judgment. It declared transgenders along with Hajaras eunuchs as third gender and held that the fundamental rights granted under Part 3 of the Constitution are equally applicable to them. It also upheld transgender persons' right to decide their self-identified gender and directed the central and state governments to grant legal recognition of their gender identity, such as male, female, or as third gender. It also directed the central and state governments to take steps to treat them as socially and educationally backward classes of citizens and extend all kinds of reservation in cases of admission in educational institutions and for public appointments. The court held that non-recognition of transgender denies them equal protection of law under Article 14. It further held that Article 21 protects one's right of self-determination of the gender to which a person belongs. In other words, gender identity is integral to the dignity of an individual and is at the core of personal autonomy and self-determination. Impact of the judgment. This judgment led to the enactment of the Transgender Persons Protection of Rights Act, 2019. The objective of this act is to provide for protection of rights of transgender persons and their welfare. This act prohibits discrimination against transgender persons and confers right upon them to be recognized as such, and a right to self-perceived gender identity. F. Shreya Singhal Case 2015. Name of the case, Shreya Singhal vs. Union of India. Year of Judgment, 2015. Popular name, related IPIC. Restrictions on online issue speech-related Article 19 Schedule. Supreme Court Judgment, it struck down Section 66A of the Information Technology Act 2000, which provides punishment for sending offensive messages by any person through a computer resource or a communication device. It held that the section in its entirety is violative of the freedom of speech 640 Indian and expression guaranteed under Article I9(a). It further held that the section is not saved by Article 19(2), as it creates an offense which is vague and overbroad. It also held that the wider range of circulation over the Internet cannot restrict the content of the right under Article 19(a), nor can it justify the denial of that right. Supreme Court Advocates and Record Association Case 2015. Name of the case. Year of Judgment. Popular name, related to PIC issue. Related Article Schedule. Supreme Court Advocates on Record Association vs. Union of India, 2015. Fourth Judges Case or NJC Case, Appointment of Supreme Court and High Court Judges, 124 and 217. Supreme Court Judgment. It declared the 99th Amendment Act 2014 as unconstitutional and void on the ground that it affects the independence of judiciary, which is one of the components of the basic structure of the Constitution. It also declared the National Judicial Appointments Commission Act 2014 as unconstitutional and void. Further, it declared the earlier collegium system of appointment of judges to the Supreme Court and the High Courts to be operative. It ordered to list the case to consider introduction of appropriate measures, if any, for an improved working of the collegium system. Impact of the judgment. Consequent to this judgment, both the 99th Amendment Act 2014 as well as the National Judicial Appointments Commission Act 2014 became invalid. Therefore, the earlier collegium system of appointment of judges to the Supreme Court and the High Courts was restored. Shiara Bank Case 2017. Name of the case. Year of Judgment. Popular name related to PIC issue related Article Schedule. Shara Banu vs. Union of India, 2017. Triple Talaq Case, Divorce in the Muslim Community, 14. Supreme Court Judgment. It declared triple talaq, i.e., talaq bidat, the Muslim practice that allows men to instantly divorce their wives, as unconstitutional. It held that this form of talaq is manifestly arbitrary in the sense that the marital tie can be broken capriciously and whimsically by a Muslim man without any attempt at reconciliation so as to save it. Therefore, the court held this form of talaq to be violative of the fundamental right contained under Article 14 of the Constitution. Similarly, it declared Section 2 of the Muslim Personal Law, Shariat, Application Act, 1937, as void to the extent that it recognizes and enforces triple talaq. Further, it ruled that triple talaq is against the basic tenets of the Holy Quran, and what is held to be bad in the Holy Quran cannot be good in Shariat, and, in that sense, what is bad in theology is bad in law as well. Moreover, the court directed the central government to make a law within 6 months to govern divorce in the Muslim community. Till then, an injunction order of the court against the pronouncement of triple talaq would be in force. Impact of the judgment. This judgment led to the enactment of the Muslim Women Protection of Rights on Marriage Act, 2019. This act is popularly known as the Triple Talaq Act. It protects the rights of married Muslim women and prohibits divorce by pronouncing talaq by their husbands. T.K.S. Puttaswamy Case 2017. Name of the case, K.S. Puttaswamy vs. Union of India. Year of Judgment, 2017. Popular name, Right to Privacy Case related to PIC. Fundamental Right to Issue Privacy related Article 21 Schedule. Supreme Court Judgment. It declared right to privacy as a fundamental right. It ruled that right to privacy is protected as an intrinsic part of right to life and personal liberty under Article 2, and as a part of the freedoms guaranteed by Part 3 of the Constitution. It said that privacy safeguards individual autonomy and recognizes the ability of the individual to control vital aspects of his life. However, it also stated that the right to privacy is not an absolute right and hence is subject to reasonable restrictions which are placed on fundamental freedoms under Part 3 of the Constitution. This means that a law which encroaches upon private act will have to withstand the touchstone of permissible restrictions on fundamental freedoms. In the context of Article 21, an invasion of privacy must be justified on the basis of a law which stipulates a procedure which is fair, just, and reasonable. The law must also be valid with reference to the encroachment on life and personal liberty under Article 21. An invasion of life or personal liberty must meet the threefold requirement of I. Legality, which stipulates the existence of law. 2. Need, defined in terms of a legitimate state aim. And 3. Proportionality, which ensures a rational nexus between the objects and the means adopted to achieve them. Impact of the judgment. This judgment overruled the 2 earlier judgments delivered in MP Sharma Case 24, 1954, and Kuruk Singh Case 25, 1962. In both the cases, the Supreme Court had held that the right to privacy is not protected by the Constitution. This judgment also clarified that the various judgments subsequent to Kuruk Singh, which have recognized the fundamental right to privacy, laid down the correct position of law. Further, this judgment influenced the later judgments delivered by the Supreme Court in Indian. 24 M.P. Sharma vs. Sarish Chandra, 1954. 25 Kuruk Singh vs. State of U.P. 1962. Landmark judgments and their impact. 641. Young Lawyers Association Case 26, 2018, Joseph Shine Case 27, 2018, Navtej Singh Johar Case 2018, and other cases. Based on this judgment, the Supreme Court delivered, in 2018, a separate judgment on the validity of Aadhaar law. This judgment is popularly known as the Aadhaar judgment or Puttaswamy II judgment. In this judgment, the Supreme Court upheld the constitutional validity of the Aadhaar, Targeted Delivery of Financial and Other Subsidies, Benefits and Services, Act, 2016. It ruled that the requirement under the Aadhaar Act to give one's demographic and biometric information does not violate the fundamental right of privacy. It said that the Aadhaar Act does not create an architecture for pervasive surveillance and provides protection and safety of the data received from individuals. However, the court struck down certain provisions of the Act and suggested changes. Accordingly, the Aadhaar and Other Laws Amendment, Act, 2019 was enacted. Indian Young Lawyers Association Case 2018. Name of the case, Indian Young Lawyers Association vs. State of Kerala. Year of Judgment, 2018. Popular name, Sabarimala Case. Related topic, Women's Entry into Jesha Sabarimala Temple. Related article, 14, 21, and 25 Schedule. Supreme Court Judgment. It held that the women of all ages can enter into the Sabarimal Temple and worship Lord Adyappa. It declared that the ban on the entry of women of the age group of 10 to 50 years into the temple is unconstitutional. It held that the ban violates the right to equality under Article 14. The 26 Indian Young Lawyers Association vs. State of Kerala 2018. This case is popularly known as the Sabarimala case. 27 Joseph Shine vs. Union of India 2018. 28 Navtej Singh Johar vs. Union of India 2018. 642 Indian Polity. Right to personal liberty under Article 21 and the right to freedom of religion under Article 25. Accordingly, it struck down Rule 3b of the Kerala Hindu Places of Public Worship, Authorization of Entry, Rules, 1965, which prohibits the entry of women into the temple. Impact of the judgment. This judgment led to the protests and hartals by lakhs of devotees of Lord Adyappa in Kerala. On the other hand, some women made attempts to enter the temple, but they faced strong resistance from the devotees as well as temple priests and authorities. However, there were some successful attempts also. In November 2019, the 5-judge Sabarimala Review Bench has referred this case to a larger bench for adjudication. Subsequently, a 9-judge bench was constituted to conduct the hearing on this reference. Decriminalization of adultery, 14, 15, and 21. F. Joseph Shine Case 2018. Name of the case, Joseph Shine vs. Union of India. Year of Judgment, 2018. Popular name. Related topic, issue related article, schedule. Supreme Court Judgment. It decriminalized adultery and struck down Section 497 of the Indian Penal Code. It declared that this section dealing with the criminalization of adultery is unconstitutional. It held that this section violates Articles 14, 15, and 21. Further, the court declared that the Section 198(2) of the Code of Criminal Procedure is also unconstitutional to the extent that it is applicable to the offense of adultery. It observed that when the substantive provision goes, the procedural provision has to pave the same path. Impact of the judgment. This judgment has overruled all the previous judgments which had upheld the above Section 497 as constitutionally valid. After this judgment, adultery is no longer a criminal offense, attracting up to 5 years imprisonment. However, it can be considered as a civil wrong and it is a ground for the dissolution of marriage. Navtej Singh Johar. Case 2018. Name of the case. Year of Judgment. Popular name. Related topic, issue. Related article, schedule. Navtej Singh Johar vs. Union of India, 2018. Decriminalization of homosexuality, 14, 15, 19, and 21. Supreme Court Judgment. It decriminalized homosexuality and partly struck down Section 377 of the Indian Penal Code, which criminalized carnal intercourse against the order of nature. It held that this section is unconstitutional insofar as it criminalizes consensual sexual acts of adults of the same sex. It declared that this section violates the right to equality under Article 14, the right to non-discrimination under Article 15, the right to freedom of expression under Article 19, L.A., and the right to live a life of dignity and privacy under Article 21. It said that the LGBT, lesbian, gay, bisexual, and transgender persons are entitled to the same fundamental rights as others. Impact of the judgment. This judgment overruled the earlier judgment delivered in the Suresh Kumar Kushal Case 29, 201-3. In this case, the Supreme Court had upheld the constitutional validity of the above Section 377. Before this judgment, the members of the LGBT community were compelled to live a life full of fear of reprisal and persecution. Now, they are legally permitted to engage in consensual sexual conduct. Notably, the provisions of the above Section 377 will continue to govern non-consensual sexual acts against adults, all acts of carnal intercourse against minors, and acts of bestiality. 29 Suresh Kumar Kushal vs. Naz Foundation, 2013. Landmark Judgments and Their Impact 643. T.M. S1 Dick Case, 2019. Name of the case, M. Siddiq vs. Mahant. Suresh Das. Year of Judgment, 2019. Popular name, Ayodhya Case. Related epic, Ram Janmabhoomi Issue Babri Masjid Land Dispute. Related article, Schedule. Supreme Court Judgment. It awarded the entire 2.77 acres of the disputed land in Ayodhya to the deity Ram Lala Virajman. It gave the following directions. It directed the center to formulate a scheme for the setting up of a trust for the construction of a Ram Mandir at the disputed site where the centuries-old Babri Masjid stood before its demolition in 1992. 2. It directed the center and UP government to allot an alternative 5 acres of land to the UP Sunni Central Waqf Board at a suitable prominent place in Ayodhya for the construction of a mosque. 3. It directed that in framing the scheme for the setting up of the trust, an appropriate representation may be given to the Nirmoni Akara in such manner as the center deems fit. The suit filed by the Akara claiming Shabadi rights has been held to be barred by limitation and shall accordingly stand dismissed. Impact of the judgment. This judgment has put an end to the more than a century-old dispute that has shook the communal harmony dimension of the Indian society. Subsequent to this judgment, the center announced the formation of the Ayodhya Temple Trust called as the Sri Ram Janmabhoomi Tirth Kshetra. Similarly, the UP government announced the allocation of 5 acres of land to the UP Sunni Central Waqf Board in Danapur, Ayodhya. Further, this judgment has overturned the 2010 Allahabad High Court judgment. The High Court had equally divided the disputed land between the 3 parties, viz. 1/3 for Ram Lala Virajman, 1/3 for UP Sunni Central Waqf Board, and 1/3 for Nirmohi Akara. 7 Anuradha Bhushan Case, 2020. Name of the case, Anuradha Bhushan vs. Union of India. Year of Judgment, 2020. Popular name, Related epic, Suspension of Internet Issue Services. Related article, 19 Schedule. Supreme Court Judgment. It held the following. The freedom of speech and expression and the freedom to practice any profession or carry on any trade, business, or occupation over the medium of Internet enjoys constitutional protection under Article 19(1)(a) and Article 19(l)(g). The restriction upon such fundamental rights should be in consonance with the mandate under Article 19(2) and 6, inclusive of the test of proportionality. 2. An order suspending Internet services indefinitely is impermissible under the temporary suspension of IBLCOM services, public emergency, or public safety rules, 2017. Suspension can be utilized for temporary duration only. 3. Any order suspending Internet issued under the suspension rules must adhere to the principle of proportionality and must not extend beyond necessary duration. Impact of the judgment. This judgment led to the emergence of the right to access to the Internet, or right to access to information via the Internet, as a fundamental right under the Constitution. On the other hand, this judgment also recognized the right of the government to shut down the Internet by adhering to the principle of proportionality. These two situations may create conflicts in the provision of Internet services in the country. Rambabu Singh Thakur Case, 2020. Name of the case, Rambabu Singh Thakur vs. Sunil Arora. Year of Judgment, 2020. Popular name, 644_JTL. Indian Polity. Related to PIC, Criminalization of Issue Politics. Related article, Schedule. Supreme Court Judgment. It issued various directions aimed at curbing the growing incidence of criminals in politics. These are, It shall be mandatory for political parties at the central and state election level to upload on their website detailed information regarding individuals with pending criminal cases who have been selected as candidates. This should include the nature of the offenses and relevant particulars such as whether charges have been framed, the concerned court, the case number, etc. The party should also state the reasons for such selection as well as the reasons for such selection as well as the reasons as to why other individuals without criminal antecedents could not be selected as candidates. 2. The reasons as to selection shall be with reference to the qualifications, achievements, and merit of the candidate concerned and not mere winnability at the polls. 3. This information shall also be published in one local vernacular newspaper and one national newspaper, and on the official social media platforms of the political party, including Facebook and Twitter. Impact of the judgment. Subsequent to this judgment, the Election Commission sent a communication to all the recognized political parties requiring them to follow the above directions. Further, it also released a new Form C-7 wherein the political parties have to provide all the information regarding selected candidates having criminal background. Internet and Mobile Association of India Case, 2020. Name of the case. Year of Judgment. Popular name. Related topic. Issue. Related article. Schedule. Internet and Mobile Association of India vs. Reserve Bank of India, 2020. Ban on cryptocurrency trading, 19. Supreme Court Judgment. It struck down a circular issued by the Reserve Bank of India, RBI, that had directed the banks and financial institutions not to deal in virtual currencies (VCs), nor provide services in relation to VCs. It declared the circular as illegal and unenforceable on the ground of proportionality. It said that the RBI itself had not found that the banks and financial institutions have suffered any loss or adversely affected on account of VC exchanges. Further, it also ruled that the circular violates the freedom to carry on trade under Article 19, L.G. Hence, it declared the circular as unconstitutional. Impact of the judgment. This judgment removed the ban on cryptocurrency trading in India. This made the banks and financial institutions to rejoin the virtual currency industry and do the trading. Further, this judgment also brought into focus the need for creating a legal framework for regulating the cryptocurrency trading and the various issues associated with this industry in India. Landmark judgments and their impact. 645. Table 90.1 Cases declaring amendments as unconstitutional. SI. No. Case, year, amendment challenged in the Supreme Court. Provision declared as unconstitutional by the Supreme Court. 1. LC. Golaknath vs. State of Punjab, 1967, 17th Amendment Act, 1964 17th Amendment, in part. 2. Kesavananda Bharati vs. State of Kerala, 1973, popularly known as the Fundamental Rights Case. 25th Amendment Act, 1971, Article 31C, in part. 3. Indira Nehru Gandhi vs. Raj Narain, 1975, popularly known as the Election Case. 39th Amendment Act, 1975, Article 329A, Clause 4. I. 4. Minerva Mills vs. Union of India, 1980, 42nd Amendment Act. 1976. Article 368, Clauses 4 and 5, and Article 31C, in part. 5. P. Sambamurthy vs. State of Andhra Pradesh, 1986. 32nd Amendment Act, 1973, Article 371D, Clause 5, and its proviso. 6 V. Kahoto Halahan vs. Zakilhu, 1992, popularly known as the defection case. 52nd Amendment Act, 1985. 10th Schedule, Paragraph 7. 7. L. Chandrakumar vs. Union of India, 1997, 42nd Amendment Act. 1976. Article 323A, Subclause D, of Clause 2, and Article 3238, Sub-Clause D, of Clause 3. 8. Supreme Court Advocates on Record Association vs. Union of India, 2015, popularly known as the Fourth Judge's Case. 99th Amendment Act, 2014 99th Amendment, total. 9. Union of India vs. Rajendra N. Shah, 2021, 97th Amendment Act, 2011 97th Amendment, in part. Table 90.2 Cases leading to constitutional amendments. SI. No. Case, year, led to the enactment of the Amendment Act, partly or fully. J1. Romesh Thapar vs. State of Madras, 1950, popularly known as the Crossroads Case. First Amendment Act, 1951. 2. Brij Bhushan vs. State of Delhi, 1950, First Amendment Act, 1951. 3. State of Madras vs. Champakam Durarajan, 1951, First Amendment Act, 1951. 1. 4. State of West Bengal vs. Bela Banerjee, 1953, Fourth Amendment Act, 1955. 5. Election Commission vs. Venkata Rao, 1953, 15th Amendment Act, 1962, S6, State of Bombay vs. United Motors India, P. Limited, 1953, 6th Amendment Act, 1956. 7. Sagar Ahmed vs. State of Uttar Pradesh, 1954, 4th Amendment Act, 1955 R. 8. Bengal Immunity Company, Ltd. vs. State of Bihar, 1955, 6th Amendment Act, 1956. 9. MB Karev vs. Election Commission, 1957, 11th Amendment Act, 1961. Continued. Gag J. Indian Polity. SI. No. Case year. Led to the enactment of the Y Amendment Act, partly or fully. 10. State of Madras vs. MS. Gannon Dunkerley and Company. Madras, 1958, 46th Amendment Act, 1982-11. Barabari Union, in Re. 1960, 9th Amendment Act, 1960. 12. New India Sugar Mills vs. Commissioner of Sales Tax, Bihar, 1962, 46th Amendment Act, 1982-13. Chandra Mohan vs. State of UP, 1966, 20th Amendment Act, 1962-14. IC Golaknath vs. State of Punjab, 1967, 24th Amendment Act, 1971. 15. R.C. Cooper vs. Union of India, 1970, popularly known as the Bank. Nationalization case. 25th Amendment Act, 1971. 16. Madhav Rao Scindia vs. Union of India, 1970, popularly known as the Privy Purse case. 26th Amendment Act, 1971. 17. State of Himachal Pradesh vs. Associated Hotels of India Ltd. 1972, 46th Amendment Act, 1982-18. OH and Natural Gas Commission vs. State of Bihar, 1976, 46th Amendment Act, 1982-19. Miss Rilal Jain vs. State of Orissa, 1977, 43rd Amendment Act, 1977-20. Vulshu Agencies vs. Commercial Tax Officer, 1977, 46th Amendment Act, 1982-21. Northern India Caterers, India, Ltd. vs. Lt. Governor of Delhi, 1978, 46th Amendment Act, 1982-22. Prabhakaran Nair vs. State of Tamil Nadu, 1987, 75th Amendment Act, 1993-23. Indra Soni vs. Union of India, 1992, popularly known as the Mundal case. 76th Amendment Act, 1994. 77th Amendment Act, 1995. 81st Amendment Act, 2000. 82nd Amendment Act, 2000. And 85th Amendment Act, 2001. 24. Uni Krishnan vs. State of AP, 1993, 86th Amendment Act, 2002-25. Union of India vs. Virpal Singh Chauhan, 1995, 85th Amendment Act, 2001-26. S. Vinod Kumar vs. Union of India, 1996, 82nd Amendment Act, 2027. Ajit Singh Januja vs. State of Punjab, 1996, 85th Amendment Act, 2001-28. TMA. Pi Foundation vs. State of Karnataka, 2002, 93rd Amendment Act, 2005. 29. 93rd Amendment Act, 2005 Chapter 91 Important Doctrines of Constitutional Interpretation. Doctrine of Severability. Q. Meaning of the doctrine. The doctrine of severability is also known as the doctrine of separability. This doctrine was devised by the Supreme Court to resolve the problem of the validity of laws which are declared as unconstitutional. When a part of the law is declared as institutional, then a question arises whether the whole of the law is to be declared void or only that part of the law, which is unconstitutional, should be declared as void. According to this doctrine, if the offending provision of the law can be separated from that provision which is constitutional, then only that part of the law, which is offending, is to be declared as void and not the whole of the law. In other words, if invalid part of the law can be separated from the rest, then the rest may continue to be valid and operative. If, however, it is not possible to separate the valid part of the law from the invalid part, then the whole of the law is declared as void. Basis of the doctrine. Article 13 is the basis of the doctrine of severability. It makes the following two provisions in this regard. Asterisk Article 13, 1, deals with the pre-Constitution laws and declares that all such laws are void to the extent to which they are inconsistent with the fundamental rights. 1. 2. Article 13, 2, reads as follows. 2. The state shall not make law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. 3. R.M.D. Kamarbugwala vs. Union of India, 1957. For Ibid. 1. Article 13, 1, reads as follows. 1. All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. 2. Article 13, 2, deals with the post-Constitution laws and prohibits the state from making a law which takes away or abridges the fundamental rights, and any such law is void to the extent of the contravention. 2. Only that portion of a law, which violates the fundamental rights, can be declared as void and not the whole of it. The Supreme Court has explained the doctrine of severability in the following way. 3. The question whether a statute which is void in part is to be treated as void in toto, or whether it is capable of enforcement as to that part which is valid. The answer to this question must depend on whether what is valid could be separated from what is invalid, and that is a question which has to be decided by the court on a consideration of the provisions of the Act. 31 propositions of the doctrine. The Supreme Court has laid down the following propositions, rules, regarding the doctrine of severability. 4. 1. In determining whether the valid parts of a statute are separable from the invalid parts thereof, it is the intention of the legislature that is the determining factor. The test to be applied is whether the 648 Indian Polity legislature would have enacted the valid part if it had known that the rest of the statute was invalid. 2. If the valid and invalid provisions are so inextricably mixed up that they cannot be separated from one another, then the invalidity of a portion must result in the invalidity of the act in its entirety. On the other hand, if they are so distinct and separate that after striking out what is invalid, what remains is in itself a complete code independent of the rest, then it will be upheld notwithstanding that the rest has become unenforceable. 3. Even when the provisions which are valid are distinct and separate from those which are invalid, if they all form part of a single scheme which is intended to be operative as a whole, then also the invalidity of a part will result in the failure of the whole. For likewise, when the valid and invalid parts of a statute are independent and do not form part of a scheme, but what is left after omitting the invalid portion is so thin and truncated as to be in substance different from what it was when it emerged out of the legislature, then also it will be rejected in its entirety. 5. The separability of the valid and invalid provisions of a statute does not depend on whether the law is enacted in the same section or different section. It is not the form, but the substance of the matter that is material, and that has to be ascertained on an examination of the act as a whole and of the setting of the relevant provision therein. 6. If after the invalid portion is expunged from the statute what remains cannot be enforced without making alterations and modifications therein, then the whole of it must be struck down as void, as otherwise it will amount to judicial legislation. In determining the legislative intent on the question of separability, it will be legitimate to take into account the history of the legislation, its object, the title, and the preamble to it. The important cases relating to the doctrine of severability and their judgments are given in FBLE 91.1. Table 91.1 Important cases relating to the doctrine of severability. SI. No. Case, year, Supreme Court judgment. 1. A.K. Gopalan vs. State of Madras, 1950. It struck down Section 14 of the Preventive Detention Act, 1950, on the ground that it violates the fundamental right under Article 22 of the Constitution. It declared the rest of the Act as valid and effective. 5. 2. State of Bombay vs. F. N. Balsera, 1951. It declared 8 sections of the Bombay Prohibition Act, 1949, as ultravires on the ground of infringement of the fundamental rights. It held that the void provisions did not affect the validity of the entire Act. 3. RMD Kamarbagwala vs. Union of India, 1957. It held that the provisions of the Prize Competitions Act, 1955, were severable and struck down those provisions which related to competitions involving skill. In this case, the validity of Section 2d of the Act, which included competition of gambling as well as those involving skill, was challenged. According to Article 19(1)(g), the Parliament can restrict prize competitions only of a gambling nature, but not those involving skill. 5. The Supreme Court observed, the impugned Act minus this section can remain unaffected. The omission of this section will not change the nature or the structure or the object of the legislation. Therefore, the decision that Section 14 is ultra vires does not affect the validity of the rest of the Act. Important doctrines of constitutional interpretation at 49. SI. No. Case, year, Supreme Court judgment 4. Minerva Mills vs. Unio of India, 1980. It struck down Sections 4 and 55 of the 42nd Amendment Act, 1976. For being beyond the amending power of the Parliament, it declared the rest of the Act as valid. 5. Kahoto Holohan vs. Zakilhu, 1992, popularly known as the defection case. It declared paragraph 7 of the 10th Schedule, which was inserted by the 52nd Amendment Act, 1985, as unconstitutional for violating the provision under Article 368, 2. It upheld the rest of the 10th Schedule, i.e., 10th Schedule minus paragraph 7 is valid. Doctrine of waiver. Meaning of the doctrine. The doctrine of waiver is based on the premise that a person who is entitled to a right or privilege is at liberty to waive or give up that right or privilege. It is a voluntary renunciation of a known right or privilege. The doctrine of waiver is defined in the following way: *7. Paragraph 7 requires ratification under the proviso to Article 368, 2, for excluding the jurisdiction of high courts under Article 226 and Supreme Court under Article 136. 7. Surendra Malik and Sudeep Malik, Supreme Court on Doctrines and Maxims, Eastern Book Company, 2014, pp. 697-698. 8. Bashishar Nath vs. Commissioner of Income THX, 1958. Waiver is an intentional relinquishment of a right. It involves conscious abandonment of an existing legal right, advantage, benefit, claim, or privilege, which except for such a waiver, a party could have enjoyed. In fact, it is an agreement not to assert a right. There can be no waiver unless the person who is said to have waived is fully informed as to his rights, and with full knowledge about the same, he intentionally abandons them. It must be noted here that the doctrine of waiver is not applicable to the fundamental rights in India. In other words, a citizen cannot waive his fundamental rights in India. On the other hand, the doctrine of waiver is applicable to the fundamental rights in USA. In other words, an American citizen can waive his fundamental rights. In short, there is the doctrine of non-waiver in India. Q position in India with respect to the application of the doctrine of waiver to India, the Supreme Court made the following observations. 1. Fundamental rights cannot be waived by a citizen. They are mandatory on the state and necessary to attain the objectives enshrined in the preamble. Hence, no citizen can relieve the state of this obligation which is imposed on it by the Constitution. 2. The doctrine of waiver enunciated by some American judges in construing the American Constitution cannot be introduced in our Constitution. 3. The fundamental rights have not been put in the Constitution merely for individual benefit, though ultimately they come into operation in considering individual rights. They have been put there as a matter of public policy, and the doctrine of waiver can have no application to provisions of law which have been enacted as a matter of constitutional policy. 4. Reference to some of the articles, inter alia, Articles 15, 1, 20, 21, makes the proposition quite plain. A citizen cannot get discrimination by telling the state, you can discriminate, or get convicted by waiving the protection given under Articles 20 and 21. 650 Indian Polity. Table 91.2 Important cases relating to the doctrine of waiver. 1 SI. No. Case, year, Supreme Court Judgment 1. Biram Khurshid Pesakaka vs. State of Bombay, 1954. It held that in a criminal prosecution, it is not open to an accused person to waive his fundamental rights and get convicted. 2. Bashiz Arnath vs. Commissioner of Income Tax, 1958. It rejected the contention of the respondent that the petitioner, by voluntarily entering into an agreement to pay the tax, had waived his fundamental right guaranteed under Article 14. It upheld the contention of the petitioner holding that the fundamental rights could not be waived. 3. Olga Tellis vs. Bombay Municipal Corporation, 1985, popularly known as the Pavement Dwellers case. It held that a person cannot waive any of the fundamental rights conferred upon him by any of his act, and there cannot be any estoppel against the Constitution. It asserted that the high purpose which the Constitution seeks to achieve by conferment of fundamental rights is not only to benefit the individual but to secure the larger interests of the community. 4. Nar Singh Pal vs. Union of India, 2000. It reiterated that the fundamental rights under the Constitution cannot be bartered away. It asserted that the fundamental rights cannot be compromised, nor can there be any estoppel against the exercise of fundamental rights. 5. Whatever be the position in America, no distinction can be drawn here, as has been attempted in the United States of America, between the fundamental rights which may be said to have been enacted for the benefit of the individual and those enacted in public interest or on grounds of public policy. 6. Ours is a nascent democracy, and situated as we are, socially, economically, educationally, and politically, it is the sacred duty of the Supreme Court to safeguard the fundamental rights. 3 important cases. The important cases relating to the doctrine of waiver and their judgments are given in THBLI 91.2. Doctrine of eclipse. Meaning of the doctrine. The prospective nature of the provision under Article 13, 1, of the Constitution has led to the emergence of the doctrine of eclipse. This provision deals with the pre-Constitution laws and declares that all such laws are void to the extent to which they are inconsistent with the fundamental rights. 9 Article 13, 1, reads as follows. 1. All laws in force in the territory of India immediately before the commencement of this Constitution, in so far as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. The doctrine of eclipse is based on the notion that a pre-constitutional law which is inconsistent with a fundamental right is not a nullity or void from its very inception. Such a law becomes only inoperative from the date of the commencement of the Constitution. It is overshadowed or eclipsed by the fundamental right and remains dormant but is not dead altogether. It is not wiped out completely from the statute book. It continues to exist, for all past transactions. 2. For the enforcement of rights acquired and liabilities incurred before the date of the commencement of the Constitution. And 3. For the determination of rights of non-citizens who have not been given the fundamental rights by the Constitution. Thus, it does not become void in toto or for all purposes or for all times or for all persons. Important doctrines of constitutional interpretation. 651. However, if the shadow cast on such a law by the relevant fundamental right is removed by an amendment of the Constitution, then the law would again become constitutional and enforceable. In other words, the amendment of the fundamental right makes the impugned law free from all blemish or infirmity. 2. Formulation of the doctrine. The doctrine of eclipse was enunciated by the Supreme Court in the Bakaji Case 10, 1955. In this case, Section 43 of the Motor Vehicles Act, 1939, was amended by the Central Provinces and Berar Motor Vehicles Amendment Act 1947. This provision empowered the state government to take over the motor transport business to the exclusion of individual operations. But it became void with the commencement of the Constitution in 1950 as it violated the fundamental right under Article 19, L.G. Article 13.2 reads as follows. 2. The state shall not make law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. 12 Deepchand vs. State of U.P. 1959. 13 Mahindra Lal Jain vs. State of U.P. 1962. 14 Deepchand vs. State of UP 1959. 15 State of Gujarat vs. Sri Ambika Mills Ltd. 1974. Later, the First Amendment Act 1951 amended Article 19(6) and enabled the government to take over any trade or business either exclusively or in competition with the individuals. Consequently, the state government issued a notification to take over the motor transport business. This notification was challenged in the Supreme Court. The state government argued that from January 26, 1950 to June 18, 1951, Section 43 of the Motor Vehicles Act, 1939, remained invalid. But the amendment of the provision under Article 19(6) by the First Amendment Act, 1951, made the same Section 43 of the Act valid again. Finally, the Supreme Court held that the impugned Act became, for the time being, eclipsed be the fundamental right, but the amendment of Article 19(6) removed the shadow. In other words, the court upheld the validity of the notification by applying the doctrine of eclipse. Application to post-constitutional laws. Article 13(1) deals with the pre-constitution laws, while Article 13(2) deals with the post-constitution laws. The latter prohibits the 10 Bikaji Narin Doctras vs. State of M.P. 1955. State from making a law which takes away or abridges the fundamental rights, and any such law is void to the extent of the contravention. 11. In Deepchand Case 12, 1959, the Supreme Court held that the doctrine of eclipse applies only to the pre-constitution laws and not to the post-constitution laws. This is because a post-constitution law which contravenes a fundamental right is a nullity or void from its very inception and a stillborn law. Therefore, it cannot be revived by a subsequent constitutional amendment. Accordingly, the court upheld the constitutionality of the Uttar Pradesh Transport Service Development Act, 1955, saying that it did not violate Article 31 of the Constitution. In Mahindra Lal Jain Case 13, 1962, the Supreme Court reiterated its verdict delivered in Deepchand Case 14, 1959, and held that the doctrine of eclipse cannot be applied to the post-constitution laws. The court observed, the doctrine of eclipse will apply to pre-constitution laws which are governed by Article 13(1), and would not apply to post-constitution laws which are governed by Article 13(2). Unlike a law governed by Article 13(1), which was valid when made, the law made in contravention of the prohibition contained in Article 13(2) is a stillborn law either wholly or partially depending upon the extent of the contravention. Such a law is dead from the beginning, and there can be no question of its revival under the doctrine of eclipse. However, the position in Ambika Mills Case 15, 1974, was different. In this case, the Supreme Court reversed its earlier stand and applied the doctrine of eclipse even to a post-constitution law. The court held that a post-constitution law which violates the 652p Indian Polity fundamental rights is not a nullity or void in all cases and for all purposes. Further, it said that there are many exceptions to the doctrine of absolute nullity, and hence, it cannot be regarded as a universal rule. A post-constitution law which violates the fundamental right conferred by Article 19 will be effective as regards to non-citizens because fundamental rights are not conferred on them. On the other hand, such a law will become a nullity or void only against citizens because fundamental rights are available to them. Accordingly, the Bombay Labour Welfare Funct Act, 1953, was held to be valid and operative with regard to non-citizens. Later, the Supreme Court applied the doctrine of eclipse to a post-constitution law even against citizens in Delari Lod Case 1, 1984. Doctrine of Territorial Nexus K_HI meaning of the doctrine of territorial nexus is rated to Article 245, which deals with the extent of laws made by the Parliament and the state legislatures. It contains the following provisions. 1. The Parliament is empowered to make laws for the whole or any part of the territory of India. In addition, it can also make extraterritorial legislation. This implies that the parliamentary laws are applicable not only to the persons and property within the territory of India, but also to the Indian citizens and their property in any part of the world. 2. A state legislature is empowered to make laws for the whole or any part of the state. Unlike the Parliament, a state legislature cannot make extraterritorial legislation. From the above, it is clear that the laws made by a state legislature are not applicable outside the state. However, there is one exception to this general rule, i.e., an extraterritorial Delari Lod vs. Heard Additional District Judge, Kanpur, 1984. Legislation made by a state legislature is valid when there is a sufficient nexus between the state and the object. This is known as the doctrine of territorial nexus. According to the doctrine of territorial nexus, the object to which a state law applies need not be physically located within the state territory, but it is required that there should be a sufficient nexus or connection between the state and the subject matter of the law. This means that a state law having extraterritorial operation is held valid by applying the doctrine of territorial nexus. A formulation of the doctrine. In the pre-Constitution period, there were three important cases in which the doctrine of territorial nexus was applied. The federal court applied the doctrine in Raleigh Case 1 Foot, 1944, and Wadia Case 1 Inch, 1949, while the Privy Council applied it in Wallace Case 19, 1948. These three cases were related to the income tax law. 1. Governor General versus Raleigh Investment Company, 1944. 18A.H. Wadia versus Commissioner of Income THX, 1949. Wallace Brothers and Company Limited versus Commissioner of Income LUX, 1948. Tin State of Bombay versus RMB Kamerbadwala, 1957. Ayatada Iron and Steel Company versus State of Bihar, 1958. In the post-Constitution period, the Supreme Court applied the doctrine in RMD Kamerbadwala Case 211, 1957. This case was related to the law imposing a tax on gambling. In this case, the court held that if there is a sufficient territorial nexus between the person sought to be taxed and the state seeking to tax him, the taxing law is upheld. It also clarified that the sufficiency of territorial nexus involves a consideration of the following two important elements. 1. The nexus must be real and not illusory. And 2. The liability sought to be imposed must be relevant to that nexus. In Tisco Case 21, 1958, the Supreme Court applied the doctrine to the sales tax law. An important doctrines of constitutional interpretation *1653. This case, the court observed that this doctrine does not impose the tax, but it only indicates the circumstances in which a tax imposed by a law shall be enforced in a particular case. In NTPC Case 22, 2002, the Supreme Court has explained the doctrine in the following way. 22 State OFA. P. versus National Thermal Power Corporation Limited, 2002. 23 State of Bihar versus Karisala Desai, 1959. 24 Shrikant Balchandra Karolkar versus State of Gujarat, 1994. 25 Kazan Singh versus State of U. P. 1973. 26 Ibid. It is by reference to the ambit or limits of territory by which the legislative powers vested in Parliament and the state legislatures are divided in Art. 245. Generally speaking, a legislation having extraterritorial operation can be enacted only by Parliament and not by any state legislature. Possibly the only exception being one where extraterritorial operation of a state legislation is sustainable on the ground of territorial nexus. Such territorial nexus, when pleaded, must be sufficient and real and not illusory. Q. Application to non-tax laws. The doctrine of territorial nexus is applicable not only to tax laws like income tax law, law imposing a tax on gambling and sales tax law, but also to other kinds of laws. Thus, in Karisala Desai Case 23, 1959, the Supreme Court held that a state legislature is empowered to make laws with respect to charitable and religious trusts situated within the territory of the state, even though some part of the trust property is situated in another state. As a natural corollary to this, the state legislature is also empowered to make laws in respect of the trustees, their servants and agents who are in that state to administer the trust. Accordingly, the court upheld the validity of a law made by the Bihar legislature with respect to trust property situated in the state of West Bengal. Likewise, in Shrikant Case 24, 1994, the Supreme Court held that the Gujarat state was empowered to make the law so as to provide that the ceiling of agricultural land of a person in that state could be determined by taking into account the agricultural land held by him outside that state also. Accordingly, the court upheld the validity of the Gujarat Agricultural Land Ceiling Act, 1960. Q. Exceptions to the doctrine. The doctrine of territorial nexus is not applicable in the following two situations. 1. When a state government, while acting under the Motor Vehicles Act, a central legislation, approves a scheme for interstate routes for the state transport undertaking. In Kazan Singh Case 1973, the Supreme Court upheld the validity of a Uttar Pradesh scheme nationalizing certain routes between that state and the state of Rajasthan. 2. When a state carry on trade and business under the provision of Article 298. In the same Kazan Singh Case 1973, the Supreme Court held that the trade and business to be carried on by a state need not be restricted to the area within its boundaries. 26. Doctrine of Pith and Substance. Q. Meaning of the doctrine. Article 246 deals with the division of legislative powers between the Parliament and the state legislatures. It specifies the different subjects of legislation in three lists, namely, List I, Union List, List 2, State List, and List 3, Concurrent List. Accordingly, the Parliament or a state legislature should make laws within their respective jurisdictions and should not encroach upon the other's sphere. If it encroaches, then the validity of the law enacted by it is determined by applying the doctrine of pith and substance. According to this doctrine, a law in question must be looked into as an organic whole and not as a mere collection of sections, for $654 Indian Polity. Determining the true nature and character of the impugned law, i.e., the pith and substance of the law. If it is found that the pith and substance of the impugned law relates to the subject within the domain of the legislature enacting the law, then the law would be held valid even though it incidentally encroaches on subjects which have been assigned to another legislature. Further, for applying the doctrine, one must have regard, a. to the enactment as a whole, b. to its main objects, and C. To the scope and effect of its provisions. A rationale of a doctrine. The doctrine of pith and substance was evolved by the Privy Council when it determined appeals from Canada or Australia involving the question of legislative competence of the centre or the states in those federations. Later, this doctrine came to be established in India, where it derives its genesis from the approach adopted by the courts, including the Privy Council, in dealing with controversies arising in other federations. While explaining the rationale of the doctrine, the Supreme Court made the following observation: 27a.s. Krishna vs. State of Madras, 1956. Prafulla Kumar Mukherjee vs. Bank of Commerce, 1947. It must be remembered that we are construing a federal constitution. It is of the essence of such a constitution that there should be a distribution of the legislative powers of the federation between the center and the provinces. The scheme of distribution has varied with different constitutions, but even when the constitution enumerates elaborately the topics on which the center and the states could legislate, some overlapping of the fields of legislation is inevitable. E.s. Principles of the doctrine. In the pre-constitution period, the doctrine of pith and substance was applied by the Privy Council in Prafulla Kumar Case 28, 1947. This case involved the interpretation of the Division of Powers under the Government of India Act, 1935. In this case, the validity of the Bengal Money Lenders Act, 1946 was challenged on the ground that it was ultra vires the Bengal legislature insofar as it related to promissory notes, which was a central subject. The Calcutta High Court held the act to be intra vires, while the federal court, on appeal, reversed it. Finally, the Privy Council held that the act was, in pith and substance, a law in respect of money lending and money lenders, a state subject, and hence was valid even though it incidentally encroached on promissory notes. In the above case, the Privy Council laid down the following principles of the doctrine of pith and substance. 1. It is not possible to make a clear-cut demarcation between the powers of the federal legislature and the provincial legislature. The powers are bound to overlap from time. Where they overlap, the questions must be asked are: A. What, in pith and substance, is the effect of the enactment of which complaint is made? B. In what list is its true nature and character to be found? If these questions could not be asked, much beneficent legislation would be stifled at birth, and many of the subjects entrusted to the provisional legislature could never effectively be dealt with. 2. The extent of the invasion by the provinces into subjects enumerated in the federal list has to be considered. No doubt it is an important matter, not because the validity of an act can be determined by discriminating between degrees of invasion, but for the purpose of determining what is the pith and substance of the impugned act. 3. Where the three lists come in conflict, List I has priority over List 3 and 2, and List 3 has priority over List 2. But the question still remains, priority in what respect? Does the priority of the federal legislature prevent the provincial legislature from dealing with any matter? Important doctrines of constitutional interpretation. 655. Table 91.3 Important cases relating to the doctrine of pith and substance. ISI. No. Case, year, Supreme Court Judgment 1. State of Bombay vs. F.N. Balsara, 1951. It upheld the validity of the Bombay Prohibition Act, 1950. This act was challenged on the ground that it encroached upon a matter enumerated in the Union List. 2. D.N. Banerjee vs. P.R. Mukherjee, 1952. It upheld the validity of the Industrial Disputes Act of the Parliament. This act, insofar as it applied to the municipalities, was challenged on the ground that it related to the local government, which was a subject enumerated in the state list. 3. State of Rajasthan vs. G. Chawla, 1958. It upheld the validity of the Rajasthan Act, which restricted the use of sound amplifiers. This act was challenged on the ground that it encroached upon a subject of broadcasting or communication which is mentioned in the Union List. 4. State of Gujarat vs. Shanalal Mangattas, 1969. It held that the doctrine of pith and substance is applicable in determining whether an act is within the competence of the legislature. It is wholly irrelevant in determining whether the act infringes any fundamental right. 5. M. Ismail Farikal vs. Union of India, 1994. It upheld the validity of the acquisition of certain area at Ayodhya Act 1993 made by the Parliament. It held that the pith and substance of the act was acquisition of property and not related to public order, and hence it fell within the ambit of the concurrent list. 6. Zamir Ahmed Latifer Raymond Sheikh vs. State of Maharashtra 2010. It upheld the validity of the Maharashtra Control of Organized Crime Act, 1999. The act was challenged on the ground that it encroached upon the subject enumerated in the Union List, which may incidentally affect any item in its list, or in each case has one to consider what the substance of the act is, and, whatever its ancillary effect, attribute it to the appropriate list according to its true character. The latter is the true view. In the post-Constitution period, the Supreme Court has consistently applied the above principles in a number of cases. The important cases relating to the doctrine of pith and substance and their judgments are given in Table 91.3. Doctrine of colorable legislation. The Parliament and the state legislatures. It enumerates the legislative subjects in three lists, namely, the Union List, the state, and the concurrent list under the 7th Schedule. Both are required to operate within their respective legislative competence. But, sometimes, a legislature makes a law which, though in form appears to be within its competence, in effect and substance lies beyond its ambit. Then the law would be declared as void. In other words, the different color given to the law by the legislature so as to bring it within its ambit would not save it from being declared as invalid. Such a law is called as colorable legislation. Colorable legislation would emerge only when a legislature had no power to legislate on an item either because it was not included in the list assigned to it under the respective entries in the 7th Schedule, or on account of limitations imposed whether under Part 3 of the Constitution relating to. Meaning of the doctrine. The Constitution, under Article 246, provides for the division of legislative powers between 656 Indian Polity. The fundamental rights, or any other power under the Constitution. The whole doctrine of colorable legislation is based upon the maxim that you cannot do indirectly what you cannot do directly, i.e., what cannot be done directly, cannot also be done indirectly. This means that the use of the expression colorable legislation seeks to convey that by enacting the legislation in question, the legislature is seeking to do indirectly what it cannot do directly. Q propositions of the doctrine. The Supreme Court has laid down the following propositions in respect of the doctrine of colorable legislation. 29 K.C. Gajapati Narayan Deo vs. Store of Orissa, 1953. 1. If the Constitution distributes the legislative powers amongst different legislative bodies, which have to act within their respective spheres marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, questions do arise as to whether the legislature in a particular case has or has not, in respect of the subject matter of the statute or in the method of enacting it, transgressed the limits of its constitutional powers. Such transgression may be patent, manifest, or direct, but it may also be disguised, covert and indirect, and it is to this latter class of cases that the expression colorable legislation has been applied in judicial pronouncements. 2. The idea conveyed by the expression that although apparently a legislature in passing a statute purported to act within the limits of its powers, yet in substance and in reality it transgressed these powers, the transgression being veiled by what appears, on proper examination, to be a mere pretense or disguise. 3. It is the substance of the act that is material and not merely the form or outward appearance, and if the subject matter in substance is something which is beyond the powers of that legislature to legislate upon, the form in which the law is clothed would not save it from condemnation. 4. The legislature cannot violate the constitutional prohibitions by employing an indirect method. In cases like these, the inquiry must always be as to the true nature and character of the challenged legislation, and it is the result of such investigation and not the form alone that will determine as to whether or not it relates to a subject which is within the power of the legislative authority. For the purpose of this investigation, the court would certainly examine the effect of the legislation and take into consideration its object, purpose, or design. But these are only relevant for the purpose of ascertaining the true character and substance of the enactment and the class of subjects of legislation to which it really belongs and not for finding out the motives which induce the legislature to exercise its powers. 5. The doctrine of colorable legislation does not involve any question of bona fides or mala fides on the part of the legislature. The whole doctrine resolves itself into the question of competency of a particular legislature to enact a particular law. If the legislature is competent to pass a particular law, the motives which impelled it to act are really irrelevant. On the other hand, if the legislature lacks competency, the question of motive does not arise at all. Whether a statute is constitutional or not, and thus always a question of power. 6. A court must be blind indeed if it looks merely at the language of a statute and ignores its obvious purpose, effect, and operation. Hence, when a statute is impugned as being a mere colorable device to evade constitutional provisions, the court is required to scrutinize in its entirety the impugned statute as well as important doctrines of constitutional interpretation. 657. 2. 3. Other bills or acts which may form part of a scheme for such evasion, for the purpose of ascertaining the true nature and character, or pith and substance of the impugned statute. Sometimes, it may so happen that statute, when considered independently, may be free from any objection, but if it could be shown that it is part of a general scheme on the part of the legislature, by a series of acts to achieve an object which it could not validly achieve in one piece of legislation, the statute would also be struck down as unconstitutional. The doctrine of colorable legislation is also known as the doctrine of fraud on the Constitution. The Supreme Court, in this context, has made the following observation. 30. Colorable piece of legislation is a legislation ostensibly under one or the other of the powers conferred by the Constitution, but in substance and reality, not falling within the content of that power. The failure to comply with a constitutional condition for the exercise of legislative power may be overt or it may be covert. When it is overt, we say the law is obviously bad for non-compliance with the requirements of the Constitution, that is to say, the law is ultra vires. When, however, the non-compliance is covert, we say that it is a fraud on the Constitution, the fraud complained of being that the legislature pretends to act within its power while in fact it is not so doing. Therefore, the charge of fraud on the Constitution is, on ultimate analysis, nothing but a picturesque and epigrammatic way of expressing the idea of non-compliance with the terms of the Constitution. It must be noted here that the doctrine of fraud on the Constitution is different from the doctrine of fraud on legislative power. The Supreme Court, while explaining this distinction, made the following observation 31. The doctrine of fraud on legislative power means that the legislature really has the power, but does not exercise that power. It merely pretends to have exercised the power. In the eye of law, such an act is not a law at all, but is a mere pretense of law, and the courts will not take notice of such a law. The doctrine of fraud on the Constitution is altogether a different principle and a serious charge. When there is a constitutional prohibition to make an act, but the legislature, in spite of the constitutional prohibition, enacts such a law, it is a fraud on the Constitution. Therefore, the distinction between the fraud on legislative power and fraud on the Constitution is clear and unambiguous. The principle of fraud on legislative power is applicable when the legislature has power to enact, but has not exercised that power as envisaged upon. On the other hand, the doctrine of fraud on the Constitution means that when the legislature has no power and in spite of the constitutional prohibition, it makes an enactment in pretense of or purported exercise of the power. It would, therefore, be necessary to examine these concepts in the light of the related subject, the legislative history. The respective entries in the list concerned of the seventh schedule and the power of the legislature to determine whether the legislature has competence to enact law or enacted it by playing a fraud on the Constitution colorable exercise of power. A doctrine of fraud on the Constitution. L. Doctrine of fraud on legislative power. State of Bihar vs. Kameshwar Singh, 1952. I. S. Bola vs. V.D. Sardana, 1997. 658b Indian Polity. Table 91.4 Important cases relating to the doctrine of colorable legislation. S.I. No. Case, year, Supreme Court judgment. 1. State of Bihar vs. Kameshwar Singh, 1952. It invalidated the Bihar Land Reforms Act, 1950. It held that the provision of the act relating to the payment of compensation for the acquisition of surplus land was only a pretension and not a reality. 2. K.C. Gajapal Narayan Deo vs. State of Orissa, 1953. It upheld the validity of the Orissa Agricultural Income Tax Amendment Act, 1950. It held that the act was not a colorable legislation as it fell within the legislative competency of the state legislature. 3. K.D. Mupilnir vs. State of Kerala, 1960. And declared the Travancore-Cochin Land Tax Act, 1955 as invalid. It held that the act violated Articles 14 and 19, 1, f, and its provisions were confiscatory in nature. 4. M.R. Balaji vs. State of Mysore, 1962. It declared the state order reserving 68% of seats in educational institutions to the backward class students as void. It held that the executive order violated Article 15, 4, and hence was a fraud on the Constitution. Doctrine of implied powers. The important cases relating to the doctrine of colorable legislation and their judgments are given in TBLI 91.4. Q meaning of the doctrine of implied powers is also known as the doctrine of implication. This doctrine is based on the maxim that whoever grants a thing is deemed also to grant that without which the grant itself would be of no effect. According to the Black's Law Dictionary, the term implied power means a political power that is not enumerated but that nonetheless exists because it is needed to carry out an express power. While defining the doctrine of implied powers, Craze observed, one of the first principles of law with regard to the effect of an enabling act is that if a legislature enables something to be done, it gives power at the same time by necessary implication to do everything which is indispensable for the purpose of carrying out the purposes in view. Similarly, C.B. Pollock, while dealing with this doctrine, said 32, whenever anything is authorized, and especially if, as matter of duty, required to be done by law, and it is found impossible to do that thing unless something else not authorized in express terms be also done, then that something will be supplied by necessary intendment. This doctrine can be invoked in cases where an act confers a jurisdiction. It also confers by implication the power of doing all such acts, or employing such means as are essentially necessary to its execution. 32 Michaeli Fenton and James Fraser vs. John Stephen, Hempton, 1858. 33 Biddy Leaves and Tobacco Merchants Association vs. State of Bombay, 1961. A scope of the doctrine. The Supreme Court has explained the scope and effect of the doctrine of implied powers in the following way. 33. The doctrine of implied powers can be legitimately invoked when it is found that a duty has been imposed or a power conferred on an authority by a statute, and it is further found that the duty cannot important doctrines of constitutional interpretation. 659. Be discharged or the power cannot be exercised at all unless some auxiliary or incidental power is assumed to exist. In such a case, in the absence of an implied power, the statute itself would become impossible of compliance. The impossibility in question must be a general nature, as that the performance of duty or the exercise of power is rendered impossible in all cases. It really means that the statutory provision would become a dead letter and cannot be enforced unless a subsidiary power is implied. Q. Application of the doctrine. The Supreme Court has applied the doctrine of implied powers in a number of constitutional cases. The important among them are as follows. In Gopal Chandra Mishra Case 34, 1978, the Supreme Court held that a judge of a state high court has an implied power under the provisions of Article 217 to revoke his resignation even after his resignation letter has been received. 34 Union of India vs. Gopal Chandra Mishra, 1978. 35 Rupa Ashokura vs. Ashokura, 2002. 36 Raja Rampal vs. Speaker of the Lok Sabha, 2007. 37 State of Punjab vs. Salil Sablok, 2013. In Rupa Ashokura Case 35, 2002, the Supreme Court held that it has an implied power, i.e., inherent power, which enables it to reconsider its own judgments. It suggested that a curative petition can be filed for seeking reconsideration of a judgment that has become final after dismissal of a review petition under the provisions of Article 137. It said that a curative petition is allowed in order to cure a gross miscarriage of justice and to prevent abuse of its process. In Raja Rampal Case 36, 2007, the Supreme Court held that the Parliament has an implied power under the provisions of Article 105 to expel its members for its contempt. In Salil Sablok Case 37, 201-3, the Supreme Court held that Article 316, which grants a state governor the power to appoint the members of the State Public Service Commission, SPSC, also grants the implied power to lay down the procedures for such appointments. A doctrine of implied prohibition. The doctrine of implied prohibition is the opposite of the doctrine of implied powers. This doctrine is based on the maxim that express mention of one thing implies the exclusion of another. The doctrine of implied prohibition is applied in USA and Australia. In these federal countries, only the powers of the central legislature are enumerated in the Constitution and the residuary powers have been left to the state legislature. This means that there is an implied prohibition on the central legislature to make laws on the residuary subjects. However, this prohibition is not applicable to those encroachments on the residuary powers of the state legislature, which are incidental and ancillary to the proper execution of the express powers granted to the central legislature. The doctrine of implied prohibition is not applicable in India. In the Indian Constitution, the powers of both the central legislature and the state legislature have been separately enumerated. The Parliament can legislate on the subjects enumerated in the Union list, concurrent list, and also on the residuary subjects. On the other hand, a state legislature can legislate on the subjects enumerated in the state list and concurrent list. However, the doctrine of incidental and ancillary powers is applied in India also. 7. Doctrine of incidental and ancillary powers. Of the doctrine. The legislative powers of the Parliament and the state legislatures are mentioned in the 7th Schedule of the Constitution. Every such power, i.e., expressly mentions $660 Indian Polity. Legislative power carries with it the incidental or ancillary power which is necessary to execute that power. In other words, the incidental and ancillary powers are those powers which are required to be exercised by the legislatures for the effective exercise of legislative powers expressly bestowed on them by the Constitution. In USA, such powers are called as necessary and proper powers, while in Australia, they are described as powers incidental to the execution of that power. According to this doctrine, the entries enumerated in the 3 legislative lists are not to be read in a narrow or restricted sense, and each general word in an entry should be held to extend to all incidental or ancillary matters which can fairly and reasonably be comprehended. In it 39. Hence, the power to levy tax would include the power to make provisions for checking tax evasion 40. Similarly, the power to legislate with respect to collection of rent includes the power to legislate with respect to remission of rent 41. For LCHCCK Post Officer vs. KP Abdullah, 1970. RMD Kamarbagwala vs. State of Mysore, 1961. 44 S.S. Bola vs. VD Sardana, 1997. However, the above logic of wider interpretation does not mean that the scope of the American Constitution describes the incidental or ancillary powers of the Congress in the following way. LB make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Justice Gajendra Dukkar, while explaining the doctrine of incidental and ancillary powers, made the following observation. It is an elementary cardinal rule of interpretation that the words used in the Constitution which confer legislative power must receive the most liberal construction, and if they are words of wide amplitude, they must be interpreted so as to give effect to that amplitude. It would be out of place to put a narrow or restricted construction on words of wide amplitude in a Constitution. A general word used in any entry must be construed to extend to all ancillary or subsidiary matters which can fairly and reasonably be held to be included in it. 40 Commissioner of Commercial Taxes vs. R.S. Javer, 1967. 41 United Provinces vs. Attica Begum, 1941. Incidental or ancillary power can be extended to any unreasonable extent. Hence, the power to levy tax cannot be held to include the power to confiscate goods 42. Further, This doctrine cannot be used as a cloak for extending the power of a legislature so as to comprehend a subject which is explicitly mentioned in a list. For example, the legislative power in respect of betting and gambling. In Entry 34 of the state list does not include the power to impose taxes on betting and gambling, which is explicitly mentioned as a separate subject in Entry 62 of the state list 43. Moreover, this doctrine cannot be extended to the exercise of the legislative power colorably or by fraud on the Constitution. A rationale of the doctrine. The Supreme Court has founded the doctrine of incidental and ancillary powers to relieve a statute from its invalidity or unconstitutionality. The Court, while explaining the rationale of the doctrine, made the following observation 44. The courts have applied the doctrine of pith and substance, and in some cases the doctrine of incidental or ancillary or subsidiary power of the legislature to uphold the law or to validate the law declared by the courts as invalid. Thereon, one of the doctrines is applied when the court finds that the law in pith and substance is within the legislative competence but incidentally trenches upon another subject of legislation. Equally, the doctrine of ancillary or subsidiary power of the legislature is applied when the court records a finding that the impugned act is substantially within the legislative competence, but incidentally it trenches upon another subject of legislation assigned either to Parliament or the legislature of a state, as the case may be. The doctrine of incidental or ancillary power is founded upon the principle that important doctrines of constitutional interpretation 661. Table 91.5 Important cases relating to the doctrine of incidental and ancillary powers. SI. No. Case, year, Supreme Court judgment. 1. Chutterbhuj vs. Union of India, 1959. It held that the power to impose tax includes power of raising revenue by imposing license fee. 2. Rai Ramkrishna vs. State of Bihar, 1963. It held that the power to enact laws on a subject includes the power to make a valid law retrospectively, if the existing law on the same subject is declared as unconstitutional. 3. Pathumma vs. State of Kerala, 1978. It held that the power to enact laws in respect of moneylending and moneylenders. Relief of agricultural indebtedness includes power to enact a law relating to debt of agriculturists already paid by sale of property and execution of the decree and any measure to provide relief and recompense. 4. State of Haryana vs. Santlal, 1993. It held that the power to levy sales tax cannot be used to include within that law merely transporters of goods. 5. Godfrey Phillips India Limited vs. State of UP 2005. It held that the power to impose tax includes all events concerning that tax, unless an event is included in another list. In a case where on the face of a statute, it appears that the legislative subject falls both in the union as well as the state list, but on a careful scrutiny it becomes clear that it falls merely incidentally in one list, but substantially in another list. However, it cannot be regarded as the case of substantial encroachment trespassing into another field. The incidental encroachment, therefore, means that in enacting a legislation, the legislature has not traversed beyond the legislative field allotted to it by the arrangement of distribution of powers in the respective entries in the list concerned in the 7th schedule. Key important cases. The important cases relating to the doctrine of incidental and ancillary powers and their judgments are given in Table 91.5. Doctrine of precedent. Q meaning of the doctrine. The doctrine of precedent, or the doctrine of stare decisis, is an English doctrine. According to this doctrine, the lower courts are bound by the decisions of the higher courts. Therefore, in Britain, every court is bound by the decisions of the House of Lords. It is a settled principle of law that a judgment, which has held the field for a long time, should not be unsettled. The doctrine of stare decisis is expressed in the maxim stare decisis et non quieta movere, which means to stand by decisions and not to disturb what is settled. Lord Coke aptly described this in his classic English version as those things which have been so often adjudged ought to rest in peace. The underlying logic of this doctrine is to maintain consistency and avoid uncertainty. The guiding philosophy is that a view which has held the field for a long time should not be disturbed only because another view is possible. 45. 45 Shankar Raju vs. Union of India 2011. 46 Vaman Rao vs. Union of India, 1980. The above point has been aptly described by the former Chief Justice Chandrachud in the following way. 46. It is sufficient for invoking the rule of stare decisis that a certain decision was arrived at on a question which arose or was argued, no matter on what reason the decision rests or what is the basis of the decision. In other words, for the 662 Indian Polity purpose of applying the rule of stare decisis, it is unnecessary to inquire or determine as to what was the rationale of the earlier decision which is said to operate as stare decisis. The basis of the doctrine of precedent, has been incorporated in Article 141 of the Constitution. According to this provision, the law declared by the Supreme Court shall be binding on all courts within the territory of India. Hence, all the courts and tribunals including the high courts in India are required to follow the decisions of the Supreme Court. The Supreme Court has explained the significance of Article 141 of the Constitution in the following way. 47. 47 Director of Settlements, AP vs. Emirapurao 2002. 48 Signathi Suresh Kumar vs. Jagdishan, 2002. 49 Krishna Kumar vs. Union of India, 1990. 50 Assistant Collector of Central Excise vs. Dunlop India Limited, 1984. Government of Andhra Pradesh vs. A.P. Jaiswal, 2000. When the Supreme Court decides a principle, it would be the duty of the High Court or a subordinate court to follow the decision of the Supreme Court. A judgment of the High Court which refuses to follow the decision and directions of the Supreme Court or seeks to revive a decision of the High Court which had been set aside by the Supreme Court is a nullity. According to the Supreme Court, it is impermissible for the High Court to overrule the decision of the Apex Court on the ground that the Apex Court laid down the legal position without considering any other point. The Court further emphasized that it is not only a matter of judicial discipline for the High Courts in India, but also a mandate of the Constitution as provided in Article 141 that the law declared by the Apex Court shall be binding on all courts in the country 4849. Apart from Article 141 of the Constitution, the policy of courts is to stand by precedent and not to disturb settled point. When court has once laid down a principle of law as applicable to certain state of facts, it will adhere to that principle and apply it to all future cases where facts are substantially the same. A deliberate and solemn decision of court made after argument on question of law fairly arising in the case, and necessary to its determination, is an authority or binding precedent in the same court, or in other courts of equal or lower rank in subsequent cases where the very point is again in controversy. SI rationale of the doctrine in the hierarchical system of courts which exists in India, it is necessary for each lower tier, including the high courts, to accept loyally the decisions of the higher tiers. It is inevitable in a hierarchical system of courts that there are decisions of the Supreme Appellate Tribunal which do not attract the unanimous approval of all members of the judiciary. But the judicial system only works if someone is allowed to have the last word, and that last word, once spoken, is loyally accepted. The better wisdom of the court below must yield to the higher wisdom of the court above. That is the strength of the hierarchical judicial system. 50. While explaining the rationale of the doctrine of precedent, the Supreme Court made the following observation. 51. Consistency is the cornerstone of the administration of justice. It is consistency which creates confidence in the system, and this consistency can never be achieved without respect to the rule of finality. It is with a view to achieve consistency in judicial pronouncements, the courts have evolved the rule of precedence, principle of stare decisis, etc. These rules and principles are based on public policy, and if these are not followed by courts, then there will be chaos in the administration of justice. Important doctrines of constitutional interpretation. M663. The doctrine of binding precedent has the merit of promoting a certainty and consistency in judicial decisions, and enables an organic development of the law. The Supreme Court has enunciated the importance of the doctrine in the development of jurisprudence of law in the following way. 52. 52 Union of India vs. Raghubar Singh, 1989. 53 Hari Singh vs. State of Haryana, 1993. 54 Dwarak Sugar Industries Limited vs. Prem Heavy Engineering Works Limited, 1997. 55 Ganga Sugar Corporation vs. State of UP, 1979. Taking note of the hierarchical character of the judicial system in India, it is of paramount importance that the law declared by this court should be certain, clear, and consistent. It is commonly known that most decisions of the courts are of significance not merely because they constitute an adjudication on the rights of the parties and resolve a dispute between them, but also because in doing so they embody a declaration of law operating as a binding principle in future cases. In this latter aspect lies their particular value in developing the jurisprudence of the law. While stating the importance of consistent opinions and achieving harmony in the judicial system, the Supreme Court observed as follows. 53. It is true that in the system of justice which is being administered by the courts, one of the basic principles which has to be kept in view is that courts of coordinate jurisdiction should have consistent opinions in respect of an identical set of facts or on a question of law. If courts express different opinions on the identical sets of facts or question of law while exercising the same jurisdiction, then instead of achieving harmony in the judicial system, it will lead to judicial anarchy. When a position in law is well settled as a result of the judicial pronouncements of the Supreme Court, it would amount to judicial impropriety on the part of subordinate courts, including the high courts, to ignore the settled decisions and then to pass a judicial order which is clearly contrary to the settled legal position. The Supreme Court, in this context, observed as follows. 54. Such judicial adventurism cannot be permitted, and we strongly deprecate the tendency of the subordinate courts in not applying the settled principles and in passing whimsical orders which necessarily has the effect of granting wrongful and unwarranted relied to one of the parties. It is time that this tendency stops. The Supreme Court cautioned that the judgments of this court are decisional between litigants but declaratory for the nation. This court further observed. 55. Enlightened litigative policy in the country must accept as final the pronouncements of this court unless the subject be of such fundamental importance to national life or the reasoning is so plainly erroneous in the light of later thought that it is wiser to be ultimately right rather than to be consistently wrong. Stare decisis is not a ritual of convenience but a rule with limited exceptions. T. Doctrine of occupied field. Q meaning of the doctrine. The doctrine of occupied field says that when the Parliament enacts a law on a particular subject and thereby occupies the field, a state legislature will not have authority to make any law on that field. In other words, according to this doctrine, when a legislative field is already occupied by a central legislation, there would be no scope for a state legislation in that field. This doctrine is also known as the doctrine of covered field. $664 If the matter is within the exclusive competence of the Parliament, i.e., Union List, List L, then the state legislature is prohibited to make any law with regard to the same 56. Similarly, if any matter is within the exclusive competence of the state legislature, i.e., State List, List 2, then it becomes a prohibited field for the Parliament 57. On the other hand, if the matter is enumerated in the concurrent list, List 3, then both the Parliament as well as the state legislature will have the competence to make the law. 56 Hindustan Lever vs. State of Maharashtra 2003. 57 Ibid. 58 Ibid. 59 State of Rajasthan vs. Baton Medical and General Store 2001. 60 Deep Chand vs. State of U.P. 1959. 61 M. Karunanthi vs. Union of India 1979. There may be a situation where a state legislature is making a law on a matter enumerated in the concurrent list. It may notice that the legislative field is already occupied by a law of the Parliament. Therefore, the doctrine of occupied field is relevant in the case of laws made with reference to entries in the concurrent list 58-59. In other words, the doctrine of occupied field can be applied only to the entries of the concurrent list 19. It must be noted here that the doctrine of occupied field originates from Article 254, which deals with the inconsistency, repugnancy, between laws made by the Parliament and the state legislature. Q Doctrine of Repugnancy. Article 254 declares that in case of any inconsistency between a parliamentary law and a state law in respect of matters enumerated in the concurrent list, the parliamentary law shall prevail and the state law shall be void to the extent of repugnancy. According to the Supreme Court, the repugnancy between the two laws may be ascertained on the following three principles. 60. I. Direct conflict. Whether there is direct conflict between the two provisions. 2. Intended occupation. Whether Parliament intended to lay down an exhaustive code in respect of the subject matter replacing the act of the state legislature. And 3. Occupied field. Whether the law made by Parliament and the law made by the state legislature occupied the same field. In order to determine the question of repugnancy between the two laws, the Supreme Court laid down the following test. 61. Propositions 1. It must be shown that the two enactments contain inconsistent and irreconcilable provisions so that they cannot stand together or operate in the same field. 2. There can be no repeal by implication unless the inconsistency appears on the face of the two statutes. 3. Where the two statutes occupy a particular field, but there is room or possibility of both the statutes operating in the same field without coming into collision with each other, no repugnancy results. 4. Where there is no inconsistency but a statute occupying the same field seeks to create district and separate offenses, no question of repugnancy arises and both the statutes continue to operate in the same field. Article 254 also contains an exception to the above rule of repugnancy. It says that if the state law has been reserved for the consideration of the President and has received his assent, then the state law shall prevail over the parliamentary law and operates in that state as valid law. However, the Parliament may again supersede the state law, which has been assented to by the President, by subsequently enacting a law on the same matter. If the Parliament enacts such a law, then the state law would be void to the extent of repugnancy with the parliamentary law. Important doctrines of constitutions. Interpretation 665. Repugnancy outside the concurrent list. The question of repugnancy between the parliamentary legislation and state legislation arises in two ways. First, where the legislations, though enacted with respect to matters in their allotted spheres, overlap and conflict. Second, where the two legislations are with respect to matters in the concurrent list, and there is a conflict. In both the situations, the parliamentary legislation will predominate, in the first, by virtue of non-obstante clause in Article 246(1). In the second, by reason of Article 254(1). The Supreme Court has further explained the above points of repugnancy in the following way. 63. Me. C. Goloknath vs. State of Punjab, 1967. 65 Ibid. 66 Shankari Prasad Singh vs. Union of India, 1951. 67 Sajjan Singh vs. State of Rajasthan, 1964. 68 I.C. Goloknath vs. State of Punjab, 1967. The question of repugnancy under Article 254(1) between a law made by Parliament and a law made by the state legislature arises only in case both the legislations occupy the same field with respect to one of the matters enumerated in the concurrent list, and there is direct conflict between the two laws. It is only when both these requirements are fulfilled that the state law will, to the extent of repugnancy, become void. Article 254(1) has no application to cases of repugnancy due to overlapping found between List 2 on the one hand and List I and List 3 on the other. If such overlapping exists in any particular case, the state law will be ultra vires because of the non-obstante clause in Article 246(1). Doctrine of prospective overruling. QI meaning of the doctrine of prospective overruling is an American doctrine. It was applied in India 62 State of Kerala versus Mismara Prem Curry Company Limited 2012. E3 Hooked Pharmaceuticals Limited versus State of Bihar 1983. For the first time by the Supreme Court in the Golok Nath case 64, 1967. When a court overrules its earlier decision and announces a new ruling, it can restrict the application of the new ruling only to the future transactions so that the validity of the past transactions is not affected. This is known as the doctrine of prospective overruling. In other words, this doctrine enables a court to overrule an old precedent, stare decisis, from a future date only and not retrospectively. In the Golok Nath case 65, 196-7, the Supreme Court overruled its earlier verdicts delivered in the Shankari Prasad case 66, 1951, as well as in the Sujjan Singh case 67, 1964. In both the cases, the Supreme Court held that the Parliament's amending power under Article 368 also includes the power to amend the fundamental rights guaranteed in Part 3 of the Constitution. Hence, a constitutional amendment act enacted to abridge or take away the fundamental rights is not void under Article 13(2). Later, in the Golok Nath case 68, 1967, the Supreme Court held that the amending power under Article 368 cannot be used to abridge or take away the fundamental rights, and a constitutional amendment act is law within the meaning of Article 13(2). But the Supreme Court applied the doctrine of prospective overruling and declared that this decision will have only prospective operation and not retrospective operation. This means that the Parliament will have no power from the date of this decision to amend any of the provisions of Part 3 of the Constitution so as to abridge or take away the fundamental rights enshrined therein. Further, the First Amendment Act, 1951, the Fourth Amendment Act, 1955, and the 17th Amendment Act, 1964 will continue to be valid for the future. $666 Indian Polity Q formulation of the doctrine. The Supreme Court negated the contention in Golok Nath case 6970, 1967, that prospective overruling amounts to judicial legislation. Explaining the Blackstonian theory of law, i.e., judge discovers law and does not make law, and the efficacy of prospective overruling, the court made the following observation. 69 ibid. 70 ibid. 71 ibid. The doctrine of prospective overruling is a modem doctrine and is suitable for a fast-moving society. It does not do away with the doctrine of stare decisis, but confines it to past transactions. It is true that in one sense the court only declares the law, either customary or statutory or personal law. While in strict theory it may be said that the doctrine involves the making of law, what the court really does is to declare the law but refuses to give retroactivity to it. It is really a pragmatic solution reconciling the two conflicting doctrines, namely, that a court finds the law and that it does make the law. It finds the law but restricts its operation to the future. It enables the court to bring about a smooth transition by correcting its errors without disturbing the impact of those errors on the past transactions. It is left to the discretion of the court to prescribe the limits of the retroactivity, and thereby the doctrine enables the court to mold the relief to meet the ends of justice. By the application of this doctrine, the past may be preserved and the future protected. AI basis of the doctrine. The Supreme Court explained the legal and constitutional basis of the doctrine of prospective overruling in the following way. 71. In India, there is no statutory prohibition against the court refusing to give retroactivity to the law declared by it. Indeed, the doctrine of res judicata precludes any scope for retroactivity in respect of a subject matter that has been finally decided between the parties. Further, the Indian court by interpretation reject retroactivity to statutory provisions though couched in general terms on the ground that they affect vested rights. The present case only attempts a further extension of the said rule against retroactivity. Our Constitution does not expressly or by necessary implication speak against the doctrine of prospective overruling. Indeed, Articles 32, 141, and 142 are couched in such wide and elastic terms as to enable this court to formulate legal doctrines to meet the ends of justice. The only limitation thereon is reason, restraint, and injustice. Under Article 32, for the enforcement of the fundamental rights, the Supreme Court has the power to issue suitable directions or orders or writs. Article 141 says that the law declared by the Supreme Court shall be binding on all courts. And Article 142 enables it, in the exercise of its jurisdiction, to pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. These articles are designedly made comprehensive to enable the Supreme Court to declare law and to give such directions or pass such orders as are necessary to do complete justice. The expression declared is wider than the words found or made. To declare is to announce opinion. Indeed, the latter involves the process, while the former expresses result. Interpretation, ascertainment, and evolution are parts of the process, while that interpreted, ascertained, or evolved is declared as law. The law declared by the Supreme Court is the law of the land. If so, there is no acceptable reason why the court, in declaring the law in supersession of the law declared by it earlier, could not restrict the operation of the law, as declared, to the future and save the important doctrines of constitutional interpretation 667. Transactions, whether statutory or otherwise, that were effected on the basis of the earlier law. IB deny this power to the Supreme Court on the basis of some outmoded theory that the court only finds law but does not make it, is to make ineffective the powerful instrument of justice placed in the hands of the highest judiciary of this country. Q propositions of the doctrine. The Supreme Court laid down 3 propositions with respect to the doctrine of prospective overruling. The court, in this context, observed as follows: 72 ibid. 73 ibid. As this court for the first time has been called upon to apply the doctrine evolved in a different country, under different circumstances, it would like to move warily in the beginning, and would lay down the following propositions. 1. The doctrine of prospective overruling can be invoked only in matters arising under our Constitution. 2. It can be applied only by the highest court of the country, i.e., the Supreme Court, as it has the constitutional jurisdiction to declare a law binding on all the courts in India. 3. The scope of the retroactive operation of the law declared by the Supreme Court superseding its earlier decisions is left to its discretion to be molded in accordance with the justice of the cause or matter before it. 5. Rationale of the doctrine. The Supreme Court has explained the rationale of the application of the doctrine of prospective overruling in the following ways. 73. We have arrived at 2 conclusions, namely, 1. Parliament has no power to amend Part 3 of the Constitution so as to take away or abridge the fundamental rights. And 2. This is a fit case to invoke and apply the doctrine of prospective overruling. What then is the effect of our conclusion on the instant case? Having regard to the history of the amendments, their impact on the social and economic affairs of our country, and the chaotic situation that may be brought about by the sudden withdrawal at this stage of the amendments from the Constitution, we think that considerable judicial restraint is called for. We, therefore, declare that our decision will not affect the validity of the Constitution, 17th Amendment, Act, 1964, or other amendments made to the Constitution taking away or abridging the fundamental rights. We further declare that in future Parliament will have no power to amend Part 3 of the Constitution so as to take away or abridge the fundamental rights. According to the Supreme Court. 74. 1. The prospective declaration of law is a device innovated by the apex court to avoid reopening of settled issues and to prevent multiplicity of proceedings. 2. It is also a device adopted to avoid uncertainty and avoidable litigation. 3. By the very object of prospective declaration of law, it is deemed that all actions taken contrary to the declaration of law prior to its date of declaration are validated. This is done in the larger public interest. 31. Criticism of the doctrine. While considering the various arguments made against the application of the doctrine of prospective overruling, the Supreme Court made the following observation. 75. Let us now consider some of the objections to this doctrine. The objections are: I. The doctrine involved legislation by courts. 2. It would not encourage parties to prefer appeals as they would not get. 7. Ababurum vs. C.C. Jacob, 1999. 751. C. Goloknath vs. State of Punjab, 1967. 668. Indian Polity. Any benefit therefrom. 3. The declaration for the future would only be obiter. 4. It is not a desirable change. And 5. The doctrine of retroactivity serves as a brake on court which otherwise might be tempted to be so facile in overruling. But in our view, these objections are not insurmountable. If a court can overrule its earlier decision, there cannot be any dispute. When the court can do so, there cannot be any valid reason why it should not restrict its ruling to the future and not to the past. Even if the party filing an appeal may not be benefited by it, in similar appeals which Husham may file after the change in the law, Husha will have the benefit. The decision cannot be obiter, for what the court in effect does is to declare the law, but on the basis of another doctrine restricts its scope. Stability in law does not mean that injustice shall be perpetuated. BL continuation of the doctrine. It must be noted here that even though the judgment delivered in the Goloknath case 76, 1967, was overruled in the Kesavananda Burdi case 77, 1973, the doctrine of prospective overruling was upheld and followed in several subsequent judgments. 76 ibid. 77. Kesavananda Burdi vs. State of Kerala, 1973. 78. Indrasansi vs. Union of India, 1992. 9. Managing Director, ECIL, Hyderabad vs. B. Karnakar, 1993. Moreover, the Supreme Court has also extended the application of the doctrine to the matters arising under the ordinary statutes as well. The judgment in Mundal case 78, 1992, postponing the operation for 5 years from the date of the judgment, is an instance of, and an extension to the principle of prospective overruling. In Karnakar case 79, 1993, the Supreme Court held that benefit of the decisions would be given only to the parties to the cases pending before the authorities from the date of the judgment, but not to the actions already taken by the date of that judgment. Doctrine of harmonious construction. I.m. meaning of the doctrine: when different provisions of the Constitution are found to be in conflict with each other, the courts should interpret them harmoniously so as to avoid the conflictual implications between them. This is known as the doctrine of harmonious construction. This doctrine is also called as the rule of avoidance of conflict. While explaining the doctrine of harmonious construction, Justice Venkatrama Iyer observed 80. In case of two irreconcilable provisions, they should be so interpreted that effect can be given to both and none of the two is rendered nugatory. Similarly, Justice Mukherjee said 81. If certain provisions in the Constitution appear to be in conflict with each other, these provisions should be interpreted so as to effect a reconciliation between them so that, if possible, effect could be given to all. The doctrine of harmonious construction should be understood in the light of the following points. 1. The court should read the Constitution as a whole and take into consideration its different parts. 2. The court should proceed on the presumption that no conflict between the different parts was intended by the Constitution makers. BL application of the doctrine. The Supreme Court has applied the doctrine of harmonious construction to reconcile the conflict. 1. Between the fundamental rights and directive principles of state policy. 2. Between different fundamental rights. 0. 1 Sri Venkateramana Deveru vs. State of Mysore, 1957. 81 A.K. Gopalan vs. State of Madras, 1950. Important Doctrines of Constitutional Interpretation, 669. 3. Between fundamental rights and legislative privileges. 4. Between fundamental rights and amendment procedure. 5. Between fundamental rights and other parts of the Constitution. And 6. Between different entries of the legislative lists in the 7th Schedule. The Supreme Court, on the application of the doctrine of harmonious construction to the fundamental rights and directive principles of state policy so as to give effect to both as much as possible, made the following observation. 82. 82 Ranjan Dwivedi vs. Union of India, 1983. 83 Kesavananda Bharati vs. State of Kerala, 1973. 84 Calcutta Gas Company vs. State of West Bengal, 1962. 85 Attorney General for New South Wales vs. Brewery Employees Union, 1908. Although an earlier decision, the court paid scant regard to the directives on the ground that the courts had little to do with them since they were not justiciable or enforceable like the fundamental rights. The duty of court in relation to the directives came to be emphasized in the later decision, which reached its culmination in the Kesavananda Bharati case 83, 1973, laying down certain broad propositions. Law of these is that there is no disharmony between the directives and the fundamental rights because they supplement each other on aiming at the same goal of bringing about a social revolution and the establishment of a welfare state, which is envisaged in the preamble. The courts, therefore, have responsibility in so interpreting the Constitution as to ensure implementation of the directives and to harmonize the social objective underlying the directives with individual rights. Similarly, the Supreme Court, while applying the doctrine of harmonious construction to the interpretation of the different entries of the legislative list in the 7th Schedule, made the following observation. 84. It is also well settled that widest amplitude should be given to the language of the entries, but some of the entries in the different lists or in the same list may overlap and sometimes may also appear to be in direct conflict with each other. It is then the duty of this court to reconcile the entries and bring about harmony between them. In this way it may, in most cases, be found possible to arrive at a reasonable and practical construction of the language of the sections, so as to reconcile the respective powers they contain and to give effect to all of them. It is only when such a reconciliation proves impossible, then, and only then, should the overriding power of the Union legislature, the non-obstante clause, operate and the Union power prevail. ESI important cases. The important cases relating to the doctrine of harmonious construction and their judgments are given in IBL 91.6. Doctrine of liberal K interpretation. Meaning of the doctrine. According to the doctrine of liberal interpretation, the Constitution must be interpreted in a broad and liberal manner and not in a narrow or pedantic sense. In other words, a broad and liberal spirit should inspire the interpreters of the Constitution. The doctrine of liberal interpretation envisages that the Constitution should be interpreted not as a mere law, but as the machinery by which the laws are to be made. It assumes that the Constitution is a living and organic thing and hence, it must be interpreted broadly and liberally. While explaining the doctrine of liberal interpretation, Justice Higgins made the following observation. 85*. Although we are to interpret the words of the Constitution on the same principles of interpretation as we apply to Table 91.6 important cases relating to the doctrine of harmonious construction. SI. No. Case, year, Supreme Court judgment. 1. Sri Venkateramana Bharati vs. State of Mysore, 1957. It ruled that the right of a religious denomination to manage its own affairs and matters of religion under Article 26b is subject to Article 25(2)b. 2. Imisam Sharma vs. Krishna Sinha, 1958. It held that the fundamental right to freedom of speech and expression under Article 19(1)(a) is to be read subject to the privileges of House of Legislature guaranteed by Article 194(3). 3. Owen Mohindru vs. Bar Council of Delhi, 1968. It held that the Parliament is exclusively empowered to legislate with respect to persons entitled to practice before the Supreme Court and the High Court, and the power to legislate with respect to the rest of the practitioners falls under the concurrent list. 4. D.V. College versus State of Punjab, 1971. It held that no state has the legislative competence to prescribe any particular medium of instruction with respect to higher education, if it interferes with the power of Parliament under Union list. 5. Kesavananda Bharat versus State of Kerala, 1973. It held that the word law in Article 13(2) includes only the ordinary laws and not the amendment acts made under Article 368. Any ordinary law, these very principles of interpretation compel us to take into account the nature and scope of the act we are interpreting, to remember that it is a constitution, a mechanism under which laws are to be made, and not a mere act which declares what the law is to be. The Supreme Court has explained the doctrine of liberal interpretation in the following way. 86. 87 LL Hotels and Investments Limited versus Union of India, 1989. A constitutional provision is never static, it is ever evolving and ever changing and, therefore, does not admit of a narrow, pedantic, or syllogistic approach. It seems well settled that constitutional provisions must receive a broad interpretation, and the scope and ambit of such provisions, and in particular the fundamental rights, should not be cut down by too astute or too restricted an approach. With respect to the application of the doctrine of liberal interpretation to the entries enumerated in the legislative lists under the 8 Insurance Corporation of India versus Munna B.D. Shah, 1992. 7th Schedule of the Constitution, the Supreme Court observed as follows. 87. The cardinal rule of interpretation is that the entries in the legislative lists are not to be read in a narrow or restricted sense, and that each general word should be held to extend to all ancillary or subsidiary matters which can fairly and reasonably be said to be comprehended in it. The widest possible construction, according to the ordinary meaning of the words in the entry, must be put upon them. In construing the words in a constitutional document conferring legislative power, the most liberal construction should be put upon the words, so that the same may have effect in their widest amplitude. A doctrine of literal interpretation. The doctrine of literal interpretation is also known as the doctrine of strict construction or the doctrine of positivist construction. According to this doctrine, the provisions important doctrines of constitutional interpretation 671 of the Constitution should be expounded in their plain, ordinary, natural, and grammatical meaning. While laying down the doctrine of literal interpretation, Justice Mukherjee has said, in interpreting the provisions of our Constitution, we should go by the plain words used by the Constitution makers. The doctrine of literal interpretation says that the Constitution must be interpreted with reference to its terms and those alone. Nothing is to be read into it on grounds of some supposed spirit pervading the Constitution, or on the ground of policy, or even for the purpose of supplying omissions or of correcting errors. 89. 91 in presidential reference to the Supreme Court with respect to the Barabara Union and exchange of enclaves in 1960. 92 S. R. Chowdhury versus State of Punjab 2001. 93 J.S. Varma, New Dimensions of Justice, Universal, 2000, pp. 1-2. The Supreme Court, in the above context, made the following observation. 90. The courts are not at liberty to declare an act void because in their opinion it is opposed to a spirit supposed to pervade the Constitution but not expressed in words. Where the fundamental law has not limited, either in terms or by necessary implication, the general powers conferred upon the legislature, courts cannot declare a limitation upon the motion of having discovered something in the spirit of the Constitution which is not even mentioned in the statute. It is difficult upon any general principles to limit the omnipotence of the sovereign legislative power by judicial interpretation, except so far as the express words of a written constitution give that authority. QI Doctrine of Purposive Interpretation. The doctrine of purposive interpretation says that the courts, while making an interpretation of the Constitution, should look into the purpose for incorporating a provision in the Constitution. It emphasizes that the Consti. 88 Kiranjit Lal Choiteri versus Union of India, 1950. 89 inches presidential reference to the Supreme Court with respect to the Sea Customs Act in 1963. G.I. A.K. Gopalan versus State of Madras, 1950. Constitutional interpretation should ascertain the intention of the makers of the Constitution. The preamble to the Constitution and the Constituent Assembly debates throws a light on the purposes of the constitutional provisions and the intent of the Constitution makers. Suralati Krishnaswamy Iyer, a member of the drafting committee of the Constituent Assembly, said, "The preamble to our Constitution expresses what we had thought or dreamt so long." Similarly, in the Barabara Union Case 91, 1960, the Supreme Court said that the preamble is a key to the minds of the makers of the Constitution. While making an argument in favor of the doctrine of purposive interpretation, the Supreme Court made the following observation. 92. Constitutional provisions are required to be understood and interpreted with an object-oriented approach. A constitution must not be construed in a narrow and pedantic sense. The words used may be general in terms, but their full import and true meaning has to be appreciated considering the true context in which the same are used and the purpose which they seek to achieve. Similarly, the former Chief Justice of India, J.S. Varma, while advocating the doctrine of purposive interpretation, said as follows: 93. The Constitution is to be interpreted as a living and vibrant organism to provide for the current societal needs. Constitution is to be construed as enacting concepts. In construing a provision of the Constitution, the constitutional purpose it is meant to subserve has to be borne in mind. Indian Polity L. Doctrine of Creative Interpretation. The doctrine of creative interpretation envisages an innovative judicial interpretation of the provisions of the Constitution. This doctrine says that the courts should evolve new concepts and new procedures in order to meet the requirements of the changing situations. The judgment delivered by the Supreme Court in the Lokpal case, 1967, is an important illustration of the doctrine of creative interpretation. In this case, the Supreme Court embarked on a creative role by introducing for the first time in India the American doctrine of prospective overruling. According to this doctrine, an old precedent, stare decisis, can be overruled from a future date and not retrospectively. While asserting a creative role for itself in the Lokpal case 93, 1967, the Supreme Court made the following observation. 9 H.C. Loknath vs. State of Punjab, 1967. 95 Ibid. 96 Kesavananda Bharti vs. State of Kerala, 1973. Articles 32, 141, and 142 are couched in such wide and elastic terms as to enable this court to formulate legal doctrines to meet the ends of justice. LB deny this power to the Supreme Court on the basis of some outmoded theory that the court only finds the law but does not make it, is to make ineffective the powerful instrument of justice placed in the hands of the highest judiciary of this country. Another significant manifestation of the doctrine of creative interpretation is the judgment delivered by the Supreme Court in the Kesavananda Bharti case *95. 6, 1973. In this case, the Supreme Court innovated a new constitutional doctrine called the doctrine of basic structure of the Constitution. In fact, this judgment is regarded as the watermark of the judicial creativity in India. Part X Comparison of the Constitutions. Chapter 92 World Constitutions. T. American Constitution legislatures of 3/4, 38 out of 50 of the states within a 7-year time span. 2. Alternatively, an amendment can be proposed by a constitutional convention called by the Congress on the petition of 2/3, 34 out of 50, of the state legislatures. It should be ratified by the convention in 3/4, 38 out of 50, of state legislatures. Hence, the procedure prescribed by the American Constitution for its amendment is very difficult, complicated, and slow. Its rigid character is evident from the fact that it has been amended only 27 times since its promulgation in 1789. 3. Federal Constitution. USA is a federal state. In fact, the USA is the first and the oldest federal state in the modern world. It is a federal republic comprising 50 states, originally 13 states, in the District of Columbia. The Constitution provides for division of powers between the federal, central government, and the state governments. It confers limited and specified powers on the center and vests the residuary powers, which are not enumerated in the Constitution, in the states. Each state has its own constitution, elected legislature, governor, and Supreme Court. 4. Presidential government. Unlike the British Constitution, the American Constitution provides. The American Constitution is the Constitution of the United States of America, which was formed in 1787 following the American Revolution, 1775 to 1783. The Constitution was adopted in 1787 at the Philadelphia Convention and came into force in 1789. The salient features of the American Constitution are explained as follows. 1. Written Constitution. The American Constitution is usually cited as a classic example of a written constitution. In fact, it is the oldest among the existing written constitutions of the world. It is contained in a document of some 12 pages and consists of a preamble, 7 articles, and 27 amendments. 2. Rigid Constitution. Unlike the British Constitution, the American Constitution is a rigid one. It cannot be amended by the Congress in the same manner as the ordinary laws are made. It can be amended by the Congress only by means of a special process provided by the Constitution for that purpose. Therefore, in the USA, there exists a distinction between a constitutional law and an ordinary law. The American Constitution, the most rigid constitution in the world, lays down the following 2 methods for its amendment. An amendment can be proposed by 2/3 votes of both the houses of the Congress. It should be ratified by the 674 Indian Polity. For the presidential form of government. The features of the American presidential system of government are as follows. The American president is both the head of state and the head of government. As the head of state, Pisha occupies a ceremonial position. As the head of government, Pisha leads the executive organ of government. The president of the USA is the chief real executive. 2. The president is elected by an electoral college for a fixed tenure of 4 years. Pisha cannot be removed by the Congress except by impeachment for a grave unconstitutional act. 3. The president governs with the help of the cabinet or a smaller body called kitchen cabinet. It is only an advisory body and consists of non-elected departmental secretaries. They are selected and appointed by him/her and are responsible only to him/her. They can also be removed by him/her any time. 4. The President and his secretaries are not responsible to the Congress for their acts. They neither possess membership in the Congress nor attend its sessions. The President cannot dissolve the House of Representatives, the lower house of the Congress. 5. Separation of powers. The doctrine of separation of powers is the basis of the American constitutional system. The legislative, executive, and judicial powers of the government are separated and vested in the three independent organs of the government. The first three articles of the Constitution clearly manifest this feature of the Constitution. Article 1 says that all legislative powers herein granted shall be vested in the Congress. Article 2 states that the executive powers shall be vested in the President. Article 3 provides that the judicial powers shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. 6. Checks and balances. The system of checks and balances in the American Constitution is an outcome of the adoption of the principle of separation of powers. It enables each organ of the government to exercise partial control on others so that no organ becomes autocratic and irresponsible. This means that no organ of government has unrestricted powers even in its own sphere. Some aspects of the working of the system of checks and balances in the American constitutional system are: the President can veto the bills passed by the Congress. Husha enjoys two kinds of vetoes: pocket veto and qualified veto. 2. The Senate confirms the higher appointments made and international treaties concluded by the President. 3. The Congress determines the organization and appellate jurisdiction of the judiciary. 4. The President appoints the judges with the consent of the Senate. The Supreme Court can declare the congressional laws and presidential orders as ultra vires. 7. Supremacy of Constitution and judicial review. The American Constitution embodies the principle of hierarchy of laws. The written Constitution is regarded as the highest, supreme, or fundamental law of the land. The statutes of the Congress and state legislatures must conform to this supreme law. If these statutes are against the provisions of the Constitution, they can be declared by the Supreme Court as ultra vires and hence null and void. The Supreme Court thus acts as the custodian of the Constitution through its power of judicial review. 8. Bill of Rights. The American Constitution is the first constitution in the world to carry the Bill of Rights. It guarantees a large number of rights to the people. It says that no person is to be deprived of life, liberty, and property without due process of law. These rights impose restrictions on the authority of the government. The Supreme Court acts as the protector of these rights through its power of World Constitutions 675. Judicial Review. This Bill of Rights was added to the original Constitution in 1791 through the first 10 amendments. 9. Bicameralism. The American federal legislature, called the Congress, is bicameral. That is, it consists of two houses, namely the Senate and the House of Representatives. The Senate is the upper house, while the House of Representatives is the lower house. The Senate consists of 100 members, 2 being elected from each state to serve for a fixed 6-year term. The House of Representatives consists of 435 members elected from single-member constituencies to serve for a fixed 2-year term. The Senate is the more powerful chamber of the Congress. In fact, the American Senate is the most powerful second chamber, upper house, in the world. American President. Mode of election. The American Constitution provides for an indirect election of the President. However, the growth of political parties and political conventions has converted it into a direct election. Constitutionally, the President is elected by an electoral college constituted for the purpose. The members of this college, called as presidential electors, are elected directly by the people of all the states. The number of presidential electors in each state is equal to the number of its members in the Congress, both in the House of Representatives and in the Senate. It means that the Electoral College consists of as many members as is the total strength of the two houses of the Congress. Additionally, 3 votes have been given to the District of Columbia, a federal enclave and not a state. Thus, the total strength of the Electoral College is 538, 435 is the strength of the House of Representatives, 100 is the strength of the Senate, and 3 members of the District of Columbia. A candidate in order to win the presidential election needs 270 votes, that is, 269, half of the total votes of 538, plus 1. It must be stressed here that the members of the Electoral College are not the members of the Congress. The college is a special body which is formed only for electing the president, and it gets dissolved after this. If no candidate secures the requisite majority, the House of Representatives elects the president from among the 3 candidates securing the highest votes in the Electoral College. There have been 3 such occasions: 1800, 1824, and 1876. Qualifications, term, and removal. According to the Constitution, a candidate for the presidency must have the following 3 qualifications. Husha must be a natural-born citizen of the USA. A naturalized citizen is not eligible. 2. Husha must have attained the age of 35 years. 3. Husha must have been a resident of the USA for 14 years, not necessarily consecutive. The president holds the office for a fixed tenure of 4 years. Husha is eligible for re-election, but only once. The 22nd Amendment Act of 1951 has fixed the maximum total term for any president at 10 years. In other words, it bars any person from being elected as president more than twice. The presidential term of 4 years begins on January 20th. The president may be removed from the office before the expiry of his or normal tenure of 4 years through impeachment for treason, bribery, or other high crimes and misdemeanors. The House of Representatives initiates the impeachment proceedings by a majority vote. The case is then tried by the Senate. During this trial period, the Senate acts as a judicial tribunal and is presided over by the Chief Justice of the Supreme Court and not the Vice President. If the Senate also passes the impeachment resolution by a 2/3 majority, the president stands impeached. So far, no American president has ever been removed by impeachment. However, there have been 5 impeachment $676 Indian Polity attempts: Andrew Johnson, 1868, Richard Nixon, 1974, Bill Clinton, 1998, Donald Trump, first time in 2019, and Donald Trump, second time in 2021. Powers and functions: the American presidency is one of the strongest democratic offices in the world. Lord Bryce regards it as the greatest office in the world. Monroe observed, "The American president exercises the largest amount of authority ever wielded by any man in a democracy." Ogg regards him/her as the greatest ruler of the world. Harold Laski remarked, "The President of the United States is both more and less than a king. Husha is also both more and less than a prime minister." The President derives his/her powers and functions from 4 sources: Constitution, statutes of Congress, judicial interpretations, and political conventions. These are mentioned below. 1. Husha has to enforce the Constitution, federal laws and treaties, and judicial decisions throughout the country. 2. Husha is the Supreme Commander of the Armed Forces of the U.S. 3. Husha appoints the Supreme Court judges, ambassadors, heads of executive departments, diplomatic officials, consuls, and other top officials. 4. Husha formulates foreign policy and conducts foreign affairs of the U.S. 5. Husha can grant pardon and reprieve for offenses against federal laws, except in cases of impeachment. 6. When a bill approved by both the houses of the Congress is sent to him/her for his/her assent, Husha has 3 options before him/her. I. Husha may give his/her assent to the bill, and the bill then becomes an act. 2. Husha may reject the bill and return it to the Congress within 10 days. However, if the same bill is repassed by the Congress by a 2/3 majority, then the bill becomes a law and the president has to sign it. This is known as qualified veto. 3. Husha may reserve the bill with him. Then, the bill becomes a law after the expiry of 10 days without his/her assent. However, if the Congress ends the session before 10 days, then the bill automatically dies. This is known as pocket veto. 7. Husha can send messages to the Congress proposing some legislative measures, either orally delivered to the House or sent in the form of a document. 8. Husha can call special sessions of the Congress for consideration of urgent matters. 9. Husha prepares the national budget and submits it to the Congress for approval. 10. Husha is empowered to make rules and regulations in the form of executive orders. This is known as delegated legislation. 11. Husha is empowered to adjourn the Congress when there is a disagreement between 2 houses on the date of adjournment. British Constitution. The British Constitution is the Constitution of the United Kingdom of Great Britain and Northern Ireland. Great Britain consists of England, Wales, and Scotland. England and Wales were united in 1535 and Scotland joined them to form the state of Great Britain in 1707. While the United Kingdom of Great Britain and Northern Ireland was formed in 1921. The British constitutional system is the oldest in the world and is also the oldest democratic system. In fact, the British Constitution is the mother of constitutions. The principles and institutions of representative government were first developed in Britain. The British Constitution is a blend of monarchy, aristocracy, and democracy. The salient features of the British Constitution are explained as follows. 1. Unwritten Constitution. Unlike the American Constitution, the British Constitution is unwritten. In the UK, most of the principles governing the distribution and exercise of the governmental powers are not written. Only a small portion of the British Constitution is covered by written documents. The British Constitution is an evolved constitution, not an enacted one. It is a product of history and a result of evolution. It is a child of chance, accident, as well as wisdom, design. It is not a static constitution but a remarkably dynamic one. Hence, L.S. Amory in his book Thoughts on the Constitution says that the British Constitution is a blend of formal law, precedent, and tradition. The various elements or sources of the British Constitution are explained as follows. I. Conventions. Conventions constitute a major element of the British Constitution. These are the unwritten principles of political practices and customary principles of constitutional behavior which have developed in the course of time. J.S. Mill described them as the unwritten maxims of the Constitution. However, unlike the laws, they are not recognized and enforced by judicial courts. but they play a very significant role in the actual working of the British political institutions. They are generally observed as they are backed by tradition and public opinion. The well-known conventions in Britain are: A. The King or Queen should exercise his legal powers on the advice of the cabinet headed by the Prime Minister. B. The King or Queen should appoint the leader of the majority party in the House of Commons as the Prime Minister. C. The King or Queen should dissolve the lower house of Parliament on the advice of the Prime Minister. D. The King or Queen should give his or her assent to all the bills passed by the Parliament. E. The Cabinet is collectively responsible to the House of Commons. 2. Great Charters. These are also called constitutional charters or constitutional landmarks. They are historical. World Constitutions J. 4677. Documents which define the powers of the Crown and liberties of the citizens, and so on. They have a significant bearing on some of the basic aspects of the British Constitution. The important among such charters are the Magna Carta, 1215, the Petition of Rights, 1628, the Bill of Rights, 1689, and others. 3. Statutes. These are the laws made by the British Parliament from time to time. They define and regulate the principles, structures, and functions of many British political institutions. The important statutes in Britain are the Habeas Corpus Act, 1679, the Statute of Westminster, 1931, Ministers of the Crown Act, 1937, the People's Representation Act, 1948, and others. For common law, it is a body of judge-made laws. It has defined some of the significant rules and principles pertaining to the powers of the government and its relationship with the citizens. They are accepted and enforced by judicial courts. Dr. Ogg defines common law as the vast body of legal precept and usage, which through the centuries has acquired binding and almost immutable character. V. Legal commentaries. These are the commentaries or textbooks written on the constitutional law of the country by the constitutional experts. They provide insight into the working of the British political institutions. They clarify the meaning and fix the scope of certain constitutional principles. Some of the popular legal commentaries on the British Constitution are A. V. Dicey's Law of the Constitution, Bagehot's English Constitution, Blackstone's Commentaries on the Laws of England, and others. 2. Flexible Constitution. Unlike the American Constitution, the British Constitution is flexible in nature. It requires no special procedure for its amendment. It can be amended by the Parliament in the same manner as the ordinary laws are made. Thus, in Great Britain, there 678 W and INPA, ITY. Exists no distinction between the constitutional law and the ordinary law. 3. Unitary Constitution. Great Britain is a unitary state. Hence, all the powers of the government are vested in a single supreme central government. The local governments are created only for administrative convenience, and they work under the complete control of the central government located at London. They derive their authority from the central government, which can also abolish them altogether at any time. 4. Parliamentary government. The British Constitution provides for parliamentary form of government in which the executive hails from the legislature and remains responsible to it. The features of the British parliamentary system of government are as follows. J. The King or Queen is the nominal executive while the cabinet is the real executive. The King or Queen is head of the state while the Prime Minister is head of the government. 2. The party which secures majority seats in the House of Commons forms the government. The leader of that party is appointed as the Prime Minister by the King-Queen. 3. The ministers are individually as well as collectively responsible to the House of Commons for their acts. They remain in office so long as they enjoy the majority support in the House. 4. The King or Queen can dissolve the House of Commons on the advice of the Prime Minister. V. The ministers, members of the executive, are also the members of the British Parliament. This avoids conflicts between the executive and the legislature and facilitates better coordination between them. 5. Sovereignty of Parliament. Sovereignty means the supreme power within the state. That supreme power in Great Britain lies with the Parliament. Hence, sovereignty of Parliament, or supremacy of Parliament, is a cardinal principle of the British constitutional law and political system. This principle implies the following things. I. The British Parliament can make, amend, substitute, or repeal any law. De Lolme said, the British Parliament can do everything except make a woman a man and a man a woman. 2. The Parliament can make constitutional laws by the same procedure as ordinary laws. In other words, there is no legal distinction between the constituent authority and the lawmaking authority of the British Parliament. 3. The parliamentary laws cannot be declared invalid by the judiciary as being unconstitutional. In other words, there is no system of judicial review in Great Britain. 6. Rule of law. The doctrine of rule of law is one of the fundamental characteristics of the British constitutional system. It lays down that the law is supreme and hence the government must act according to law and within the limits of the law. A. V. Dicey in his book The Law of the Constitution, 1885, has given the following 3 implications of the doctrine of rule of law. I. Absence of arbitrary power, that is, no man can be punished except for a breach of law. 2. Equality before the law, that is, equal subjection of all citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law courts. 3. The primacy of the rights of the individual, that is, the Constitution is the result of the rights of individual as defined and enforced by the courts of law, rather than the Constitution being the source of the individual rights. The rights of the citizens of Great Britain flow from judicial decisions, not from the Constitution. 7. Constitutional monarchy. Great Britain is a monarchical state. It is described as a limited hereditary monarchy. The hereditary monarch, king or queen, is the head of the state. The crown is the visible symbol of the supreme world. Constitution 679. Executive power. However, the king or queen only reigns, but does not rule. These powers are actually exercised by the cabinet headed by the prime minister. The cabinet is collectively responsible to the parliament for its actions and ultimately to the electorate. Hence, what Great Britain has is a constitutional monarchy. The distinction between the crown and the king is the distinction between the monarchy as an institution and the monarch as a person. In other words, the king is a person whereas the crown is an institution, i.e. the institution of kingship. The king is mortal whereas the crown is immortal. This is clearly expressed by the popular statement in Great Britain that the king is dead. Long live the king. It means that the person who occupied the throne is dead, but the institution of kingship survives. 8. Bicameralism. The British Parliament is bicameral, that is, it consists of two houses, namely the House of Lords and the House of Commons. The House of Lords is the upper house. It is the oldest second chamber in the world. It consists of lords, peers, and nobles and hence represent the aristocratic element of the British political system. At present it has 677 appointed members who fall into 4 distinct groups. It is mostly a hereditary body. The House of Commons is the lower house but more important and powerful than the House of Lords. It is the oldest popular legislative body in the world. It consists of the representatives elected by the people on the basis of universal adult franchise. There are at present 659 seats in the House of Commons and these are distributed among England, Wales, Scotland, and Northern Ireland. F. British Cabinet. Composition. As the British Constitution provides for parliamentary system of government, the cabinet acts as the real executive authority. It consists of the Prime Minister as its head and 20 or so of his most senior ministerial colleagues. It includes the following. 1. Prime Minister and First Lord of the Treasury and Minister for the Civil Service. 2. Chancellor of the Exchequer. 3. Lord Privy Seal. 4. Chancellor of the Duchy of Lancaster. 5. Lord President of the Council. 6. President of the Board of Trade. 7. Lord Chancellor. 8. First Lord of Admiralty. 9. Postmaster General. 10. Secretaries of State for Home, Foreign, Defense, Social Services, Environment, and Education and Science. 11. Ministers of Agriculture and Fisheries, Health, Pension, Transport, and Labour. 12. Secretary of State of Scotland. 13. Secretary of State for Wales. It must be mentioned here that the Attorney General, Solicitor General, Lord Advocate, and Paymaster General are not members of the British Cabinet. Privy Council. There is a close relationship between the Cabinet and the Privy Council. This council, in its present form, came into existence in the 15th century as an advisory body to the British monarch. In the course of time, most of its powers were transferred to the Cabinet as its inner committee. Presently, it consists of 330 members and includes, inter alia, all cabinet ministers, past and present. It is presided over by the Lord President of the Council. Prime ministerial government. In the past, the British constitutional and political experts had described the relationship between the Prime Minister and the Cabinet as primus inter pares, first among equals. In the recent period, the Prime Minister's power, influence, and position have increased significantly vis-a-vis the Cabinet. Husha has come to play a dominant role in the British politico-administrative system. Hence, the later political analysts like Crossman, Mackintosh, and others have described the British Cabinet government as prime ministerial government. Shadow Cabinet. It is a unique institution of the British Cabinet system. It is formed by the opposition party to balance the ruling cabinet and to prepare its members for future 680F Indian Polity. Ministerial office. In Britain, the opposition enjoys an official recognition and is as well organized as the government. It runs a parallel government with its shadow cabinet. In this shadow cabinet, almost every member in the ruling cabinet is shadowed by a corresponding member in the opposition cabinet. The members of the shadow cabinet watch critically the working of the departments assigned to them. They match the cabinet ministers in the parliamentary debates. The shadow cabinet serves as the alternative cabinet if there is change of government. That is why Ivor Jennings described the leader of opposition as the alternative prime minister. Husha enjoys the status of a minister and is paid by the government. F. French Constitution. The French Revolution, 1789 to 1799, had a significant impact on the growth of the French constitutional system. Since the Revolution, France has changed its constitution on an average after every 12 years. It adopted 3 monarchic, 2 dictatorial, 3 imperial, and 4 republican constitutions. The present French Constitution, which established the Fifth Republic, came into force in 1958. It was prepared under the instructions of General de Gaulle. It was designed to give France a strong and stable government. The salient features of the Constitution of the Fifth French Republic are as follows. I. Written constitution. Like the American Constitution, the French Constitution is a written constitution. Originally, it contained a preamble and 92 articles divided into 15 chapters. It declares liberty, equality, and fraternity as the motto of the Fifth Republic. It states France is an indivisible, secular, democratic, and social republic. The chapters of the Constitution are mentioned in Table 92.1. Articles 78 to 86 were repealed. Table 92.1 French Constitution at a glance, as amended till now, number chapter heading articles covered. Rigid Constitution. Unlike the British Constitution, the French Constitution is rigid in nature. It contains a special procedure for its amendment. It can be amended by the Parliament by 60% majority vote in both the houses. Alternatively, the President can call a national referendum on constitutional amendment. However, the Republican form of government in France is not subject to amendment. Thus, there is no place for monarchy in France. 3. Unitary Constitution. France is a unitary state. There is no division of powers between the central and local governments. All powers are vested in the single supreme central government located in Paris. The local governments are created and abolished by the central government for administrative convenience. In fact, France is more unitary than Britain. 4. Quasi-presidential and quasi-parliamentary. The French Constitution provides neither presidential nor parliamentary government. Rather, it combines the elements of both. On one hand, it provides for a powerful president who is directly elected by the people for a 5-year term. On the other, there is a nominated council of ministers headed by the prime minister, which is responsible to the parliament. However, the ministers shall not be the members of the parliament. Over a period of time, the provisions of the Constitution relating to the mode of election, tenure of office, and number of terms of the President of France have been amended. These are mentioned in February 5, 92. 5. Bicameralism. The French Parliament comprises the National Assembly, the lower world constitutions for 681 House, and the Senate, upper house. The National Assembly has 577 members who are directly elected for a 5-year term. The Senate has 348 members who are indirectly elected for a 6-year term. The National Assembly is more dominant and powerful than the Senate. 6. Rationalized Parliament. The Constitution of France established a rationalized parliament, that is, a parliament with restricted and limited powers. The powers of the French Parliament are restricted vis-a-vis the political executive. It can make laws only on those items which are defined in the Constitution. On all other matters, the government is empowered to legislate by executive decree. The Parliament can also delegate lawmaking power to the executive branch. These limitations on parliamentary authority were imposed to provide for a strong executive. 7. Constitutional Council. France has a Constitutional Council. It consists of 9 members who are appointed for a term of 9 years. It functions as a judicial watchdog and ensures that the executive decrees and parliamentary laws conform to the provisions of the Constitution. However, it is only an advisory body and its opinion is not binding. 8. Recognition of political parties. The Constitution of France gives recognition to political parties and their role. It is for the first time in France that a republican constitution not only mentions parties but also acknowledges them as a normal part of political life. The Constitution states that the parties must respect the principles of national sovereignty and democracy. Table 92.2 Amended provisions of the Constitution relating to the French President ISI. No. Elements. Original provisions. Amended provisions. Year 1. Mode of election. Indirect election. Direct election. 1962. 1 2-foot tenure of office 7 years 5 years 2000. 3. Number of terms allowed. No limit on the number of terms, not more than 2 consecutive terms. 2008. 682 are Indian Polity. French President. Mode of election. Originally, the Constitution provided for an indirect election of the President. Husha was to be elected by an electoral college consisting of 3 types of members. National representatives, members of 2 houses of parliament. 2. Representatives of the local authorities, and 3. Representatives of the overseas territories. However, in 1962, the Constitution was amended through a referendum. The President is now directly elected by universal suffrage. In order to win the election, a candidate has to obtain an absolute majority of the votes cast. In case no candidate obtains the requisite majority in the first ballot, then a second ballot is held. Only the 2 candidates who have received the highest number of votes in the first ballot may stand in the second ballot. Tenure and removal. The President is elected for a term of 5 years. Husha is eligible for re-election, but for another consecutive term only. Moreover, the Constitution has not prescribed any qualifications, including the minimum age limit, for the presidential office. If the presidency falls vacant, the functions of the President, except submitting a bill to a referendum and dissolution of the National Assembly, are performed temporarily by the President of the Senate, and if Husha is also not in a position, the functions are performed by the government. The President can be removed from the office before the expiry of his normal tenure of 5 years through an impeachment for high treason. The impeachment resolution should be passed by both the houses of Parliament by an absolute majority. After this indictment by the Parliament, the President is tried by the High Court of Justice. Powers and functions. The President is the pivot of the Constitution and occupies a dominant position in the system of government. Husha is the real head of the state, the leader of the nation, and the symbol of national unity. His powers and functions are as follows. 1. Hsha appoints the Prime Minister and accepts Hsha resignation. 2. Hsha appoints and dismisses the other members of the Government Council of Ministers on the advice of the Prime Minister. 3. Hsha presides over the meetings of Council of Ministers. This provides him/her a direct opportunity to influence, guide, direct, and control the policies of the government. 4. Hsha makes appointments to civil and military posts of the state. 5. Hsha is the Commander-in-Chief of the armed forces of the country. 6. Hsha negotiates and ratifies treaties and sends and receives diplomats. 7. Hsha is kept informed of all the negotiations leading to the conclusion of an international agreement not subject to ratification. 8. Hsha presides over the higher councils and committees of national defense. 9. Hsha presides over and represents the French community. 10. Hsha appoints the President and 3 members of the Constitutional Council. 11. Hsha promulgates the laws within 15 days following their final adoption by the Parliament and transmission to the government. However, before the end of this period, Hsha can ask the Parliament to reconsider a law. This reconsideration cannot be refused by the Parliament. 12. Hsha can send messages to the Parliament and summon its special sessions. 13. Hsha can submit to a referendum any government bill on the proposal of the government during the parliamentary sessions or on the joint proposal of the 2 houses of the Parliament. If the bill is approved in the referendum, the President should promulgate it within 15 days. 14. Hsha signs the ordinances and decrees that have been considered by the Council of Ministers. World Constitution 683. 15. Hsha has the right to pardon. 16. Hsha presides over the higher council of the Judiciary. Hsha also appoints 9 members to it. 17. Hsha is the protector of the independence of the judicial authority. 18. Hsha is vested with special powers to deal with emergencies. During this period, Hsha can take the required measures after consulting the Prime Minister, the presidents of the 2 assemblies, houses, of the Parliament, and the Constitutional Council. 19. Hsha can dissolve the National Assembly, after consulting the Prime Minister and the presidents of the 2 assemblies, houses of the Parliament. The Constitution, however, imposes 2 limitations. Hsha cannot dissolve the National Assembly more than once in 12 months, and 2. The National Assembly cannot be dissolved during an emergency. Notably, the President is not required to follow the advice of the Prime Minister and the presidents of the 2 assemblies. Further, the President can refuse dissolution when asked by the Prime Minister. Japanese Constitution. The modern state of Japan came into existence with the Meiji Restoration in 1868. The Meiji Constitution remained in force for 58 years, from 1889 to 1947. This constitution was based on the ideals of autocracy, authoritarianism, and monarchy. After the Second World War, 1939 to 1945, Japan was placed under Allied occupation from 1945 to 1952. The U.S. General Douglas MacArthur was the supreme commander of the Allied powers in Japan. Under his direction, Japan adopted a new democratic constitution in 1946. This constitution is based on the ideals of democracy and peace, as conceived by the occupation authorities. The new and the present Constitution of Japan became operative in 1947. It came to be known both as the MacArthur Constitution, as well as the Showa Constitution. Showa is the title of the reign of Emperor Hirohito and means radiant peace. At the time of adoption of the new constitution, Hirohito was the emperor and Shidehara was the prime minister of Japan. The salient features of the present Constitution of Japan are as follows. 1. Written constitution. Like the American Constitution, the Japanese Constitution is a written constitution. It contains a preamble and 103 articles divided into 11 chapters. It is a unique blend of the American and the British system. The preamble emphasizes the principle of the sovereignty of the people. The chapters of the Constitution are mentioned in Iqbal 92.3. 2. Rigid constitution. Like the American Constitution, the Japanese Constitution is a rigid one. It cannot be amended by the Diet, Japanese Parliament, in the same manner as the ordinary laws are made. It can be amended only by means of a special process provided by the Constitution for that purpose. Hence, in Japan, there exists a distinction between a constitutional law and an ordinary law. The Japanese Constitution lays down the following procedure for its amendment. The amendment shall be initiated by the Diet. Such a proposal must be passed by a majority of 2/3 of its membership. 2. After that, it is submitted to the people for ratification at a special referendum or a specific election. It must be approved by the majority of the people. 3. Amendment, when so ratified, shall immediately be promulgated by the Emperor in the name of the people, as an integral part of the Constitution. It must be mentioned here that the Japanese Constitution has not so far been amended even once. Thus, the Constitution reads today as it did in 1947. 3. Unitary Constitution. Like the British Constitution, the Japanese Constitution provides for a unitary state. There is no division of powers between the central and provincial. 684 Indian Polity. Table 92.3 Japanese Constitution at a glance. Chapter number. Chapter heading. Articles covered. 1. The Emperor. 1 to 8. 2. Renunciation of war 9. 3. Rights and duties of the people 10 to 40. For the Diet 41 to 64. V. The Cabinet 65 to 75. 6. Judiciary 76 to 82. 7. Finance 83 to SI. 8. Local self-government 92 to 95. 9. Amendments 96. Ex Supreme Law 97 to 99. 11. Supplementary Provisions 100 to 103. Governments. All powers are vested in the single supreme central government located at Tokyo. The provinces derive their authority from the central government. The Diet can expand or diminish the authority and jurisdiction of the provinces. Thus, the provinces are subordinate units of government and enjoy only those powers which are delegated to them by the supreme central government. 4. Parliamentary government. Japan has shown a preference for the British parliamentary system rather than the American presidential system of government. The features of the Japanese parliamentary system of government are as follows. I. The emperor is the nominal executive while the cabinet is the real executive. The cabinet consists of the prime minister as its head and 20 ministers of state. The emperor is the head of the state while the prime minister is head of the government. 2. The party which secures majority seats in the House of Representatives forms the government. The leader of the majority party or majority coalition invariably becomes the prime minister. 3. The prime minister is designated from among the members of the Diet by a resolution of the Diet. The emperor appoints the prime minister as designated by the Diet. 4. The prime minister appoints the ministers of state. But a majority of them should be chosen from among the members of the Diet. V. The prime minister can remove the ministers of state as he chooses. 6. The cabinet, in the exercise of the executive power, is collectively responsible to the Diet. It must resign when the House of Representatives passes a no-confidence resolution. 7. The emperor can dissolve the House of Representatives on the advice of the prime minister. An analysis of the above points makes it clear that Japan, though adopted the British parliamentary pattern, differed from Britain in the following 4 respects. 1. In Britain, the prime minister is chosen as well as appointed by the king-queen, while in Japan, the prime minister is chosen by the Diet but appointed by the emperor. World Constitutions 685. 2. In Britain, the ministers are appointed by the king-queen, while in Japan, the ministers are appointed by the prime minister. 3. In Britain, the prime minister cannot remove the ministers, while in Japan, the prime minister can remove the ministers at his will. 4. In Britain, all the ministers must be members of the parliament, while in Japan, only a majority of the ministers must be members of the Diet. 5. Constitutional monarchy. Japan is a monarchical state. It is described as a limited hereditary monarchy. The Constitution, though it preserves the institution of the emperor, it deprives him her all powers, privileges and prerogatives Husha formerly exercised and enjoyed. It makes the following provisions with regard to the institution of the emperor. I. The emperor is the symbol of the state and of the unity of the people. Husha derives his position from the will of the people with whom resides sovereign power. Thus, the sovereignty of the emperor is absolutised. 2. The imperial throne is dynastic and succeeded to in accordance with the law passed by the Diet. 3. The advice and approval of the cabinet is required for all acts of the emperor. 4. The emperor performs only those acts which are enumerated in the Constitution, and Husha has no powers related to government. V. The emperor can neither give nor receive imperial property without the authorization of the Diet. Thus, the Constitution has made the emperor merely a constitutional head. His authority is strictly limited to ceremonial functions of a constitutional monarch. Like his British counterpart, Husha only reigns and does not rule. 6. Supremacy of Constitution and Judicial Review. The Japanese Constitution establishes the principle of supremacy of Constitution. The Constitution is regarded as the supreme, highest or fundamental law of the land. The laws, ordinances, imperial rescript and official acts must conform to this supreme law. If these are against the provisions of the Constitution, they can be declared by the Supreme Court as ultra vires and hence null and void. Thus, the American principle of judicial review is adopted in Japan. But there is a difference. The American Supreme Court does not derive its power of judicial review from the Constitution, whereas the Japanese Supreme Court derives its power of judicial review directly from the Constitution. The Japanese Constitution specifically says that the Supreme Court is the court of last resort with power to determine the constitutionality of any law, order, regulation, or official act. 7. Fundamental rights. The Japanese Constitution provides for rights on the model of the Bill of Rights in the USA. It guarantees a large number of civil, political, and economic rights to the people of Japan and declares them as eternal and inviolate. The judiciary headed by the Supreme Court acts as the protector of these rights through its power of judicial review. The rights provided by the Japanese Constitution are more elaborate and definite than the American Bill of Rights. Out of a total of 103 articles in the Constitution, 31 articles, 10 to 40, are devoted to the rights and duties of the people. The rights provided for in the Constitution are I. Right to equality. 2. Right to freedom. 3. Right to freedom of religion. 4. Right to private property. v. Economic rights. 6. Right to education. 7. Cultural rights. 8. Right to constitutional remedies. 8. Renunciation of war. The Japanese Constitution renounces war as a sovereign right of the nation and the threat or use of force as means of settling international disputes. It prohibits Japan from maintaining land, sea, and air forces, as well as other war potential. It also does not recognize the right of belligerency of the state. 686 Indian Polity. Japan is the only modern state which has constitutionally renounced war forever. It is the most peculiar as well as the most controversial feature of the Japanese Constitution. This provision got inserted into the Constitution by General MacArthur to see that Japan would never again be allowed to act as a military nation as it did during the period of 1931 to 1945 and to abolish forever the power of Japan as a rival to the U.S. in the Far East. However, it does not mean that Japan cannot use arms and other forces for its security and defense. Like any other modern state, Japan has its defense capabilities, but the term used is self-defense forces to look constitutionally correct. They are justified on the ground that every state has an inherent right to defend itself against foreign aggression. 9. Bicameralism. The Japanese Diet is bicameral, that is, it consists of two houses, namely the House of Councillors, upper house, and the House of Representatives, lower house. The House of Councillors consists of 252 members elected for a term of 6 years. Out of the total 252 members, 152 are elected on a geographical basis, local constituencies, and the remaining 100 are elected by the nation at large, national constituency. The House of Representatives consists of 512 members elected for a term of 4 years. The House of Representatives has more powers than the House of Councillors, especially in financial matters. Constitutionally, the Diet is the highest organ of state power and is the sole lawmaking organ of the state. Soviet Constitution. The state of the USSR, also called as the Soviet Union, was formed in 1917 following the Russian Revolution, Bolshevik Revolution, led by the charismatic V.I. Lenin. After being a superpower for more than 70 years, the USSR finally collapsed and disintegrated in 1989 to 1991 mainly due to economic crisis. The Russian Revolution of October 1917 created, for the first time ever, a socialist state, whose goal was communism. Hence, the Soviet Constitution was the first socialist constitution of the world. Since its formation in 1917, the USSR adopted 4 constitutions, that is, in 1918, 1924, 1936, Stalin Constitution, and 1977, Brezhnev Constitution. The constitutional system of the USSR was based on the principles and ideologies of Marxism, Leninism. Thus, the Communist Party dominated the entire political and administrative system of the USSR. It was in this respect that the politico-administrative system of the USSR was different from that of the UK, USA, and France. The salient features of the Soviet Constitution of 1977 are explained as follows. 1. Written constitution. Like American and French constitutions, the Soviet Constitution was also a written one. It was drafted by a committee headed by Mr. Brezhnev. It had 20 chapters and 174 articles divided into 9 parts. 2. Rigid constitution. The Soviet Constitution was rigid in nature. It provided for a special procedure for its amendment. It could be amended by the legislature of the USSR, Supreme Soviet, by a 2/3 majority in each house. Z. Socialist Constitution. The Constitution was socialistic in nature and laid down the foundation of a socialist state. It stated that the Union of Soviet Socialist Republics is a socialist state of the whole people, expressing the will and interests of the workers, peasants, and intelligentsia, the working people of all the nations and nationalities of the country. It also stated that the foundation of the economic system of the USSR is socialist ownership of the means of production in the form of state property, belonging to all the people, and collective farm and cooperative property. 4. Federal Constitution. The Constitution provided for a federal state consisting of 15 units called Union Republics. These units of the Soviet Federation were Russia, Ukraine, Belarus, Uzbekistan, Kazakhstan, Georgia, Azerbaijan, Lithuania, Moldavia, Latvia, Kyrgyzstan, Tajikistan, Armenia, Turkmenistan, and Estonia. The powers were divided between the center and the units. The powers of the center were enumerated while the residuary powers were given to the units, as in the case of the USA. These 15 Union republics had their own separate constitutions conforming to the Constitution of the USSR and enjoyed the right to secede from the USSR. Within several Union republics existed autonomous republics, 20, autonomous regions, 8, and autonomous areas, 10. They were vested with a certain amount of autonomy. Hence, the Union republics were called sub-federations within the Soviet Federation, and the USSR was called a federation of federations. 5. Parliamentary government. The Constitution provided for a parliamentary form of government in the USSR. The Council of Ministers was elected by the Supreme Soviet, legislature of the USSR, and remained responsible to it for its policies and acts. The Supreme Soviet could also remove the ministers from their offices. The Constitution stated that the Council of Ministers headed by the Premier is the highest executive and administrative authority of the USSR. 6. Bicameralism. The Constitution provided for a bicameral legislature for the USSR. Thus, the Supreme Soviet consisted of the Soviet of the Union, lower house, and the Soviet of the Nationalities, upper house. Both the houses had equal number of members, i.e., 750 in each, elected directly every 5 years. The lower house represented the nation as a whole, while the upper house represented the units of the Soviet Federation. The two houses had equal and coordinated powers in all policy matters. 7. Presidium. The Supreme Soviet, constitutionally the highest body of state authority of the USSR, elected a governing body known as the Presidium. The Constitution termed it as the Standing Committee of the Supreme Soviet. It was a 39-member body consisting World Constitutions 687 of a chairman, first vice-chairman, 15 vice-chairmen, i.e. the heads of the 15 Union republics, a secretary, and 21 members. The chairman, president, of the Presidium was the formal head of the state of the USSR. It functioned as a collective presidency of the USSR. Hence it was called the collegial executive, or the plural executive, or the collegiate president of the USSR. It combined executive, legislative, diplomatic, military, and judicial functions. Because of its multifarious functions and the plural character, the Presidium of the Supreme Soviet of the USSR has been described as the 20th century innovation. This type of institution was not provided by any other constitution of the world. 8. One-party dictatorship. The most important feature of the constitutional system of the USSR was the monopoly of the political power enjoyed by the Communist Party of the Soviet Union, CPSU. The Soviet Constitution stated, the leading and guiding force of Soviet society and the nucleus of its political system, of all state organizations and public organizations, is the Communist Party of the Soviet Union. The CPSU exists for the people and serves the people. The Communist Party, armed with Marxism-Leninism, determines the general perspectives of the development of society and the course of home and foreign policy of the USSR, directs the great constructive work of the Soviet people, and imparts a planned, systematic, and theoretically substantiated character to their struggle for the victory of communism. 9. Democratic centralism. The Constitution stated that the Soviet state is organized and functions on the principle of democratic centralism, namely the electiveness of all bodies of state authority from the lowest to the highest, their accountability to the people, and the obligation of lower bodies to observe the decisions of higher ones. Democratic centralism combines central leadership with local initiative and creative activity, and with the responsibility of each state body and official for the work entrusted to them. 688 Indian Polity. This principle was applicable to governmental organization. Hierarchy of the Soviets and the Communist Party organization. 10. Fundamental rights. The Constitution also provided for a large number of economic, social, personal, cultural, and political rights to the citizens of the USSR. These rights were guaranteed to all the citizens of the country equally, irrespective of nationality, race, sex, and so on. The form of the rights granted to the citizens was socialist, not personal, that is, they were meant for the establishment of a socialist system in the USSR. Thus, the enjoyment of these rights by the citizens was not to detriment the interests of society or state or the rights of other citizens. 11. Fundamental duties. Apart from the fundamental rights, the Constitution also provided for fundamental duties. The Constitution stated that the exercise of these rights and freedoms by the citizens was inseparable from the performance of these duties and obligations. The following is the list of the fundamental duties contained in the Constitution. Observe the Constitution of the USSR and Soviet laws. 2. To observe labor discipline. 3. Preserve and protect the socialist property. 4. Safeguard the interest of our Soviet state. Defend the socialist motherland. 6. To render military service. 7. To respect the national dignity of other citizens. 8. Respect the rights and lawful interests of other persons. 9. To protect nature and conserve its richness. To preserve historical monuments and other cultural values. 11. Promote and strengthen world peace. Russian Constitution. Russia was the largest constituent unit of the former USSR. It was 75% of the total area of the former USSR and had 50% of its total population. It also contributed about 70% to the total agricultural and industrial output of the former USSR. After the dissolution of the USSR in December 1991, Russia adopted a new constitution on December 20, 1993, and thus established a new politico-administrative system. The salient features of the Russian constitution are mentioned as follows. 1. It declares Russia as a sovereign and multi-ethnic republican state. 2. It provides for a federal state. The Russian Federation consists of 21 republics, 6 territories, Krai, 49 regions, Oblast, 10 autonomous areas, Autonomy Okrug, World Constitutions 689. 2 cities, Moscow and St. Petersburg, of federal status, and Birobidzhan, Jewish Autonomous Region. 3. It establishes a liberal democratic order and guarantees fundamental rights to the citizens. Thus, it discards the earlier totalitarian system. 4. It introduces multi-party system and ensures free and fair periodic elections. 5. It provides for the division of the state power among the legislature, executive, and judiciary. These 3 organs are independent of one another. 6I4. Establishes bicameral legislature, Federal Assembly, consisting of Federation Council, Upper House, and State Duma, Lower House. The Federation Council consists of 178 members, 2 from each territorial units of the Russian Federation. The State Duma consists of 450 members who are directly elected for a period of 4 years. 7 asterisk, it declares President of the Russian Federation as head of the state. The President is elected for a term of 4 years by universal and direct suffrage. Husha is head of the executive as well as Commander-in-Chief of the Armed Forces. 8. It authorizes the President of the Republic to appoint the Chairman of the government as the Prime Minister. The President is to appoint other federal minister on the advice of the Prime Minister. Husha can also dismiss the Prime Minister or any other federal minister. It provides for a 19-member constitutional court. Its function is to decide the constitutionality of the presidential decrees, government orders, and laws of the Federal Assembly. 10 asterisk, it authorizes the Russian legislature, Federal Assembly, to remove the president by way of impeachment on the charge of high treason or grave crime. The resolution of impeachment should be approved by both the houses by 2/3 majority. Chinese Constitution. After the Communist Revolution, New Democratic Revolution, led by the Communist Party of China, CPC, with Chairman Mao Zedong as its leader, the People's Republic of China was formed in 1949. Since then, China adopted 4 constitutions, i.e., in 1954, 1975, 1978, and 1982. The 4th and the present Constitution of 1982 was drafted by the National Constitution Revision Committee set up by the National People's Congress, NPC. The draft constitution, after it was approved by the Standing Committee of the NPC, was submitted to the people for nationwide discussions. Finally, the draft constitution was adopted by the NPC and promulgated for implementation by the announcement of the NPC on December 4, 1982. Its salient features are as follows. 1. Written constitution. The Chinese constitution is a written constitution. It consisted, originally, of a preamble and 138 articles divided into 4 chapters. These are mentioned in Table 92.4. 2. Rigid constitution. The Chinese constitution is rigid in nature. It contains a special procedure for its amendment. It can be amended by the NPC by a majority of 2/3 of its membership. But the amendments to the Constitution must be proposed either by the Standing Committee of the NPC or by 1/5 or more of the total deputies, members of the NPC. 3. Socialist Constitution. The Chinese Constitution is socialistic in nature and lays down the foundation of a socialist state. It declares that China is a socialist state governed by a people's democratic dictatorship that is led by the working class and based on an alliance of workers and peasants. It further declares that the socialist system is the fundamental system of China. Leadership by the CPC is the defining feature of socialism with Chinese characteristics. And it is prohibited for any organization or individual to damage the socialist system. $690 Indian Polity. Table 92.4 Chinese Constitution at a glance, as amended till now. Chapter number chapter heading articles covered 1 General Principles 1 to 32 2 Fundament Rights and Obligations of Citizens 33 to 56. 3 State Institutions Section 1. The National People's Congress Section 2. The President of the People's Republic of China Section 3. The State Council Section 4. The Central Military Commission Section 5. Local People's Congresses at all levels and local people's governments at all levels Section 6. Autonomous Organs of Ethnic Autonomous Areas Section 7. Commissions of Supervision Section 8. People's Courts and People's Procuratorrates. 57 to 140. For the national flag, national anthem, national emblem, and the capital 141 to 143. 4. Unitary Constitution. The Chinese Constitution establishes a unitary state rather than a federal state. The preamble declares that China is a unitary multinational state built up jointly by the people of all its nationalities. There are no division of powers between the central and provincial governments. All powers are vested on the single supreme central government located at Beijing. The provincial governments derive their authority from the delegation made by the central government. They are created or abolished by the central government only for administrative convenience. 5. Parliamentary government. The Chinese Constitution provides for a parliamentary form of government. According to the Constitution, the State Council of China, namely, the Central People's Government, is the executive organ of the highest state organ of power, i.e., NPC, and it is the highest state administrative organ. The State Council, headed by a Premier, is responsible to the NPC and reports to the NPC on its work. The Premier is chosen by the NPC based on the nomination of the President of China, and the other members of the State Council are chosen by the NPC based on the nomination of the Premier. The President of China, pursuant to decisions of the NPC, appoints or removes the Premier and other members of the State Council. The Premier directs the work of the State Council and presides over its meetings, but his authority cannot be compared with that of the Indian Prime Minister or the British Prime Minister. The head of the state, i.e., the President of China, is an elected executive. Pasha is elected by the NPC for a term of 5 years. Any citizen of China who has the right to vote and stand for election and who has reached the age of 45 is eligible for election as the president. However, the president is only a ceremonial executive and not a real executive. Hence, his authority cannot be compared with that of the American president. 6. Unicameralism. The Chinese constitution provides for a unicameral legislature, i.e., the NPC. Constitutionally, the NPC is the highest state organ of power and exercises the legislative power of the state. It is composed of deputies elected from the provinces, autonomous regions, cities directly under the jurisdiction of central government, special administrative regions, and armed forces. The number of deputies and the procedures for their election are prescribed by law. Hence, their number varies from time to time. It is approximately 3,000. The NPC is elected for a term of 5 years. Its permanent organ is the Standing Committee consisting of approximately 200 members. 7. Communist Party leadership. The Chinese constitution recognizes a multi-party system in the country. But, at the same time, it also clearly establishes the leadership role of the CPC. The preamble says that the system of multi-party cooperation and political consultation under the leadership of the CPC will continue and develop long into the future. It also says that the Chinese people of all ethnic groups will continue, under the leadership of the CPC and the guidance of Marxism-Leninism, Mao Zedong. Thought. Deng Xiaoping theory. The theory of three represents the scientific outlook on development and Xi Jinping thought on socialism with Chinese characteristics for a new era, to uphold the people's democratic leadership, stay on the socialist road and develop the socialist market economy. Further, Article 1 declares that leadership by the CPC is the defining feature of socialism with Chinese characteristics. 8. Democratic centralism. The Chinese constitution declares that the state institutions shall practice the principle of democratic centralism. The NPC and the local people's congresses at all levels are created through democratic election and are responsible to the people and are also subject to their oversight. Also, all administrative, supervisory, adjudicatory, and procuratorial organs of the state are created by the people's congresses and are responsible to them and are also subject to their oversight. Further, the division of functions and powers between the central and local state institutions should honor the principle of giving full play to the initiative and motivation of local authorities under the unified leadership of the central authorities. 9. Fundamental rights. The Constitution provides for a large number of rights to the citizens of China. They include civil, political, World Constitutions M691, personal, economic, social, and cultural rights. But the enjoyment of these rights by the citizens should not undermine the interests of the state or society or collectives or the rights of other citizens. 17. Right of women to enjoy equal rights with men in all spheres of life, political, economic, cultural, social, and familial. 18. Right to protection of marriage and family. 19. Protection of the rights of Chinese nationals living abroad. 10. Fundamental duties. In addition to the above fundamental rights, the Chinese Constitution also provides for the fundamental duties of citizens. The Constitution says that every citizen must fulfill the duties prescribed by it. These are as follows. LB safeguard national unity and solidarity. 2. LB abide by the Constitution and the law, keep state secrets, protect public property, observe discipline in the workplace, observe public order, and respect social morality. 3. LB safeguard the security, honor, and interests of the motherland. 692p. Indian Polity. 4. LB defend the motherland and resist aggression. V. LB perform military service or join the militia. 6. TB pay taxes in accordance with law. 7. To work, receive education, and practice family planning. T. Swiss Constitution. Till now, Switzerland adopted 3 constitutions, I. 6. 1848, 1874, and 1999. The Constitution of 1848 established the federal state in Switzerland. This constitution was replaced by the next Constitution of 1874. After a long period of 125 years, this second constitution was replaced by the third constitution of 1999. At present, the third constitution is continuing in Switzerland. It was adopted by the Federal Assembly on December 18, 1998. Subsequently, it was approved by the people and the cantons, i.e., states, on April 18, 1999. Finally, it came into force on January 1, 2000. Its salient features are explained below. 1. Written constitution. The Swiss constitution is a comprehensive written document. Originally, it consisted of a preamble and 196 articles divided into 6 titles, i.e., parts. These are mentioned in THBLI 92.5. 2. Rigid constitution. The Swiss constitution is rigid in nature. It contains a special procedure for its amendment. It provides for 2 types of revision, amendment, i.e., total revision and partial revision, i. A total revision of the Constitution may be proposed by the people or by either of the 2 chambers of the Federal Assembly or may be decreed by the Federal Assembly. If the initiative emanates from the people or if the 2 chambers are unable to agree, then the people will decide on whether a. Table 92.5 Swiss Constitution at a glance, as amended till now. Title heading articles covered 1 General Provisions 1 to 6 2. Fundamental Rights. Citizenship and Social Goals Chapter 1. Fundamental Rights Chapter 2. Citizenship and Political Rights Chapter 3. Social Goals. 7 to 41. 3 Confederation, Cantons and Communes Chapter 1. Relations between the Confederation and the Cantons. Chapter 2. Powers Chapter 3. Financial System. 42 to 135. For the People and the Cantons Chapter 1. General Provisions Chapter 2. Initiative and Referendum. 136 to 142. 143 to Idle. V. Federal Authorities Chapter 1. General Provisions Chapter 2. Federal Assembly Chapter 3. Federal Council and Federal Administration Chapter 4. Federal Supreme Court and other judicial authorities. 6. Revision of the Federal Constitution and Transitional Provisions. Chapter 1. Revision. Chapter 2. Transitional Provisions. 192 to 197. Total revision should be carried out. If the people vote for a total revision, then new elections are held to both the chambers. 2. A partial revision of the Constitution may be requested by the people or may be decreed by the Federal Assembly. The partial revision must respect the principle of cohesion of subject matter. Further, the popular initiative for partial revision must also respect the principle of consistency of form. The totally revised or the partially revised Constitution comes into force when it is approved by the people and the cantons. 3. Federal Constitution. The Swiss Constitution provides for a federal republic consisting of 26 units called as cantons. The powers are divided between the federal government and the cantons. The powers of the federal government are specified while the residuary powers are given to the cantons as in the case of the USA. Each canton has its own constitution, legislature, executive, and judiciary. The cantons are of 2 types, namely, full cantons and half cantons. Out of the total 26 cantons, 20 are full cantons and 6 are half cantons. The half cantons were formed as a result of split in the cantons for settling internal conflicts due to religion or language or some other factor. They differ in the following 2 respects. Each half canton has 1 representative in the upper house of the Federal Assembly, whereas each full canton has 2 representatives. 2. Each half canton has a half vote on the proposals for total or partial revision, amendment, of the Constitution, whereas each full canton has 1 vote. 4. Council model of government. The Swiss Constitution provides for neither the British parliamentary system of government nor the American presidential system of government. It, on the other hand, provides for a unique system of executive called as the Federal Council, Bundesrat, which is a plural collegial. World Constitutions X 693. Executive. The features of the Swiss Council model of government are as follows. The Federal Council has 7 members who are elected by the Federal Assembly following each general election to the National Council. 2. The members of the Federal Council are elected for a term of 4 years. Any Swiss citizen eligible for election to the National Council may be elected to the Federal Council. 3. In electing the Federal Council, care must be taken to ensure that the various geographical and language regions of the country are appropriately represented. 4. The President and the Vice President of the Federal Council are elected by the Federal Assembly from the members of the Federal Council for a term of 1 year. Re-election for the following year is not permitted. The President may not be elected Vice President for the following year. V. The members of the Federal Council act both collectively as well as individually. Collectively, they make all the executive decisions of the federal government, and individually, they act as the heads of the departments of the federal government. 6. All the 7 members of the Federal Council are vested with co-equal authority. The President does not possess any special powers. Husha is only a primus inter pares, first among equals. Husha acts as a nominal head of the Swiss Federal Republic and performs the ceremonial duties. Hence, Husha authority cannot be compared with that of the British Prime Minister or the American President. 7. The members of the Federal Council are not the members of the Federal Assembly. However, they participate in the deliberations of the Federal Assembly but without the right to vote. Further, they cannot be removed from 694 or Indian Polity. Their office by the Federal Assembly either by passing a motion of no confidence as in the case of British Cabinet or by passing a resolution of impeachment as in the case of American President. 8. The Federal Council is non-partisan in nature. It is composed of the members who belong to different political parties. But they do not work on party lines. From the above, it is clear that the Swiss executive is basically different from both the British executive and the American executive. According to C.F. Strong, the Swiss executive system combines the merits and excludes the defects of both the parliamentary and presidential executive systems. 5. Bicameralism. The Swiss federal legislature, called the Federal Assembly, is bicameral. That is, it consists of two houses, namely, the Council of States and the National Council. The Council of States is the upper house chamber, and while the National Council is the lower house chamber. The Council of States is composed of 46 representatives of the cantons. The full cantons elect 2 representatives each, while the half cantons elect 1 representative each. This means that the cantons, irrespective of their size and population, are provided equal representation in the Council of States like that of the American Senate. The cantons determine the rules for the election of their representatives to the Council of States. Hence, the mode of election and the tenure of the representatives to the Council of States varies from canton to canton. In some cantons, they are elected by the cantonal legislatures, while in some other cantons, they are elected directly by the people. Similarly, their tenure also varies from 1 year to 4 years. The National Council is composed of 200 representatives of the people. These representatives are elected directly by the people according to a system of proportional representation. Their term of office is 4 years. The 2 chambers in Switzerland are of equal standing and have equal powers. C.F. Strong, in this context, observed, the Swiss legislature, like the Swiss executive, is unique. It is the only legislature in the world the powers of whose upper house are in no way different from those of the lower house. 6. Direct democracy. The Swiss constitution provides for the operation of the direct democracy and thereby enables the people to directly participate in the affairs of the state. It specifies 2 direct democratic devices, namely, referendum and initiative. There are 2 types of referendum, mandatory and optional. Mandatory referendum. The following must be put to the vote of the people and the cantons. A. Amendments to the Constitution. B. Accession to organizations for collective security or to supranational communities. C. Emergency federal acts that are not based on a provision of the Constitution. The following are submitted to a vote of the people. A. Popular initiatives for a total revision of the Constitution. B. Popular initiatives for a partial revision of the Constitution in the form of a general proposal that have been rejected by the Federal Assembly. C. The question of whether a total revision of the Constitution should be carried out in the event that there is disagreement between the 2 chambers of the Federal Assembly. 2. Optional referendum. If 50,000 voters or 8 cantons request it, the following are submitted to a vote of the people. A. Federal acts. B. Emergency federal acts whose term of validity exceeds 1 year. C. Federal decrees, if Constitution or an act so requires. D. International treaties of specified categories. Under the Constitution, the device of initiative is allowed, at the federal level, only in the World Constitution's 695 case of constitutional amendments and not in the case of federal laws or international treaties. Any 1,000,000 voters may propose a total revision of the Constitution. Similarly, any 1,000,000 voters may request a partial revision of the Constitution. A popular initiative for the partial revision of the Constitution may take the form of a general proposal, e.e., unformulative initiative, or of a specific draft of the provisions proposed, e.e., formulative initiative. 7. Triple citizenship. Under the Swiss Constitution, the citizenship is threefold, i.e., the citizenship of the commune, municipality, the canton, and the federation. The Constitution declares that any person who is a citizen of a commune and of the canton to which that commune belongs is a Swiss citizen. This means that no person can be a citizen of Switzerland without being a citizen of a canton, and no person can be a citizen of a canton without being a citizen of a commune. In Switzerland, the communal citizenship is regarded as more valuable than the cantonal and federal citizenship. 8. Fundamental rights. The Swiss Constitution contains an elaborate list of fundamental rights of the citizens. They include civil, social, economic, political, and personal rights. These are mentioned below. I. Protection of human dignity. 2. Right to equality before the law. 3. Protection against arbitrary conduct and principle of good faith. 4. Right to life and to personal freedom. V. Protection of children and young people. 6. Right to assistance when in need. 7. Right to privacy. 8. Right to marry and to have a family. 9. Freedom of religion and conscience. X. Freedom of expression and of information. 11. Freedom of the media. 12. Freedom to use any language. 13. Right to basic education. 14. Freedom of research and teaching. 15. Freedom of artistic expression. 16. Freedom of assembly. 17. Freedom of association. 18. Freedom of domicile. 19. Protection against expulsion, extradition, and deportation. XX. Right to property. 21. Economic freedom. 22. Right to form professional associations. 23. Right to access to the courts. 24. Right to petition. 25. Political rights. 9. Social goals of the government. The Swiss Constitution, in addition to the fundamental rights of the citizens, also contains the list of social goals of the government. The federal and cantonal governments shall endeavor to achieve these social goals within the scope of their constitutional powers and the resources available to them. But no direct right to state benefits may be established on the basis of these social goals. These are as follows. I.T.B. ensure that every person has access to social security and to health care. 2. L.B. ensure that families are protected and encouraged as communities of adults and children. 3. T.B. ensure that every person can earn their living by working under fair conditions. 4. L.B. ensure that every person can find suitable accommodation. V. 1b. ensure that children and young people can obtain education and undergo training. 6. T.B. ensure that children and young people are supported in their social, cultural, and political integration. 7. L.B. ensure that every person is protected against the economic consequences of old age, invalidity, illness, accident, unemployment, maternity, being orphaned, and being widowed. Appendices. In this part, Appendix I Articles of the Constitution, Appendix II Subjects of Union, State, and Concurrent Lists, Appendix III Table of Precedents, Appendix IV Constitutional Amendments at a glance. Appendix V Constitutional Amendments with reference to Articles, Appendix VI Flag Code of India, Appendix VII Presidents, Vice Presidents, Prime Ministers, etc. Appendix 8 Chairpersons of the National Commissions. Appendal Articles of the Constitution, 1 to 395. Union and its territory. 1. Name and territory of the Union. 2. Admission or establishment of new states. 2a. Sikkim to be associated with the Union, repealed. 3. Formation of new states and alteration of areas, boundaries, or names of existing states. 4. Laws made under Articles 2 and 3 to provide for the amendment of the first and the fourth schedules and supplemental, incidental, and consequential matters. Citizenship. 5. Citizenship at the commencement of the Constitution. 6. Rights of citizenship of certain persons who have migrated to India from Pakistan. 7. Rights of citizenship of certain migrants to Pakistan. 8. Rights of citizenship of certain persons of Indian origin residing outside India. 9. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. 10. Continuance of the rights of citizenship. 11. Parliament to regulate the right of citizenship by law. T. Fundamental rights. 12. Definition of state. 13. Laws inconsistent with or in derogation of the fundamental rights. 14. Equality before law. 15. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. 16. Equality of opportunity in matters of public employment. 17. Abolition of untouchability. 18. Abolition of titles. 19. Protection of certain rights regarding freedom of speech, etc. 20. Protection in respect of conviction for offenses. 21. Protection of life and personal liberty. 21a. Right to elementary education. 22. Protection against arrest and detention in certain cases. 23. Prohibition of traffic in human beings and forced labor. 24. Prohibition of employment of children in factories, etc. 25. Freedom of conscience and free profession, practice, and propagation of religion. 26. Freedom to manage religious affairs. 27. Freedom as to payment of taxes for promotion of any particular religion. 28. Freedom as to attendance at religious instruction or religious worship in certain educational institutions. 29. Protection of interests of minorities. 30. Right of minorities to establish and administer educational institutions. 31. Compulsory acquisition of property, repealed. 31a. Saving of laws providing for acquisition of estates, etc. 31b. Validation of certain acts and regulations. 31c. Saving of laws giving effect to certain directive principles. 31d. Saving off laws in respect of anti-national activities. Repealed. 32. Remedies for enforcement of fundamental rights, including writs. 32a. Constitutional validity of state laws not to be considered in proceedings under Article 32, repealed. 33. Power of Parliament to modify the fundamental rights in their application to forces, etc. 34. Restriction on fundamental rights while martial law is in force in any area. 35. Legislation to give effect to some of the provisions of fundamental rights, directive principles, of state policy. 36. Definition of state. 37. Application of the directive principles. 38. State to secure a social order for the promotion of welfare of the people. 39. Certain principles of policy to be followed by the state. 39a. Equal justice and free legal aid. 40. Organization of village panchayats. 41. Right to work, to education, and to public assistance in certain cases. Articles of the Constitution, 1 to 395, VJ 697. 42. Provision for just and humane conditions of work and maternity relief. 43. Living wage, etc. For workers. 43a. Participation of workers in management of industries. 43b. Promotion of cooperative societies. 44. Uniform Civil Code for the citizens. 45. Provision for early childhood care and education to children below the age of 6 years. 46. Promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. 47. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. 48. Organization of Agriculture and Animal Husbandry 48A. Protection and improvement of environment and safeguarding of forests and wildlife 49. Protection of monuments and places and objects of national importance 50. Separation of judiciary from executive 51. Promotion of international peace and security. I. Fundamental duties. 51A. Fundamental duties. T. President and Vice President. 52. The President of India 53. Executive power of the Union 54. Election of President 55. Manner of election of President 56. Term of office of President 57. Eligibility of re-election 58. Qualifications for election as President 59. Conditions of President's office 60. Oath or affirmation by the President 61. Procedure for impeachment of the President 62. Time of holding election to fill vacancy in the office of President in the term of office of person elected to fill casual vacancy 63. The Vice President of India 698 Indian Polity. 64. The Vice President to be ex officio Chairman of the Council of State 65. The Vice President to act as President or to discharge his functions during casual vacancies in the office or during the absence of President 66. Election of Vice President 67. Term of office of Vice President 68. Time of holding election to fill vacancy in the office of Vice President in the term of office of person elected to fill casual vacancy. 69. Oath or affirmation by the Vice President 70. Discharge of President's functions and other contingencies 71. Matters relating to or connected with the election of a President or Vice President 72. Power of the President to grant pardons, etc. And to suspend, remit, or commute sentences in certain cases 73. Extent of executive power of the Union. Union Ministers and Attorney General ____ 74. Council of Ministers to aid and advise President 75. Other provisions as to Ministers 76. Attorney General for India 77. Conduct of business of the Government of India 78. Duties of Prime Minister as respects the furnishing of information to the President, etc. F. Parliament. 79. Constitution of Parliament 80. Composition of the Council of States 81. Composition of the House of the People 82. Readjustment after each census 83. Duration of Houses of Parliament 84. Qualification for membership of Parliament 85. Sessions of Parliament, prorogation and dissolution 86. Right of President to address and send messages to Houses 87. Special address by the President. 88. Rights of Ministers and Attorney General as respects Houses 89. The Chairman and Deputy Chairman of the Council of States 90. Vacation and resignation of, and removal from, the office of Deputy Chairman 91. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman 92. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration 93. The Speaker and Deputy Speaker of the House of the People 94. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker 95. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker 96. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration 97. Salaries and allowances of the Chairman and Deputy Chairman and the Speaker and Deputy Speaker 98. Secretariat of Parliament 99. Oath or affirmation by members 100. Voting in Houses, power of Houses to act notwithstanding vacancies and quorum 101. Vacation of seats 102. Disqualifications for membership 103. Decision on questions as to disqualifications of members 104. Penalty for sitting and voting before making oath or affirmation under Article 99, or when not qualified, or when disqualified 105. Powers, privileges, etc. Of the Houses of Parliament and of the members and committees thereof 106. Salaries and allowances of members 107. Provisions as to introduction and passing of bills 108. Joint sitting of both houses in certain cases 109. Special procedure in respect of money bills 110. Definition of money bills 111. Assent to bills 112. Annual financial statement, budget 113. Procedure in Parliament with respect to estimates 114. Appropriation bills 115. Supplementary, additional or excess grants 116. Votes on account, votes of credit and exceptional grants 117. Special provisions as to financial bills 118. Rules of procedure 119. Regulation by law of procedure in Parliament in relation to financial business 120. Language to be used in Parliament 121. Restriction on discussion in Parliament 122. Courts not to inquire into proceedings of Parliament 123. Power of President to promulgate ordinances during recess of Parliament. F. Supreme Court. 124. Establishment and Constitution of Supreme Court 124A. National Judicial Appointments Commission 1248. Functions of Commission 124C. Power of Parliament to make law 125. Salaries, etc. of judges 126. Appointment of acting Chief Justice 127. Appointment of ad hoc judges 128. Attendance of retired judges at sittings of the Supreme Court 129. Supreme Court to be a court of record 130. Seat of Supreme Court 131. Original jurisdiction of the Supreme Court 131A. Exclusive jurisdiction of the Supreme Court in regard to questions as to the constitutional validity of central laws, repealed, 132. Appellate jurisdiction of Supreme Court in appeals from high courts in certain cases 133. Appellate jurisdiction of Supreme Court in appeals from high courts in regard to civil matters. Articles of the Constitution, 1 to 395, TSGG. 134. Appellate jurisdiction of Supreme Court in regard to criminal matters 134A. Certificate for appeal to the Supreme Court 135. Jurisdiction and powers of the federal court under existing law to be exercisable by the Supreme Court 136. Special leave to appeal by the Supreme Court 137. Review of judgments or orders by the Supreme Court 138. Enlargement of the jurisdiction of the Supreme Court 139. Conferment on the Supreme Court of powers to issue certain writs 139A. Transfer of certain cases 140. Ancillary powers of Supreme Court 141. Law declared by Supreme Court to be binding on all courts 142. Enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. 143. Power of President to consult Supreme Court 144. Civil and judicial authorities to act in aid of the Supreme Court 144A. Special provisions as to disposal of questions relating to constitutional validity of laws, repealed, 145. Rules of court, etc. 146. Officers and servants and the expenses of the Supreme Court 147. Interpretation. Comptroller and Auditor. L. General of India. 148. Comptroller and Auditor General of India 149. Duties and powers of the Comptroller and Auditor General 150. Form of accounts of the Union and of the States 151. Audit reports. F. Governor. 152. Definition of State 153. Governors of State 700 are Indian Polity. 154. Executive power of State 155. Appointment of Governor 156. Term of office of Governor 157. Qualifications for appointment as Governor 158. Conditions of Governor's office 159. Oath or affirmation by the Governor 160. Discharge of the functions of the Governor in certain contingencies 161. Power of Governor to grant pardons, etc. and to suspend, remit, or commute sentences in certain cases 162. Extent of executive power of state. State ministers and Advocate General. 163. Council of Ministers to aid and advise Governor 164. Other provisions as to ministers 165. Advocate General for the state 166. Conduct of business of the government of a state 167. Duties of Chief Minister as respects the furnishing of information to Governor, etc. State Legislature _ 168. Constitution of Legislatures in States 169. Abolition or creation of legislative councils in States 170. Composition of the Legislative Assemblies 171. Composition of the Legislative Councils 172. Duration of state legislatures 173. Qualification for membership of the state legislature 174. Sessions of the state legislature, prorogation and dissolution 175. Right of governor to address and send messages to the House of Houses 176. Special address by the governor 177. Rights of ministers and advocate general as respects the Houses 178. The Speaker and Deputy Speaker of the Legislative Assembly 179. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. 180. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker 181. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration 182. The Chairman and Deputy Chairman of the Legislative Council 183. Vacation and resignation of, and removal from, the offices of Chairman and Deputy Chairman 184. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman 185. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration 186. Salaries and allowances of the Speaker and Deputy Speaker and the Chairman and Deputy Chairman 187. Secretariat of State Legislature 188. Oath or affirmation by members 189. Voting in houses, power of houses to act notwithstanding vacancies, and quorum 190. Vacation of seats 191. Disqualifications for membership 192. Decision on questions as to disqualifications of members 193. Penalty for sitting and voting before making oath or affirmation under Article 188, or when not qualified, or when disqualified 194. Powers, privileges, etc., of the House of Legislatures and of the members and committees thereof 195. Salaries and allowances of members 196. Provisions as to introduction and passing of bills 197. Restriction on powers of Legislative Council as to bills other than money bills 198. Special procedure in respect of money bills 199. Definition of money bills 200. Assent to bills 201. Bills reserved for consideration of the President Articles of the Constitution 1 to 395, 701. 202. Annual Financial Statement 203. Procedure in Legislature with respect to estimates 204. Appropriation Bills 205. Supplementary, additional or excess grants 206. Votes on account, votes of credit and exceptional grants 207. Special provisions as to financial bills 208. Rules of procedure 209. Regulation by law of procedure in the legislature of the state in relation to financial business 210. Language to be used in the legislature 211. Restriction on discussion in the legislature 212. Courts not to inquire into proceedings of the legislature 213. Power of governor to promulgate ordinances during recess of legislature. High courts 214. High courts for states 215. High courts to be courts of record 216. Constitution of high courts 217. Appointment and conditions of the office of a judge of a high court 218. Application of certain provisions relating to Supreme Court to high courts 219. Oath or affirmation by judges of high courts 220. Restriction on practice after being a permanent judge 221. Salaries, etc. Off judges 222. Transfer of a judge from one high court to another 223. Appointment of acting Chief Justice 224. Appointment of additional and acting judges 224A. Appointment of retired judges at sittings of high courts 225. Jurisdiction of existing high courts 226. Power of high courts to issue certain writs 226A. Constitutional validity of central laws not to be considered in proceedings under Article 226, repealed. 227. Power of superintendents over all courts by the High Court 228. Transfer of certain cases to High Court 228A. Special provisions as to disposal of questions relating to constitutional validity of state laws, repealed, 229. Officers and servants and the expenses of high courts 230. Extension of jurisdiction of high courts to union territories 231. Establishment of a common high court for two or more states 232. Interpretation, repealed, 7 subordinate courts 233. Appointment of district judges 233A. Validation of appointments of and judgments, etc. Delivered by certain district judges 234. Recruitment of persons other than district judges to the judicial service 235. Control over subordinate courts 236. Interpretation 237. Application of the provisions of this chapter to certain class or classes of magistrates. States in Part B of the First Schedule, repealed, 238. Application of provisions of Part 6 to states in Part B of the First Schedule, repealed. Union territories. 239. Administration of Union Territories 239A. Creation of local legislatures or council of ministers or both for certain Union Territories 239AA. Special provisions with respect to Delhi 239AB. Provision in case of failure of constitutional machinery 239B. Power of administrator to promulgate ordinances during recess of legislature 702 Indian Polity. 240. Power of the President to make regulations for certain Union Territories 241. High Courts for Union Territories 242. Court, repealed. T. Panchayats. 243. Definitions 243A. Gram Sabha 243B. Constitution of Panchayats 243C. Composition of Panchayats 243D. Reservation of seats 243E. Duration of Panchayats, etc. 243F. Disqualifications for membership 243G. Powers, authority and responsibilities of Panchayats 243H. Powers to impose taxes by and funds of the Panchayats 2431. Constitution of Finance Commission to review financial position 2433. Audit of accounts of Panchayats 243K. Elections to the Panchayats 243L. Application to Union Territories 243M. Part not to apply to certain areas 243N. Continuance of existing laws and Panchayats 2430. Bar to interference by courts in electoral matters. T. Municipalities. 243p. Definitions 243 Quetzales. Constitution of Municipalities 243r. Composition of Municipalities 2438. Constitution and composition of wards committees, etc. 2431. Reservation of seats 243u. Duration of municipalities, etc. 243v. Disqualifications for membership 243w. Powers, authority, and responsibilities of municipalities, etc. 243x. Power to impose taxes by, and funds of, the municipalities 243v. Finance Commission 2432. Audit of accounts of municipalities 243za. Elections to the municipalities 243zb. Application to Union Territories 243zc. Part not to apply to certain areas. 243zd. Committee for District Planning 243ze. Committee for Metropolitan Planning 243zf. Continuance of existing laws and municipalities 243zg. Bar to interference by courts in electoral matters. Cooperative Societies. 243zh. Definitions 243zi. Incorporation of Cooperative Societies 243zj. Number and term of members of board and its office bearers 243 Zambian Kwacha. Election of members of board 243zl. Supersession and suspension of board and interim management 243zm. Audit of accounts of cooperative societies 243zn. Convening of general body meetings 243zo. Right of a member to get information 243zp. Returns 243zq. Offenses and penalties 243zr. Application to multi-state cooperative societies 243zs. Application to Union Territories 243zt. Continuance of existing laws. 7 Scheduled and tribal areas. 244. Administration of scheduled areas and tribal areas 244a. Formation of an autonomous state comprising certain tribal areas in Assam and creation of local legislature or council of ministers or both therefore. T. Center-state legislative relations. 245. Extent of laws made by Parliament and by the legislatures of states 246. Subject matter of laws made by Parliament and by the legislatures of states 246a. Special provision with respect to goods and services tax 247. Power of Parliament to provide for the establishment of certain additional courts 248. Residuary powers of legislation articles of the Constitution 1 to 395, 703. 249. Power of Parliament to legislate with respect to a matter in the state list in the national interest 250. Power of Parliament to legislate with respect to any matter in the state list if a proclamation of emergency is in operation 251. Inconsistency between laws made by Parliament under Articles 249 and 250 and laws made by the legislatures of states 252. Power of Parliament to legislate for 2 or more states by consent and adoption of such legislation by any other state. 253. Legislation for giving effect to international agreements 254. Inconsistency between laws made by Parliament and laws made by the legislatures of states 255. Requirements as to recommendations and previous sanctions to be regarded as matters of procedure only. Center State. Administrative Relations 256. Obligation of states in the Union 257. Control of the Union over states in certain cases 257a. Assistance to states by deployment of armed forces or other forces of the Union, repealed, 258. Power of the Union to confer powers, etc. On states in certain cases 258a. Power of the states to entrust functions to the Union 259. Armed forces in states in Part B of the First Schedule, repealed, 260. Jurisdiction of the Union in relation to territories outside India 261. Public Acts, Records and Judicial Proceedings 262. Adjudication of disputes relating to waters of interstate rivers or river valleys 263. Provisions with respect to an interstate council. Center-state financial T relations underscore 264. Interpretation 265. Cease not to be imposed save by authority of law 266. Consolidated funds and public accounts of India and of the states 267. Contingency Fund 268. Duties levied by the Union but collected and appropriated by the states 268a. Service tax levied by Union and collected and appropriated by the Union and the states, repealed, 269. Fees levied and collected by the Union but assigned to the states 269a. Levy and collection of goods and services tax in course of interstate trade or commerce 270. Ikes levied and distributed between the Union and the states 271. Surcharge on certain duties and taxes for purposes of the Union 272. Ikes which are levied and collected by the Union and may be distributed between the Union and the states, repealed, 273. Grants in lieu of export duty on jute and jute products 274. Prior recommendation of the President required to bills affecting taxation in which states are interested 275. Grants from the Union to certain states 276. Seas on professions, trades, callings, and employments 277. Savings 278. Agreement with states in Part B of the first schedule with regard to certain financial matters, repealed, 279. Calculation of net proceeds, etc. 279a. Goods and Services Ikes Council 280. Finance Commission 281. Recommendations of the Finance Commission 282. Expenditure defrayable by the Union or a state out of its revenues 283. Custody, etc. Of consolidated funds, contingency funds and monies credited to the public accounts 284. Custody of suitors' deposits and other monies received by public servants and courts 285. Exemption of property of the Union from state taxation 286. Restrictions as to imposition of tax on the sale or purchase of goods 287. Exemption from taxes on electricity 288. Exemption from taxation by states in respect of water or electricity in certain cases 289. Exemption of property and income of a state from Union taxation 290. Adjustment in respect of certain expenses and pensions 290a. Annual payment to certain Devaswom funds 291. Privy purse sums of rulers, repealed, 292. Borrowing by the Government of India 293. Borrowing by states. Degree rights and liabilities of the government 294. Succession to property, assets, rights, liabilities and obligations in certain cases 295. Succession to property, assets, rights, liabilities and obligations in other cases 296. Property accruing by escheat or lapse or bona vacantia 297. Things of value within territorial waters or continental shelf and resources of the exclusive economic zone to vest in the Union 298. Power to carry on trade, etc. 299. Contracts 300. Suits and proceedings. T. Right to property. 300a. Persons not to be deprived of property save by authority of law. F. Trade, commerce, and intercourse. 301. Freedom of trade, commerce, and intercourse 302. Power of Parliament to impose restrictions on trade, commerce, and intercourse. 303. Restrictions on the legislative powers of the Union and of the states with regard to trade and commerce 304. Restrictions on trade, commerce, and intercourse among states 305. Saving of existing laws and laws providing for state monopolies 306. Power of certain states in Part B of the first schedule to impose restrictions on trade and commerce, repealed, 307. Appointment of authority for carrying out the purposes of Articles 301 to 304. T. Public Services. 308. Interpretation 309. Recruitment and conditions of service of persons serving the Union or a state 310. Sphere of office of persons serving the Union or a state 311. Dismissal, removal, or reduction in rank of persons employed in civil capacities under the Union or a state 312. All India Services 312a. Power of Parliament to vary or revoke conditions of service of officers of certain services 313. Transitional Provisions 314. Provision for protection of existing officers of certain services repealed. T. Public Service Commissions. 315. Public Service Commissions for the Union and for the states 316. Appointment and term of office of members 317. Removal and suspension of a member of a Public Service Commission 318. Power to make regulations as to conditions of service of members and staff of the Commission 319. Prohibition as to the holding of offices by members of the Commission on ceasing to be such members 320. Functions of Public Service Commissions 321. Power to extend functions of Public Service Commissions Articles of the Constitution 1 to 395, 705. 322. Expenses of Public Service Commissions 323. Reports of Public Service Commissions. F. Tribunals. 323a. Administrative Tribunals 3238. Tribunals for other matters. F. Elections. 324. Superintendence, direction, and control of elections to be vested in an Election Commission 325. No person to been eligible for inclusion in, or to claim to be included in a special electoral roll on grounds of religion, race, caste, or sex 326. Elections to the House of the People and to the Legislative Assemblies of States to be on the basis of adult suffrage 327. Power of Parliament to make provision with respect to elections to legislatures 328. Power of legislature of a state to make provision with respect to elections to such legislature 329. Bar to interference by courts in electoral matters 329a. Special provision as to elections to Parliament in the case of Prime Minister and Speaker, repealed. Special provisions relating to certain classes. 330. Reservation of seats for scheduled castes and scheduled tribes in the House of the People 331. Representation of the Anglo-Indian community in the House of the People 332. Reservation of seats for scheduled castes and scheduled tribes in the legislative assemblies of the states 333. Representation of the Anglo-Indian community in the legislative assemblies of the states 334. Reservation of seats and special representation to cease after certain period 335. Claims of scheduled castes and scheduled tribes to services and posts 336. Special provision for Anglo-Indian community in certain services 337. Special provision with respect to educational grants for the benefit of Anglo-Indian community 338. National Commission for Scheduled Castes 338A. National Commission for Scheduled Tribes 338B. National Commission for Backward Classes 339. Control of the Union over the administration of scheduled areas and the welfare of scheduled tribes 340. Appointment OFA Commission to investigate the conditions of backward classes 341. Scheduled castes 342. Scheduled tribes 342A. Socially and educationally backward classes. F. Official language 343. Official language of the Union 344. Commission and Committee of Parliament on Official Language 345. Official language or languages of a state 346. Official languages for communication between one state and another or between a state and the Union 347. Special provision relating to language spoken by a section of the population of a state 348. Language to be used in the Supreme Court and in the High Courts and for acts, bills, etc. 349. Special procedure for enactment of certain laws relating to language 350. Language to be used in representations for redress of grievances 350A. Facilities for instruction in mother tongue at primary stage 350B. Special Officer for Linguistic Minorities 351. Directive for Development of the Hindi Language F. Emergency Provisions 352. Proclamation of Emergency, National Emergency 353. Effective Proclamation of Emergency 706 Indian Polity 354. Application of provisions relating to distribution of revenues while a proclamation of emergency is in operation 355. Duty of the Union to protect states against external aggression and internal disturbance 356. Provisions in case of failure of constitutional machinery in states, President's Rule 357. Exercise of legislative powers under proclamation issued under Article 356-358. Suspension of provisions of Article 19 during emergencies 359. Suspension of the enforcement of fundamental rights during emergencies 359A. Application of this part to the state of Punjab, repealed, 360. Provisions as to financial emergency. Miscellaneous provisions. 361. Protection of the President and Governors and Raj Pramukhs 361A. Protection of publication of proceedings of Parliament and state legislatures 361B. Disqualification for appointment on remunerative political posts 362. Rights and privileges of rulers of Indian states, repealed, 363. Bar to interference by courts in disputes arising out of certain treaties, agreements, etc. 363A. Recognition granted to rulers of Indian states to cease and privy purses to be abolished 364. Special provisions as to major ports and aerodromes 365. Effective failure to comply with, or to give effect to directions given by the Union, President's Rule 366. Definitions 367. Interpretation. Amendment of the Constitution, _ 368. Power of Parliament to amend the Constitution and procedure therefore. Temporary, transitional and special provisions. 369. Temporary power to Parliament to make laws with respect to certain matters in the state list as if they were matters in the concurrent list 370. Temporary provisions with respect to the state of Jammu and Kashmir 371. Special provision with respect to the states of Maharashtra and Gujarat 371A. Special provision with respect to the state of Nagaland 371B. Special provision with respect to the state of Assam 371C. Special provision with respect to the state of Manipur 371D. Special provisions with respect to the state of Andhra Pradesh or the state of Telangana 371E. Establishment of Central University in Andhra Pradesh 371F. Special provision with respect to the state of Sikkim 371G. Special provision with respect to the state of Mizoram 371H. Special provision with respect to the state of Arunachal Pradesh 3711. Special provision with respect to the state of Goa 371J. Special provision with respect to the state of Karnataka 372. Continuance in force of existing laws and their adaptation 372A. Power of the President to adapt laws 373. Power of the President to make order in respect of persons under preventive detention in certain cases 374. Provisions as to judges of the federal court and proceedings pending in the federal court or before His Majesty and Council 375. Courts, authorities and officers to continue to function subject to the provisions of the Constitution 376. Provisions as to judges of high courts 377. Provisions as to Comptroller and Auditor General of India Articles of the Constitution 1 to 395, M 707. 378. Provisions as to Public Service Commissions 378A. Special provisions as to duration of Andhra Pradesh Legislative Assembly 379. Provisions as to Provisional Parliament and the Speaker and Deputy Speaker thereof, repealed, 380. Provisions as to President, repealed, 381. Council of Ministers of the President, repealed, 382. Provisions as to provisional legislatures for states and Part A of the First Schedule, repealed, 383. Provisions as to governors of provinces, repealed, 384. Council of Ministers of Governors, repealed, 385. Provisions as to provisional legislatures in states in Part B of the First Schedule, repealed, 386. Council of Ministers for states in Part B of the First Schedule, repealed, 387. Special provision as to determination of population for the purposes of certain elections, repealed. 388. Provisions as to the filling of casual vacancies in the provisional parliament and provisional legislatures of the states, repealed. 389. Provisions as to bills pending in the Dominion legislature and in the legislatures of provinces and Indian states, repealed. 390. Monies received or raised or expenditure incurred between the commencement of the Constitution and the 31st day of March, 1950, repealed. 391. Power of the President to amend the first and fourth schedules in certain contingencies, repealed. 392. Power of the President to remove difficulties. Short title, commencement, etc. 393. Short title 394. Commencement 394A. Authoritative text in the Hindi language 395. Repeals Appendix. Subjects of Union, State, and Concurrent Lists. T. Union List, List I, 1. Defense of India 2. Naval, Military, and Air Forces. Any other armed forces of the Union 2A. Deployment of any armed force of the Union in any state in aid of the civil power 3. Cantonment areas and local self-government in such areas 4. Naval, Military, and Air Force Works 5. Arms, firearms, ammunition, and explosives 6. Atomic energy and mineral resources necessary for its production 7. Defense Industries 8. Central Bureau of Intelligence and Investigation 9. Preventive detention for reasons connected with defense, foreign affairs, or the security of India 10. Foreign Affairs 11. Diplomatic, Consular, and Trade Representation 12. United Nations Organization 13. International Conferences, Associations, and Other Bodies 14. Treaties, Agreements, and Conventions with Foreign Countries 15. War and Peace 16. Foreign Jurisdiction 17. Citizenship, Naturalization, and Aliens 18. Extradition 19. Passports and Visas 20. Pilgrimages to places outside India 21. Piracies and crimes committed on the high seas or in the air and offenses against the law of nations. 22. Railways. 23. National Highways 24. Shipping and Navigation on National Waterways 25. Maritime Shipping and Navigation 26. Lighthouses for the Safety of Shipping and Aircraft 27. Major Ports 28. Port Quarantine, Seamen and Marine Hospitals 29. Airways. Aircraft and Air Navigation. Provision of Aerodromes 30. Carriage of passengers and goods by railway, sea, air, or national waterways 31. Posts and telegraphs. Telephones, wireless, broadcasting, and other like forms of communication 32. Property of the Union 33. Omitted 34. Courts of wards for the estates of rulers of Indian states 35. Public debt of the Union 36. Currency, coinage, and legal tender. Foreign exchange 37. Foreign loans 38.